Good morning and welcome to live coverage of the confirmation hearings of Brett Kavanaugh, President Trump's nominee to be the next Supreme Court Justice. Day 2 starts at 9:30 a.m. Eastern Time, and we'll bring it to you live. We're looking at a shot of the hearing room. This is Hart 216, when in just a little while, senators will get their chance to grill the nominee. I'm Libby Casey, and I'm joined here in the studio with Eugene Scott, reporter for The Fix. Welcome, Eugene. Great
Thanks
to have you here.
Thanks for having me.
Thank you. You can catch our broadcast today on our homepage, WashingtonPost.com, also on YouTube and on the streaming site Twitch. A special hello to our viewers on Twitch. Thanks for watching and for your comments in chat. You can follow and subscribe if you'd like more political news from the Washington Post. So, Eugene, today is the day that the Democrats have been waiting for, a chance to publicly ask questions of this nominee. Biggest topics that they'll come up with today?
Well, certainly abortion. There are lots of interest in where Kavanaugh, who's quite a social conservative, stands on this issue and what he could be ruling on in the future. Other topics related to voting rights, affirmative action in higher education, all of these key topics for the left, progressives specifically, will probably come up by some of the lawmakers who are looking to be leaders of the Democratic Party moving forward.
All right, great. Ann Marimo is our colleague on Capitol Hill who's covering this hearing live. Ann, thanks so much for stepping out of the hearing room for a moment to join us. You wrote a piece looking at the 10 issues likely to come up today, and you were there all throughout yesterday in the fireworks as things got started. What are the issues you're going to be watching for this morning?
Right. Yesterday we heard Kavanaugh's opening remarks about 20 minutes. Today will be the first time Senate Democrats are questioning Kavanaugh and Republicans. I think in addition to abortion, we'll hear questions from Senator Feinstein about gun control laws and what Kavanaugh's views will be on those laws. In addition, I think we'll hear questions about how Kavanaugh can separate himself from the man who nominated him, President Trump, questions about limits on presidential power.
And this question of presidential power is very important, not just to Democrats, but also a couple of Republicans who are on this committee as well, namely Ben Sasse and Jeff Flake. Do you get the sense that they're going to try to hold Kavanaugh to any sort of commitment, say recusing himself if there is a decision that comes before the Supreme Court regarding presidential power?
I think the Republicans were more expressing their concerns about President Trump's attacks on the Justice Department. I think we'll see the Senate Democrats trying to ask Kavanaugh about whether he would be involved in a case about whether a president can be subpoenaed or indicted.
And do you get the sense that we'll get any commitments from Judge Kavanaugh today? The history shows us that nominees tend to try to avoid expressing any opinion that could pin them down and obligate them in the future.
Right. I think Kavanaugh's been having a lot of mock hearings and practicing his answers. I think we'll hear him talking about being a neutral umpire, as Chief Justice Roberts said, and being impartial and having an open mind and not committing to any specific positions.
Finally, Ann, yesterday during Judge Kavanaugh's opening statement, it was sort of long anticipated. We finally got to it late in the afternoon. I didn't hear a lot of substance there. I heard him talking about his family, how he enjoys coaching. Was there anything that you gleaned from that gives us a sense of what kind of Supreme Court justice he would be?
He did talk about being a team player, one of 9. I know on the D.C. circuit, even when he has disagreed with his colleagues, he has very good relationships with those other judges. So I think that gives us a sense personally of what he'll be like as a member of the court if he is confirmed.
All right, Ann Marimo, reporter covering this hearing live. Thanks so much for joining us from Capitol Hill. Eugene, Republicans have to play some defense today and show that they support this nominee and give the American public a reason why. What do you expect to hear from them?
Well, I expect them to argue that Kavanaugh's been well vetted, that he has a reputation on the bench and in his legal career elsewhere of just upholding American values that are consistent with what's in the best interest, according to what conservatives think. I think what they're going to have to do is prove to Democrats and other conservatives who have lots of questions that can be answered in these 100,000 pages of missing documents that have not been made available to Congress, that he's still someone who can be trusted, even if they don't know themselves from firsthand knowledge.
Let's talk about these documents. Democrats wanted to point out yesterday that they are especially looking for documents during the time when he served in the George W. Bush White House. Senator Durbin held up a floor chart. One of his staffers held up a floor chart showing a 35-month gap that he says they don't have information about. Republicans say that that is such a huge lift, and that a lot of that information, because he was essentially a staff secretary, so much information went through his hands that it wouldn't give any insight into his judicial history and where he would be on the bench. But Democrats really made this an issue yesterday. Did they get any closer to accessing these documents?
No, they didn't. And we saw a few lawmakers making the morning show circus communicating that. It's really hard to believe that Republicans would be making that same argument if a Democrat was in the White House and was nominating someone who had a 35-month gap, that information wouldn't tell them much. I think this whole argument from people on the left and some on the right supports the idea that maybe this should not happen this fast. If it's such a huge lift that we can't get information from 35 months, then maybe the vote shouldn't happen right now. But the likelihood of Republicans going with that argument is really low.
Yeah, let's listen to how yesterday's hearing started. You know, the first day is usually very procedural. We really know what to expect. Opening statements. The fireworks are expected on day 2 when the senators get to interview and ask questions of the nominee. But yesterday, just seconds in, Democrats tried to stop the procedure. Let's watch yesterday morning's opening.
Mr. Chairman, I'd like to be recognized to ask a question before we proceed. The committee received just last night, less than 15 hours ago, 42,000 pages of documents that we have not had an opportunity to review or read or analyze.
You're out of order. I'll proceed.
We cannot possibly move forward, Mr. Chairman,
I
with this
extend a
hearing.
very warm welcome
We have not
to
been
Judge
given
Kavanaugh,
an opportunity to have a meaningful
his wife,
hearing on
Ashley.
this nominee.
Their 2 daughters.
Mr. Chairman,
Their
I
extended
agree with my
family and
colleague,
friends.
Senator Harris. Mr. Chairman,
Judge
we
Kavanaugh's
received
many law
42,000
clerks
documents that we haven't
and
been able
everyone else
to
joining us
review last
today.
night, and we believe this hearing should
I
be
know this is an
postponed.
exciting day for all of you here,
Mr. Chairman,
and you're rightly proud
Mr. Chairman,
of
if
Judge.
we cannot be recognized, I move to adjourn.
The American people.
Chairman, I move to adjourn.
So you hear there Chairman Grassley just plowing through and trying to continue. Now, he did stop after a while, and Democrats did get a chance to make their case as to why they wanted to be able to vote. He did not allow that, though. He said that's executive session, not here. Now, he has the ability to turn it into an executive session, so it's not like that would be terribly difficult. But Democrats weren't likely to get the chairman to adjourn yesterday, or even really recess. But they still wanted to make this demonstration, Eugene, and show the American public that they're not happy. One question, though, would these documents really change anybody's opinion? I mean, a lot of these Democrats on the committee have said they're not going to vote for the nominee anyway.
It wouldn't change opinions, but what people on both sides of the aisle are hoping is that the documents would affirm why they believe Kavanaugh is the right person or the wrong person. They would be pointing to examples of decisions he's made and things he said and done that they think would make him the best judge for conservatives, or for make him a terrible selection if you're on the left. It would just add some weight to these positions, because right now things seem so clearly partisan and not with a lot of substance behind it, because there's not enough data and material to point to why people have the positions they have other than political tribalism.
Republicans want to get this process going, though. The Supreme Court takes the bench in October, as they do every year, and so they're using that as the timeline, the motivator. But the subtext is the midterm elections.
Right.
I mean, really, Republicans want to get this done before the midterm elections, because we've obviously seen a Supreme Court of 8 justices, which happened during the end of President Obama's term, be able to function. It's not a requirement to start the term to have the full bench seated with 9. But Republicans have the concern that if they lose the House or even lose the Senate, that could gum up the works for any presidential Supreme Court nominee.
Absolutely. And another reason they want to get this moving forward for October is because President Trump promised one of his largest constituencies, social conservatives, white evangelicals, that one of the reasons they should get on the Trump train is because of his judicial picks. And so if they can get this confirmed, Kavanaugh confirmed by October, when conservatives head to the polls just a few weeks later, Trump could say, I fulfilled so many of my promises to you, and that's why you should back me. If that doesn't happen, it adds to the list of attacks from the Democrats showing that Trump isn't who he said he would be.
That's a great point. Yesterday, two Republicans stood out in their opening statements, Ben Sasse and Jeff Flake. Now, it's important to point out that they were very supportive of the nominee. They praised Judge Kavanaugh, they praised his record, and they praised him as a pick. But they both voiced concerns about President Trump's behavior, especially over the weekend when he was tweeting against his own Attorney General, Jeff Sessions. Let's take a listen to how Jeff Flake talked about this.
Now, I know, and it has been brought up today, that a lot of the concern on the other side of the aisle stems from the concern of an administration that doesn't seem to understand and appreciate separation of powers and the rule of law. I have that concern as well. If you just look at what was said just yesterday by the president, I think it's very concerning. He said in a tweet, 2 long-running Obama-era investigations of 2 very popular Republican congressmen were brought to a well-publicized charge just ahead of the midterms by the Jeff Sessions Justice Department, he calls it. 2 easy wins now in doubt because there is not enough time. Good job, Jeff. That is why a lot of people are concerned about this administration and why they want to ensure that our institutions hold. Thus far they have, gratefully. Jeff Sessions has resisted pressure from the president to punish his enemies and relieve pressure on his friends. And many of the questions that you will get on the other side of the aisle and from me will be how you view that relationship, where you believe the Article 1 powers and Article 2 powers of the administration begin.
Big question there from Jeff Flake. We can expect him to ask questions along those lines today when he gets the opportunity to question Judge Kavanaugh. How important is his role on this committee?
Very. I mean, Flake and Sasse have made names for themselves since Trump entered the White House as being Republicans not afraid to push back on the president and other conservative lawmakers. And so they want to see someone on the bench who's not going to be a yes man either. The challenge is reports from inside the White House are that Trump is looking for someone who will not be the judicial version of Jeff Flake or Ben Sasse. And so whether or not Kavanaugh is going to follow their approach to this administration is going to be key to these lawmakers. It's worth noting, though, that when the president introduced Kavanaugh to the American public, it was with Kavanaugh responded with so much praise of Trump that people were very shocked and won't expect him to continue the approach that we've seen Flake, Sasse, and the late McCain take when it comes to Trump's decisions and behavior and other actions.
We'll certainly hear more about Judge Kavanaugh's history today. He did work on the Ken Starr investigation, looking into President Clinton, and Democrats have raised concerns about his role in that. Afterwards, though, after he spent time working in the Bush White House in particular, he put out an article that we heard Amy Klobuchar mention yesterday from the Minnesota Law Review, where the judge said that Congress might consider a law exempting a president while in office from criminal prosecution and investigation. And that's a lot of what Democrats want to hear about today. The social issues such as abortion, such as gun control, gay marriage, but also this big question of just where does the president's power begin and end, Eugene?
Absolutely, and the obvious undertext is that we have an investigation going on right now that could find something that could lead the president to having to answer for his actions if something did happen during the election, during the campaign, that they want to know that Kavanaugh will hold him accountable. And if Kavanaugh does not think that this is something that should happen to a sitting president, that's very concerning for Democrats.
Okay, so you mentioned that you're going to be watching some Democrats in particular who might have political ambitions beyond even the Senate. Even if they can't move the needle on getting the Senate as a body to vote against Judge Kavanaugh, what opportunity do Democrats have today to get a really vital exchange with him that they could use in a campaign ad, or that they could send to their constituents and say, look, I'm fighting for you?
The Democratic Party right now is a party that is very much controlled by the grassroots and the base. And the base is incredibly diverse in terms of gender, age, race, socioeconomic status. And so I think we're going to be looking for lawmakers to make comments about the working poor, about people of color, about immigrants, about gay rights. These key issues that will motivate the base to come out in 2018 and more importantly for some of these lawmakers in 2020. I think those are the sound bites that they'll be looking for.
Who are you going to be watching for in particular?
Kamala Harris, Cory Booker, Gillibrand, just some of these lawmakers that we think could be interested in having larger, higher ambitions.
Amy Klobuchar, also
Yeah.
someone to watch as well. You really got a sense yesterday morning as things kicked off and Democrats lodged their protest. You saw right off the bat Senator Kamala Harris being the first one to try to slow things down, and then Amy Klobuchar right after that. You see here on the dais the senators preparing. We can see some of the Republicans there on the right side of your screen. This will be the day that Judge Kavanaugh sits in front of them and gets questions from each member of this committee. The way that the chairman has set it up, each senator gets 30 minutes to ask their questions, get that Q&A, that back and forth. There's Cory Booker. He definitely went over his time limit yesterday in the opening statements. He did this whole preamble about his relationships and friendships in the committee and how much he likes the chairman. And then when you thought it was about to wrap up, he said, "And now for my opening statement." And you sort of felt everyone say, so we'll see how long and drawn out people make this today, but I think it's those exchanges that's what's going to help us learn the most.
Yeah.
Not just hearing from the senators themselves. So 30 minutes for each senator, and then another round of 20 minutes for each senator to do follow-up. This may go 12 hours today, according to the Senate offices, and then we're also going to see any continuation, what's not been finished up today, tomorrow.
Yeah.
And then after that, Eugene, we will hear from people who are supportive of the nominee and then opposed to the nominee. So we do expect this to run through Friday.
Yeah.
What do you think Democrats would take away as a win today? And what would Republicans take away as a win today when it's all said and done?
I think if Democrats can communicate and prove to listeners that we just do not know enough about Kavanaugh to put him in this position of power, and just to create so much more doubt to increase the lack of approval, lack of support for Kavanaugh in polling, that will be an argument that they will be able to make heading into the midterm elections in 2020, showing that Trump and the Republican Party and the people that back him are people we do not know that well. And that's an argument I think Democrats and even some independents are pretty sensitive to right now, considering some of the other issues we've had come up with people related to Trump in the last couple of weeks. I think conservatives will show what will be a win for conservatives if they can prove to their base that this is someone who can protect their values, their vision of what America should be, and move the court in a direction as far away from the direction Obama was moving it as possible.
You see Judge Kavanaugh there coming in through the back and moving past senators. There's Senator Kennedy, Republican. We see him there with Chairman Grassley escorting him to his seat. His family was sitting behind him for much of the hearing yesterday. We saw supportive opening statements from Condoleezza Rice, who worked with him during the Bush administration. Also, a liberal lawyer, Lisa Blatt, who actually is the person who has argued the most cases before the Supreme Court as a woman, the most in history, and she supported him. But certainly, she's basically the only liberal out there who's willing to put her name out there supporting this nominee. We'll see tough questions from the senators today. Camera's going in for that classic shot as things get started. He looked pretty unflappable yesterday, even as protesters interrupted the hearing multiple times. 70 people arrested yesterday for protests.
Wow.
So we'll see if that happens again today. We did hear from Ann Marimo telling us offline that the handmaid protesters are back. We saw women yesterday in the sort of the Handmaid's Tale garb, standing silently in the Senate Hart building. They are back today.
And we saw protesters outside as well. There's a crowd that has made it known that they don't have much interest in getting Kavanaugh on the bench, and they were holding signs and chanting, trying to communicate why. One thing I was noticing yesterday quite a bit, he definitely seemed unflappable, but he was taking so many notes.
He was taking a lot of
particularly
notes.
when I think liberal lawmakers were taking jabs at him. And I'm sure he's going to respond to those at some point and try to clarify what he probably views as a misrepresentation of his positions and his career.
So we'll bring this to you live and uninterrupted throughout the day today, and it may go as long as 12 hours. So stay tuned to the Washington Post as we cover this hearing. We'll leave you now as the chairman prepares to gavel in. I'm Libby Casey. Eugene Scott, thanks so much
Thanks
for
for
your insight
having
and
me.
analysis.
Good morning, everybody, and we welcome everybody back again, and especially Judge Kavanaugh and his wife, Ashley. Yesterday, each senator made their opening remarks. We also heard from three people who had the honor of introducing Judge Kavanaugh: Secretary Rice, Senator Portman, and Attorney Lisa Blatt. And we heard for the first time directly from Judge Kavanaugh. He made a powerful, compelling, and convincing statement demonstrating his exceptional background and qualifications to serve our nation's highest court. NBC News reported that Democratic members of the committee plotted with the minority leader to disrupt the hearing yesterday. Democratic senators interrupted the hearing 63 times before lunch. In the audience, 70 people were arrested yesterday who were following their lead. All probably very constitutionally prepared to do that, doing what the Constitution says, the right of freedom of speech, but we also were able to finally conduct our hearing the way it should be conducted. Yesterday was just opening statements. It was only our time as committee members that we wasted on disruption and disorder over procedural matters. But today is different.
We're going all day.
Your advice was to waive.
My advice was
Senator Grassley, I take offense. I called out Senator Durbin. I don't see how you can say that I was working with Senator Durbin. I'm from his state and I called him out specifically. That we are not working with the Democrats. We are working for ourselves. I'm in the middle of this building.
It was our time as committee members yesterday to make our case. Today is different. Today is the day that the American people are supposed to hear from the nominee. This morning, we'll begin our questioning of Judge Kavanaugh. We will get through all members' first rounds of questions today, no matter how long it takes. Members are allotted 30 minutes for the first round. If your time expires, your remaining questions may be continued, of course, in the second round tomorrow. We'll take a lunch break, as well as probably 2 other 15-minute breaks throughout the day. For now, let's plan our first break after 5 senators or so have completed their questions. I assume that this will be around 12:15, which will hopefully coincide with the floor vote that's already scheduled. This would be a 3-minute or 30-minute break for vote and lunch. But Judge, if you would like to take a break any other time, let us know. We're happy to accommodate that. And with that, I will start the questioning of my 30 minutes. Judge, for the last 12 years, you have served as a federal circuit judge on one of the most influential circuits in America. You have offered 307 judicial opinions and joined hundreds more, totaling more than 10,000 pages of record. You have decided some of the most pressing legal issues facing our country. The Supreme Court of the United States, the one you're nominated to be on, has adopted a legal position, your legal position, from at least 12 opinions. The Senate Judiciary Committee has received dozens of strong letters of support from hundreds of people, many of whom you know best, from all across the political and ideological spectrum. And the American Bar Association has given you its highest rating, unanimously well qualified. My Democratic colleagues have said that this is the gold standard of judicial nomination. There is no dispute that you're one of the most qualified Supreme Court nominees. Some people say the most qualified, and I don't disagree with their judgment. And that could be for anybody coming before the United States Senate. I'm not the only one who says that, because we have a letter from Robert Bennett, surprisingly, President Clinton's attorney, and your opposing counsel during the independent counsel investigation of President Clinton. He wrote a very strong letter in support of your confirmation. Quote, Brett is the most qualified person any Republican president could possibly have nominated. Were the Senate to fail to confirm Brett, it would not only mean passing up the opportunity to confirm a great jurist, but it would also undermine civility in politics twice over. First, in playing politics with such an obviously qualified nominee, and then again in losing the opportunity to put such a strong advocate of decency and civility on our nation's highest court. Mr. Bennett also speaks highly of your integrity and to your fairness and open-mindedness. And so without objection, I would enter that letter in the record. Now to a question. I imagine that your 12 years of judicial service on the second highest court in the land has given you plenty of opportunity to think about my first question, which is, what makes a judge a good one, and what influences in your life have shaped your vision of how a judge should go about doing his job?
Thank you, Mr. Chairman. I think the first quality of a good judge in our constitutional system is independence. Independence comes directly from Article 3 of the Constitution. The independence of the federal judges really is guaranteed by the framers in our life tenure and our protection from pay reduction. So because we have life tenure, we are independent and immune from political or public pressure. So I think the first thing that makes a good judge is independence, not being swayed by political or public pressure. That takes some backbone. That takes some judicial fortitude. The great moments in American judicial history, the judges had backbone and independence. You think about Youngstown Steel. You think about, for example, Brown versus Board of Education, where the court came together and knew they were going to face political pressure and still enforce the promise of the Constitution. You think about United States versus Nixon, which I've identified as one of the greatest moments in American judicial history, where Chief Justice Burger, who had been appointed by President Nixon, brought the court together in a unanimous decision to order President Nixon in response to a criminal trial subpoena to disclose information. Those great moments of independence and unanimity are important. Respect for precedent is another one. We are a system of constitutional precedent. Precedent is not just a judicial policy. It's sometimes stated that it's just a policy. Precedent comes right from Article 3 of the Constitution. Article 3 of the Constitution refers to the judicial power. What does that mean? What does judicial power mean?
Judicial power, you look at Federalist 78, and what's described there is a system of precedent. So precedent is rooted right into the Constitution itself and is constitutionally dictated to pay attention and pay heed to the rules of precedent. Beyond that, being a good judge means paying attention to the words that are written, the words of the Constitution, the words of the statutes that are passed by Congress, not doing what I want to do, not deferring when the executive rewrites the laws passed by Congress, but respect for the laws passed by Congress, respect for the law, the words put into the Constitution itself. That's part of being a good judge. That's part of being independent. That's part of precedent. And then I would say being a good judge, there are human qualities in terms of the interaction. Although these confirmation processes focus on one person, as if you're making all the decisions, as I said yesterday, I'm joining a team of 9 if I were fortunate enough to be confirmed. And that means something. It means something in sports. It means something in judging. I don't make decisions by myself. For the last 12 years, I have not been making decisions by myself. Every case has been in a panel of at least 3 judges. And you learn from each other when you're deciding cases. You work with each other when you're deciding cases. And so having collegiality and civility, as Justice Kennedy showed us so powerfully, repeatedly, with how he conducted himself over the years. That's very important, because those great moments that I was talking about at the beginning, like United States versus Nixon, like Brown v. Board, the court came together in unanimous decisions, and the unanimity of the decisions added force. That took personal interaction, that took collegiality. So I think, I've tried to be a very collegial judge. I've tried to be civil. I want, Mr. Chairman, the losing party in every case to come out and say, Kavanaugh gave me a fair shake. He was well prepared. He wrote a clear opinion. He explained everything. I disagree, but at least I get it. So I want the losing party, and I want both parties to walk out at oral argument and say, he had an open mind, he gave me a fair shake, and I think I've done that for 12 years. I've tried to do that consistently. Everything you do as a judge matters in terms of being a good judge. Oral argument, writing opinions, how you decide. So those are the qualities. I guess the last thing I always remember about it is the thing I said my mom taught me in the first instance. Judging is not just about theory. It's not theory. It's not just what a law review article is. Judging is real people in the real world, and every decision we make, no matter how high-minded it might sound, affects real people in the real world with real interests. And we have to remember that in how we explain the decisions. Thank you, Mr. Chairman.
Now, following up on the wise words of Senator Sass yesterday on separation of powers, your record before the Senate includes more than 10,000 pages of judicial writings over your dozen years. We have over 440,000 pages of emails and other records from your legal service at the White House and Judge Starr. And you have written extensively on the issue of our Constitution's separation of power among the 3 branches. A key component of the separation of powers is the independent judiciary. Obviously, everybody learns in 8th grade civics about judges interpreting law. The judiciary must continue to be the least political and least dangerous branch. A judge's sole job is to find and apply the law evenly and fairly, without regard to the president who nominated him, the senators who voted for him, the parties before him, and the political consequences of his judicial decision. So, Judge, let's discuss judicial independence from the executive branch. No one, not even the president, is above the law. Some of my colleagues have criticized your views of presidential authority, suggesting, wrongly in my opinion, that your views of presidential authority would not allow any meaningful check on the president, particularly this one. Please tell us what judicial independence means to you, including whether you have any trouble ruling against the president who appointed you and against the executive branch in any case before you. You partly talked about independence, but apply it specifically to a ruling against the president or the executive branch generally.
Thank you, Mr. Chairman. To begin with, you're correct. No one is above the law in our constitutional system. Federalist 69, Hamilton, makes clear all the ways that the executive branch, as designed by the framers of the Constitution, was different from the monarchy. Under our system of government, the executive branch is subject to the law, subject to the court system, and that's an important part of Federalist 69. It's an important part of the constitutional structure. In general, so too, we as judges are separate from the Congress. We are not supposed to be influenced by political pressure from the executive or from the Congress. We are independent. We make decisions based on law, not based on policy, not based on political pressure, not based on the identity of the parties, no matter who you are in our system, no matter where you come from, no matter how rich you are or how poor you are, no matter your race, your gender, no matter your station in life, no matter your position in government. It's all equal justice under law. And again, look at our examples in history. I always will go back to the great moments in our history where these principles, which sound abstract if you're just describing them, were actually implemented. And I go back to Youngstown Steel. And you think about, it's a 6-3 decision where the Supreme Court rules that President Truman has violated the law by seizing the steel mills. Now, this is a time of war where lots of Americans were killed. And the Supreme Court's under pressure to defer to the president's war effort. And a 6-3 decision, but what's interesting to me, Justice Clark, you don't usually talk about Justice Clark in that decision. Why is he important? He's important. He was appointed by President Truman to the Supreme Court. What a moment of judicial independence there to rule in that case. You think about Justice Jackson, who had been working for President Roosevelt, and then he dissents in the Korematsu case. Stands up and says, letting racism like this is like letting a loaded weapon lie around. Dissents against President Roosevelt's decision. Justice Jackson's...
Ask him to suspend.
Justice Jackson's concurrence in Youngstown, which is, of course, what has become the law, that 3-part test, Category 1, Category 2, Category 3. But again, he writes that concurrence in Youngstown. Why is that a moment of judicial independence? He had taken positions contrary to that when he had worked in the executive branch in the Roosevelt administration, yet when he's a judge, he sees it differently as an independent judge. How about Chief Justice Burger? United States versus Nixon. Writes the opinion. Unanimous. Moments of judicial independence. So it's resisting public pressure, political pressure. It's treating everyone equally, no matter where you are, what station. When I was became a judge on the D.C. Circuit, I had a case called Hamdan versus United States. Who's Hamdan? So in the Hamdan case, Hamdan's one of bin Laden's associates. You will never have a nominee. Mr. Chairman, should I proceed?
Yeah. This is coming out of my time, but that's okay. Let these people have their free speech and interrupt the other 300 million people. Listen, that this is your opportunity to speak to the American people and for them to make a judge about it. If they want to affect what the other 300 million people hear from you, then that's just too bad. You proceed now.
Hamdan's one of bin Laden's associates involved before September 11th, worst attack ever on American soil. He's prosecuted before a military commission, signature prosecution of the Bush administration. Comes to the D.C. Circuit. I'm on the panel. I write the opinion saying that his military commission prosecution is unconstitutional, violates ex post facto principles. You'll never have a nominee who's ruled for a more unpopular defendant than ruling for Salim Hamdan. And why did I do that in that case? Why did I rule for someone who had been involved in the September 11th? It's because the law compelled it, as Justice Kennedy showed us in the Texas versus Johnson case. We don't make decisions based on who people are or their policy preferences or the moment. We base decisions on the law. Justice Kennedy's example of independence is something I've tried to follow. And it means, you're not a pro, as I said yesterday, not a pro-plaintiff or pro-defense judge, not a pro-prosecution or pro-defense judge. I'm a pro-law judge, and I've ruled for parties based on whether they have the law on their side. That's part of being an independent judge, is ruling for the party no matter who they are, so long as the party is right. If you walk into my courtroom and you have the better legal arguments, you will win.
I think you answered my next question based upon what you said about Hamdan, but there's probably other examples. You don't need to go into detail, but you have President. President Bush appointed you. Are there other cases that there's been other cases, presumably you've ruled against the administration of the person that appointed you?
Absolutely, Mr. Chairman. There were a slew of cases on everything from Freedom of Information Act to some of the administrative law cases. The Hamdan one is certainly the one that comes to mind most because of the importance of that case, yet I ruled that it was unlawful.
Yeah. Now, did anyone ask you to make any promises or assurances at all about the way that you would rule in certain cases?
No.
Were you asked about your views on Roe v. Wade?
No.
We're talking about separation of powers. Have you ever written any decisions where you use the 10th Amendment? I'm talking about division of powers between federal and states.
Mr. Chairman, most of the cases that come to the D.C. Circuit are at the national level and therefore involving questions of separation of powers between the legislative, executive, and judicial branches. Of course, federalism is a critical part of our constitutional structure as well. The genius of our system, Federalist 39, as described by Madison, is that we have both a national government and a federal government simultaneously. And the House of Representatives really represents, in some ways, the national part, proportional representation. This body, with 2 senators from each state, represents, in many ways, the federal part, each state represented equally. And the federalism system by which the states are allowed to regulate local matters. In some of the Commerce Clause cases, such as United States versus Lopez and United States versus Morrison, reinforce the idea that there is a core of authority that is exclusively in the province of the states and beyond the scope of the federal government. The 10th Amendment The 10th Amendment reinforces the structure of federalism that's in our constitutional system. It's important always to remember the role of the states in our constitutional systems. And it's important to recognize as individual citizens, something we often forget, particularly in a process like this. Our rights and liberties are protected by the federal Constitution and by the federal courts, but they're also protected by state constitutions and state courts. A great judge on the Sixth Circuit, Judge Jeff Sutton's written a new book about using state constitutions to help protect your individual liberties and rights too. This whole document, through the separation of powers and the federalism, tilts toward liberty.
Okay. Now, we've talked about your independence from a president. There's also the question of independence from the legislative branch, equally as important. You're going to be asked about your personal views on a variety of topics and whether you believe various Supreme Court cases were correctly decided. Presumably, this is because senators are going to try to predict how you'll rule in cases before you. The idea is that if you agree with your personal views on, if they agree with your personal views on particular issues of morality or on Supreme Court precedent, they maybe would vote to confirm you. If not, they might not. Of course, that's improper. Judges should never promise their future votes on the bench in exchange for a senator's vote for them. If you answer these questions about your views on specific Supreme Court cases or public controversies of the day, you'd be showing the opposite of independence from the legislative branch. Politicians can make promises about how they'll vote on issues. Judges, by the very nature of the job, should never promise any outcome. If a nominee answers these questions, it threatens to undermine judicial independence. Of course, there may be times where it's appropriate to reconsider certain decisions, especially if more recent opinions have called into question the rationale of the original decisions. So, with this in mind, I'd like to explore the approach that you'd take towards Supreme Court precedent. Could you tell us your views on the value of precedent? I think you've already done that. But if you want to expand on it, go ahead. Have you ever followed precedent of the Supreme Court when doing so conflicted with your personal beliefs?
Well, my personal beliefs are not relevant to how I decide cases. The role of precedent in our system, which I said is rooted in Article 3 of the Constitution, it's not just a judicial policy. The role of precedents to ensure stability in the law, which is critically important. It's also to ensure predictability of the law. People who order their affairs around judicial decisions need to know that the law is predictable. Whether you're an individual or a business or a worker, you need to have predictability. People rely on the decisions of the courts. And so reliance interests are critically important to consider as a matter of precedent. They are one of the reasons we have the system of precedent, so that people can rely on the decisions. Precedent also reinforces the impartiality and independence of the judiciary. The people need to know in this country that the judges are independent and that we're not making decisions based on policy views. Part of that is to understand we're following a system of precedent of what has been done before. The court, every time someone gets on, it's not just bouncing around to what do I think's best. It's what's the precedent of the Supreme Court is always part of the analysis, an important part. And for 12 years, I've been applying precedent of the Supreme Court and of my court. Every day for 12 years, I haven't been getting up saying, how can I rewrite the law? I've been getting up for 12 years every day saying, okay, how can I apply this Fourth Amendment precedent to this fact pattern that comes before me? Or how can I apply this First Amendment precedent to this fact pattern that comes before me? So precedent is the foundation of our system. It's part of the stability. It's ensuring predictability. And it's just foundational to the Constitution, as Article 3 and Federalist 78 make clear.
Now you'll be asked by other members which Supreme Court precedents you like and don't like, but as you know, it's inappropriate for a nominee to answer those questions. And this refers to Justice Ginsburg. She said, quote, "A judge sworn to decide impartiality can offer no forecasts, no hints, for that would show not only disregard for the specifics of a particular case, it would display disdain for the entire judicial process, end of quote. The underlying reason for this, of course, is that making promises or giving hints undermines the very independence that we've discussed. Would you agree with that?
I do, Senator, Mr. Chairman, and one of the things that I have to remember sitting in this seat is that this moment is a moment of judicial independence with how I interact with this committee. And what I've done in each of the jobs I've had, and particularly as a judge over the last 12 years, but also in the executive branch, I always ask myself, and I tell people I'm working with to ask, how has it been done before? How has it been done before? So as a judge, how has it been done before is precedent. That's how's it been done before. When I'm sitting here, what did I do? I went and studied all the nominee precedent. I've read Thurgood Marshall's hearing and Justice Brennan's hearing, and I've read the hearings of the 8 justices currently sitting on the Supreme Court. It's what I call nominee precedent. And so all the nominees currently sitting on the Supreme Court, all the justices, have made clear a couple things. First of all, they can't discuss cases or issues that might come before them. As Justice Ginsburg said, no hints, no forecasts, no previews. That also means, with respect to at least the vast body of Supreme Court precedent going back, you can't give a thumbs up or thumbs down on the case. That's Justice Kagan's formulation. She said repeatedly, no thumbs up or thumbs down when she was asked, what do you think about this case? What do you think about that case? I liked her formulation there, no thumbs up or thumbs down. That nominee precedent, as I call it, is now, in my view, part of the independence of the judiciary. And that nominee precedent is something I need to adhere to when I am here as a nominee now, because that's one of my jobs here is not to advance my own interest, but remember I'm a representative of the judiciary as a whole, and I have a responsibility to judicial independence right here, right now as a nominee. So following that nominee precedent is going to be critical. Now, there's an exception that the 8 justices have drawn currently sitting on the court, if you read all the hearings, for some older cases, and I'll be happy to use some older cases where nominee precedent does allow the justices, has allowed them to talk about a few older cases. And again, why do we do this? Why is this nominee precedent there? When 8 justices of widely ranging views do this, there must be a reason. The reason is judicial independence. What does that mean? It means 2 things in this context. One, the litigants who come before us have to know we have an open mind, that we don't have a closed mind, that we haven't committed something in this process that is going to affect how we decide a case because we feel bound by what we promised to this committee. And believe me, judges do feel bound by what they said to this committee. So if I say something and the case comes before me 5 years from now, I'm going to feel morally bound by what I said here. And if I've crossed the line of what I should say, then I'm not going to have an open mind in that case. That's a violation of judicial independence. Secondly, as Chief Justice Roberts described perhaps better than anyone, if I get into some kind of process that appears to be a bargaining process where I say, well, I'll agree with this decision in exchange for your vote, it's never that explicit. But that's, as Chief Justice Roberts described it, that's kind of the what seems to be going on sometime. Well, that's a complete violation of judicial independence, because then the judges aren't making the decisions based on their reading of the law. It's really, as Chief Justice Roberts described it, it's the Senate or the Senate Judiciary Committee really sending a nominee as a delegate to the judiciary and really doing what the Senate Judiciary Committee thinks is the right thing to do. Chief Justice Roberts explained very forcefully that doing that would be a violation of judicial independence. That nominee precedent weighs heavily on me as a nominee here because it's rooted in judicial independence, and I've said repeatedly already that I'm going to be an independent judge. Well, I have to be an independent nominee as well, so I'm going to have to adhere to the lines drawn by those prior nominees, Mr. Chairman.
With only 25 seconds left, I'm going to reserve that time and go to Senator Feinstein.
Thank you very much, Mr. Chairman. Good morning, Judge.
Thank you.
I'm sorry about the circumstances, but we'll get through it. I wanted to talk to you this morning about guns and go back to Roe v. Wade, if I might. My office wrote the assault weapons legislation in 1993. It was law from 94 to 2004, and it essentially prohibited the transfer, sale, and manufacture of assault weapons. It did not, at the time, affect possession. I happen to believe that it did work and that it was important. And I have watched case after case, and I think I mentioned earlier, school shootings, which are just, I never thought this would happen in our country, that someone would bring a semi-automatic assault weapon into a school and just mow down children and staff. And so I've been very interested in your thinking on assault weapons. You specifically argued that the D.C. assault weapons ban was unconstitutional, and I think because you said these weapons were in common use. What did you base your conclusion that assault weapons are in common use? And what evidence or study did you use to do that?
Thank you, Senator Feinstein, for the question. And I understand, of course, your role on that issue and your long leadership on that issue, and appreciate that. I faced a decision where, as in every other decision just about on the D.C. Circuit, I had to follow precedent of the Supreme Court. I don't get to pick and choose which Supreme Court precedents I get to follow. I follow them all. And so in the Second Amendment context, the Supreme Court in the Heller decision, written by Justice Scalia, had held that there was an individual right to keep and bear arms. And then in explaining what that meant and what exceptions would be allowed to that right, Justice Scalia's opinion for the court in Part 3 of the opinion went through, this does not mean that there's no gun regulation permissible. So that was an important part of the opinion, Part 3 of the Supreme Court's opinion, where it pre-identified a number of exceptions that would be allowed. Felon in possession laws, concealed carry, laws, possession of the mentally ill, possession of guns in schools, possession in certain kinds of buildings. He pre-identified that. As to the weapons, the way I understood what he said there and what was said in the McDonald's case later was that dangerous and unusual weapons could be prohibited. And what he referred to specifically is machine guns could be prohibited. So it's very important to recognize under the Heller decision, machine guns can be prohibited. And
they were in the Firearms Act a long time ago.
Yes, and that's
have been prohibited.
Yes, Senator, and Justice Scalia's opinion did not disturb that long-standing regulation. In fact, specifically reaffirmed that machine guns could be prohibited. The court in Heller, the Supreme Court, upheld or struck down a D.C. ban on handguns, most of which are semi-automatic.
Let me interrupt you because I think we're on totally different wavelengths. I'm talking about your statement on common use, as common use being a justification, and assault weapons are not in common use.
And Justice Scalia's opinion used that phrase. Then I think the next sentence of the opinion talked about dangerous and unusual weapons. And the court in Heller itself, the Supreme Court, struck down a D.C. ban on handguns. Now, most handguns are semi-automatic. That's something that not everyone appreciates. Most handguns are semi-automatic. And the question came before us of semi-automatic rifles, and the question was, can you distinguish as a matter of precedent? Again, this is all about precedent for me, trying to read exactly what the Supreme Court said. And if you read the McDonald case, and I concluded that it could not be distinguished as a matter of law semi-automatic rifles from semi-automatic handguns, and semi-automatic rifles are widely possessed in the United States. There are millions and millions and millions of semi-automatic rifles that are possessed, so that seemed to fit common use and not being a dangerous and unusual weapon. That was the basis of my dissent. In a nutshell, the basis of my dissent was I was trying to follow strictly and carefully the Supreme Court precedent. And I know you've read the opinion.
You're saying the numbers determine common use? Common use is an activity. It's not common storage or possession, it's use. So what you said was that these weapons are commonly used. They're not.
They're widely possessed in the United States, Senator, and they are used and possessed, but the question is, are they dangerous and unusual? They're certainly dangerous. All weapons are dangerous. Are they unusual? And given how prevalent they are in the United States, it seemed under Justice Scalia's test, and if you look at the majority opinion in McDonald, the same thing. I want to reiterate, the Supreme Court made clear that machine guns can be banned. Machine guns can be banned.
Let me speak to you. I'm talking about the Heller case. Let me be specific. And you specifically argued that it was unconstitutional to defend assault weapons because they are, to ban assault weapons because they are in common use. And that, I believe, was your dissent in the case.
Yes, and I was referring to some kinds of semi-automatic rifles that are banned by D.C. are widely owned in the United States. And that seemed to be the test that the Supreme Court had set forth in the Heller and McDonald cases. In other words, if a type of firearm is widely owned in the United States. Now, whether I agree with that test or not was not the issue before me. I have to follow the precedent of the Supreme Court as it's written. And that's what I tried to do in that case. It's a very long opinion. I also made clear, Senator Feinstein, at the end of the opinion, I am a native of this area. I'm a native of an urban, suburban area where I grew up in a city plagued by gun violence and gang violence and drug violence. So I fully understand, as I explained in the opinion, the importance of this issue. I specifically referenced that Police Chief Kathy Lanier's goals of reducing gang and gun violence was something I certainly applauded, but that I had to follow the precedent of the Supreme Court in that case. And as I read it, that's what it said. I'm sorry.
How do you reconcile what you've just said with the hundreds of school shootings using assault weapons that have taken place in recent history? How do you reconcile that?
Senator, of course, the violence in the schools is something we all detest and want to do something about. And there are lots of efforts I know underway to make schools safer. I know at my girls' school they do a lot of things now that are different than they did just a few years ago in terms of trying to harden the school and make it safer for everyone. Handguns and semi-automatic rifles are weapons used for hunting and self-defense, but as you say, Senator, you rightly say, they're used in a lot of violent crime and cause a lot of deaths. Handguns are used in lots of crimes that result in death, and so are semi-automatic rifles. That's what makes this issue difficult. As I said in the last 2 pages of my dissent in Heller, I fully understand the gang violence, gun violence, drug violence that has plagued various cities, including Washington, D.C. This was known as the murder capital of the world for a while, this city, and that was a lot of handgun violence at the time. And so I understand the issue, but as a judge, my job, as I saw it, was to follow the Second Amendment opinion of the Supreme Court, whether I agreed with it or disagreed with it. At the end of the opinion, I cited Justice Kennedy's Texas versus Johnson quote, which I read yesterday as the guiding light for the lower court judges and all judges.
Let me give you a couple of other quotes because I'm going to change the subject. Do you agree with Justice O'Connor that a woman's right to control her reproductive life impacts her ability to quote, participate equally in the economic and social life of the nation, end quote.
Well, as a general proposition, I understand the importance of the precedent set forth in Roe v. Wade. So Roe v. Wade held, of course, and it's reaffirmed in Planned Parenthood versus Casey, that a woman has a constitutional right to obtain an abortion before viability, subject to reasonable regulation by the state, up to the point where that regulation constitutes an undue burden on the woman's right to obtain an abortion. And one of the reasons for that holding, as explained by the court in Roe and also in Planned Parenthood versus Casey more fully, is along the lines of what you said, Senator Feinstein, about the quote from Justice O'Connor. So that's one of the rationales that undergirds Roe v. Wade. It's one of the rationales that undergirds Planned Parenthood versus Casey.
Well, let me give you another one, rationale. In the 1950s and 60s, the 2 decades before Roe, deaths from illegal abortions in this country ran between 200,000 and 1.2 million. That's according to the Guttmacher Institute. So a lot of women died in that period. So the question comes, and you have said today, not today, but it's been reported that you have said that Roe is now settled law. The first question I have of you is, what do you mean by settled law? I tried to ask earlier, do you believe it is correct law? Have your views on whether Roe is settled precedent or could be overturned? And has your views changed since you were in the Bush White House?
Senator, I said that it's settled as a precedent of the Supreme Court entitled to respect under principles of stare decisis. And one of the important things to keep in mind about Roe v. Wade is that it has been reaffirmed many times over the past 45 years, as you know. And most prominently, most importantly, reaffirmed in Planned Parenthood versus Casey in 1992. And as you well recall, Senator, I know when that case came up, the Supreme Court didn't just reaffirm it in passing. The court specifically went through all the factors of stare decisis in considering whether to overrule it. And the joint opinion of Justice Kennedy, Justice O'Connor, and Justice Souter at great length went through those factors. That was the question presented in the case.
Could I interrupt you to say, since you mentioned stare decisis, and I sat on 9 of these hearings, and when the subject comes up, the person says, I will follow stare decisis, and they get confirmed, and then, of course, they don't. So I think knowing going into it, how you make a judgment on these issues is really important to our vote as whether to support you or not, because I don't want to go back to those death totals in this country. And I truly believe that women should be able to control their own reproductive systems within, obviously, some concern for a viable fetus.
Mm-hmm. And I understand your point of view on that, Senator, and I understand how passionate and how deeply people feel about this issue. I understand the importance of the issue. I understand the importance that people attach to the Roe v. Wade decision, to the Planned Parenthood versus Casey decision. I don't live in a bubble. I understand. I live in the real world. I understand the importance of the issue.
Well, my staff just passed me a note. Let me read it to you because I think it's a good. Have your views about whether Roe is settled precedent changed since you were in the Bush White House?
My
yes or no?
Well, I'll tell you what my views. I'm not sure what it's referring to about Bush White House, but I will tell you what my view right now is, which is an important precedent of the Supreme Court that's been reaffirmed many times, but then and this is the point I want to make that I think is important, Planned Parenthood versus Casey reaffirmed Roe and did so by considering the stare decisis factors. So Casey now becomes a precedent on precedent. It's not as if it's just a run-of-the-mill case that was decided and never been reconsidered, but Casey specifically reconsidered it, applied the stare decisis factors, and decided to reaffirm it. That makes Casey a precedent on precedent. Another example of that, because you might say, are there other cases like that, is Miranda. So Miranda's reaffirmed a lot, but then in the Dickerson case in 2000, Chief Justice Rehnquist writes the opinion considering the stare decisis factors and reaffirming Miranda, even though Chief Justice Rehnquist, by the way, had been a fervent critic of Miranda throughout his career. He decided that it had been settled too long, had been precedent too long, and he reaffirmed it. So precedent on, I'm sorry to interrupt.
I'm sorry to interrupt. But I want to switch subjects, and one last question. What would you say your position today is on a woman's right to choose?
Well, as a judge,
As a judge?
As a judge, it is an important precedent of the Supreme Court. By it, I mean Roe v. Wade and Planned Parenthood versus Casey. Been reaffirmed many times. Casey is precedent on precedent, which itself is an important factor to remember. And I understand the significance of the issue, the jurisprudential issue, and I understand the significance as best I can. I always try, and I do here, of the real-world effects of that decision, as I tried to do of all the decisions of my court and of the Supreme Court.
Well, I thank you for that. Let's go to presidential power for a moment. You were part of Ken Starr's independent counsel team, which conducted a sweeping investigation into possible wrongdoing by President Clinton and the First Lady. At the time, you argued for aggressive questioning of the president. You did not take the position that President Clinton was immune from investigation. Since then, you have taken the opposite position. In fact, you have said that, and I quote, "If the president were the sole subject of a criminal investigation, I would say no one should be investigating that at all." What did you mean by that? And what are the circumstances where a sitting president could be subject to criminal investigation?
And I appreciate the sign there. Senator, the last sign I should have mentioned while I was up, the Second Amendment sign, actually had a brackets around part of my quote, and I'm not sure if it was the exact quote, but this one, I just wanted to point that out.
Is this accurate?
Here's what I was saying, Sarah. Let me explain it. This one. The last one may or may not have been accurate. I just wanted to point that out for the record. It had brackets for my quote. This one. So what happens after the Starr investigation? Then I work 5.5 years in the White House. So let me just give you, if I can, some context here, and I'm going to get specifically to your question. So I work in the independent counsel investigation, and that is obviously difficult, controversial, a moment for our country that I wish hadn't happened. We all wish it hadn't happened. And I reflect on that. I wrote a Georgetown University Law Journal article in '99 reflecting on some of my thoughts about that. This seems to be a tendency of mine to go through an experience, write an article reflecting on it. And then I work in the Bush White House for 5.5 years. And I write an article in the Minnesota Law Review, Senator Klobuchar, in 2009, when President Obama was in office, I should point out. And I reflected on a number of things I had learned working in the independent counsel office and then working in the White House. And I thought there were a number of things Congress could take a look at that I had experienced. One of them was I proposed timelines for consideration of judicial nominees. I proposed a 180-day up or down vote for every judicial nominee. That was something that, from my experience, I thought would avoid controversy and have rules of the road set in advance, and I proposed that specifically for Congress to consider. Other aspects, I said, another thing I proposed was for Congress to consider whether it should look at Clinton versus Jones or the principle of Clinton versus Jones. So you call Clinton versus Jones and said a president is subject to civil suit while in office, the Paula Jones suit. That was a controversial decision, but the Supreme Court made clear at the end of the decision Congress could provide extra deferral of suits, not immunity, but deferral of suits for presidents if Congress so wanted. And so in the Minnesota Law Review article, I put out some ideas about whether Congress may want to think about that. And why did I do that? I think Senator Durbin asked yesterday, what changed that made me think about that from the time? What changed was September 11th. That's what changed. So after September 11th, I thought very deeply about the presidency. And I thought very deeply about the independent counsel experience. And I thought very deeply about how those things interacted. And I thought very deeply about seeing President Bush. When he came into the Oval Office on September 12, 2001 in the morning, President Bush said, "This will not happen again. This will not happen again." And he was of single-minded focus. Every morning for the next 7 years for President Bush was still September 12, 2001. Single-minded focus. And then thinking back to the independent counsel experience in August of 1998. So I proposed some ideas for Congress to consider. Here's the bottom line point. There were ideas for Congress to consider. They were not my constitutional views. If a case came up where someone was trying to say this is a constitutional principle, I would have a completely open mind on that because I've never taken a position on the Constitution on that question. I've only put out proposals for you all to study, to think about the balance of a president fighting a war, leading a war, and a president subject to, say, ordinary civil lawsuits as in the Clinton versus Jones case.
Let me ask you, you're becoming very good. You're learning to filibuster. But let me ask this question precisely. The Supreme Court has unanimously ruled that a president can be required to turn over information. It upheld the subpoena for the tapes of Oval Office conversations that revealed President Nixon's efforts to cover up the Watergate break-in. This, as you know, was U.S. v. Nixon. You have said that the Nixon case might have been wrongly decided. Was U.S. v. Nixon wrongly decided, in your view?
So that quote is not in context and is a misunderstanding of my position that's up there. I have repeatedly called U.S. v. Nixon one of the 4 greatest moments in Supreme Court history. So I've called that, the 4 I've always identified are Marbury versus Madison, Youngstown Steel, Brown versus Board of Education, and United States versus Richard Nixon. And why have I, Brown versus Board, by the way, the single greatest
Was
moment.
it rightly decided?
So I have said that, I've said yes, that the court's holding that a criminal trial subpoena to a president in the context of the special counsel regulations in that case for information, a criminal trial subpoena for information under the specific regulations in that case, I have said that holding is one of the 4 greatest moments in Supreme Court history. So not only I can explain how that misunderstanding came up, because I know there was a news story about that, and that's just not correct impression of my views. My views have been consistently. Why was it one of the greatest moments? It was one of the greatest moments because of the political pressures of the time. The court stood up for judicial independence in a moment of national crisis. That's what the Supreme Court, we need the Supreme Court to decide the things we can foresee. But one of the things that's really important for the Supreme Court, we're going to have crisis moments at the Supreme Court on things we can't even predict. And we need people on the Supreme Court who are prepared for that. And U.S. v. Nixon is...
My time's going to run out very quickly. Let me just ask you this. Can a sitting president be required to respond to a subpoena?
So that's a hypothetical question about what would be an elaboration or a difference from U.S. v. Nixon's precise holding.
That's right.
And I think going with the Justice Ginsburg principle, which is really not the Justice Ginsburg alone principle, it's everyone's principle on the current Supreme Court. And as a matter of the canons of judicial independence, I can't give you an answer on that hypothetical question.
So you can't give me an answer on whether a president has to respond to a subpoena from a court of law?
As my understanding is that you're asking me to give my view on a potential hypothetical, and that's something that each of the 8 justices currently sitting on the Supreme Court, when they're sitting in my seat, declined to decide potential hypothetical cases. I can tell you about the U.S. v. Nixon precedent, and I did, about Chief Justice Burger's role in forging a unanimous opinion, and really all the justices worked together on that. But Chief Justice Burger, who had been appointed by President Nixon, writes the opinion in U.S. v. Nixon, 8-0, Rehnquist was recused, 8-0, ordering President Nixon to disclose the tapes in response to a criminal trial subpoena. A moment of crisis argument, I think July 8th, 1974, they decided 2 weeks later. Really important opinion. Moment of judicial independence. Important precedent of the Supreme Court. But how that would apply to other hypotheticals, I best, as a sitting judge and as a nominee, follow the precedent of the nominees who've been here before, and as a matter of judicial independence, not give you a precise answer on a hypothetical that could come before me.
Understand. Thank you very much for being forthcoming. Appreciate it.
Thank you,
you,
Senator.
Mr. Chairman.
You want, I assume you want to reserve your 3 minutes?
Can I do that?
No.
I will.
Senator Hatch.
Well, thank you, Mr. Chairman. Before I begin, I'd like to enter into the record 3 letters and an op-ed supporting Judge Kavanaugh's confirmation. The first letter, which I mentioned yesterday in my opening statement, is a letter from 41 attorneys who are members of the Supreme Court Bar. The signers include people like Lisa Blatt, Deanne Maynard, and Kathleen Sullivan. As the letter notes, the signers, quote, hold a broad range of political, policy, and jurisprudential views, but they speak as one in supporting Judge Kavanaugh's nomination, unquote. The letter authors write, quote, based on our experience with Judge Kavanaugh and his work over 12 years of distinguished judicial service, we are confident that he possesses the character, temperament, and intellect that will make him an asset to our nation's highest court, unquote. Now, the second letter is from Carolyn Williams, a partner at the venerable D.C. law firm Williams & Connolly, who served on the ABA's Standing Committee on the Federal Judiciary. She writes that she has followed Judge Kavanaugh's legal career since 1990, when she was the hiring partner at the firm, and he was a law student. Ms. Williams says that Judge Kavanaugh, quote, has all the qualities litigants and lawyers hope to find in a Supreme Court justice: superb intellect and legal acumen, fundamental fairness and decency, abiding respect for precedent, and the rule of law, unquote. Now, I also want to enter to the record a letter and op-ed by Jay Lefkowitz. The op-ed appeared in National Review and is entitled, Brett Kavanaugh is a Mensch. In it, Mr. Lefkowitz writes that Judge Kavanaugh, quote, has a strong commitment to protecting Americans' freedom of religion, no matter what their faith, unquote. And Mr. Lefkowitz should know, he and Judge Kavanaugh worked together in private practice on a pro bono religious freedom case representing a Jewish synagogue in Maryland. And they won the case, vindicating the right of the congregation to build a place of worship in their neighborhood.
Okay.
Now, let me just begin with this. Before I begin, Judge, I'd like to ask you to keep your answers to my questions as concise as you can so I can get through as many of them as time allows. Some of my colleagues have suggested that President Trump nominated you because he thought you'd rule in his favor should certain issues come before the court. Suppose you had a case involving President Trump or an issue near and dear to the president. What assurances can you provide that you will not allow the president's personal views on a case or personal interest to impact your decision?
Senator, I'm an independent judge. For 12 years, I've been deciding cases based on the law and the precedent in each case. If confirmed to the Supreme Court, that's how I'll do it as well. I'll be part of a team of 9. I'll decide cases based on the Constitution, the law, the precedent, the Supreme Court, working with the other 8 justices, without fear or favor, independently, without pressure from any quarter. The person who has the best arguments on the law and the precedent is the person who will win with me.
Well, thank you. If at the end of the process, of this process, you are confirmed to the Supreme Court, which I expect you will be, what sort of loyalty will you owe to the president? How will that loyalty differ from the loyalty you owe to, say, the American people?
Senator, if confirmed to the Supreme Court and as a sitting judge, I owe my loyalty to the Constitution. That's what I owe loyalty to. And the Constitution establishes me as an independent judge, bound to follow the law as written, the precedents of the Supreme Court as articulated, subject to the rules of stare decisis, and I would do so.
Okay, you were appointed to the D.C. Circuit by George W. Bush. I think it's fair to say you were close to President Bush. You worked for him for a number of years. Can you give us some example of cases in which you ruled against the Bush administration, notwithstanding that President Bush was the one who put you on the bench?
Senator, the most prominent example is the Hamdan case.
Yeah.
That was the military commissions case. That was a signature prosecution of the Bush administration. They had established, with congressional authorization eventually, after a unilateral effort didn't succeed in the courts, established military commissions. The military commissions were to try al-Qaeda terrorists who had committed war crimes. And one case came to us, Salim Hamdan, and the question was the prosecution unlawful because the crime of which he was convicted was not an identified crime as of 2001 when he was alleged to have committed it, ex post facto principles. And I wrote the opinion reversing his conviction, even though it was a signature prosecution of the United States, even though it was a national security case, because was the right answer under the law, and it doesn't matter who you are or where you come from. If you're right under the law, you prevail.
I'd like to turn now to your work in the Bush administration. As you know, my Democratic colleagues are demanding to see every piece of paper or every single scrap of paper you ever touched during your 6 years in the Bush administration, in part because they want to know what role, if any, you played in developing the Bush administration's interrogation policies. Well, 6 years ago, Ranking Member Feinstein, who was then the chairman of the Senate Intelligence Committee, and a good one at that, issued a lengthy report on the CIA's detention and interrogation program under President Bush. The report detailed the origins, development, and implementation of the program. In 2014, a declassified version of that report was released to the public. The declassified version, or report, runs well over 500 pages, and your name appears nowhere in it. Now, I myself spent over 20 years on the Intelligence Committee. I know the quality of its staff and the work that they do, and I know the ranking member and how diligent she is. If you had played a role in the Bush administration's interrogation policies, I think the ranking member would have discovered it. Numerous administration lawyers appear in the report, but not you. And that should tell us something. With that said, Judge Kavanaugh, I want to ask you for the record, what role, if any, did you play in developing or implementing the Bush administration's detention and interrogation policies?
Well, the policies that are reflected and described in Senator Feinstein's extensive, thorough report. Were very controversial, as you know, Senator, the enhanced interrogation techniques.
Right.
And the legal memos that were involved in justifying some of those techniques also were very controversial when they were disclosed in 2004. And I was not involved, I was not read into that program, not involved in crafting that program, nor crafting the legal justifications for that program. In addition to Senator Feinstein's report, the Justice Department did a lengthy Office of Professional Responsibility report about the legal memos that had been involved to justify some of those programs. My name's not in that report, Senator, because I was not read into that program and not involved. There were a number of lawyers, and this came up at my last hearing, a number of lawyers who were involved, including a couple who were then judicial nominees. And at my last hearing, I recall Senator Durbin asking about whether I also was likewise involved as these other judicial nominees had been. And the answer was no, and that answer was accurate. And that answer has been shown to be accurate by the Office of Professional Responsibility report, by Senator Feinstein's thorough report. And I do want to say on Senator Feinstein's report, that is an important piece of work that collected facts about a program, that it's important for us to know those facts for the future. And I know it was an enormous effort and a lot of tough work to get all that information for Senator Feinstein and the Intelligence Committee. But I have looked through that report and looked through the Office of Professional Responsibility report. I was not read into that program, Senator. Thank you for asking.
Okay. Judge, you've been accused of misleading this committee during your 2006 confirmation hearing regarding your role in developing the Bush administration detention policy. Now, you have a strong reputation in the legal community for honesty and integrity. Read any one of the dozens of letters we received supporting your nomination, and you'll see that right away. Now, some of my colleagues may not give you the opportunity to answer this question fully, so I'd like to give you the opportunity now. Did you mislead this committee in 2006? If not, what is the source of the confusion about your prior testimony?
I told the truth and the whole truth in my prior testimony. I was not read into that program. The subsequent reports of Senator Feinstein and Office of Professional Responsibility show that. And that is what I did then. That's the answer now. I was not read into that program.
Okay, as I mentioned in my opening statement, 18 of your former women law clerks have written to the committee in support of your nomination. That's all of your former women law clerks who were not precluded by their current or pending employment from signing the letter. Now, these women describe the mentoring and encouragement you've given them in their careers. And they say that you are, quote, one of the strongest advocates in the federal judiciary for women lawyers, unquote. Quite a compliment. The majority of your clerks, in fact, have been women. Now, I understand that you were the first judge in the history of the D.C. Circuit to have an all-female class of clerks. Why do you believe it important to encourage young women lawyers and to ensure that both men and women are well represented in the legal profession?
Senator, I believe in equality. Equality for all Americans, men and women, also regardless of race, ethnicity. My mom was an example, as I described yesterday, of breaking barriers, showing me first on racial equality by her example of teaching at McKinley Tech. Then, when she became a lawyer, In the late 70s, there were not many women prosecutors at the time, definitely male-dominated, and how she overcame barriers, was a great prosecutor, became a state trial judge in Maryland, appointed by Democratic governors. She showed me by her example the importance of women's equality. During college, you've received a letter from 10 college friends of mine who are women athletes at Yale. Talked about how I treated them in women's sports with respect and as equal, even when I was in college. You have a letter from 84 women I worked with in the Bush administration who talked about my efforts to work with them in the tense environment of the West Wing, especially after September 11th.
Did you say 84?
84 women signed a letter who had worked in the Bush White House, and worked in that tense environment. But I came to be a judge in 2006, May 2006. And August 2006, Linda Greenhouse of the New York Times runs a story in the New York Times about the scarcity of women law clerks at the Supreme Court that year. There were 7, I believe, that year out of 37. And she wrote a story about that. And that seemed to me very odd and unacceptable. And I started thinking about what I could do. First of all, why is that happening? And what can I do about it? What's the problem? What can I do? So the problem seemed to me these networks that judges rely on for clerk hiring, some professor networks, were excluding women, or at least women weren't fully represented in those. That's true with minorities as well, by the way. And so I made sure when I was talking to professors at law schools that I made sure I want to see a broad pool of well-qualified applicants, including women. And in that year, for example, fall of 2006, which was my first year on the bench, we hire a year ahead, so I'm hiring for 2007. And I hired 3 women for that clerk class, 2007, 3 out of the 4. Zena Bash, Britt Grant, and Porter Wilkinson. Zena's right here. And that was the start of my efforts to make sure that women were not being excluded. And I really worked on why is this happening. So Yale Law Women did a study about 5 years ago about participation in class, the differences on who gets called on in class. And there's slight differences there, men and women, who then get selected as research assistants, slight differences there, and it just keeps building till you get a disparity in the clerk network. And there's a pipeline problem, and I've said I'm breaking through that problem. I'm not listening to that. And so I've been very aggressive about hiring the best and understanding that the best include women. And as you say, Senator, a majority of my clerks have been women, 25. I believe 21 of them have gone on to clerk at the Supreme Court. And they're an awesome group. And if confirmed to the Supreme Court, I will continue to do this. What it takes, and I think my mom showed me this, President Bush showed me this a little, what it takes is just not accepting the same old answer. Oh, there's a disparity. Well, why? And then do something about it. And I tried to figure out why, and we can talk about minority clerks too, but on women, why were those disparities existing as described by Linda Greenhouse? And I tried to figure out why, and then I did something about it. I'm very proud of that because I do believe that all people should be treated equally, and the law clerk position, which may sound ministerial, and to some extent the job is helping the judge and shortly out of law school, but those positions are very important launching pads for the next generation of leaders. The people will be sitting in these seats. The people will be sitting in my seat. Lots of them are going to come from law clerks. So if we're not being inclusive now, that will show up later. And so it's just been a critical part. It's something I'm very focused on at all times, is equality in the clerkship hiring process and making sure women are getting the same opportunities that men are. I appreciate the question, Senator.
Well, thank you, and I appreciate the answer. And I think everybody in this country should appreciate the answer. And I think it distinguishes you. Late last year, allegations against former Ninth Circuit Judge Alex Kozinski surfaced when the Washington Post published an article detailing disturbing allegations of misconduct by the judge. You clerked for Judge Kozinski for 1 year in 1991, 1992. Some of your opponents have suggested that you must have known about these allegations. This seems to me to be an effort at guilt by association, which is not the way this committee should operate in any way. With that in mind, I want to give you a chance to answer a few questions about Judge Kozinski so that we're all operating on the same foundation of facts. First, how long have you known Judge Kozinski?
I clerked for him in 1991, 92, so I started the clerkship 27 years ago.
Second, I understand from media reports that Judge Kozinski operated an email list where he would send inappropriate material. Were you on this email list?
I don't remember anything like that, Senator.
How often did you talk with Judge Kozinski on the phone?
Not often. Not often, Senator.
How often did you see him in person?
Again, not often. Maybe when there's a legal convention or...
That's what a lot of people don't seem to understand, you know.
I was not working in the courthouse. He was in the Pasadena courthouse in California with small courthouse with 10 other Court of Appeals judges in that courthouse. I, of course, was working in Washington, D.C.
When you did see and talk with Judge Kozinski, what type of things did you talk about?
We were among the 12 co-authors of the Brian Garner-led book on judicial precedent. So for several years, that was a project all of us were, the 12 of us, I guess it was in total, were working on that. Diane Wood, Chief Judge of the Seventh Circuit, and, and Justice Gorsuch was also a co-author, so we worked on that as a group. And then Justice Kennedy, for the last 30 years, had Judge Kozinski run Justice Kennedy's law clerk hiring process, and in the course of that process, I would have communications with the judge.
Okay. Did you know anything about these allegations?
Nothing.
Okay. Before they became public last year?
No. When they became public, you know, the first thought I had was no woman should be subjected to sexual harassment in the workplace, ever, including in the judiciary, especially in the judiciary. And when I heard, when they became public, I think it was in December, it was a gut punch. It was a gut punch for me.
It was for me, too.
It was a gut punch for the judiciary. And I was shocked and disappointed, angry, swirl of emotions. No woman should be subjected to sexual harassment in the workplace. And I applaud Chief Justice Roberts' appointed committee of judges to establish better procedures. Chief Judge Garland did the same thing for our court. And those are first steps. I don't think they're final steps by any stretch. And this is part of a much larger national problem of abuse and harassment. And one of the things we've learned is we need better reporting mechanisms. Women, in particular in the workplace, need to know if they're the victim of harassment, where to report it immediately, who to report it to. They need to be know that they'll be safe if they report it. They need to have a safe working environment and be safe if they report it. They won't be retaliated against, and they'll be protected if they report it. And that's part of the steps, or one of the steps that's, I think, being improved as a result of the working group or committee that the Chief Justice has appointed. And I'm interested in doing everything I can to assist those efforts to make those workplaces safe. Again, it's part of a broader national problem, whether it's priests or teachers or coaches or doctors or business people or news people. there's a broad national problem that needs to be addressed, including in the judiciary, and
Okay.
I applaud Chief Justice Roberts for doing so.
Okay, I'd like to talk to you now about the Chevron doctrine. Now, this is an important judicial doctrine that takes its name from the Supreme Court case that created it back in the 1980s. In that case, the Supreme Court instructed federal courts to defer an agency's interpretation of the law if the law is, quote, ambiguous, unquote. Some of your academic writings express skepticism about the Chevron doctrine and concern that it allows an administration to impose its policy preference by avoiding the political process. I can understand why this would be appealing to an administration, but I also think it's a threat to the separation of powers because it transfers power from Congress and the judiciary to the executive branch. That's why I've introduced the Separation of Powers Restoration Act to reverse the Chevron doctrine. Many members of this committee have co-sponsored this legislation. And as someone who has written extensively about the separation of powers, can you tell us why the separation of powers is so important and how it helps to protect individual freedom?
The separation of powers protects individual liberty because it responds to the concern the framers had, that something Senator Klobuchar said yesterday from Federalist 47, that the accumulation of all power in one body would be the very definition of tyranny. So Federalist 47 talks about that, Federalist 69. So the separation of powers, to begin with, protects individual liberty. It does so because Congress can pass the laws, but you can't enforce the laws. A separate body has to decide to enforce the laws. And then even if the law is enforced, and a citizen may say, well, I want someone who didn't pass the law or enforce it to decide whether I violated the law or whether the law is constitutional. And that's why we have an independent judiciary to guarantee, as an independent matter, our rights and liberties. And the three branches, therefore, do separate things because it all tilts toward liberty. It's hard to pass a law, as you know, in the Congress. And then even if it does get passed and affects your liberty, a separate body has to decide, usually U.S. Attorney's Office, to enforce the law, and that's a separate decision. That helps protect your liberty. And then even if that happens, you go to a court and you say, either I didn't violate that law, as I'm accused of doing, or that law is unconstitutional, or they're interpreting that law in a way that's not consistent with what the law said. The court independently decides that. It's not the members of Congress or the executive deciding that. That's how the Constitution's separation of powers tilts toward liberty in all its respects. Now, as to your specific question, Senator, one of the things I've seen in my experience in the executive branch and in the judicial branch is a natural tendency, but it's a natural tendency that judges need to be aware of and then respond to. So here's the natural tendency. Congress passes laws, but then can't update the law. So maybe it's an environmental law, or maybe it's some kind of law dealing with national security. Let's take those two examples to illustrate. And then an executive branch agency wants to do some new policy and proposes a new policy to Congress, but Congress doesn't pass the new policy. What often happens, or too often I've seen, is that the executive branch then relies on the old law as a source of authority to do this new thing. And they try to say, well, the old law is ambiguous, so we can fit this new policy into the old law as justification for doing this new thing. And I've seen this in national security cases. I've seen it in environmental cases. You see it all over the place. It's a natural phenomenon because the executive branch wants to implement what it thinks is good policy. Now, when those cases come to court, it's our job to figure out whether the executive branch has acted within the authority given to it by Congress. Have you given them the authority? And my administrative law jurisprudence is rooted in respect for Congress. Have you passed the law to give the authority? I've heard it said that I'm a skeptic of regulation. I am not a skeptic of regulation at all. I am a skeptic of unauthorized regulation. of illegal regulation, of regulation that's outside the bounds of what the laws passed by Congress have said. And that is what is at the root of our administrative law jurisprudence.
Okay, one of the most important qualities I look for in a judicial nominee is the ability to impartially interpret the law and apply it to the case before the court. Now, this can often be the most difficult part of a judge's job because it may require the judge to rule against a litigant that may be sympathetic or against a policy that the judge may personally agree with. As Justice Sotomayor's confirmation hearings, Senator Schumer commended her for, quote, hewing carefully to the text of statutes, even when doing so results in rulings that go against so-called sympathetic litigants, unquote. Do you believe that it's important for a judge to interpret and apply the laws that Congress has actually passed, rather than seeking to make up or change the law if the judge doesn't like what the Congress has done? And if so, why or why not?
I agree completely, Senator. That's at the foundation of what I view as the proper judicial philosophy.
Okay.
The separation of powers system you described, we have to stick to the laws passed by Congress. You make the policy, we'll follow the policy direction that you put into the laws that are enacted, passed by the House and Senate, signed by the President. We don't rewrite those laws. The executive branch also shouldn't be rewriting those laws beyond the scope of the authority granted.
Okay, some of my colleagues have criticized you for purportedly ruling too often against environmental interests. It seems to me that many of these circumstances boil down to the fact that some of my colleagues don't like the environmental laws Congress has actually passed and are frustrated that they haven't been able to get their own preferred environmental policies signed into law. Now, I've looked through your record, and I found that you have not hesitated at all to uphold environmental regulations when they were actually authorized by statute. Could you give us a few examples of cases where you have upheld environmental regulations because you concluded that Congress had authorized them?
Limit it to as many few as you can as time is running out.
Senator, as I said yesterday, I'm a pro-law judge, and in environmental cases, in some cases I've ruled against environmentalist interests, and in many cases I've ruled for environmentalist interests. And they're big cases, cases like the American Trucking Association's case, where I upheld a California regulation for a majority over a dissent, stricter air quality standards in the National Association of Manufacturers case, EPA rules for particulate matter in the UARG case, permit process applicable to surface coal mining in the National Mining Association case, the Murray Energy case rejecting a premature challenge to a Clean Power Plan regulation, the National Resources Defense Council case versus EPA, ruling for environmentalist groups. In a case, that was a big money case where the industry wanted an affirmative defense to be created for accidental emissions. The affirmative defense was not in the statutes passed by Congress. The industry came in with their lawyers and said, well, just write the affirmative defense into the law. And I wrote the opinion saying, no, it's not in the law. And yes, that might be a problem for industry, but we follow the law regardless. And so there are a large number of cases where I've ruled in favor of environmentalist interests because that's what the law required in that case.
Thank you, Judge. I appreciate it.
Thank you, Senator.
Senator Leahy.
Well, thank you, Mr. Chairman, and good morning, Judge.
Thank you, Senator.
You and your family. We have a lot of questions, and I know you've done a lot of preparation with a couple of our distinguished Republican colleagues about the questions you might be asked. But let me ask you something that normally isn't an issue during Supreme Court hearings. You testified before this committee in both 2004 and 2006 as part of your nomination to the D.C. Circuit Court. Then you were nice enough to come by my office and chat with me last month. I asked you that if you change anything in your prior testimony, and you said no. Is that still your position?
It is, Senator. I told the truth. I was not read into the programs.
No, I'm not asking about what we did, but I just asked you if you would change anything in your...
Well, I'd like to explain if I can.
Well, I'm going to give you a chance, because I'm going to ask you a couple questions. Go ahead.
Well, I just wanted to explain that at the last hearing in 2006 in particular, you were concerned, understandably, because there had been 2 judicial nominees who had been involved in the legal memos, in the legal discussions around crafting the enhanced interrogation techniques and detention policies. You were concerned whether I also was involved in those. And I made clear in response to those questions that I was not read into that program. That was 100% accurate. It's still accurate today. I think Senator Feinstein's report and the Office of Professional Responsibility report established that I was not involved in those programs. Now, there were two judicial nominees.
Okay, I'm going to go into that in a little bit. I don't want to go over my time as the preceding senator did. I want to stay with
Well, Senator, I just want to be clear. I want to reassure you.
I'm going to go into it. I'm going to give you a chance to speak a lot more.
Without
But let me
Hey,
ask,
I'm not going to take time away from you, but I want to explain something. I said yesterday that if a question is asked within the 30 minutes, that he can finish the question and it can be answered. So he did not go over his time.
Sorry, I didn't mean to hit a sensitive area. Let me ask you this: between 2001, I'm new here. Between 2001 and 2003, 2 Republican staffers on this committee regularly hacked into the private computer files of 6 Democratic senators, including mine. These Republican staffers stole 4,670 files, and they used them to assist in getting President Bush's most controversial judicial nominees confirmed. Now, the theft by these Republican staffers became public in late 2003 when the Wall Street Journal happened to print some of the stolen materials. The ringleader behind this massive theft was a Republican staffer named Manny Miranda, who had worked for one of the members of this committee. In a way, it was considered by many, both Republicans and Democrats, as a digital Watergate, not a theft not unlike what the Russians did in hacking of the DNC. Now, during all this, you worked hand in hand in the White House with Manny Miranda to advance these same nominees where he was stealing material. Not surprisingly, you were asked extensively about your knowledge of this theft during both your 2004, 2006 hearings. And I don't use the word extensively lightly. You were asked over 100 questions from 6 senators, both Republicans and Democrats. And you testified repeatedly that you never received any stolen materials. You knew nothing about it until it was public. You testified that if you had suspected anything untoward, you would have reported to the White House counsel, who would have raised it with Senator Hatch, especially as Mr. Miranda had worked for him. And at the time, we left it there. We didn't know any better. Today, with the very limited amount of your White House record that has been provided to this committee, and it is limited, for the first time, we've been able to learn about your relationship with Mr. Miranda and your knowledge of these events. So my question is this: did Mr. Miranda ever provide you with highly specific information regarding what I or other Democratic senators were planning on asking certain judicial nominees?
Senator, well, let me contextualize, because I'm looking at what you're putting up here first. And the renewed.
Thank you.
Well, the question. So that what's up there is 100% accurate. That's my memory.
Okay, so let me ask you this. That's
never knew or suspected. True. Never suspected anything untoward. True. Had I suspected something untoward, I would have talked to Judge Gonzalez.
And I've already.
I would have talked to Senator Hatch. That's all 100% true.
And that's what I'd already said. But did Mr. Miranda ever provide you with highly specific information regarding what I or other Democratic senators were planning in the future to ask certain judicial nominees?
Well, one of the things we would do as a White House is on judicial nominations, and I'm coming to your answer, but I want to explain, is to meet up here, and this happens on both sides all the time, with teams up here about, okay, their judicial nominations, our judicial nominees are coming up, how are we going to get them through? Here's a hearing coming up. And during those meetings, of course, it would be discussed, well, I think here's what Senator Leahy's going to be interested in. That's very common. I'm sure in President Obama's administration, when they had similar meetings, they would probably have meetings and say, well, I think this is what Senator Graham will be interested in. That's what you do in meetings with, so highly specific would, I think, I'm not sure what you're getting at by highly specific.
I've been here over 40 years. I know what both Republican and Democratic administrations do in preparing. I'm not asking about that. I'm asking you, why before this did Mr. Miranda send you an email asking you on July 19, 2002, asking you and another Bush official why the Leahy people were looking into financial ties between two special interest groups and Priscilla Owen, a particular controversial nominee to the Fifth Circuit? You would handle that Owen nomination. As you know, as a judge, she had received a lot of contributions.
Well,
did Mr. Miranda send you an email asking you why the Leahy people were looking into her financial ties?
Is that what this email is?
I'm just asking you.
Well, can I take a minute to read it?
Of course.
Okay.
This incident was 4 days before her hearing on July 23rd.
Did I send any of the emails on this chain? I don't think so. I think I'm CC'd. Or in any event, if he said, why are the Leahy people looking into this? From Manny Miranda. I don't really have a specific recollection of any of this, Senator, but it would not have been at all unusual for, and this happens all the time, I think, which is the Leahy people are looking into this and the Hatch people are looking into that. I think.
You say all the time, 2 days before the hearing, he told you that the Democrats were passing around a related 60 Minutes story, and he said his intelligence suggests that Leahy will focus on all things money. Well, that appears to come from a stolen email to me, stolen by the Republican staff member, sent to me the night before, and then given to you the next morning. Were you aware that you were getting from Mr. Miranda stolen emails?
Not at all, Senator. It was part of what appeared to be standard discussion about. It's common, Senator, for at the White House, it'd be common to hear from our Leg Affairs team. This is, in fact, in this process, it's common to hear. This is what Senator X is interested in. This is what Senator Y is going to focus on.
Was it common to have copies of a private email sent to a particular senator?
Copies of a private email sent to a particular senator?
Yes. Wouldn't that jump out at you? For
What,
example,
what are you referring to?
Well, Mr. Miranda is telling you about emails sent to me the night before. There'd be no way that he would even have that unless he stole it. Did that raise any question in your mind?
Did he refer to that email in this?
Yes.
And where is that, Senator?
I'll let you read it.
Well, I'm not seeing where I'm not seeing what you're referring to.
Yeah, it's not here.
Okay. Well, let me take you one that you do have, because you do have this information from Mr. Miranda, and the very limited amount of material that the Republicans are allowing us to see of your information about you, that at least did come through. But in January 2003, let me go to something very specific. Mr. Miranda forwarded you a letter from me and other Judiciary Democrats to then Majority Leader Tom Daschle. The letter was clearly a draft. It had typos and it wasn't signed. Somebody eventually, we never put it out, but somebody eventually leaked its existence to Fox News. I'm not sure who, I could guess. It was a private letter. At the time I was shocked to learn it existed. It had been leaked, but here's the thing. You had the full text of my letter in your inbox before anything had been said about it publicly. Did you find it at all unusual to receive a draft letter from Democratic senators to each other before any mention of it was made public?
Well, the only thing I said on the email exchange, if I'm looking at it correctly, Senator, was who signed this, which would imply that I thought it was a signed letter.
It was sent to you. Were you surprised to get it? I mean, it's obviously a draft. It's got typos and everything else. Were you surprised the draft letter circulated among Democrats ended up in your inbox?
But
from Mr. Miranda.
I think the premise of your question is not accurately describing my apparent recollection or understanding at the time, because I wouldn't have said who signed this if I thought it was a draft. And my email says who signed this.
So you didn't realize what you had was a stolen letter signed by me, that you had a letter that had not been sent to anybody, had not been made public?
Well, all I see that I said was who signed this. That's all I see.
Well, let me ask you some more, because so much of this came from Mr. Miranda, who was a Republican staffer who was, as we now know, stealing things. Did he ever ask to meet privately with you at an off-site location somewhere other than the White House or Capitol Hill?
I think sometimes, Senator, that the meetings with Senate staffers and White House and Justice
I'm
Department.
just asking about one particular one, Mr. Miranda.
Yeah, sometimes, usually it would be either at the White House or the Senate, but I think sometimes we'd meet, or DOJ, but sometimes it could be somewhere else.
Well, did he ask to meet with you privately so he could give you information about Senator Biden and Senator Feinstein?
I'm not remembering anything specific, but that's certainly possible. And again, Senator, I just want to be clear here, because it's very common when you're in judicial selection process to determine what are all the senators interested in for an upcoming nominee or an upcoming hearing. That is the coin of the realm. Senator X is interested in focusing on administrative law. Senator Y is going to ask about environmental law. Senator is concerned about your past work for this client. And that's a very common kind of discussion.
Did he ever ask to have you meet him, not at the White House, not at the Capitol, but at his home?
I don't remember that.
Okay. Did he ever ask to meet you outside of the White House or the Capitol?
I can't rule that out, but again, that wouldn't have been typical.
Did he ever hand you material separately from what would be emailed back and forth?
Not remembering if you're referring to something in particular, I can answer that. But
Okay,
I'm
well,
not
let me ask you this. Did you ever receive information via Mr. Miranda, information marked confidential that informed you what my staff was sharing with other Democrats?
I don't know the answer to that, Senator, but again, it's not always the case, at least my understanding, that the people on, for example, your staff and Senator Hatch's staff were necessarily working at odds. It seemed like a lot of times the staff was cooperating at times, not at other times, obviously, but at times about judicial nominations. And so it wouldn't have raised anything in particular in my mind if we learned, oh, Senator Leahy's concerned about this.
Did my staff ever send you confidential material from Senator Hatch that was stolen from his emails?
Well, not the last part, but I certainly did talk to your staff when we were working on the airline bill, on the September 20, 2001 airline bill. I did remember being here all night one night with your staff, and I'm sure we did talk that night about what other senators thought, and that was the airline bill where, as I think you recall, Speaker Hastert was involved, and we were up there with the OMB team. So in that, I worked hard with your staff on that. It just struck me as not uncommon at all to be talking with our ledge team about what senators on both sides think. It didn't strike me that it was always armed camps.
But no, and oftentimes it was not. But here you're getting obviously very private Democratic emails. You weren't concerned how Mr. Miranda got them?
Well, I guess I'm not sure about your premise.
Were you at all concerned about where Mr. Miranda got some of the material he was showing you?
I don't recall that, but on the premise of your last question, I want to step back to that. Not sure I agree with the premise.
I just say, if you're getting something that's marked confidential, wouldn't you assume that's not something being shared back and forth?
Unless it was shared. I mean, this is the thing. If a staffer said, here's what we're sending to, you all should be aware of this because we're going to make we're going to be really opposed to this judicial nominee. So just to be clear, it seemed to me sometimes there were judicial nominees you were very opposed to, sometimes you were supportive of, and sometimes in between, and there would be messages passed back and forth and sharing of information. Very cooperative, as I recall.
Well,
you were transparent. In other words, when you had problems with nominees, I recall transparency, and when you were supportive, you were at the May 9th, 2001 event at the White House, I recall, where the president announced his first 11 Court of Appeals nominees, and you were supportive of many of them.
Well, as you know, but as a fact, I voted for a lot of Republican nominees.
Yes.
Both to the Supreme Court, the Courts of Appeals, and the District Court.
Yes.
But when I've opposed one, like with Judge Owen, when I was raising some very questions about funding that she was getting from people that were before her court, that might have raised a red flag that I had some concerns about her. Now, when you worked at the White House, did anyone ever tell you they had a mole that provided them with secret information related to nominations?
I don't recall the reference to a mole, which sounds highly specific, but certainly it is common. Again, the people behind you can probably refer to this, but it's common, I think, for everyone to talk to each other at times and share information. At least this was my experience. This is 20 years ago almost, where you would talk to people and the committee.
You never received an email from a Republican staff member with information claiming to come from spying on Democratic mole?
I'm not going to rule anything out, Senator, But if I did, I wouldn't have thought that anything. I wouldn't have thought that the literal meaning of that. But
Wouldn't it surprise you that if you got an email saying you got that from somebody spying on Democrats?
Well, is there such an email, Senator? I don't know. I mean, that's.
Well, we'd have to ask the chairman what he has in his confidential material.
But here's the, if you're referring to something particular, here's what I know.
Hey, just stop a minute here. Reference twice in your 30 minutes, and don't take this off of his time. You made reference. You're talking about the period of time that he was White House counsel.
Yep.
That material's available to everybody.
So that bit of the material about him that's marked committee confidential is now public and available? Is that what you're saying? If that's what the chairman's saying, we got a whole new series of questions.
No, not if it's committee confidential, but
So it's not available.
you have access to it.
Not so that I
But
can
don't
ask.
forget, 80% of the material we've gotten from the library is on the website of the Judiciary Committee, so the public has access to it.
No,
Proceed.
I want Judge Kavanaugh to have access so that we can ask him these questions under oath and he can see them. So I would ask and we'll have another round, but I would ask the chairman if he might look at some of these that are marked committee confidential, which limits the ability of us to ask you specifically and hand you the specific emails. But I would state on what has been public.
Let me answer that for you. There's only one Democratic senator asked for access to that. Senator Klobuchar got it. If you're interested in it, you could have been asking ever since August the 25th, I believe.
We've been asking to have those made public. I'm not as interested if I see this in a closed room where I can't talk about it. I want Judge Kavanaugh to see the emails which came from Mr. Miranda
Give us a citation of the documents and we'll get them for you.
That
And we'll
testimony
make
up there is true, 100%.
Can somebody read it? You can't see it. What?
Well, of course, it would be helpful if we allowed the National Archives time to complete their review.
But I just want to reassure you, Senator, because you're asking important questions. I want to reassure you that what you've got up on the board is 100% accurate.
Can somebody move it so we can see it here?
Well, I am concerned because there is evidence that Mr. Miranda provided you with materials that were stolen from me. And that would contradict your prior testimony. It's also clear from public emails, and I'm restrained from not going into the non-public ones, that you had reason to believe materials were obtained inappropriately at the time. Now, Mr. Chairman, there are at least 6 documents that you consider committee confidential that are directly related to this. Just like the 3 documents I shared, they're already public. These other 6 contain no personal information, no Presidential Records Act restricted material. There is simply no reason they can't be made public. I hope they will be before this next round. You know, it is difficult when to ask a question, I have to ask the Republicans, will you allow me to ask the question? I certainly never did that when I was chairman. Now, I'd asked you in 2006 whether you'd seen any documents relating to President Bush's NSA warrantless wiretapping program, or whether you'd heard anything about it. You answered you learned about it with the rest of us in December 2005 when the New York Times reported. Now, I know it's been 12 years, so here's a video of your sworn testimony. Should be on the TV screens. Documents relating to the President's NSA warrantless wiretapping program?
Senator, I learned of that program when there was a New York Times story, or the reports of that program when there was a New York Times story that came over the wire, I think on a Thursday night in mid-December of last
You had
year.
not seen anything or had you heard anything about it prior to the New York Times article?
No,
Nothing at all?
nothing at all.
Mr. Chairman, can I?
Can I, again, don't take this time away from him. Now, as far as I know, in 15 hearings, so I'm going to read something in just a minute, but preface it with this. As far as I know, in 15 hearings that I've been involved in of Supreme Court justices, there's never been such a video shown. So since this is precedential, I want to read this. The use of a video at a confirmation is highly irregular, but I see no reason why my colleagues can't use a video that was provided by the nominee himself in response to the Senate questionnaire. I've been assured that the video is from Judge Kavanaugh's submission to the committee. Based on this assurance, we've allowed this video to be shown. But I want to emphasize that I expect that video to be used fairly. The video clip should not be presented in a way that deprives it of relevant context. This is consistent with requirements in federal court. That's why I will insist that Judge Kavanaugh have the opportunity, before he answers this question, to request if any additional video be played if it provided appropriate context. So, Judge Kavanaugh, I would ask you, do you believe that more context is needed to be able to address the question?
Well, I don't think I've heard the question yet, but I'll let you know when I hear the question.
Let me ask you this. I'll repeat the question I asked before. You said you heard about this with the rest of us in December 2005. You said on there that you had no knowledge of anything related to this until the New York Times article. Now we have a declassified Inspector General report that on September 17, which was before several months before the New York Times article, John Yoo issued a memo on surveillance of the White House that helped form the legal underpinnings of the NSA warrantless wiretapping program. When you were in the White House in 2001, did you ever work with John Yoo on the constitutional implications of a warrantless surveillance program?
We're talking about a lot of different things, Senator, here.
Warrantless surveillance program.
And that's talking about a lot of different things. So what you were asking about right there was the specific, what President Bush called the terrorist surveillance program. That was his name for it.
Which is a warrantless surveillance program.
Along with many others. And you were asking me about the terrorist surveillance program, TSP, I think he called it. That story was broken. That testimony is 100% accurate. That story was broken in the New York Times. I had not been read into that program. And when it came in the New York Times, I actually still remember my exact reaction when I read that story. And then the president that Saturday, I believe, did a live radio address to explain to the country what that program was about. There was a huge controversy. And so everyone was then working on getting the speech together. And you asked me if I'd learned about it before then. I said no, and that's accurate.
Okay. When you were in the White House, did you ever work with John Yoo on the constitutional implications of any warrantless surveillance program?
Well, I can't rule that. Right in the wake of September 11th, it was all hands on deck on all fronts. And then we were farming out assignments, but we were all involved. On September 12th, when we came in, let's just back up. On September 12th, when we came into the White House, it was, we have to work on everything. And so then over time, people figured out what issues they were going to work on. The airline bill that I was up here on September 20th when the President Bush spoke to Congress that night, as you recall. And then after that, we were in the meeting room together, you and I and others, working on the airline bill. But there were all sorts of other things going on. The Patriot Act was going on.
I know. I was involved with all of those. And
yes,
I remember
I know.
the discussions. But what I want to know, did you ever raise questions about warrantless surveillance?
I can't rule anything out like that. There was so much going on in the wake of September 11th, Senator, as you recall, up here too, but in the White House in particular, and in the counsel's office in particular. We had 8 lawyers in there, 8 or 9, as I recall, and there were so many issues to consider for the president and for the legal team, and those issues, like I said, for President Bush, every day for the next 7 years was September 12th. 2001. And, for the legal team, there was a lot.
For a lot of us, it was.
Yes.
But Mr. Chairman, I sent a letter to you, along with Senators Feinstein and Durbin, on August 16th of this year, asking that we make documents related to this issue public. Without them being public, it's not fair to me, and it's not fair to Judge Kavanaugh that I can't hand him the actual documents, which I think would refresh his memory. And I would ask again, you might look at that before my next term, can we make those public?
You tell us what documents you want, and I'll make them available to you, but I can't say that they can be made public. Just as I said last year during Justice Gorsuch's confirmation, I put a process in place that will allow my colleagues to obtain the public release of confidential documents for use during the hearing. All I asked was my colleagues to identify the documents they intended to use, and I would work to get the Department of Justice and former President Bush to agree to waive restrictions on the documents. Senator Feinstein secured the public release of 19 documents last year under this process, and Senator Klobuchar secured the release of 4 documents this year. If my colleagues truly believe that other committee confidential documents should have been made public, they never told me about them. So let us know what you want, and then you can go ahead and we'll get them for you.
I want the same thing that I requested on August 16th. Because it's directly relevant to Judge Kavanaugh's testimony, directly relevant to the questions I've been asking here, directly relevant to his own emails with John Yoo. So before my next turn, we could take a look at that.
Okay, well, we'll get them for you for your next turn tomorrow.
Now, you said everyone agrees the pardon power gives the president absolute, unfettered, unchecked power to pardon every violator of every federal law. Could a president issue a pardon in exchange for a bribe? Yes or no?
Senator, I think that question has been litigated before, and I don't want to comment about anything.
Well, let me ask you this:
the scope of the pardon. I don't want to scope about. There are a couple things involved in that question. One is what's the effect of the pardon, and the other question is can you be separately charged with the bribery crime, both the briber and the bribee. And those are two distinct questions. You'd want to keep those two questions separate in thinking about how the hypothetical.
Then in that, Mr. Chairman, I got interrupted an awful lot during my time. I just want to finish this question.
But I made sure that if the timer didn't give him another minute.
Thank you. God bless you. I'll be forever thankful. President Trump claims he has an absolute right to pardon himself, does he?
The question of self-pardons is something I've never analyzed. It's a question that I've not written about. It's a question, therefore, that's a hypothetical question that I can't begin to answer in this context as a sitting judge and as a nominee to the Supreme Court.
And the other half of that is the obvious one. Does the president have the ability to pardon somebody in exchange for a promise from that person they wouldn't testify against him?
Sarah, I'm not going to answer hypothetical questions of that sort. And there's a good reason for it. When judges don't, when we decide, we get briefs and arguments of the parties. We have a record. We have an appendix with all the information. We have amicus briefs, and then I never decide anything alone. I'm in a panel of 3, and if I'm confirmed to the Supreme Court, I'd be on a team of 9.
Thank you, Mr. Chairman. I hope for the sake of the country that remains a hypothetical question. Thank you
And
very
since
much.
I gave you an extra minute, I'm not going to let you reserve the 25 seconds.
I'm done.
Senator Graham.
Thank you very much. July the 21st, 1993. I certainly don't want you to have to lay out a test here in the abstract, which might determine what your vote or your test would be in a case you have yet to see that may well come before the Supreme Court. That was wise counsel by Senator Leahy in the Ginsburg confirmation. Very directly, did you ever knowingly participate in stealing anything from Senator Leahy or any other senator?
No.
Did you ever know that you were dealing with anything that was stolen property?
No.
As to the terrorist surveillance program, did you help create this program?
No.
Did you give legal advice about it?
No.
Thank you.
We're referring to the same program I was talking about
yes,
there. Yes.
The one that the article was about. So a bit of a kind of a run through here. You're probably going to get 55 votes. I don't know, 54 to 56 or 57. I don't know what the number will be. There are 11 undecided senators before the hearing. 3 of them are Republicans. I like your chances. 8 of them are Democrat. You're in play with about 5 or 6 of them. And I just want you and your family to know that in other times, someone like you would probably get 90 votes. I want your daughters to know that what happened yesterday is unique to the times that we live in. And I want to give you a chance to say some things to the people who have attended this hearing. I think there's a father of a Parkland student who was killed. I think there's a mother of a child who has got terrible health care problems, and there are many other people here with personal situations. What would you like to say to them, if anything, about your job as a Supreme Court Justice?
Well, Senator, I understand the real-world effects of our decisions. In my job as a judge for the last 12 years, I've gone out of my way in my opinions and at oral arguments, if you listen to oral arguments, to make clear to everyone before me that I understand the situation, the circumstances, the facts. For example, as I was saying to Senator Feinstein earlier in the Heller 2 case about the facts in D.C. And I want to reassure everyone that I base my decisions on the law, but I do so with an awareness of the facts and an awareness of the real-world consequences. And I've not lived in a bubble, and I understand how passionately people feel about particular issues, and I understand how personally people are affected by issues. And I understand the difficulties that people have in America. I understand, for example, well, to start, I understand the situation of homeless people because I see them on a regular basis when I'm serving meals.
So tell me about that. What interaction do you have with homeless people?
Senator, I regularly serve meals at Catholic Charities at 10th and G with Father John Ensler, who's the head of Catholic Charities D.C., and I've known since I was 9 years old when I was an altar boy. He was at Little Flower Parish. And what you learn when you're at, I said I'm a Matthew 25, try to follow the lesson of serving the least fortunate among us. You know, when I was hungry, you gave me food, thirsty, you gave me drink, stranger, and you welcomed me, naked, and you clothed me, sick, and you cared for me, in prison, and you visited me. Six groups that That's not exclusive, but that's a good place to start with your charitable works in your private time.
So describe the difference between Brett Kavanaugh, the man, and Brett Kavanaugh, the judge.
Well, as a man, I'm trying to do what I can in community service as a dad, as a coach, as a volunteer, as a teacher, as a husband, and serving meals to the homeless. The one thing, Senator, you know, we're all God's children. We're all equal. People have gotten there because maybe they have a mental illness, maybe they had a terrible family situation, maybe they didn't have anyone to care for, maybe they lost a job and had no family. But every person you serve a meal to is just as good as me, or better, frankly, because they've what they've had to go through on a daily basis just to get a meal. And you talk to them. That's the other thing. When you're walking by the street, you see people, and I understand, I'm sure I've done this. I don't want to sound better than someone when describing this, but you don't necessarily look and you don't say, how's it going?
Right.
But when you serve meals to them, and you talk to people who are homeless, and they are just as human and just as good people as all of us. And they're, we're all part of one community. And so I think about that, and I don't want to sound like I can always do more and more and do better. I know I fall short, but Father John has been a big influence on that and thinking about others. So that's as a person. I try to do Washington Jesuit Academy. So I tutor up there. I'm now on the board of Washington Jesuit Academy. That's a little different situation. Okay, those are low-income boys from low-income families, tuition-free school, one of these 7:30 a.m. to 7 schools. And I started tutoring up there because I wanted to do some more tutoring and just be involved more. I mean, judging's important, but I wanted to be more directly involved in the community. And they had tutoring. You do all your homework there because it was a situation you don't want to go home and have anything else to do. You get 3 meals there and you do your homework there, and to help them do their homework. And you see these great kids, and they're in a structured environment, and you make an effect in their lives. And like I said yesterday, the teachers and coaches throughout America, they change lives. And for me to be able to participate, you can't change everything at once, but just changing one life, one meal one day at the shelter, or one kid that remembers something you said in a tutoring program. If we all did that more, and I fall short too, I know, and I want to do more on that front, but you can make a big difference in people's lives. I just bring that into the judging. I think I judge based on the law, but how does that affect me as a judge? I think first of all, just standing in the shoes of others. We could all be that homeless person. We could all be that kid who needs a more structured educational environment. And one of the things I was taught by my mom, but also I remember Chris Abel, my 6th grade English teacher and religion teacher, and football coach and baseball coach. One of his, and he drove me to school, one of his, and he's now on the board of Washington Jesuit Academy with me, but one of his lessons in To Kill a Mockingbird was to stand in the shoes of others. And I still have the To Kill a Mockingbird that we used in 6th grade. It's in my chambers, still, the same copy.
Is it fair to say that your job as a judge is to not so much stand in the shoes of somebody you're sympathetic to, but stand in the shoes of the law?
You're in the shoes of the law, but with awareness of the impacts of your decisions.
Right.
And that's the critical distinction. You can't be unaware. When you write an opinion, how's it going to affect people?
Right.
And understand, try to explain. I think, it's explaining is such an important feature. And then when people come into the courtroom, and how you treat litigants. So we're all familiar. We've all been in courtrooms where the judge is acting a little too full of being a judge, and we've all been there. I try not to do that. I can't say I'm perfect, but I try to make sure the litigants understand that I get it. Whether it's a criminal defendant case, we had a pro se case where litigant comes in and argues pro se in our court, which rarely happens in our court where the pro se actually argues. And it was a guy who said he had been called the N-word by a supervisor. And he's arguing pro se, and the question's whether a single instance of the N-word constitutes racial harassment under the civil rights laws. And I wrote a separate opinion explaining, yes, a single instance of the N-word does constitute a racially hostile work environment. And I explained, in doing that, I explained the history of racism in this country and how that word, no other word in the English language so powerfully or instantly calls to mind our country's long and brutal struggle against racism, I wrote in that opinion. And I cited To Kill a Mockingbird in that opinion, among other things. But what I wanted to make clear by bringing this example up is I understood his situation. I tried to understand what that would be like, and I decided the case based on the law, but I understood with the pro se litigant. The point being, I always try to be aware of the facts and circumstances.
Have you ever made a legal decision that personally was upsetting to you?
Well, I'm sure I have, and that's what Justice Kennedy talked about in Texas versus Johnson. That case, in case people didn't know what I was referring to on Texas versus Johnson, that's the flag burning case. And Justice Kennedy is in the majority with Justice Scalia and Justice Brennan, Justice Marshall, and says that a law against flag burning is unconstitutional under the First Amendment. And that obviously tore Justice Kennedy, really bothered him because he's such a patriot. But he still ruled the way he did because he read the First Amendment to compel that result. And that's why he wrote that great concurrence in that case. And that concurrence is such a great model for judging and a great model of independence and a great model, to your point, Senator Graham, of we follow the law, but we're aware. And you're a better judge if you're aware.
Well, I would just want to say this to my colleagues. Everything he said, I think, has been verified by the people who know him the best. I can't say I've read 307 of your opinions. I can tell you without hesitation I have not. I did not read Sotomayor opinions or Kagan's writings. But what I chose to do was look at the people who knew them the best. And I think Bob Bennett, who defended President Clinton during impeachment, I know him very well, said that Brett is a judge's judge, someone doing his absolute best to follow the law rather than his policy preferences. Brett is an all-star in both his professional and his personal life. I've yet to find anybody that I find credible, or really anybody at all, that would suggest that you were unfair to litigants. I've yet to find a colleague that thought you were a politician and a rogue. But you are a Republican, is that true?
I registered.
Okay.
Yeah.
The only reason I'm glad to hear you say that, it makes a lot of sense, given who you work for. And,
I haven't, well, I'll let you finish your question.
Well, you work for a lot of Republicans, like
Yes.
the president, who was a Republican. So
President Bush
Yeah.
worked for, yes.
yeah, so that's all fine. So I remember. I'll tell you what I remember when she leaves. So I asked Elena Kagan about a statement that Greg Craig made. Do you know Greg Craig by any chance?
I've met him. I haven't seen him in many years, but yes.
He was the one of the defenders of President Clinton during the impeachment hearing. And somewhere in here, I've got Greg Craig's statement about Kagan.
This is the Graham-Kagan exchange.
No, I'm looking for Greg Craig's statement. Here we go. Here's what Kagan was a progressive in the mold of Obama himself. Elena Kagan is clearly a legal progressive and comes from the progressive side of the, according to Ronald Klein. The first was Greg Craig. Exchange with Justice Kagan when she was the nominee. I'm not trying to trick you. I don't have anything on Greg. He said on May 16th that you're largely progressive in the mold of Obama himself. Do you agree with that? Ms. Kagan. Senator Graham, you know, in terms of my political views, I've been a Democrat all my life. I worked for 2 Democrat presidents, and that is what my political views are. And I ask, would you consider your political views progressive? Ms. Kagan, my political views are generally progressive, which is true. I really appreciate what she said because I expect President Obama to go to someone like Elena Kagan, who is progressive, shares his general view of judging, and who happened to be highly qualified. Sotomayor. President Obama nominated Sotomayor because he wanted someone whose philosophy of judging was his, which is applied to the law and constitutional principles, was be ready to adopt them to a modern context. So President Obama nominated Sotomayor because he wanted someone whose philosophy of judging was his. I expect that to happen. If Donald Trump is president in 2020, he'll be our next president. If it's somebody else, I expect that to happen. To my colleagues on the other side, what do you really expect? You should celebrate, even though you don't vote for him, and I don't know why you wouldn't, the quality of the man chosen by President Obama. Elena Kagan and Sotomayor came from the progressive wing of the judging world and of legal thought. They're absolutely highly qualified, good, decent people. And they got, let's see if I can find the vote totals. Ms. Kagan got 63 votes and Sonia Sotomayor got 68. It's going to bother me that you don't get those numbers, but what bothers me is they should have gotten 90. They should have gotten 95. Anthony Kennedy got 97. Anthony Scalia got 98. Ruth Bader Ginsburg got 96. So what's happened? Between then and now, advise and consent has taken on a different meaning. It used to be the understanding of this body that elections have consequences, and you would expect the president who won the election to pick somebody of their philosophy. I promise you that when Strom Thurmond voted for Ruth Bader Ginsburg, he did not agree with her legal philosophy. And I doubt if Senator Leahy agreed with Justice Scalia. Senator Leahy has voted for a lot of Republicans. I have voted for everyone presented since I have been here because I find them to be highly qualified, coming from backgrounds I would expect the president in question to choose from. So as to your qualifications, how long have you been a judge?
I've been judge for 12 years.
How many opinions have you written?
I have written over 300 opinions.
Okay. Do you think there's a lot we can learn from those opinions if we spend time looking at them?
Yes, I am very proud of my opinions. And as I mentioned, I tell people don't just read about the opinions, read the opinions. I'm very proud of them.
You were nominated by President Trump on July the 9th, my birthday, which I thought was a pretty good birthday present for somebody who thinks like I do. And I think Don may have something to do with that, at 9 o'clock. By 9:23, Chuck Schumer says, I will oppose Judge Kavanaugh. By 9:25, Senator Harris, Trump Supreme Court Justice nominee Judge Kavanaugh represents a direct and fundamental threat to the rights and health care of hundreds of millions of Americans. I will oppose his nomination. Elizabeth Warren at 9:55. President Brett Kavanaugh's record as judge and lawyer is clear, hostile to health care for millions, opposed to the CFPB, corporate accountability, thinks President Trump is above the law, on and on and on. Nancy Pelosi at 10:11, Bernie Sanders at 10:18. If Brett Kavanaugh is confirmed to the Supreme Court, it will have profoundly negative effect on workers' rights, women's rights, and voting rights for the decades to come. All I can say, within an hour and 18 minutes of your nomination, you became the biggest threat to democracy. In the eyes of some of the most partisan people in the country, who would hold Kagan and Sotomayor up as highly qualified and would challenge any Republican dare vote against them. You live in unusual times, as I do. You should get more than 90 votes, but you won't. And I am sorry it has gotten to where it has. It's got nothing to do about you. If you don't mind, and you don't have to, what did you tell your children yesterday about the hearing?
They did as they, I'll tell them what they told me. I think they gave me a big hug and said, "Good job, Daddy." And Margaret, before she went to bed, made a special trip down and said, "Give me a special hug."
I just wish if we could have a hearing where the nominees' kids could show up. Is that asking too much? So what kind of country have we become? None of this happened just a couple of years ago. It's getting worse and worse and worse, and all of us have an obligation to try to correct it where we can. Roe v. Wade. Are you familiar with the case?
I am, Senator.
Can you, in 30 seconds, give me the general holding of Roe v. Wade?
As elaborated upon in Planned Parenthood versus Casey, a woman has a constitutional right, as interpreted by the Supreme Court on the Constitution, to obtain an abortion up to the point of viability, subject to reasonable regulations by the state, so long as those reasonable regulations do not constitute an undue burden on the woman's right.
Okay, as to how the system works, can you sit down with you and 4 other judges and overrule Roe v. Wade just because you want to?
Senator, Roe v. Wade's an important precedent of the Supreme Court, been reaffirmed.
Don't you have to have a case I mean, you just can't, hey, what are you doing for lunch? Let's overrule Roe v. Wade. It doesn't work that way, right?
I see what you're asking, Senator. Right, there's the way cases come up to us in that context or in other contexts would be a law's passed.
Can I give you an example, because I can do this quicker?
Yes.
So some state somewhere or some town somewhere passes a law that runs into the face of Roe. Somebody will object, they'll go to lower courts, and eventually it might come up to the Supreme Court challenging the foundations of Roe v. Wade. It would take some legislative enactment for that to happen, is that correct?
That's correct.
If there was such a action by a state or a local government challenging Roe, and it came before the Supreme Court, would you listen to both sides?
I listen to both sides in every case, Senator. I have for 12 years, yes.
When it comes to overruling a longstanding precedent of the court, is there a formula that you use? Analysis.
First of all, you start with the notion of precedent. And as I've said to Senator Feinstein, in this context, this is a precedent that's been reaffirmed many times over 45 years, including in Planned Parenthood versus Casey, where they specifically considered whether to overrule and reaffirmed and applied all the stare decisis factors. So that, importantly, became precedent on precedent in this context. But you look at, there are factors you look at whenever you're considering any precedent.
So there's a process in place that the court has followed for a very long time. Is that correct?
That is correct, Senator.
Citizens United.
Yes.
If somebody said Citizens United has been harmful to the country and made a record that the effects of Citizens United has empowered about 20 or 30 people in the country to run all the elections, and some state or locality somewhere passed a ban on soft money, and it got to the court, would you at least listen to the argument that Citizens United needs to be revisited?
Of course, I listen to all arguments. You have an open mind. You get the briefs and arguments, and some arguments are better than others. Precedent's critically important. It's a foundation of our system, but you listen to all arguments.
Okay. Where were you on September 11th, 2001?
I was initially I was in my then office in the EOB, and then after the first, as I recall, after the first building was hit, I was in the council's office on the second floor of the West Wing for the next few minutes. Then we were all told to go down to the bottom of the West Wing, and then we were all evacuated. And I think the thought was Flight 93 might have been heading for the White House. It might have been heading here, and Secret Service. We were being hustled out, and then kind of panic, started screaming at us, sprint, run, and we sprinted out. My wife was a few steps ahead of me. She was President Bush's personal aide at the time, and we sprinted out. She was wearing a black and white check shirt, I remember. And we sprinted out the front gate, kind of into Lafayette Park, and no iPhones or anything like that. BlackBerries at that point in time, we didn't have that, and our cell phones didn't work, so we were all just kind of out there. And then I remember somehow ending up seeing on TV down more on Connecticut Avenue, there were TVs out at the Mayflower Hotel. I remember I was with Sarah Taylor, who worked at the White House, and we were watching as standing with her when the buildings fell.
So when somebody says post 9/11 that we've been at war, and it's called the war on terrorism, do you generally agree with that concept?
I do, Senator, because Congress passed the authorization for use of military force, which is still in effect, and that was passed, of course, on September 14th, 2001, 3 days later.
Let's talk about the law in war. Is there a body of law called the law of armed conflict?
There is such a body, Senator.
Is there a body of law that's called basic criminal law?
Yes, Senator.
Are there differences between those two bodies of law?
Yes, Senator.
From an American citizen's point of view, do your constitutional rights follow you? If you're in Paris, does the Fourth Amendment protect you as an American from your own government?
From your own government, yes.
Okay. So if you're in Afghanistan, do your constitutional rights protect you against your own government?
If you're an American in Afghanistan, you have constitutional rights as against the U.S. government.
Is there a long-standing...
That's long settled law.
Isn't there also a long-settled law that it goes back to the Eisentrager case? I can't remember the name of it.
Yeah, Johnson versus Eisentrager.
Right. That American citizens who collaborate with the enemy have considered enemy combatants.
They can be.
Can be.
They can be. They're sometimes criminally prosecuted, sometimes treated in the military.
Well, let's talk about can be. I think
under Supreme Court precedent.
Right. There's a Supreme Court decision that said that American citizens who collaborated with Nazi saboteurs were tried by the military. Is that correct?
That is correct.
I think a couple of them were executed.
Yeah.
So if anybody doubts, there's a long-standing history in this country that your constitutional rights follow you wherever you go, but you don't have a constitutional right to turn on your own government and collaborate with the enemy of the nation. You'll be treated differently. What's the name of the case, if you can recall, that reaffirmed the concept that you could hold one of our own as an enemy combatant if they were engaged in terrorist activities in Afghanistan? Are you familiar with that case?
Yeah, Hamdi.
Okay. So the bottom line is, on every American citizen, no, you have constitutional rights, but you do not have a constitutional right to collaborate with the enemy. There's a body of law well-developed long before 9/11 that understood the difference between basic criminal law and the law of armed conflict. Do you understand those differences?
I do understand that there are different bodies of law, of course, Senator.
Okay, if you're confirmed, and I believe you will be, what is your hope when all of this is said and done and your time is up? How would you like to be remembered?
A good dad, good judge.
Good husband.
I think he's getting there.
Good husband.
Thanks, Diane. You helped him a lot. going to be better for you tonight.
Good. I owe you. Good son, I'll quickly add. Good friend. I think about the pillars of my life are being a judge, of course, being a teacher. I've done that, and either way this ends up, I'm going to continue teaching. Coaching, as I mentioned, huge part of my life. Try to continue that. Senator Kennedy advised me when we met, make sure you keep coaching, even if you get. I'm going to follow that. Volunteering, and being a dad and a son, and a husband, and being a friend. I talked about my friends yesterday. I didn't really expect. I got a little choked up talking about my friends. But
That was well said. You got to tighten it up because I just ran out of time.
okay. Thank you, Senator. I can go on, as you know, but I'll stop there.
Thank you.
We're about ready to break for lunch and a vote that we have, and it'll be 30 minutes. But before I do that, I have letters that Senator Feinstein asked me to put in the record from 70 letters from people in opposition to your nomination. And then we also have letters in support of Judge Kavanaugh from hundreds of men and women across the country holding diverse political views. They strongly support his confirmation without objection. Those will also be entered in the record. And then I wanted to explain the exchange that I had with Senator Leahy, that just so people don't think that that's something that I did on my own. We had previously sent out a letter, and only Senator Klobuchar up to that point had taken advantage of the letter to be able to ask for documents that were committee confidential so that they could use them at the hearing. And the only thing I've done for Senator Leahy that wasn't already in that letter was to remind people that we did the same thing for the Gorsuch nomination to the Supreme Court, and it's a policy that Senator Leahy, when he was chairman of the committee, followed. And so the only courtesy was extended to Senator Leahy the fact that he didn't make the request by the timeline that was in the letter, which I think was August 25th. We're going to adjourn 30 minutes for lunch break, and I think that we'll be back here exactly in 30 minutes. If not, Judge Kavanaugh, we will let your staff know if it's going to be a little later, because you never know what happens in the United States Senate when you have a vote.
Live coverage from the Washington Post of this second day for the confirmation hearings for Brett Kavanaugh to be the next Supreme Court justice. We'll continue to bring you live and uninterrupted coverage as soon as the Senate committee gavels back in about a half hour. And of course, we'll be here all day long as they go possibly into the night. The committee chairman has said they may go as long as 12 hours today in this first opportunity for senators to question Judge Kavanaugh publicly. I'm Libby Casey, and I'm joined here in the Washington Post studio by Eugene Scott, writer for The Fix. Thanks for being here. Also, Robert Barnes, Supreme Court reporter. Thanks so much, Bob, for being here.
My pleasure.
Okay, Bob, highlights and big takeaways so far. Were Democrats able to gain any traction on the issues that they care about this morning?
Well, I don't think a whole lot. I mean, I think what you saw is that Judge Kavanaugh is very polished. He has prepared. He's been through this confirmation process before. He prepared others, as you heard, for their judicial confirmation hearings, and so he knows what he's doing. You know, I think that he tried very quickly, under some gentle questioning from Chairman Grassley, to get across that he's independent. You know, one of the big questions about him is he going to be beholden to President Trump? There are a lot of potential legal issues that can come up about the investigation of the president. He tried to show his independence quickly. And, you know, he tried also on the big issue of abortion to say, you know, I'm not going to commit to anything, but he did it in a way that tried to make it sound as if he was keeping an open mind. He promised to keep an open mind, and he talked about Roe v. Wade and subsequent decisions of the Supreme Court that guarantee a woman's right to abortion, as he put it, precedent upon precedent. And so, you know, whether or not that is going to assuage doubts about him on that issue, probably not, but it was an attempt to show that he heard, especially Senator Feinstein.
And we've only heard from 2 Democrats so far, 3 Republicans. There's 21 senators on this committee, so still a long way to go. But right out of the gate, as soon as that first Democrat, Dianne Feinstein, the ranking on this committee, got her opportunity to ask questions, she really went through a range of topics, including abortion. So let's hear an excerpt of her exchange with Judge Kavanaugh.
I understand the importance that people attach to the Roe v. Wade decision, to the Planned Parenthood versus Casey decision. I don't live in a bubble. I understand. I live in the real world. I understand the importance of the issue.
Well, my staff just passed me a note. Let me read it to you because I think it's a good. Have your views about whether Roe is settled precedent changed since you were in the Bush White House?
My
yes or no?
Well, I'll tell you what my views. I'm not sure what it's referring to about Bush White House, but I will tell you what my view right now is, which is this important precedent of the Supreme Court that's been reaffirmed many times, but then and this is the point I want to make that I think is important, Planned Parenthood versus Casey reaffirmed Roe and did so by considering the stare decisis factors. So Casey now becomes a precedent on precedent. It's not as if it's just a run-of-the-mill case that was decided and never been reconsidered, but Casey specifically reconsidered it, applied the stare decisis factors, and decided to reaffirm it. That makes Casey a precedent on precedent.
So there, Judge Kavanaugh talking about abortion issues. Eugene, did you get any closer to understanding his perspective and what he might do on the Supreme Court?
Well, not really. I mean, I thought he's communicated how important precedent was to him, which I think was helpful to some of the more Democratic lawmakers. But the reality is we know that many conservatives support him with the hope that he is going to rule in ways that will make abortions less or more difficult, at least, to obtain. And so he left some open space, some wiggle room in terms of how he's going to rule in the future. But he certainly made it very clear that he'd been paying attention, to no surprise, to all of the cases that have been decided before, and that would factor in heavily with his decision.
Eugene brings up the good point that there are ways to restrict abortion, even if you don't overturn Roe v. Wade, Bob.
That's right. And I think that's probably, what most people would think would happen. There are a number of restrictions. States all the time pass restrictions on abortion, and they come to the Supreme Court. Remember that Chief Justice Roberts at his confirmation hearing said much the same thing, that Roe is settled law. And of course, since then, since he's been on the court has not overturned Roe. But the Chief Justice has voted for every restriction that has come before the court. And the most recent decision was, the most recent case was about a law from the state of Texas that imposed new requirements on doctors who perform abortions and new requirements of clinics where they are performed. The court ruled 5-3. Justice Scalia had died, so there were only 8 members. They ruled 5-3 that those were just a pretext for trying to make it more difficult to obtain an abortion, and that it violated the court's rulings on putting an undue burden on a woman's right. Justice Kennedy joined the liberals in the majority in that case. Chief Justice Roberts was in the minority. He would have allowed that law to stay in place. And of course, it's Justice Kennedy's replacement that we're talking about here. So that he was really the pivotal judge in that case.
So a 5-3 decision the court now, with Neil Gorsuch on it, and someday perhaps with Justice Kavanaugh on it, could in fact be a 5-4 decision going the other way.
That's right.
I want to bring up something that Senator Leahy, the other Democrat on the committee, spent a lot of his time talking about. And this is a question of stolen materials that Republican staffers took from him as well as other members of the committee and shared. And he was trying to get a sense from Judge Kavanaugh, who's been asked about this before, if he was aware that these were stolen materials and if he should have been aware that they were stolen materials. Bob, can you explain this case to us?
I think it's a little difficult because, for one thing, Senator Leahy wasn't terribly clear in laying it out. It was very clear that Kavanaugh didn't want to directly answer questions about it. I thought the whole thing got a little mushy, and I think that Senator Leahy is going to try to explain later more about this case. But it's basically, there are some issues between Democrats on the committee and Kavanaugh about his testimony at his previous confirmation hearing. They think that he wasn't completely forthcoming about this issue and also about what role he played in the White House on certain policies about the war on terrorism, detainees. And so I think we'll see a lot more of that as the day goes on. The Democrats feel like they didn't get the whole story from him last time, and they're going to push him very hard this time. But I do think in a way it's kind of an arcane issue. It's a little off what the public probably cares the most about, but it is important to the senators.
And right after that, Republican who was asking questions put it very directly, like, did you know these were stolen materials? And it was sort of like a yes, no, yeah. So he was able to say no. Eugene, do you think Democrats succeeded at all today in getting more information about that time during the Bush White House? And do you see an opportunity for them to make more inroads there?
I don't think they got more information at a significant level as much as they would have wanted. I think what they did succeed in is putting forward the narrative that there are more questions and more gaps in what people know about Kavanaugh than they would normally have in someone who gets to this point in the process. I think what they hope to communicate to the American public is that we just don't know as much about this nominee as we would like to know, and that it's concerning because his rulings obviously will affect the entire country, and they would like to have more information on how he has seen things in the past and they currently do. Whether or not conservatives agree with that or not is actually clear. It's clear that they don't agree with it. But I think what the Democrats are going for right now is approval of the popular opinion.
We saw the radical move of videotape being played during the hearing. That seemed to really get the septuagenarian and octogenarian senators all in a tizzy. Why is that such a big deal, Bob?
The Senate doesn't change very quickly. The Senate does things in its own way. And so any change seems to be a big change.
It also seems the Republicans don't want to just use this as an opportunity to sort of let Democrats play this video in a way that could dramatize it even more. And compare past comments to present comments.
I think that's true. But we're only, as you say, just scratched the surface of the questioning here. I thought Senator Graham's questioning was smart and also a way to let Kavanaugh show his sort of extensive legal background, to show that he deals with these issues all the time. It's like, what's the name of that case? Do you remember this case? And of course, the judge is well versed in this kind of law, and so it plays to his strengths, I thought.
Senator Feinstein complimenting him on his ability to filibuster as he was sort of going back into his history and all of his philosophical leanings. As we watch the next rounds of questioning unfold, Bob, how much do you expect this question of executive authority and executive power to keep coming up? Is that going to be really crucial here? Did Democrats make any headway? And if you're a Democrat asking questions 3 hours in, you got to wonder how much they think about what's already been tread in terms of ground?
I don't think they think about it a whole lot. I think each senator wants to ask certain things. I think that they think it's important to continually put him on the record about this issue as much as they can. I think it's a real concern, not only for them. This is one that I think that the public understands pretty well. It's not sort of an arcane issue. It's one that's sort of right in the forefront of the national debate right now, and so I think it is something that you'll hear a lot more of, and I think it's important. I get the feeling, I don't know about the two of you, I get the feeling that either Kavanaugh's a little more forthcoming than Justice Gorsuch was at his hearing, or at least he's better at making it appear that he is. There was a study that came out that showed that Justice Gorsuch was the least forthcoming justice in the last 50 years at his confirmation hearing. Somehow it feels to me like Kavanaugh is, talking more and sort of engaging in a conversation more with the senators. Maybe that is filibustering. Maybe the more time he uses, the less time they have for answering questions. But I think this hearing so far feels a little different than the Gorsuch one did.
Because we have to let you go in just a moment so you can get back to reporting. What are the top things you're going to be watching for, or the top people that you'll be watching to question Judge Kavanaugh over the next couple of hours?
Well, I think that there's going to be a lot of questioning on campaign finance and his views on that, which he's very skeptical of laws that restrict campaign contributions. I think that's a big issue that Democrats will pay a lot of attention to. As we say, I don't think they're nearly through with abortion. I don't think they are nearly through with sort of probing his views on the president and executive privilege. I think that those are going to be themes that we hear, throughout the day and night, I'm afraid.
Thank you. Robert Barnes, Supreme Court reporter, thanks so much. We're going to let Robert get back to work. We're going to keep Eugene here, though. Thank you for sticking around. And we're going to go to Capitol Hill, where Sung-Min Kim, our colleague, is reporting from inside the hearing room. Thank you so much for stepping out to talk with us. I want to get a sense from you of how the atmosphere feels today versus yesterday. We have seen some protests and disruptions, but I've seen photos on Twitter. It looks like the back public area has been cleared out. What's going on inside the room?
Lost in some ways the momentum of their.
So you're definitely right that it's a little less chaotic here today than it was yesterday, when it seemed like the entire hearing was just peppered with protests throughout. And we've had a handful of demonstrators loudly break out and be subsequently hauled out. But the numbers are a lot fewer. We know that Capitol Police told us yesterday about 70 people were arrested for demonstrating during the hearing. And the numbers so far the pace of that has been a lot less. So it's a little bit quieter. The seats are a little bit emptier. The flow of the public into the public audience has been a little bit slower. We don't know if that's intentional or not. But we're really digging into these kind of legal nitty-gritty issues yesterday. Yesterday is more of the show, kind of the setting, the table of the arguments and the messaging around Kavanaugh's nomination. But today, the senators are diving into these issues of abortion access, of executive power, of gun rights, and some hypotheticals of what Kavanaugh would do should he be confirmed as a Supreme Court justice. So that's why you're seeing a little bit, the atmosphere does seem a little bit calmer at this point. But again, we'll see what happens later in the hearings.
Hey, great question coming in from one of our viewers on the streaming platform Twitch, wanting to know about this question of confidential information, committee confidential information that the committee has access to, but we the public do not. Can Democrats use that? And did we almost see a tip of the hand there between Leahy and Grassley as they were grappling over just what could be shared publicly?
Am I unclear?
Exactly. That's what we saw during that. Actually, probably one of the more contentious exchanges that we saw during the morning of the confirmation hearings, because what happened is that this has been a simmering and anger. Democrats have been angry about this issue since the confirmation process really began for Brett Kavanaugh, because what is going on right now is that the Senate Judiciary Committee has nearly 200,000 pages of documents from Kavanaugh's tenure as an associate White House counsel in the George W. Bush White House that they can see, that senators can see, that committee staff can see, but the public, we in the public, cannot have access to those documents because they've been marked as committee confidential. And so far, senators are adhering to that committee confidential basis, but Democrats have said there is important information in those committee confidential documents that the public should be able to get to see, because as we kind of saw in the hearing earlier, they can't talk fully about what is in those documents if they're still in this private status. So that is kind of the contentious exchange that we saw broke out earlier today when Senator Patrick Leahy of Vermont seemed to strongly imply that there is kind of this damning evidence in the committee confidential documents, and we're likely to hear more on this issue later today. Senator Grassley has responded that, first of all, that there are more pages available for Kavanaugh's nomination than any other Supreme Court justice in history, and that 80% of the paperwork is public. Only about the smaller percentage of that remains private, and that Democratic senators, should they have wanted to use the committee confidential documents during the hearing, they could have asked the committee in advance for permission, and only one, Amy Klobuchar of Minnesota, did.
Okay, final question for you before you get back into the hearing room and hopefully get a little bit of food before you go back in for this marathon day. Who are you going to be watching in the questions that come up in the next couple of rounds? and what issues do you think that Democrats and possibly even Republicans may be most focused on?
I'm really going to be watching Dick Durbin. He should be coming up soon on the Democratic side. Republicans tell me that they feel he's one of the best, if not the best, questioner on the Democratic side, and they do have concerns that Durbin would be able to kind of pin down Kavanaugh on these contentious issues. And Durbin has a lot of the same interests that Senator Leahy has in the questions that Senator Leahy brought up earlier in terms of these accusations, these implications that Kavanaugh misled senators during his confirmation hearings more than a decade ago. For his confirmation to the D.C. Circuit Court of Appeals. And actually, if you go back to this stolen emails or stolen documents issue that we discussed, that was the root of the contentious exchange with Senator Leahy. Senator Durbin was actually the primary victim of the stolen documents. Those stolen documents came from Senator Durbin and then Senator Ted Kennedy of Massachusetts. So I think it's fair to say that Senator Durbin has a personal interest in that issue as well. Obviously, we'll be watching Senators Cory Booker and Kamala Harris, who are widely seen as potential presidential contenders in 2020, and their line of questioning. And remember Senator Mazie Hirono of Hawaii. She has been asking every judicial nominee and other nominees who come before her committee under oath whether they have ever been accused of a sexual harassment or sexual misconduct. Obviously, everyone has responded no, but that should be a dramatic moment in the hearing.
All right, Sungmin Kim, reporter who's been covering the hearing from inside Heart 216. Thank you so much for spending some time with us. And thanks to our tech team for making that happen. It's not easy to get all these signals together, so thanks for dealing with that delay. Yeah, I want you to reflect on what we just heard from the hearing room. Some of the same players that you mentioned, senators that you mentioned that you're watching, crucial for testimony. Dick Durbin, someone we hadn't talked about. He's not one of these, no offense to Senator Durbin, young people who's trying to shake up the committee, but he is known for having a very just human way of talking to people. You know, his clips often go viral because they're just put in a straightforward language that gets to the heart of the matter and kind of makes sense to people.
Yeah.
Is that a fair assessment?
Yeah, I think it is. And I also think it speaks to the broadness of the Democratic Party and one of the bigger challenges that we see people having right now. Are they going to continue to put forward lawmakers who are more traditional and connect more with liberal voters in the heartland or maybe in the suburbs of some of the major cities? Or are they going to put forward some of these lawmakers and candidates who reflect the changing demographics of the country, who speak to younger, more diverse, more women, more gay-affirming populations? And I think what they're realizing is that the Democratic Party has to put forward quite a broad range of people in their party to connect with voters from different aspects of the American population, with the hope that they will vote in, November and overturn the House and keep things in control all the way to 2020.
Even yesterday morning when we saw the initial Democratic disruption of the process, trying to have a moment to talk about documents that they were concerned they hadn't gotten. It wasn't done by seniority, right? It wasn't the most senior members who've been around the longest who interrupted. It was Kamala Harris, one of the newest members to the committee, but who's also one of the younger members of the committee who may have some political aspirations. And then we saw Amy Klobuchar, another woman. And then we saw Richard Blumenthal, one of the men, also speak up. So they do seem to be aware of that very thing you're talking about. But the way the questioning goes, it is done by seniority, and it is done by how long you've been on the committee, and that's the flow. If you're wondering why people are getting to speak at a certain time. I want to get back to this issue of executive power and where Judge Kavanaugh stands on that. So let's take a listen to an exchange that happened earlier this morning on that topic.
I think the first quality of a good judge in our constitutional system is independence. Independence comes directly from Article 3 of the Constitution. The independence of the federal judges really is guaranteed by the framers in our life tenure and our protection from pay reduction. So because we have life tenure, we are independent and immune from political or public pressure. So I think the first thing that makes a good judge is independence. Not being swayed by political or public pressure. That takes some backbone. That takes some judicial fortitude. The great moments in American judicial history, the judges had backbone and independence. You think about Youngstown Steel. You think about, for example, Brown versus Board of Education, where the court came together and knew they were going to face political pressure and still enforce the promise of the Constitution. You think about United States versus Nixon, which I've identified as one of the greatest moments in American judicial history, where Chief Justice Burger, who had been appointed by President Nixon, brought the court together in a unanimous decision to order President Nixon in response to a criminal trial subpoena to disclose information. Those great moments of independence and unanimity are important.
Okay, so independence is important, but Eugene, did we get closer to understanding his position on how he might rule if a question of subpoenaing the president came in front of him?
I think there was a moment where he said that no one is above the law. And I think that was very important to people who were wondering if he, in fact, thought that President Trump or any executive could, in fact, be above the law. He didn't have as much time to flesh out his ideas, I think, as some people on the left would have liked, for a few reasons. One, there were a lot of interruptions, but also he really just harped on the independence thing and kept coming back to it and repeating that word, but he wasn't really clear in terms of how he would allow politics to shape things in terms of, parties in control, indictments coming forward. I think the conversations about executive power and privilege will continue. And I think when we see some of the more progressive Democratic lawmakers get a chance to ask questions, some of the questions will be a bit more pointed.
We did hear an exchange with Dianne Feinstein where she said, can a sitting president be required to respond to a subpoena? And he used a lot of words to say it's a hypothetical question.
Right.
And I'm not going to answer hypothetical questions.
Right.
And so she came back to him and said, you can't give me an answer. And
right.
he once again said, you're asking me to give my view as a potential hypothetical.
Yeah, and that was concerning because when he discussed the issue in the Minnesota Law Review piece, he seemed to be a little more clear and didn't respond to it as if it were such a hypothetical.
I do want to mention this is not the only thing happening in Capitol Hill today. So many other news stories, including another hearing that's been going on before the Senate Intelligence Committee, led by Richard Burr of North Carolina. This is a big deal because it's Sheryl Sandberg of Facebook, Jack Dorsey of Twitter, going before the lawmakers. Google was invited and expected to attend, did not send someone. And so that in itself has its own optics to see Google not present at this hearing. But I want to play a soundbite for all of you before we head back to this particular hearing to get a sense of what's going on across Capitol Hill. Listen to this.
What about when we're dealing with real people, authentic users, intentionally spreading false information? And obviously there are huge free speech implications there. But for example, what if a real person, a U.S. citizen, says that victims of a mass shootings were actually actors, for example? Would that violate your standards? And if the answer is no, how should we, and by we I mean government and industry, deal with those very real challenges?
Well, let me start by saying I find claims like that personally unbelievably upsetting. If you've been a victim or a parent of a victim, they deserve our full support. And finding the line between what is hate speech and what is misinformation is very, very difficult, especially if you're dedicated to expressing free expression. And sometimes free expression is expressing things you strongly disagree with. In the case of misinformation, what we do is we refer it to third-party fact checkers. We don't think we should be the arbiter of what's true and what's false, and we think that's really important. Third-party fact checkers then mark it as false. If it's marked as false, we dramatically decrease the distribution on our site. We warn you if you're about to share it. We warn you if you have shared it. And importantly, we show related articles next to that so people can see alternative facts. The fundamental view is that bad speech can often be countered by good speech. And if someone says something's not true and they say it incorrectly, someone else has the opportunity to say, actually, you're wrong, this is true. And that's what we're working on through our systems.
Sheryl Sandberg, that's at a hearing before the Intelligence Committee. She's testifying along with Jack Dorsey of Twitter. We are broadcasting that hearing live as well on our main website, WashingtonPost.com. It's also on YouTube. And for viewers on Twitch, we will broadcast that later on tonight. We're going to re-air it later on after about 7 o'clock, depending on how long this hearing goes.
Yeah.
And Eugene, this one could go for a while. So when this one wraps up, Twitch, you'll get an opportunity to watch the tech hearing as well. I want to point out there's a second congressional hearing this afternoon with just Jack Dorsey going before a House committee. Republicans there asking questions about bias against conservatives. That's not going to get as much attention as the Sandberg-Dorsey hearing because this one this morning is the first bite of the apple to really hear Jack Dorsey on Capitol Hill. He hasn't been a presence there. In the past, these tech companies have sent their lawyers.
Right.
And so lawmakers have really wanted to hear from them themselves.
Absolutely. And Jack has been pretty responsive on Twitter himself when some high-profile people call him out or ask him questions in terms of bias, in terms of the feed and what people are getting on their computers, where they're seeing. And I think he has a lot that he wants to clarify because the integrity of the organization is being called into question by some folks, and that could have long-term implications if it's viewed as actually being as biased as some critics perceive.
All right, well, so that's also happening today on Capitol Hill. And meanwhile, back in Hart 216, senators are returning. You can see the chairman, Chuck Grassley, already in place. Eugene, Bob Barnes, when he was here earlier, our Supreme Court reporter, said that he feels like, and he's really wise about this stuff, that he feels like we are getting a little more information from the nominee than we did in the last confirmation process. I would love to hear what you think about that. Do you have a sense that we're getting more information or at least hearing more from him?
I think Kavanaugh has a level of confidence and certainty about how this will move forward, maybe in a way that Neil Gorsuch did not portray or maybe actually have. I don't think Kavanaugh comes off as cocky by any means, but I think his anxieties about how this could end perhaps may not be as significant as previous picks. You know, Gorsuch was Trump's first, and so perhaps that's why we see him being more willing to be forthcoming and open and sharing more of what he believes and what he's done, because he knows that at the end of the day, where he's aiming to go, he likely will end up.
And he not only has been practicing for this, as all nominees do, we heard earlier that he has prepped other people for their time before congressional panels as they are nominated for lower bench positions. So he's
Indeed.
very familiar with this process.
Very much so. He's not new to this at all, and he definitely tried to communicate that he has prepped people across the perhaps identity spectrum, spoken very often about the role he's played in mentoring women and young lawyers of color, and just getting people from different aspects of the population before judicial branches
Welcome
and
back,
benches.
Judge Kavanaugh. The next person to ask questions is Senator Durbin.
Thank you, Mr. Chairman.
Thank you, Senator.
Judge Kavanaugh, Mrs. Kavanaugh, thank you for being back today to face this next round. If I had to pick an area of clear expertise when it comes to Brett Kavanaugh, it would be the area of judicial nominations. You have been engaged in that at several different levels, including your own personal experience. And so I'd like to ask you if you would comment on the strategy of your own nomination. Specifically, I would like to ask you whether those who were planning that strategy sat down and cleared with you their decision on the release of documents.
No, I was not involved in the documents process or substance.
No one told you that you'll be the first Supreme Court nominee to assert executive privilege to limit the access to 100,000 documents relating to your service in the White House?
Senator, so there's a couple things packed into your question. So I did study the nominee precedent. I've read all the hearings. This came up in Justice Scalia's hearing, so I read that. There with all his memos from being head of the Office of Legal Counsel, and he was asked about that. And I know with Chief Justice Roberts, there were 4 years of information when he was Principal Deputy Solicitor General, that those were not disclosed either.
But as for White House documents, you're breaking new ground here, or I should say covering up old ground here.
Well, I guess again, I wasn't involved in the documents discussions or process or substance in terms of the decisions that were made, but in terms of thinking about the issue, in terms of questions that could come to me, like Justice Scalia and Chief Justice Roberts received, or at least Justice Scalia did, I guess I don't distinguish. It's all executive branch documents. Justice Department documents and White House documents are not different.
But you realize that when it comes to the role of the National Archives, we're being asked to give you special treatment.
I can't comment because I don't know.
Judge Kavanaugh, this is your field, judicial nominations.
Let me ask you what the
your
question
nomination.
is. Sorry.
You are now embarking on this journey in this committee, denying us access to documents which were routinely provided for other judicial nominees. You had to have known that was taking place.
Senator, I think what Justice Scalia said in his hearing when he was asked about his Office of Legal Counsel memos is the right thing, which is that's a decision for the Senate and the executive branch to work out. As a nominee, I will in their long-term privileges and protections, as he mentioned, that were in effect for that discussion. And it's not for the nominee to make that decision.
Well, that's an interesting comment, because the way you're being presented to the American people, with only 10% of the public documentation that could be provided to this committee, is going to reflect on you and your nomination. And of course you know that.
Well, I guess again, looking at the nominee precedent, Senator, that was true in Justice Scalia's case. All his memos from 1974 to 1977, when he was head of the Office of Legal Counsel, a consequential time. At least as I understand it, those might not have been disclosed. He's asked about that at his hearing. Chief Justice Roberts, 4 years of Deputy Solicitor General memos, which would have been potentially.
So you're perfectly fine with this notion?
No, I said I am. It's up to the chairman and you and the committee, the Senate and the executive branch.
In fairness, Judge Kavanaugh, I think it's up to you. I think it's up to you. If you said at this moment to this chairman and to this committee, stop, pause, hit the pause button. I don't want any cloud or shadow over this nomination. I trust the American people. I want them to trust me. I am prepared to disclose those public documents. Take Senator Leahy's line of questioning. He was not the only victim of Manny Miranda. I was as well. And I didn't realize that this Republican staffer had hacked into my computer, stolen my staff memos, and released them to the Wall Street Journal until they showed up in an editorial. So now your knowledge of this, your role in this, we're limited to even discuss because of the fact that we are classifying and withholding information about your nomination. First is Mr. Bill Burke, who has some magic power to decide what the American people will see about your role in the White House. Then the decision by those who put your nomination before us to take 35 months of your service as staff secretary to the President of the United States and to exclude the documents. Then the unilateral classification of documents coming to this committee as committee classified in a manner no one has ever seen in the history of this committee. Judge Kavanaugh, that reflects on your reputation and your credibility. If you said at this moment, I don't want to have a cloud over this nomination, I'm prepared to suggest to the committee and ask the committee, humbly, please withhold further hearings until you disclose everything. Why won't you do that?
Senator, I do not believe that's consistent with what prior nominees have done who've been in this circumstance. It's a decision for the Senate and the executive branch. Justice Scalia explained that very clearly, I thought, in his hearing.
Are you happy with that decision?
I do not. It's not for me to say, Senator. This is a decision, the long-term interests of the Senate and the executive branch, particularly the executive branch, are at play. And Justice Scalia, again, explained that well, I thought, in his hearing.
I wasn't here for Justice Scalia, but I will tell you that...
Let me interrupt without taking time away from you, so don't charge him for this time, but here's something that the nominee doesn't need any help for me to answer this, but we don't care what the nominee thinks. We've got to follow the Presidential Records Act, and that's what we're following is the law.
Mr. Chairman, with all due respect, following the Presidential Records Act involves the National Archives. The National Archives is not involved in this process. It is a Mr. Bill Burke, who was a former assistant to the nominee, who has decided what will be withheld, what is going to be committee confidential. So it isn't the Presidential Records Act, please.
Well, let me make clear here. We anticipate some of this, so let me read. Criticize the committee process for obtaining Judge Kavanaugh's records. They have accused us of cutting the National Archives out of the process. So this is where I want to set the record straight. President Bush acted consistently with federal law when he expedited the process and gave us unprecedented access in record time to Judge Kavanaugh's record. But we have worked hand in glove with the archives throughout this process, and the documents this committee received are the same as if the archives had done the initial review. In fact, the archives is not permitted by law to produce records to the committee without giving both President Bush and a current president an opportunity to review. The National Archives was not cut out of the process. As President Bush's representative informed the committee, quote from his letter, because we have sought, received, and followed NARA's, that's the same as what I use the word archivist, views on any documents withheld as personal documents, the resulting production of documents to the committee is essentially the same as if NARA had conducted its review first and then sought our views and the current administration views as required by law. In other words, the documents this committee received are the same as if the archives had done the initial review. We're just able to get the documents faster by doing it this way, which gave the Senate and the American people unprecedented access in record time to a Supreme Court nominee record. Continue.
Mr. Chairman, the National Archives have stated publicly that the way we are handling the records for this nomination are unprecedented, and they've had nothing to do with it. They have asked until the end of October to produce records, and they've been told, we don't need you. We're going to finish this hearing long before then. I'd like to ask that be placed in the record the statement from the National Archives related to the records related to Judge Kavanaugh. I have consent to place this in the record.
Yes. I'm sorry.
Statement from the National Archives.
Put in the record, yes, without objection.
Thank you. And now I'm going to throw you a pitch which you've seen coming for 12 years. I want to talk to you about the 2006 testimony which you gave before this committee. It was at a different time. We were very concerned about the issue of torture and detention and interrogation. Yesterday, I asked you to show the American people that you have nothing to hide by coming clean with us on this issue. And I'd like to refer specifically to some of the questions that were raised because of that 2006 testimony. I believe we have here a statement of my question as well as your response. I'm sure you've seen this because it's been reported in the paper that you've been waiting for this question for a long time. When I was back in the day a trial attorney preparing a witness for interrogation, testimony, deposition, giving testimony at trial, I said two things. Tell the truth and don't answer more than you're asked. Don't volunteer information. Judge Kavanaugh, you failed on the second count. The question I asked you, what was your role in the original Haynes nomination decision to renominate him? And at the time of the nomination, what did you know about Mr. Haynes' role in crafting the administration's detention and interrogation policies? Your response, Senator, I did not. I was not involved and am not involved in the questions about the rules governing detention of combatants and so I do not have the involvement with that. And with respect to Mr. Haynes' nomination, I've known Jim Haynes, but it was not one of the nominations that I handled.
You raise it a little higher. I can't see the bottom. I got it.
Good.
Okay. Yes.
I asked you about this when we had a meeting in my office.
Yes.
And I still don't understand your answer in terms of how you could state as clearly and unequivocally, I was not involved and am not involved in the questions about the rules governing detention of combatants. You were involved in the discussions about access to counsel for detainees. You confirmed this during the meeting we had in my office, and there are multiple media reports as well. You were involved in discussions regarding detained U.S. combatants Yasser Hamdi and Jose Padilla. You confirmed that in our meetings, and there are emails that support that fact. You were involved, and this is one I want to be specific about. You were involved with President Bush's 2005 signing statement on Senator John McCain's amendment banning cruel, inhuman, and degrading treatment of detainees, and you confirmed that in the meeting. There were no exceptions in your answer given to me in 2006, not for litigation or detainee access to counsel or the McCain torture amendment. So if those three, based on the limited documents which we've been given, are obvious, what were you trying to tell me here? Did you really disclose accurately your role?
Yes, I understood the question then and my answer then, and I understood Stan. I understood the question then and the answer then, and I understand the question now and the answer now to be 100% accurate. You were concerned about whether I was involved in the program that two other nominees had been involved in, and the report that Senator Feinstein produced, the Justice Department report, they showed that I wasn't. In other words, the program, crafting the program for the enhanced interrogation techniques for the detainees.
Judge Kavanaugh, that's not the question. Do you see me asking you whether you crafted the program? I didn't. I asked you about your involvement in the Haynes judgment, and then you went further. Yes. Then you went further. You violated the second rule I gave to every witness. You answered more than I asked.
I adhered to the first one. I told the truth.
Well, you volunteered more information than I asked, and you went further than you should have. Because in the three specific instances I've given you, you clearly were involved in questions about rules governing detention of combatants.
So I understood the question then, and I understand it now in my answer about that, that program. I told the truth about that, and the reports that have come out subsequently have shown that I told the truth about that. My name is not in those reports. Now, for the 2005 signing statement, by that time I'm in staff secretary office, and everything that went to the president's desk, with a few covert exceptions, would have somehow crossed my desk on the way. So you asked, I said, on a signing statement, It would have crossed my desk on the way. So would a speech draft on the Iraq War. So would a speech, those things would have crossed my desk, prepared by others, not prepared by me, but they crossed my desk on the way to the president.
In the 2006 hearing, you told Chairman Arlen Specter you gave President Bush advice on signing statements, including, quote, identifying potential constitutional issues in legislation. Did you make any comments regarding the December 30th, 2005 signing statement on the McCain Torture Amendment, including potential constitutional issues?
I can't recall what I said. I do recall that there was a good deal of internal debate about that signing statement, as you can imagine. There would be. I remember that it was controversial internally. And I remember that I thought, and I can't remember all the ins and outs of who thought what, but I do remember that the counsel of the president was in charge ultimately of signing statements in terms of the final recommendation to the president.
And just a few months later, you, under oath, told us you were not involved in any of the questions about the rules governing detention of combatants.
Senator, again, we were, at least I understood it then and I understand it now to be referring to the program we were talking about that was very controversial, that Senator Feinstein spent years trying to dig into. And I was not read into that program. I told the truth about that. And
let me go to another area of questioning if I can. Thank you very much. In your dissent in Garza versus Hargan, you wrote that the court had created, quote, a new right for unlawful immigrant minors in the United States government detention to obtain immediate abortion on demand, thereby barring any government efforts to expeditiously transfer the minors to their immigration sponsors before they make that momentous life decision. You argued that permitting the government additional time to find a sponsor for a young woman in the case did not impose an undue burden, even though the government's conduct in the case had already forced her to delay her decision on an abortion by several weeks. We are talking about a young woman characterized as Jane Doe, who discovered that she was pregnant after crossing the border into the United States. She made a personal decision that she was not ready to be a parent and did not want to continue her pregnancy. She went through every step necessary to comply with Texas state law, as well as steps forced on her by the federal government. She visited a religious anti-abortion crisis pregnancy center. She underwent an ultrasound for no medical purpose, and she went before a judge and obtained a judicial bypass of the state's parental consent requirements. In other words, this young woman complied with every legal requirement, including Texas state requirements, placed in front of her so she could move forward with her decision, a decision affecting her body and her life. Do you believe that this was an abortion on demand?
Senator, the Garza case involved first and foremost a minor. It's important to emphasize it was a minor.
Yes.
So if she had been, and she's in an immigration facility in the United States, she's from another country, she does not speak English, she's by herself. If she had been an adult, she would have a right to obtain the abortion immediately. As a minor, the government argued that it was proper or appropriate to transfer her quickly first to an immigration sponsor. Who is an immigration sponsor, you ask? It is a family member or friend who she would not be forced to talk to, but she could consult with if she wanted about the decision facing her. So we had to analyze this first as a minor, and then for me, the first question always, what's the precedent? The precedent on point from the Supreme Court is there is no case on exact point, so you do what you do in all cases. You reason by analogy from the closest thing on point. What's the closest body of law on point? The parental consent decisions of the Supreme Court, where they've repeatedly upheld parental consent laws over the objection of dissenters who thought that's going to delay the procedure too long, up to several weeks. And I'm getting to the point.
Before you get to the point, you've just bypassed something. You just bypassed the judicial bypass, which she received from the state of Texas when it came to parental consent. That's already happened here.
But that,
and you're still stopping her.
I'm not. The government is arguing that placing her with an immigration sponsor would allow her, if she wished, to consult with someone about the decision. That is not the purpose of the state bypass procedure. So I just want to be very clear about that.
But, Judge, the clock is ticking.
It is.
The clock is ticking. 20-week clock is ticking.
And
she made the decision early in the pregnancy, and all that I've described to you and the judicial decisions, the clock is ticking. And you are suggesting that she should have waited to have a sponsor appointed who she may or may not have consulted in making this decision.
Again, I'm a judge. I'm not making the policy decision. My job is to decide whether that policy is consistent with law. What do? I look at precedent. And the most analogous precedent is the parental consent precedent. From Casey has this phrase at page 895, minors benefit from consultation about abortion. It's a quote talking about consultation with parents.
You are adding a requirement here beyond the state of Texas requirements that there be some sponsor chosen who may or may not be consulted for this decision. And the clock is ticking on her pregnancy.
Couple things there, Senator. You said you are adding. I'm not adding. I'm a judge. The policy is being made by others. I'm deciding whether the policy is then consistent with Supreme Court precedent. There are two things to look at in this context, Senator. First, is the government's goal reasonable in some way? And they say we want the minor to have the opportunity to consult about the abortion. Well, the Supreme Court precedent specifically says that that's an appropriate objective.
Was that a state requirement?
The second question.
Was that a state requirement?
The second question is the delay, your point. In the parental consent cases of the Supreme Court recognize that there could be some delay because of the parental consent procedures. And in fact, Justices Marshall, Brennan, and Blackmun repeatedly dissented in cases because they thought the delay was too long. I quoted all that in my Garza opinion, and I made clear it had to happen very quickly. And I looked at the time of the pregnancy to make sure on safety. I specifically talk about safety. I specifically say the government cannot use this as a ruse to somehow prevent the abortion. I spent a paragraph talking about she was in an undeniably difficult situation. So as I was saying to Senator Graham earlier, I tried to recognize the real world effects on her. I said, consider the circumstances. She's a 17-year-old by herself in a foreign country, in a facility where she's detained, and she has no one to talk to, and she's pregnant. Now that is a difficult situation, and I specifically recognized and tried to understand that, and then as a judge, not the policymaker, I tried to understand whether the government's policy was consistent with the Supreme Court's precedents, and I did the best I could. And I said on those parental consent precedents, I said, look, some people disagree with those precedents and think those kinds of statutes should not be allowed. But precedent's not like a cafeteria where I can take this but not that. I had to take Casey completely. Casey reaffirmed Roe.
I have some other questions, so I ask you if you please.
Well, it's an important question, though,
It's
and I want to make
critical
sure.
question,
And I did my level best in a emergency posture. So I had basically 2 days to do this case.
2-1 en banc decision, which you dissented from, correct?
I did the best to follow precedent, and as I always try to do, to be as careful as I can in following the precedent of the Supreme Court. So.
Let me ask you a personal question. What's the dirtiest, hardest job you've ever had in your life?
I worked construction when I was the summer after I was 16 for a summer, 7 a.m. to 3:30 p.m. My dad dropped me off every morning at 6:55. He wanted me to be early. That's probably the one. I should say, Senator, I had one person, I guess, is lawn business for many summers. I cut a lot of lawns, and that's how I made some cash. When I started that probably 8th grade, maybe 7th grade. I cut my parents' lawn, but then I cut a lot of lawns in the neighborhood and actually distributed flyers to all over the place to say, if you need your lawn cut, call me. So lawn cutting, and then the construction job the one summer.
My dirtiest job I ever had was 4 summers working in a slaughterhouse.
Yes.
I always wanted to go back to college.
Yes.
I couldn't wait to get out of there. It was unbearable. It was dirty. It was hot. The things I did were unimaginable, and I wouldn't even start to repeat them. Then came a case before you called Agri-Processor Company versus NLRB. At least a third of the workers, Judge Kavanaugh, in our nation's slaughterhouses are immigrants. It stands visits to Iowa or Illinois, probably Delaware, you pick it. You're going to find a lot of immigrants doing these miserable, dirty, stinking, hot jobs. Many of them are undocumented. The work is low-paid and dangerous. And as the GAO has noted, immigrants are pressured not to even report injuries on the job. Agri-Processor's case was a notorious meatpacking company owned by Shalom Rabashkin, who was convicted of 86 counts of fraud and money laundering in 2009. His 27-year sentence recently was commuted by President Trump. Agri-Processors had at the core of its business model the exploitation of undocumented workers. Half their workers, almost 400 of them, were not authorized. Workers alleged the company fostered a hostile workplace environment that included 12-hour shifts without overtime pay, exposure to dangerous chemicals, sexual harassment, and child labor. A truck driver at Agri-Processors' Brooklyn warehouse told reporters, quote, "We were treated like garbage, and if we said anything, we got fired immediately." Judge Kavanaugh, you bent over backwards to take the company's side against these workers. In a 2008 D.C. Circuit case, Agri-Processor versus NLRB, your dissent argued that this company's workers should be prohibited from unionizing because they did not fit your definition of an employee. To reach this conclusion, you imported a definition of employee from a totally different statute. You ignored the plain language of the controlling statute, the National Labor Relations Act, which has a broad definition of employee, as well as binding Supreme Court precedent. The majority in this case, and you were a dissenter, the majority in this case noted that their opinion stuck to the text of the National Labor Relations Act and to the 1986 Immigration Reform and Control Act, which did not amend the National Labor Relations Act. They said that your dissent, these other judges said about your dissent, would, quote, abandon the text of the controlling statute and lead to a, quote, absurd result. The majority in this decision included 1 Republican and 1 Democratic appointed judge. Judge Kavanaugh, you claim over and over again to be a textualist, to be carefully weighing every word of a statute.
Yes.
So why did you go out of your way to interpret the word employee in a way that benefited this horrible business and disadvantaged these exploited workers? Why didn't you stick to the plain language of the controlling statute and the binding Supreme Court precedent?
Because the Supreme Court precedent compelled me to reach the results that I reached. And here's why, Senator. Let me explain. The Supreme Court had a case in 1984 called the Shurtan decision. And the Shurtan decision considered the interaction of the National Labor Relations Law Act and the immigration laws. And what the Supreme Court did in Shurtan is had this question and said it is at that time permissible to consider an immigrant unlawfully in the country as an employee under the National Labor Relations Act. And in Part 2B of the opinion, you have to read Part 2B of the opinion, of the Supreme Court's opinion. If you read Part 2B of the opinion, the court then goes on to say, and because the immigration laws do not prohibit employment of people unlawfully in the country, and makes clear, the Supreme Court makes clear, this is when it's being considered in Congress in 84, it ends up in the 86 Act. The court makes clear, as I read Part 2B, and I think I'm correct on this, that if the immigration laws did prohibit employment of someone here unlawfully in the country, then that would also mean that they can't vote in the union election. So what I was doing there, Senator, it's all about precedent. I read that, and my opinion, if you look at the dissenting opinion, I really parsed this very carefully, and I went deep into this case. So I went back and pulled from the Shurtan case, I went and asked for the Marshall papers, Thurgood Marshall papers from the library to read all the memos that went back and forth among the justices in the Shurtan case. I cited the oral argument to make sure that what I was reading in there was actually reflected what had been going on in the Supreme Court. And it is quite clear from the oral argument, they were aware that the immigration law was about to be changed, and they were aware of the interaction between the labor law and the immigration law. So I think I stand by what I wrote then, and I think I correctly analyzed Part 2B. Now, Senator,
I have to.
If it ends
out of time here.
I know, but if it ends, if the Supreme Court's Shurtan opinion had ended at Part 2A, 100% would agree with you, and my decision would have been different.
Well, let me just say
if you read
this.
Part 2B, I think you see.
You said earlier today you don't get to pick and choose which Supreme Court precedent you follow. The majority in agri-processor's case was following Supreme Court precedent. In the Shurtan case, the Supreme Court, a 7-2 decision, said that undocumented immigrants are employees under the National Labor Relations Act. I quote, "Since undocumented aliens are not among the few groups of workers expressly exempted by Congress, they plainly come within the broad statutory definition of employee." That's a quote from the case.
But that's Part 2A. You got to go to Part 2B.
Well, let me hang on. Let me tell you some people who went to both parts and couldn't disagree with you more. Everyone else who looked at this question, the administrative law judge, the National Labor Relations Board, including Republican appointees, 2 appeals court judges, including 1 Republican appointee, followed the Supreme Court precedent and came to the opposite conclusion that you did. I understand you may have preferred the Shurtan dissent, but you failed to follow Supreme Court precedent. This was a case where the National Labor Relations Act included those who were undocumented who could unionize to protect themselves in the workplace. You went out of your way to dissent all the way along and make sure they didn't, or in your view, not have that right, that they did not have that right to unionize.
I very respectfully disagree, Senator. And the reason I disagree is that the Supreme Court did say that the immigrant was covered under the definition of NLRA. If it ends there, I'm with you 100%. But then the Supreme Court goes on to say, and we consider also in resolving this question the conflict between the National Labor Relations Act and the immigration laws, and makes clear, as I read it, if the immigration laws had made employment of someone here in the country unlawfully illegal, then that would be prohibited in the case. And I went back, like I said, if you look at Justice, I quote the oral argument transcript from Shurtan in my dissenting opinion. I have no agenda in any direction on I'm a judge, so I'm just trying to resolve the precedent.
Well, let me close by saying this. I'm just a judge. I just follow precedent. Gosh, we've heard that so often, and I hope it's the case, but we know that there's much more to your job than that.
I agree.
The fact that you were a dissenter and everyone else saw this the other way should give us pause when you say, I'm just following precedent.
Well, I respectfully, Senator, that opinion, I'm proud of that opinion because I think it carefully details the law in that case. I'm following the Supreme Court precedent. And to your point that other judges disagree, there was a case I had about 10 years ago or 8 years ago called Papano. It was a case where I ruled in favor of a criminal defendant on a restitution matter. Every other court beforehand disagreed. I wrote the majority opinion with Judge Edwards and Judge Griffith. Every other court after us disagreed. Finally got to the Supreme Court this year in the Lagos case, and they agreed with our one opinion, the Papano opinion. Just to point out that just because other courts of appeals might have disagreed does not necessarily mean we were necessarily wrong, because the Supreme Court ultimately decides that. I understand your question. I appreciate them. Thank you.
Senator Cornyn, and Senator Lee's going to chair while I have another appointment. Senator.
Thank you, Mr. Chairman. Mr. Chairman, I was grateful that today's hearing, at least as far as the committee's concerned, is a lot more dignified and civil. But unfortunately, some of the hijinks continue even on the Senate floor. I know Senator McConnell asked consent for the Judiciary Committee to continue meeting during today's session of the Senate. Senator Schumer objected, so Senator McConnell was left with no option but to adjourn the Senate and allow the committee to continue to meet. That's unfortunate. So, Judge, I believe we met in the year 2000.
Yes.
And just to take a little walk down memory lane here, when I was Attorney General of Texas and had a chance to argue a case in front of the Supreme Court of the United States, you, Ted Olson, and Paul Clement, I believe,
Yes.
helped me get ready. I regret you didn't have better material to work with. But
It was an honor, Senator.
well, it was a great experience and an educational experience. But I got to appreciate your skills as a lawyer from that time and have followed your career closely since. And I'm proud to support your nomination based on my personal knowledge of your skills, your temperament, and your character, and your fidelity to the rule of law. But I do want to pick one bone with you. I did this. This isn't unique to you. Based on that experience. That case, as you may recall, involved a tradition in the Santa Fe Independent School District, unfortunately, which was the site of a shooting here in more recent days. But back then, the practice before football games was that the students would be able to volunteer to offer a prayer before the football game. They weren't required to do so. The school didn't pick them. They could offer an inspirational saying or read a poem or anything else. But that was the practice. Well, until the ACLU filed suit, and unfortunately it was held to be unconstitutional in violation of the Establishment Clause. I'm not going to ask for your opinions because this issue will likely come back before the court, but since I mentioned it to Justice Gorsuch, I'm going to mention it to you. The thing that is stuck in my craw for the last 18 years is the dissent written by Chief Justice Rehnquist, which takes exception to the majority's decision, saying they distorted existing precedent. But he goes on to say, even more disturbing than its holding is the tone of the court's opinion. It bristles with hostility to all things religious in public life. Neither the holding nor the tone or the opinion is faithful to the meaning of the Establishment Clause. When it is recalled that George Washington himself, at the request of the very Congress which passed the Bill of Rights, proclaimed a day of public thanksgiving and prayer to be observed by acknowledging with grateful hearts the many and signal favors of the Almighty God. Since I had you here, I thought I'd mention that.
Yes.
I'm not asking for your opinion, since likely you'll be called upon to decide cases involving the Establishment Clause in the future. But since we had that history together, I thought I would just tell you that still sticks in my craw.
I understand, Senator. We remember certainly cases I lost. I remember, and they still stick in my craw too, Senator. So.
Well, I just marvel that under the First Amendment that we can, a variety of voices can speak, and that's generally a good thing, but it can be about violence, sexism. It can be about almost anything, but you can't speak about religion in a public forum.
Well, there have been cases from the Supreme Court, I think in more recent years, cases like the Good News Club case, cases like the Trinity Lutheran case, cases like the Town of Greece case, where I think the Supreme Court has recognized the importance, of course, of religious liberty in the United States, and also has recognized, I think, that religious speakers, religious people, religious speech is entitled to a space in the public square and not to be discriminated against. I think the Trinity Lutheran case is an important one on that. The Good News Club case, that's a case where there's an after-school program at a school gym, I think, or auditorium, and a religious group was excluded, and the Supreme Court made clear, no, you can't just exclude the religious group. So I think there have been some developments since then in terms of religious equality and religious liberty that are important. Those cases are always difficult factually, but the principle you're espousing, I do think, is reflected in some more recent Supreme Court precedent.
Well, I'll just conclude with this. As I understand the Constitution, it requires the government to be neutral.
Yes.
And as Chief Justice Rehnquist, I think in this case, the government evidenced hostility to religious speech in the public square. That's just one person's opinion. And again, I'm not asking you for any opinion with regard to a case that may come before the court. Mr. Chair. Mr. Chairman, I hope that time won't be subtracted from my 30 minutes.
It will not be.
Thank you. So, Judge Kavanaugh, I'm intrigued by a comment that you made earlier about the role of precedent. We've heard a lot about precedent. You alluded to this book that you and other judges wrote with Brian Garner on the law of judicial precedent. I checked it out. It's 900 pages long, and I haven't read every page of it either.
I don't think it's not meant to be read word for word. It's a treatise where you go to a section that might be on point or something.
But let me just ask you a more basic question, then we can work our way into that. When people go to court, should they expect a different outcome if the judge was nominated by a Republican from a court where the judge was nominated by a Democrat?
No. That's an important principle of judicial independence and the judicial role. Well, the judge's umpire vision that Chief Justice Roberts articulated, and I've talked about publicly many times, is critical. When you go to a baseball game, the umpire is not wearing the uniform of one team or another, and that's a critical principle.
Well, it strikes me as an important point, given the suggestion that one of the reasons people have objected to your nomination is, I believe the quote was, you have Republican blood flowing in your veins. It strikes me as a strange and bizarre statement.
I've been a judge for 12 years, Senator, and I'm 307 opinions. I'm very proud of that record, and been an independent judge for 12 years. You're not as a judge, you're not a Republican or a Democrat as a federal judge.
And you talked a little bit about the constitutional basis for a judge's obligation to apply existing precedent. Could you expand on that a little bit more? Because I think most people are under the impression this is sort of a discretionary matter, and you can sort of cherry pick between what precedents you decide to follow and which ones you don't follow.
Well, there's been a debate sometimes about what are the origins of precedent? Why do you follow precedent? And as I see it, there are a number of reasons you would cite: stability, predictability, impartiality, reliance interests. But all of those are not mere policies in my view. As I see it, the system of precedent comes from Article 3 itself. When Article 3 refers to the judicial power shall be vested in one Supreme Court and such inferior courts as Congress shall from time to time establish. To my mind, the phrase judicial power, you think about what does that entail? And you look at the meaning at the time of judicial power, and you look, one source of that is Federalist 78. And that in Federalist 78, it's well explained that judges make decisions based on precedent. And precedent, therefore, as I read judicial power, has constitutional origins and a constitutional basis in the text of the Constitution.
And I think you've touched on this as well. Judges, unlike legislators, don't run for election. You don't have a platform.
No.
Vote for me. This is what I'll do if I'm elected into office. One of the most important elements of limiting the important role of judges, I think, under the Constitution is that you're required to decide a case on a case-by-case basis rather than issuing some sort of oracle saying, henceforth, the law will be thus, assuming you could get 8 other judges on the team of 9 you talked about to agree with you. Can you talk about the importance of deciding cases on a case-by-case basis?
We'll add another 20 seconds.
Thank you.
Absolutely, Senator. It's important to understand, and I think Senator Graham alluded to this as well. As judges, you don't just issue policies or issue opinions out of the blue. You decide, as the Article 3 says, cases and controversies, and that means there's a process. Litigants come into the federal trial court, for example, and litigate against one another, and there's a process there, a trial or a summary judgment motion. The district judge renders a decision. Then that comes up to the Court of Appeals, in my case, and there's briefing and oral argument. I like to say there's a process. I like to say process protects you. It's one of my things I always like to keep in mind. You go through a process to help make good decisions, deliberative process. And we have a process. Judges were very focused on process. And having that oral argument, having the briefing, and then talking to your colleagues, you change your mind. You know, Senator, you've been a judge, of course. You change your mind sometimes based on the comments of colleagues. So that process is important. And then to your point about you're deciding that case, you write an opinion. You're not trying to resolve every issue imaginable in the opinion. You're trying to resolve this case under the principles and precedents, the text of the law in question, the text of the statute in question, and decide that case or controversy. And that's how judges build up a system of precedent over time, by deciding one case at a time and not trying to do more than they can or more than they should.
And Judge, don't you think that what you've described for us in deciding cases on a case-by-case basis has an important foundation in fairness to the litigants, the parties that come to your court? Because how would somebody feel if they know you've already announced in all cases that have to do with subject X, I've made up my mind, I don't care what the facts are? Isn't that unfair to the litigants?
It can be, Senator, at least, where an overbroad ruling may resolve things that people who are affected by it may have thought, well, I wasn't part of that case. Why am I now affected in a particular way? I think one of the things I can say about how I've tried to write my opinions, the 300 opinions, is I'm always concerned about unintended consequences. This is one of the reasons I go through so many drafts of my opinions and really work through them, is even just a sloppy footnote or an ambiguous word in opinion. It's true when you're drafting laws here too, but if you don't, you're concerned about unintended consequences, which is why it's so important to be clear in the opinions and to be exactly precise and not to decide too much.
Judge, let me ask you to tell us a little bit about September the 11th, 2001. Where were you when you heard that the planes hit the World Trade Center in Washington, D.C., and another plane hit the Pentagon here in Washington?
You know, I remember I was
New York, I should say.
Yeah, I
Washington.
was in the West Wing when the second tower. I remember that up in the upstairs counsel's office with a couple other people in the counsel's office, and then we were ushered downstairs and then told to get out and run out because there was fear, as we later learned, about Flight 93. I think don't know whether it was headed to the Capitol or the White House or some other target, of course. And the heroes of Flight 93 saved so many Americans, sacrifice that, of course, we still all celebrate in the sense of celebrating their lives and their heroism for saving all of us here in Washington, but ended up out in Lafayette Park with the rest of the staff and bewildered, and changed America, changed the world, changed the presidency, changed Congress, changed the courts, all the issues that came before. It was a new kind of war, as President Bush described, with an enemy that didn't wear uniforms and that would attack civilians. And so new kinds of laws had to be considered, and Congress had to work through that. And President Bush had to focus so intently. And as I've said before, my remembrance is that on September 12th, his basic mentality was this will not happen again. And having traveling with him from 2003 to 2006 everywhere as staff secretary and seeing him up close, I still think every day I was with him during those years, every morning when he got up, it was still September 12th, 2001. This will not happen again. And to see that focus, of course, he had to do all the other things of the presidency and all the other legislative and regulatory and ceremonial aspects, but he was so focused on that. I'm sure that's been true of the succeeding presidents as well, because the threat still exists, of course.
Well, as we came to learn, Osama bin Laden and al-Qaeda was responsible for that attack and has now morphed into other organizations like ISIS and the like. But I want to ask you, you had to then sit in judgment later on in a case, the Hamdan case, which you've alluded to earlier, where the defendant was Osama bin Laden's personal bodyguard and driver. He was captured by U.S. forces in Afghanistan after 9/11 and detained in Guantanamo Bay. He subsequently went through a military tribunal, and then that case was appealed to your court. And just correct me if I'm wrong, but notwithstanding the experience you and everybody you cared about having been through this terrible travesty of 9/11, you ruled in favor of Osama bin Laden's bodyguard and driver, correct?
That is correct. I wrote the majority opinion.
How could you do that? How could you possibly do that?
The rule of law applies to all who come before the courts of the United States.
Even an enemy combatant?
Equal justice under law. Everyone is entitled to...
Even a non-citizen?
Yes. Non-citizens who are tried in U.S. courts, of course, have the constitutional rights. And really my model on that, judicial model for thinking about something like that, because I thought about what you're asking about. Justice Jackson, of course, Robert Jackson, who had been Franklin Roosevelt's Attorney General, then he's in the Korematsu case, even though that was one of President Roosevelt's policies. Justice Jackson, now the majority opinion now overruled, but Justice Jackson dissented and ruled against the Roosevelt policy. Justices Clark and Burton, two appointees of President Truman, are the two deciding votes in Youngstown Steel. That's a 6-3 decision. Those two are the deciding votes, therefore. They both were appointees of President Truman. They get to and it's wartime against Korea. They get to the Supreme Court. They're the deciding votes in the Youngstown Steel case, which was an extraordinary national moment, one of the great moments. And so it's your conception of the role of a judge it's about the law. That's distinct from policy, and our judiciary depends on having people in it, and we are fortunate to have a wonderful federal judiciary, people in it who understand the difference between law and policy and are willing to apply principles of equal justice under law to anyone who comes before the court. Even the most unpopular possible defendant is still entitled to due process and the rule of law, and I've tried to ensure that as a judge.
Well, it's hard for me to imagine a more unpopular defendant than Osama bin Laden's driver and personal bodyguard. So I find the suggestion that somehow you are prejudiced against the small guy in favor of the big guy, or that you are picking and choosing who you're going to render judgment in favor of based on something other than the rule of law. I think this answers that question conclusively for me. The fact that you could separate yourself from the emotional involvement you had, along with so many people you worked closely with in the White House on September the 11th, and you could then, as a judge, after you put on the black robe and take the oath of office, you could then render a judgment in favor of Osama bin Laden's bodyguard and driver because you apply the law equally to everybody that comes to your court. Sometimes let me allude to something Senator Sass, I think, was eloquently speaking about yesterday in terms of the separation of powers. Very important aspect of our constitutional system, and one that I know you've dealt with often on the D.C. Circuit Court of Appeals. And that has to do with what I've read some judges talk about, some constitutional scholars talk about, a conversation between the branches. In other words, when the D.C. Circuit Court or the Supreme Court decides a case, they finally decide that case, but they don't finally decide what the policy is for the United States or the American people, correct?
That's correct, Senator. And I think one of the important things that judges can do is adhere, of course, to the laws passed by Congress, but then in writing the opinion, make clear, and I've done this before, and a lot of my colleagues do this, is that perhaps the statute needs updating, but if it does, that is the role of Congress to update the statute. Or if there's sometimes there'll be a hole in a statute or something that seems unintended in a statute, and to alert Congress to that. Chief Judge Katzmann of the Second Circuit, who's a great judge I serve with on the Judicial Branch Committee, which is appointed by the Chief Justice, and he has written a book about statutory interpretation, but he's also been a leader of a project to make sure that Congress is alerted of potential statutory issues that look like they might have been things that perhaps Congress would not have intended, or at least Congress would want brought to its attention so it could fix. And so that project's been very successful. I think Chief Judge Katzmann's project, and it's one, even without that project, how you write your opinions, I think, is important. We don't update the statutes. You update the statutes, but it's good for us to write our opinions in a way that points out potential issues that Congress might want to be aware of.
And that's part of the conversation between the two co-equal branches of government.
Absolutely, and I think that's an important dialogue to have between Congress and the judiciary, and the back and forth is very important on that front. And I think that's one thing I'm always thinking about in my opinions. You write the laws, but if the law looks like there's some issue with it, some flaw or something that might be an unintended consequence in the opinion, you can identify it, and that can be something that Congress can turn its attention to sometimes. Because I'm well aware that statutory drafting is a very difficult process. That's something I think judges need to be actually more aware of, is how difficult the legislative drafting process is. Even if you're doing it as one person, it would be difficult, but then you're doing it as a collective body, and then you're doing it with the House and with the president involved. There are a lot of people in it. It's hard to have, with all the compromises inherent in that, hard to have crystal clarity on every possible topic. So as judges, I think, number one, we have to recognize the process that you go through as legislators. That means adhere to the compromises that are made, the text as written, but also when we write our opinions, if there seems to be something that's not working out, it's appropriate, I think, for judges to point that out in their opinions.
And of course, even if it's a constitutional basis for your decision, that could be changed by constitutional amendment, correct?
Well, that's correct as well. The framers did not think the Constitution was perfect by any stretch. They knew it had imperfections. For starters, the original Constitution did not have the Bill of Rights, the first 10 amendments. So there was a lot of discussion at the ratifying conventions about having a Bill of Rights. And that was quickly done in the first Congress in New York in 1789, of course, by James Madison taking the lead on that. But so, too, they did not think it was perfect. They have an amendment process that's specified in Article 5 of the Constitution, and that amendment process was intended to be used, and we've seen it used to correct structural issues, the 12th Amendment on presidential elections, the 17th Amendment, of course, as you all know well, on Senate elections, the 22nd Amendment, which limited presidents to only 2 terms, the 25th Amendment, which corrected some issues with respect to vice presidency, and so too, of course, the 13th, 14th, and 15th Amendments, the most important amendments in the Constitution in many respects, because it brought the promise of racial equality that had been denied at the time of the original Constitution into the text of the Constitution. So the job of the people, which is the Congress and the state legislatures, is to amend the Constitution. It's not the job of judges to do that on our own. And obviously that's a basic divide of constitutional responsibility that is set forth right in the text of Article 5 of the Constitution.
I can't remember who said it. I think Justice Jackson, perhaps, who said the Supreme Court is always right, is not final because it's always right. It's right because it's final, or words to that effect. But I always thought the more I got into that, the more I disagreed with that, because it is a conversation between the branches. And if the American people believe that as a constitutional matter, the way the Constitution is being interpreted, it's within our power as the American people to change our own Constitution by amendment. There's provisions in the Constitution itself to do that. It's hard, and it should be hard, but ultimately, the authority that we delegate to the government finds its origin in the consent of the governed. It's not something dictated to us from down on high, from the Marble Palace or somewhere like that here in Washington. It is ultimately our government, our responsibility, our authority that provides legitimacy to the government itself. You agree with that?
I agree, of course, with that, Senator. The people, we the people, form the Constitution of the United States, and the sovereignty, the people are the ultimate authority. And you're right about Justice Jackson's line. I think it is a clever line, but ultimately I agree with you. I've always had a little bit of a problem with that line, because we're infallible because we're final. No, both parts of that are wrong in some sense, because I never want to think of the court as infallible. And I also never want to think of it necessarily, in the way you're describing either, because there is the people always have an ability to correct through the amendment process. Now, the amendment process is hard and hasn't been used as much in recent decades, but of course, at the beginning of the country, the amendments were critical. And Dred Scott, of course, the awful example of just a horrific Supreme Court decision that is then corrected in part, at least on paper, in the 14th Amendment, 13th, 14th Amendments. And that's an important example, I think, of probably the best example, frankly, of the point you're making about the people being able to respond to a horrific decision of the Supreme Court.
Well, in fairness to Justice Jackson,
yes,
maybe he was thinking, as I originally thought, about the expression as being binding on lower court judges, trial judges, appellate court judges, and the Supreme Court does have the final word in that food chain of the judiciary, but not in terms of the fundamental authority of the American people to decide what laws should govern them.
I think that's probably right, Senator. I don't want to be Justice Jackson's one of our greatest justices. To question anything is whether it was Korematsu dissent or Barnett or Youngstown or Morissette on mens rea. Justice Jackson wrote some of the greatest opinions and the example of judicial independence as well. So, but on that one line, I take your point.
Let me just ask you one last question. We've talked a lot about the role of precedent, and Senator Feinstein talked about stare decisis, and basically cases that have been decided provide the precedent for future cases. But on occasion, the Supreme Court has decided that its decisions were just wrong and chosen to overrule those previous decisions. I'm thinking of Plessy versus Ferguson, for example, which was a scar on our body politic that said that separate but equal educational facilities met the constitutional requirement of the 14th Amendment. But can you talk about the extraordinary circumstances under which the Supreme Court would revisit a precedent?
Well, Brown versus Board of Education, of course, overturned Plessy, and Plessy was wrong the day it was decided. It was inconsistent with text and meaning of the 14th Amendment, which guaranteed equal protection. And the Supreme Court in the Strouder versus West Virginia case in 1880, jury selection case, had said, what is this amendment but that the law shall be the same for the black and the white? And the Supreme Court, unfortunately, backtracked from that clear principle in the Plessy decision, and a horrific decision which allowed separate but equal. And then Brown versus Board corrected that in 1954, of course, corrected it on paper. It's still decades, and we're still seeking to achieve racial equality. The long march for racial equality is not over. But Brown versus Board, as I've said publicly many times before, the single greatest moment in Supreme Court history by, in so many ways, the unanimity that Chief Justice Warren achieved, which is just a great moment, the fact that it lived up to the text of the Equal Protection Clause, the fact that it understood the real-world consequences of the segregation on the African-American students who were segregated into other schools and stamped with a badge of inferiority. That moment in Brown versus Board of Education is so critical to remember, and the opinion is so inspirational. I encourage everyone to, it's a relatively short opinion, but it's very powerful. It's very focused on the text of the Equal Protection Clause and correcting that awful precedent of Plessy versus Ferguson, a great example of leadership. And just the last point I'll mention on process, they knew they were going to face popular backlash. They knew they were what, but they still did it. So that shows independence and fortitude. But they also had re-argument, which I think is a good, they had argument originally and then decided there's a lot going on and maybe not everyone's seen it the same way, the justices, and they had a re-argument, which I think is a good lesson on process protecting us, and keep working at it and see, you know, the team of 9 that I mentioned yesterday and have mentioned today, keep working at it as a team of 9, and they came out unanimous. Chief Justice Warren thankfully led the court in that decision. That was a great moment, the greatest moment in Supreme Court history.
Thank you, Judge.
Thank you. I awarded 2 additional minutes to Senator Cornyn because he was interrupted by my count 5 times during his testimony. Senator Whitehouse is next.
Thank you. Good afternoon, Judge Kavanaugh.
Thank you, Senator.
Are you good for another half hour?
I'm good.
All right, good. In my office, you told me that you could provide no assurance to me that you'd uphold a statute requiring insurance companies to provide coverage for pre-existing medical conditions. Is that still true here in public?
Well, I think, Senator, it's important to understand the principle at play here. The principles.
We've talked a lot about that, but is the statement you made, have I recited it accurately, and is it still true today that you can give no assurance that you would uphold a statute?
Well, Senator, judges like to explain their decisions.
Yep, but I get to ask the questions. Usually you get to ask the questions because you're the appellate judge, but today for half an hour I get to. So is it still true that you can give no assurance that you would uphold a statute requiring insurance companies to cover pre-existing medical conditions?
So to prepare for this moment, I went back and read.
I really would like you to be as careful with your time as you can, because I have a very limited amount of time with you. So the quicker you can get to the answer, it could be as simple as yes or no.
But I can enhance your understanding of my answer if I explain it, I think.
I really just want your answer on the record. I think I'm pretty capable of understanding it on my own.
But, well, then everyone to understand my answer. So there's nominee precedent of how justices and nominees in my position have answered in the past. I'll be succinct if I can. And all 8 sitting justices.
I know, you've actually said this in the hearing, so people who are listening and interested have actually already heard you say this.
Well, I think it's really important, so I want to...
Say it again, then.
I want to underscore it. All 8 sitting justices of the Supreme Court have made clear that it would be inconsistent with judicial independence, rooted in Article 3, to provide answers on cases or issues that could come before us. Justice Ginsburg, no hints, forecasts. Justice Kagan talking about precedent, no thumbs are up or down. And I went back, Justice Thurgood Marshall was asked repeatedly in his hearing, what do you think about Miranda? What do you think about Miranda? What do you think about Miranda?
Got it. Everybody else does it, and your answer is still no.
So the reason everyone else does it, though, is rooted in judicial independence and my respect for precedent. So it's a combination of my respect for precedent, nominee precedent, and my respect for judicial independence. So I can't give assurances on a specific hypothetical.
Okay, thank
base.
you. Let me go on to another subject, which is executive privilege. Executive privilege is a principle that is founded in the Constitution and the separation of powers, correct?
The Supreme Court so ruled in the United States versus Richard Nixon case. So that was the first, the key issue in the United States.
That's all right. I just needed the answer to the question, and you've answered it.
Okay, the source is important.
As a privilege, it needs to be asserted. Does it not? That's true of privileges generally.
I don't know where this is going, but the
pretty straightforward question. Don't privileges need to be asserted in order to apply?
Well, privileges are recognized
Once they're asserted.
I think as a general proposition.
Fair enough. I'm only asking as a general proposition.
Yeah, as an attorney-client privilege, you would assert the attorney-client privilege. Yeah.
And who asserts executive privilege?
Ordinarily, well, that is a complicated question, Senator. Actually,
Who does it come back to? Ultimately, who asserts executive privilege?
So it depends what you're talking about. So what kind of executive branch document you're talking about, it depends. In my experience,
ultimately it's the president.
There's not as much precedent on that. There's some. In the Supreme Court, this was the Supreme Court in the United States versus Richard Nixon.
Isn't it fair to say that executive privilege belongs to the president of the United States, the chief executive?
Yeah, it can also belong to the former president in the case of former presidential records. That's one caveat I want to put on that.
Fair caveat. Yeah. Is the assertion of executive privilege by the president subject to judicial review?
Well, of course, because under the precedent, United States versus Richard Nixon said two things. It said, one, the executive privilege is constitutionally rooted. The special prosecutor in that case argued that actually there was no such thing as executive privilege, and the Supreme Court rejected that argument and held that the executive privilege is rooted in the separation of powers and in Article 2. But
the reason I'm asking doesn't have much to do with you. It goes back to a point that we were talking about earlier in the hearing, which is that we have received hundreds and hundreds of pages of documents of your record that look like this. They both say committee confidential across them at an angle, and then across the front they say constitutional privilege. And as a member of the Senate, this is not a question, I'm speaking to my colleagues, I find myself in a quandary here about being denied those particular documents because I cannot find any assertion of the privilege. These documents just suddenly appeared, and somebody had put constitutional privilege on the page and wiped out all the text that was on the page. And my understanding is that there's ordinarily a process for getting to that determination that allows for, ultimately, a judicial review. And we have failed to get subpoenas out of the committee for documents, so we can't trigger it that way. And there's no apparent assertion of executive privilege that I can find in the record of how this particular paper got here. So I just wanted to establish some of the basic ground rules of executive privilege with you, because I think we agree on that. I think that's basically commonly agreed, and put that into the context of what we are looking at. And particularly with respect to Chairman Leahy's questioning earlier, if some of the documents he's looking for have now been protected by this non-assertion assertion of executive privilege, we have a problem. It is a continuing problem in the committee. We've had other witnesses come and do assertions of executive privilege, and so I'm sorry to drag committee business before you, but I do think it is important that we try to get this right.
Can I make one addendum based on my experience from the time, which is I don't think formal assertions usually occur until after there has been a subpoena, at least from my time working.
Which is why not being able to get a subpoena kind of bollockses up the process. Yes, indeed. The role of the Federalist Society in bringing you here today has been of interest to me. As you know, we spoke about it quite a lot when you and I met in my office. Mr. McGahn, who is sitting very patiently behind you, I can see him over your shoulder,
Yes.
Has said that the Federalist Society was insourced into the White House to make these recommendations, specifically to make the recommendation that you should be the nominee. You have said this regarding President Bush, that he thought it was, and I'm quoting here, improper to give one group, especially a group with interests in many issues, a preferred or favored position in the nomination process. Those were your words, speaking, I guess, to the Federalist Society National Lawyers Convention. On another occasion, you wrote a draft speech for Attorney General Gonzalez or White House Counsel Gonzalez, probably White House Counsel Gonzalez, look at the date, to deliver to the Federalist Society. And you said in that speech, as a matter of constitutional principle, it is simply inappropriate, we believe, to afford any outside group a quasi-official role in the president's nomination process. How do you square those two comments about the role of the American Bar Association in the nomination process with the role of the Federalist Society in your nomination process, assuming that Mr. McGahn was speaking accurately when he said they had been insourced to the White House for this process?
Right. So I can speak to the ABA part of that. President Bush in 2001 had to make a decision of how the ABA should play its usual rating role with respect to nominees. And the ABA files amicus briefs and takes policy positions on issues. And therefore, after some deliberation, it was decided that there was nothing wrong with the ABA rating the nominees, but to give an organization that files amicus briefs and takes policy positions a preferred role in the constitutional nomination process was unfair in some ways and favoring.
Would it be a fair description of the Federalist Society's role in your selection as the nominee to say that it was preferred over other groups?
Well, my experience was when Justice Kennedy retired on the Wednesday, Mr. McGahn called me later that afternoon, said we need to talk on Friday. He came over to my office on Friday evening or late afternoon. We talked for 3 or 4 hours, interview and going through the usual kinds of questions you would go through when you're embarking on a process like this. And then I interviewed with the president on Monday morning.
So is it your testimony that you don't know what the role of the Federalist Society was in your selection?
My experience and of my personal experience and what I know is that President Trump made the decision, for starters. President Trump made the nomination. And I know he, as I explained yesterday, I know he spent a lot of time in those 12 days on this issue, and I was aware of that. I also know that Mr. McGahn was directly involved with me and spent a lot of time on it. And I also know that the Vice President—
You have no knowledge to share with us today about the role of the Federalist Society and how they were insourced into the White House. That is a mystery to you as well as to us.
I'm not sure what Mr. McGahn meant. I think by that comment, I think Federalist Society members are lawyers in the administration are Federalist Society members, and so it should not be a surprise that because it's an organization.
And Leonard Leo's role specifically from the Federalist Society?
I don't know.
Okay.
I don't know the specifics.
Well, let's go from specifics to generals, and let me put up a graphic that shows some of the folks who fund the Federalist Society. It's a pretty significant group of people who tend to share very conservative and pro-corporate points of view. It reflects that at least 14 of the donors are actually anonymous, which is a very unfortunate part of our current political world. Actually, probably more than that, because Donors Trust here is an organization whose sole purpose is to launder the identity off of big donors so that a recipient of funds can report that they got the money from Donors Trust rather than the true party in interest. So we don't know how much anonymous money flowed through them. But I would contend that this is a pretty strong group of right-wing conservative pro-corporate funders. And presuming that to be true, should that give you or anyone in this process pause that groups like this may have had such a significant role in selecting you to be in this seat today?
Senator, Mr. McGahn was the one who contacted me. I interviewed with then the president, and I know the president was, I'm the president's nominee. He was directly involved in making that decision. I'm sure he consulted with Mr. McGahn and others. I know he consulted widely with a lot of people to get input on the, very widely to get input on the, at least the people who were the finalists. So that part of it, my 12-day experience was with the White House counsel's office and the president and vice president too.
Okay, so
and I also don't.
Whatever,
I'm not familiar with all
whatever
those
the role
groups,
is of the Federalist Society was in all of this, it was, and there's plenty of reporting. We don't need to litigate that between us. You don't know is what you've testified, and that's fine.
On my process, and again, yes.
But you're fairly familiar with the process generally because you used to run it in the Bush White House or have a significant role in it, the process of judicial nomination selection, judicial nominee selection, correct? You've been inside that machine.
I did not run it, and Judge Gonzalez, when I was in the counsel's office, was the counsel.
But you've been inside the process.
I have been inside the process, yes.
So the next thing that happens going forward is that we see the Judicial Crisis Network showing up, and they spend millions and millions and millions and millions of dollars to run ads urging senators to support you. Now, I don't know whether we can show that those were the same funders because they are engaged in what is called, as you know, dark money funding. They don't report their donors. But I'd be prepared to make a very substantial bet that there's enormous overlap between the funders of the Judicial Crisis Network campaign for your confirmation and the Federalist Society donor group, to the extent that we're aware of it, since so many of them are anonymous. Hypothetically, should the American people have concern about the role of very, very big spenders and influencers doing things like being involved in the selection of a Supreme Court nominee and running dark money campaigns to support the confirmation of a nominee? Is there any cause for concern there as a general proposition?
Well, Senator, there are a lot of premises in your question that I'm not sure about.
I'm not asking you to accept the premises as true. I'm asking it as a hypothetical.
Well,
if there were very, very significant big special interest funding behind the organization that was responsible for selecting you and recommending to the president that he nominate you, and again, from a very similar group in supporting the dark money campaigns that are being running on your behalf for your confirmation, would that be a matter of concern, or is that all just fine and we shouldn't even care about getting the answers?
So two things, Senator. One is I've described the process I went through with Mr. McGahn, the president, and the vice president. in the selection, and that's what I know about my process. 2, on the ads, there are a lot of ads against me as well, and I've seen those, and our family's seen those, and then there's ads for me, and we've seen those too, and as Chief Justice Roberts said in his hearing, it's a free country, and there are ads for and against, and obviously we've, as Senator Durbin said,
should we as citizens know who they are, who's funding the ads, just as a matter of citizenship? Is that?
Well, I think that's first and foremost a policy question for the Congress to decide on what disclosure requirements it wants to put in. And then if those disclosure requirements were put in, or state governments could try to make disclosure requirements, I think some have tried, and then there would undoubtedly be challenges to that, and what's the First Amendment implications of that, and that would come to a court, and I would keep an open mind on that case under the precedent and First Amendment law, and we would think about that. The policy question, I think, is really for Congress in the first place to determine, assess, study exactly what kind of disclosure requirements should be put in place. I understand
the potential hazard there is that the unleashed power of unlimited political dark money then becomes like a ratchet, the obstacle to solving that problem. And I hope you can understand that as a matter of political principle.
I do understand the concerns about money in the political system. When I worked for, and the time it takes all of you, and when I worked for President Bush in the 03, 04 timeframe, for example, and how many fundraisers he had to do, and going back to the September 11th point and the time and burdens on the presidency, he had to do a lot of fundraising, running for president while being president.
It's gotten a lot easier since now you can just get a huge special interest, set up a 501c4 and drop tens of millions of dollars in, and it's like that, and the public doesn't know who's behind it. Only a very few people are in on what the deal is. So it's gotten easier since President Bush, but not better.
Well, I think for some members, particularly in the House, if you're running for re-election and a third-party group comes in against you, you have to go out in the fundraising and spend even more time. I think that, at least as I understand, that's part of the concern I've heard over the years, just generally, is the time that each of you has to spend, and the members of the House have to spend.
So let me just continue on forward through this problem of funders. On the court, on the D.C. Circuit, and potentially on the Supreme Court, you will often see cases brought by groups like, for instance, the Pacific Legal Foundation. Are you familiar with that group?
Yeah, I've seen briefs by the Pacific Legal Foundation.
Do you know what they do?
I'll take your description.
Okay, my description is that they get money from right-wing, conservative, and corporate interests, and they look for cases around the country that they believe they can use to bring arguments before the court. I argued against them in the Supreme Court at one point. They came all the way across the country to the shores of Winnipesaukee Pond, Rhode Island, to hire a client whose case they could take to the Supreme Court with a purpose to make a point. And they're not alone in doing this. There are a number of similar groups who perform this service. And it causes me to think that sometimes the true party in interest is actually not the named party before the court, but rather the legal group that has hired the client and brought them to the court more or less as a prop in order to make arguments trying to direct the court in a particular direction. Is that an unreasonable concern for us to have about the process?
Senator, I think there are public interest litigation groups spanning the ideological spectrum that look for cases to weigh in on as amicus briefs, and there also, of course, there have been historically, you look for, as I understand it, people try to identify suitable plaintiffs to challenge, and this again is across the entire ideological spectrum.
What are the signals that that's gotten out of hand? that there's something rotten in Denmark?
That's an interesting question, Senator, and I think it's an important one, but it's not one that I think I have a great answer to.
Well, let me propose one thought to you, which is that the Supreme Court, at least, should fix its rules on who the amici are who turn up and require some disclosure of who's really behind them. The only thing the Supreme Court requires is to disclose who paid for the brief. The brief itself is not a very big expense. And so very powerful interests can come in behind an amicus group that has a lovely name like Citizens for Peace and Prosperity and Puppies, yes. And nobody knows who's really in interest. So that would be one thing that I think would be a concern. Another thing that would be a concern, I would think, would be when you see these special interest groups rushing out trying to lose cases in order to get before a friendly court. It really seems improbable as somebody who has actually tried cases and who's been around courtrooms a lot and who's seen a lot of litigation, a lot of great litigators. I have never seen anybody once try to lose a legitimate case. So in the wake of Justice Alito's signaling about what then became Friedrichs and Janus, to see these groups rush out and ask the court to rule against them so they can get hot foot up to the Supreme Court where they expect a good outcome, to me that there's just something that doesn't seem right about that. That seems to me a little bit like faux litigation, that there's something else going on other than real parties having real arguments and the Supreme Court ultimately settling properly prepared real disputes. Do you have any concern about the optics of people rushing to lose cases below to come before what they think is a friendly Supreme Court? Does that seem just a little bit odd?
I will acknowledge. I'll acknowledge, Senator, I'm not entirely familiar with that phenomenon. I would be interested in more.
I might follow up with you with a question for the record to get your more deliberate thoughts about it.
And on your amicus thought, I'm interested in the specifics of your proposal, and certainly, if confirmed, I would.
Because here's the concern. You know perfectly well that the court depends on, as much as anything, on its reputation. You don't have a purse and you don't have an army. Yeah. You stand on your reputation in the judiciary. And you must not only act justly, but be seen to act justly. And what I've laid out is a scenario in which very big special interests have a significant role in funding the group that I believe, and much reporting says, is responsible for getting you to the top of the greasy pole of nominee selection. Yeah. And that the same funders are behind the Judicial Crisis Network operation that is politically pushing for you. That the
Senator Whitehouse, we're going to add 1 minute to your time. You've been interrupted twice.
That some portion of the Supreme Court's docket is made up of strategic cases rather than real litigation in which somebody has gone out to find an appropriate plaintiff, hire the client, bring them in, and by the way, when they're done with them, they fire the client rather unceremoniously, in my experience. Mm-hmm. And then when the proper case comes up, you see this flood of special interest amici with terrible transparency into who is behind them. In one case, we tracked one of these big funding groups behind 11 different amicus briefs in the same Supreme Court case. So the whole amicus thing begins to have a really rank odor to it. And then at the end of the day, where things really start to go haywire, in my view, is when you go back to those 5-4 decisions that I talked about yesterday, which I think is the most heartbreaking thing that I experience in my political life. I used to argue in front of appellate courts. It was what I did. Not at your level, but I've been in front of the First Circuit a lot. I've been in front of the Supreme Court once. I've been in front of the Rhode Island Supreme Court more than I can remember. I kind of thought that I was a reasonably good appellate lawyer. And the idea that our Supreme Court is deciding as many as 80 cases under Justice Roberts on a pure partisan divide, I think that has a real signaling problem, and I hope that you'll at least consider that that's something that the court needs to cure rather than make worse in order to continue having its credibility. I think 80 cases in which all the Republicans go one way and can't bring a single Democrat appointee with them, that's a tough data point. And then when you look at that tough data point and you see that more than 90% of those cases, if you look behind at the outcome, it had a big, one of the interests that I mentioned that are very, very important to big special interests that were implicated. And then when you look at the win-loss rate in those cases, and it's 100%, 100% for this crowd of big special interests. And then here's where you come in at the end. This is the Roberts 5 majority in those 5-4 cases where these conservative groups have come in to make their pitch. They have won 92% of the time in those 5-4 cases. If you figure they're throwing a couple of long balls, you know, like Hail Marys, and maybe that's the 8%, that's a hell of a record. And then if you look at your record on the DC circuit where these conservative groups come in, you line right up. 91%, 92%. And I think when you put the whole saga together, from the big special interests lurking behind the Federalist Society, to the big special interest funding the Judicial Crisis Network, to the big special interest behind the Pacific Law Foundation and the Washington Law Foundation, and this little array of, I would say, strategic litigators who are funded by corporate interests and right-wing interests, and then these amici who we don't know who's behind them, and then you see this result. That's a tableau that is an alarming one, I think, for the court. And I would urge you to think hard about whether that's the direction you'd want to continue to go as an associate justice of that court. Because at some point, those numbers catch up with you. At some point, as I said yesterday, pattern is evidence of bias.
Senator, a couple thoughts. First, on the amicus briefs, at least in my experience, I pay attention to the quality of the arguments in the briefs, not the identity of the parties on them. But I take your point on the disclosure. I'd be interested in the specifics of anything you're talking about disclosure requirements for the Supreme Court. Two, I do believe deeply in the idea that we're a team of 9 and need to be working together. And I take the point, too, that it's very important, if I'm confirmed, that I work with as best I can, and I will, to maintain the confidence of all the American people and the independence and impartiality of the Supreme Court at all times. I am aware that we ultimately... I'm aware everything I do, if I were to be confirmed, would help affect that. How I decide, what I write in opinions, how I treat litigants at oral argument, where I speak, when I speak, where I teach, what I say on the outside, everything goes into how I behave, what I do in my volunteer time. Everything goes into the impressions of me as one part, if I'm confirmed, of the Supreme Court, and I take very seriously your broader point about maintaining confidence of all the American people in the integrity and impartiality and independence of the Supreme Court. So I appreciate that broader point.
Because right,
be a first for you. Your political hack will take
My-
away our health care and women's right to choose. Now pretending to be impartial.
my time has expired, Chairman. There will be a second round, correct?
There will be. I'm happy to give you an additional minute in light of the fact that you've had 2 additional interruptions, if you'd like.
Well, just to make a final point, actually, I think this is not an offshore storm. It has made landfall when you see polling that shows that 49% of Americans think a corporation will get a fairer shot in the United States Supreme Court than an individual. 7 times as many that think it's the other way. Now, you still have a few to work with who are undecided on that question. But the fact that about half of the American people already believe that corporations will be treated more fairly in the United States Supreme Court than human beings will, and the alignment of that with the facts that I have shown you about the Supreme Court's record of 80 partisan decisions, 92% involving big corporate special interests, and 100% win rate for them in those cases, I think we're at a tough place right now, and I think we really need to get back away from that. So thank you.
Thank you, Senator Whitehouse. Judge Kavanaugh, I want to get back to a couple of questions that my colleague, Senator Whitehouse, was asking you a minute ago. Just to be clear, did anyone from the Federalist Society contact you about the vacancy after Justice Kennedy made his announcement that he would be stepping down from the court?
No.
During the campaign of President Trump, as I recall, he came out with two different lists of possible Supreme Court nominees. The first list had 11 names on it. The second list, if I'm not mistaken, had 21 names on it, which included the previous 11. There were reports at the time that some outside groups had some involvement in that. Were you involved in the first list? Were you included in the first list?
I was not.
Were you included in the second list?
I was not.
Okay, so you were, you became under consideration only after President Trump took office, correct?
That's my understanding. That's when I became identified.
And after he was staffed up, after he had his own staff within the White House. Within the Supreme Court, is it the case that there is an aisle, much as there is in the United States Senate or the United States House of Representatives?
There's no aisle or separate caucus rooms in the Supreme Court, either literally or figuratively, in my view.
And under most circumstances, in most years, in the past decade or so, the number of cases that are decided on a 5-4 margin have been very low, less than 20% as far as I can count. Is that roughly consistent with your understanding?
That is.
Meaning that the configuration of 5-4 is much less common than basically all of the others. It is dwarfed in comparison to those cases that are decided either 9-0, which is often the biggest contingent, or 8-1, or 7-2, or 6-3. Now, even in those cases that are decided 5-4, does the fact that it was decided 5-4 make it any less of a legitimate decision? Does it make the judgment any less binding on the parties in that case?
No, it is still a decision of the court, no matter what the ultimate majority opinion is composed of.
And it would it behoove a lawyer who is an officer of the court to call into question the subjective motivations of a court simply because of the fact that the court decided a case on a 5-4 basis?
Well, if I were a lawyer arguing before the Supreme Court, I probably would refrain from questioning the motivations of the justices. I think each of the justices, I know them, they are all committed to the Constitution of the United States and impartially discharging their duties. Of course, have different perspectives on certain issues, but they're all, I think we're fortunate to have eight hardworking justices who have outstanding records and are committed to the Constitution and committed to the independence of the judiciary.
What about in the circuit court, in the D.C. Circuit where you have served? Would it be fair to suggest that a case is somehow less legitimately decided if that case were decided along the lines of which president appointed which member of the D.C. Circuit?
The precedent stands either way.
Thank you. I want to get back to a separation of powers point that has come up along various lines of questions asked by my colleagues today. Is the Constitution relegated to the judicial branch? Is it something that is to be upheld and interpreted only by those who wear black robes?
No, Senator. Let me take you through the process, I think. So Congress, of course, passes laws. And in considering laws, Congress will also often assess the possible constitutionality of the laws passed. So in the first instance, when you're considering the passage of a law, you might assess the First Amendment implications, or if it's a national security, the Fourth Amendment implications, and or the due process, Fifth Amendment implications.
And we've all taken our own oath to uphold the Constitution.
Right. So you do your best, and then the executive branch as well. They're constitutional, whether to sign the bill, for example, for the president, if the president has a constitutional concern or a policy concern, but the president could veto the bill for that reason. That has certainly happened historically. And then when it comes to the court, of course, we assess in cases or controversies the constitutionality of a law that is challenged there in the context of a specific case or controversy. We don't, President Washington, George Washington, asked the Supreme Court for an advisory opinion in his first term on a disputed legal issue. Actually, might have been his second term, but President George Washington asked for an opinion. The Supreme Court respectfully wrote back and said, we don't provide advisory opinions on, we only decide cases or controversies, thereby, I think, underscoring the point you're making with your question, which is constitutionality of laws is assessed in the first instance by Congress and the executive.
So it would not be inappropriate for us as members of the legislative branch to decide to protect something that we believe is constitutionally protected, regardless of where we might place our bets on what the courts would do with it. If we see a particular right that might be jeopardized by an act of Congress we are considering, wouldn't be inappropriate for us to say, look, we're not sure exactly how far the Supreme Court will go here. Out of an abundance of caution, out of respect for the Constitution, we're going to draw the line more carefully so that we make sure that we don't step into unconstitutional territory.
That has happened historically, and I think happens today. And that underscores how the Constitution tilts toward liberty in so many different ways. It tilts toward liberty because it's hard to pass a law, as you know, with both houses and the president. And then not only might there be policy objections, but members of Congress might say, well, even if the Supreme Court would uphold this law based on my assessment of the Supreme Court, I have a First Amendment objection, Fourth Amendment objection, Eighth Amendment cruel and unusual punishments clause objection, equal protection objection, and based on my view of the Constitution, I'm going to vote no on this law. That's another way in which the constitutional structure all fits together and tilts toward liberty.
For that very reason, it would probably lead to some bad results if we were to not do that. In other words, if we were always inclined to say, let's just pass this, if it's unconstitutional, the court will do something about it. Can you foresee instances in which that could create problems?
Yes, Senator. I think Justice Kennedy has written eloquently about this. Each official, each officer in Congress, each member of Congress, each senator, the president takes an oath, of course, a constitutional oath, to abide by the Constitution. And that's very important for each member to understand and underscore, as I know all of you do. And that is an important part of the separation of powers process. I don't think that the framers thought, well, let's pass something even though we ourselves, meaning the members of Congress, think there's a constitutional problem here. And that's not how it has worked historically, nor do I think that's how the framers necessarily intended for Congress to work.
And there are myriad instances, moreover, in which we might enact something that for one reason or another might not be challenged for a long time, or might be difficult to challenge due to justiciability issues, somebody lacking standing, absence of a ripe controversy, and so forth.
That particularly happens in the national security context, I think, Senator, because there's often not someone with standing, especially if it's something being done in a foreign country against foreign citizens that might be difficult to get into court in some way or another.
One of the reasons I focus on this today is that there was an exchange you had with one of my colleagues earlier today about the indefinite detention of American citizens apprehended on U.S. soil. There was some discussion surrounding this, suggesting that ex parte Curran might somehow justify this. You don't need to respond to this, but I think it's a point that needs to be mentioned. Justice Scalia mentioned in his dissent in Hamdi that ex parte Curran was not this court's finest hour. And in fact, what happened was the case was argued. It was decided the next day. The saboteurs were taken out and executed the next week. Then the opinion itself was issued many months later. So again, I'm not asking you to opine on the ongoing validity of ex parte Curran, but the point is you seem to agree that Congress certainly has the authority to protect liberty, notwithstanding the possibility that the Supreme Court might not step in a particular case.
Absolutely. A couple of points in response to that, Senator, if I might. Justice Scalia, of course, dissented in that case, joined by Justice Stevens. One of his more powerful dissents on individual liberty.
You will honor that corporation and its archaic worldview. You will not protect the Constitution. The American people have no faith in you, sir.
One of his more powerful dissents, protecting individual liberty, there ruling Justice Scalia with Justice Stevens that it was impermissible to hold an American citizen in long-term military detention. And I thought that was an important opinion of his. When I gave a talk once about Justice Scalia, I identified that as one of his most important opinions and a very powerful opinion. On the Kieran opinion itself, it also dealt with many who were not American citizens, but you're right, there's American citizen involved. The court, you're right, also, of course, you've studied this as much as anyone, but the court did resolve the case very quickly. In the opinion, I've spent many an hour trying to decipher certain paragraphs of that opinion for cases I've had. It's not easy. I will say the court, to its credit, give a little credit, did have an 8-hour or something oral argument. The Attorney General of the United States argued Kieran personally, and I've read the transcript of that to try to figure out what was going on in the opinion. That did not unlock the box completely for me on what was going on in the Kieran opinion. But your point, Justice Scalia did say was not the court's finest hour. It was a rush. And rushes, sometimes the court has to rush, but rush decisions in a judicial context sometimes aren't always the best.
On that point, would you be open to the idea of bringing back the era of the 8-hour oral argument? I mean,
yeah,
fun.
yeah. The 8-hour oral argument. We did have one in an in-bank case maybe 2 years ago that went all afternoon. After we got back to the conference room, I don't think anyone was saying we should do that in every case.
Understood. Let's talk about judicial philosophy for a minute. I'd like to discuss Federalist 78. In Federalist 78, Hamilton discusses the dichotomy between will on the one hand and judgment on the other. Will being something that is exercised by the political branches, primarily by the Congress, by the legislative branch, and judgment being something exercised by the judicial branch. What's the difference between those two?
The judicial branch is deciding cases or controversies according to law. The legislative branch is making the policy, exercising the will. The judicial branch can never exercise the policy-making role that is reserved to the Congress. Now, admittedly, that's speaking at a level of generality, and there are tough cases at the margins, always on trying to figure out what the line is here. But as a general proposition, it's important for every judge to go in with the mindset of, I'm not the policymaker, I'm the law interpreter, the law applier in a particular case. And I think that's a very important part of the Federalist Papers that's woven into the constitutional structure, into Article 3, and that judges, I certainly have tried for 12 years as a judge on the D.C. Circuit to incorporate that basic foundational principle into how I approach each case. And it is a very critical bedrock principle of what judges do in our constitutional system.
Now, within that framework, when we enact a law, what determines what it is that you have to interpret it, or that you have to interpret? Is it what we say, or is it what we subjectively intended?
It is what is written in the text of the statute. Senator, Justice Kagan said it well at a talk 2 years ago, maybe 3, at Harvard Law School. I was present in the audience. She said we're all textualists now. She was talking about Justice Scalia, who, of course, brought about significant change in the focus of all federal judges. I've seen it across the supposed philosophical spectrum. All federal judges pay very close attention to the text of the statute. And that's why I think Justice Kagan said we're all textualists now, because she explained that every judge really cares about the words that are passed by Congress. Now, why is that? I think about it both from a formal and a functionalist perspective. As a formal matter, the law passed by Congress is the binding law, as it is what is signed by the president. It's what's gone through the Senate and the House, and that is the law. But also as a practical or functional matter, I think having seen the legislative process, I know how compromises come together in the House and the Senate, within the House. There's negotiations late at night over precise words and compromises inevitably. Legislation is compromised. The Constitution was a compromise. Legislation is a compromise. And when we depart from the words that are specified in the text of the statute, we're potentially upsetting the compromise that you all carefully negotiated in the legislative negotiations that you might have had with each other. And so that's a danger that I try to point out when we're having oral argument in a case or we're deciding cases, that if we deviate from what Congress wrote, we're potentially upsetting this careful compromise, even if we think we would have struck the compromise in a different place as judges. That's not really our role. So I think both as a formal and functional matter, it's important to stick to the text. There are canons of interpretation which occasionally cause you a presumption of mens rea, presumption against extraterritoriality and the like, that cause you to superimpose a presumption on the text. But otherwise, sticking to what you passed is very important.
But you certainly consider yourself a textualist, and if you follow Justice Kagan's statement, we're all textualists now. That's what judging is.
Judging is paying attention to the text, in statutory cases, paying attention to the text of the statute, informed by those canons of construction such as presumption against extraterritoriality, presumption of mens rea, presumption against implied repeals, things like that are settled canons, although some of the canons are not so settled, which is a whole separate half hour of discussions.
How does textualism relate to or differ from originalism?
So originalism, as I see it, has, to my mind, means in essence constitutional textualism, meaning the original public meaning of the constitutional text. Now, the originalism, it's very careful when you talk about originalism to understand that people are hearing different things sometimes. So Justice Kagan, again, at her confirmation hearing, said we're all originalists now, which was her comment. By that, she meant the precise text of the Constitution matters, and by that, the original public meaning, of course, informed by history and tradition and precedent, those matter as well. There's a different conception that some people used to have of originalism, which was his original intent. In other words, what did some people
subjectively
intend the text to mean? And that has fallen out of the analysis because, for example, let's just take the 14th Amendment Equal Protection Clause. Well, it says right in the text, equal protection. Equal means equal. As the Supreme Court said in Strouder, what is that but the law shall be the same for the black and the white? That's Brown v. Board, focuses on the text. But there were some racist members of Congress involved in the red who didn't think it should apply in that way to certain least aspects of public life. But we don't, if you're paying attention to the text, you don't take account of those subjective intentions, and nor is it proper as a general proposition to take account of the subjective intentions. They can be evidence in certain cases, the First Amendment, for example, of the meaning of the words.
Of the original public meaning.
They can be of the original public meaning. They can be evidence of that, but you you don't follow the subjective intention. So the original public meaning, originalism, what I've referred to as constitutional textualism, what Senator Cruz yesterday, I think, referred to as constitutionalism or constitutionalist. I think those are all referring to the same things, which is the words of the Constitution matter. Of course, as I've said repeatedly, you also look at historical, the history, you look at the tradition. Federalist 37 tells us to look at the liquidation of the meeting by historical practice over time. And then you look at precedent, which is woven into Article 3, as I said in Federalist 78. But start with the words, as Justice Kagan said, we're all originalists now in that respect of paying at least some attention to, or more than some, paying attention to the words of the Constitution.
So if we stipulate for our purposes today, as we're having this conversation, that originalism refers to basically textualism applied in the constitutional sphere with an eye toward identifying the original public meaning of the constitutional text at issue, you're an originalist.
That's correct, and Justice Kagan, as Justice Kagan said, I think that's what she meant. We're all originalists now, and I think she said what she meant and meant what she said when she said that.
What, by the way, would be the argument against that? To me, that sounds like judging. What would one argue against being that type of judge, against being a textualist originalist?
Well, there are different philosophies of what a judge does, but I think the judges, what the role of a judge is. But I think the law, Article 6 of the Constitution says, this Constitution shall be the supreme law of the land. And the word law is very important there. It's not a set of aspirational principles. It's law that can be applied in court. And what is the law? The law are the words that were ratified by the people, and therefore can be applied in the courts of the United States. And it says the supreme law. What does it mean by that? It means when you pass a statute that is inconsistent with the Constitution, the supreme law controls, namely the Constitution controls over a contrary statute. And that's, of course, also discussed in Federalist 78 as well, of what's the supreme law of the land, and the Constitution's the supreme law. Again, precedent, historical practice subsequent to the passing of the text. We see that, for example, in Establishment Clause cases. The court will often look at the text, what's the historical practice, and precedent, which I've said is rooted in Article 3. Those things all go into it, but the words, the original public meaning, are an important part of constitutional interpretation, and has been, I think, throughout.
Let's suppose Congress, in its infinite wisdom, with its approval rating that ranges between 9 and 11%, making us slightly less popular than Raul Castro in America and slightly more popular than the influenza virus, which is rapidly gaining on us. What if we decided that, we're all busy, there are parades to attend, there are political rallies to organize, that we get tired of the busy, drudgerous work of actually making laws, and we also don't want to make ourselves accountable for the laws we pass. It's much easier to just pass a broader statement. So we say, we hereby pass a law that says we in the United States of America shall have good law, and we hereby delegate to the herewith created United States Commission on the Creation of Good Laws the power to promulgate and interpret and enforce good laws in the United States. What constitutional issues do you see there?
Senator, the Congress is, of course, assigned the legislative power in Article 1 of the Constitution. So if it delegates wholesale the constitutional power to another body, then that naturally poses a question of whether the body exercising that power ultimately has improperly exercised the legislative power, and whether that rule or what have you that is enacted by that body is lawful because it was not enacted by Congress. So the framers intended that Congress would enact the laws and that the executive would enforce the laws, and that the judiciary would, of course, resolve cases and controversies arising under those laws.
And yet, in some respects, it's not that far removed from some of what we do today. We may not pass something as extreme as what I've described in my hypothetical, but in some cases we will essentially say we shall have good law in area X, and we hereby give commission-wide the power to make and enforce good laws in that area. So is there some point at which we cross a threshold of unconstitutional delegation?
Well, the Supreme Court, as you know, Senator, has a non-delegation principle, and at least under current precedent, it has allowed the delegation, and I don't want to get too specific here, but it has allowed some delegation. Now, some justices or judges would say, actually, when the executive enacts rules pursuant to those delegations, that's the exercise of executive power, but I think there's been some pushback on that, and in any event, the Supreme Court has a doctrine on the non-delegation principle, and the line is debated on where that should be drawn, but there is precedent that does suggest that at some point, Congress can go too far in how much power it delegates to an executive or independent agency.
And when we do that, at some point, we're shirking our own responsibility because we're making lawmakers rather than laws. And we're also consolidating into one body the power to make and enforce laws, which is not only something that can lead to tyranny, it's the very definition of tyranny itself. I want to get to the campaign finance discussion that you were having a few minutes ago with Senator Whitehouse. With regard to Citizens United, didn't the Supreme Court uphold the disclosure requirements at issue in Citizens United?
It did. I believe that was an 8-to-1 margin.
And in fact, you've written on this, that there is a distinction for First Amendment purposes, for constitutional purposes, between laws mandating disclosure and laws banning the doing or the saying of something. Isn't that right?
That is what the Supreme Court has said in certain contexts, and that is the law as set forth by the Supreme Court. Citizens United is a good example of that, Senator.
And in a case called Emily's List versus FEC, you wrote that disclosure requirements trigger rights that receive, quote, less First Amendment protection, close quote, than speech prohibitions, other types of speech prohibitions.
And I think that followed from and is Supreme Court law and is consistent, I believe, with subsequent Supreme Court law. Of course, the subsequent Supreme Court law controls.
Okay. Do you have a favorite among the Federalist Papers?
I have
I'm not asking you to choose here between Eliza.
No, that's right. Yeah. Yes. So I like a lot of Federalist Papers. Federalist 78, of course, the independent judiciary, the role of the judiciary. Federalist 69, which says the presidency is not a monarchy, is very important when Hamilton explains all the ways in which the presidency is not a monarchy on our constitutional system. I think that's very important. Federalist 10, which talks about factions in America and explains that having the separation of powers and the federalism system dividing power in so many different ways would help prevent a faction from gaining control of all the power for the people of the United States. And that makes it frustrating at times because it's hard to pass new legislation, but that division of power helps protect individual liberty. I think that comes a bit from Federalist 10. Federalist 37 and 39 talk about, on the one hand, how we were just talking, laws that are the Constitution over time can be, the term, liquidated by historical practice. What does that mean? That means that as the branches fill out the meaning of the Constitution over time with practices, those can be relevant in how the court subsequently interprets certain provisions. We see that in Dames and Moore versus Regan, for example. We talk also about the national and federal government. So the combination in 39, the combination that we have, this odd, that's the genius, right, of having a national government plus state governments, and then within the national government, the House is proportional representation, the Senate is state representation. That interesting compromise, which Madison, by the way, was opposed to, but that compromise at the convention. Federalist 47, which Senator Klobuchar mentioned yesterday, the accumulation of all power in in one body is the very definition of tyranny. I start my separation of powers class every year with that exact quote that you read yesterday, Senator Klobuchar, because that's very important. 51, if men were angels, we wouldn't need government. So sorry, I've got like 8 kids.
It's brilliant, and I think that's a great greatest hits list. If these were on Spotify, I'd say you should put together a list of those. Let's close in the minute and a half I've got left. I gave myself an additional 30 seconds because of the 2 interruptions there. Tell me how you were informed by Federalist 51 and how that relates to your role as a jurist. Your role as a jurist now on the D.C. Circuit, the role that you would play if you were confirmed to the United States Supreme Court. This understanding that government is an exercise in understanding human nature. If we were angels, we wouldn't need government. And if we had access to angels to govern over us, we wouldn't need all these rules, these cumbersome rules that make government so inefficient and so frustrating. Why is that important, and how does that affect you as a judge when trying to interpret the Constitution and trying to interpret acts taken pursuant thereto?
That's an interesting question, Senator. I think we recognize that we're all imperfect. First of all of us as humans are imperfect, and that includes judges, and that includes legislators, and includes all of us are imperfect. And so we recognize that in how we go about setting up our government. If there were some perfect group of people, we'd put all the power in that one body. But because we're imperfect, putting all the power in that one body would be, as Senator Klobuchar was saying, the definition of tyranny. So I think the way we deal with the imperfection while also having a government, because we're imperfect, is dividing the power, separating the power. And that, again, to my mind, that all reinforces why the framers, the genius, despite the flaws in the Constitution, and there were flaws, the genius of separating the legislative, executive, and judicial powers, tilting toward liberty in all those respects, and then having a federalism system where we still have state governments that can further protect liberty and be laboratories of democracy as well. I think all that is because we're imperfect and because we recognize the imperfections. It's also why we have things like a jury system. And even within the judiciary, we didn't trust a judge to do trials on his or her own criminal trials, or civil trials. We have a jury system to recognize, and we have usually 12, and that is designed to recognize that we're imperfect, and sometimes that's why we have group decision making. That's why we have 535 legislators. That's why we have 9 justices. We don't usually have one person, and so too in juries. So I think that all maybe stems from the same philosophical understanding that we're imperfect beings and that we divide power and that we make sure that no one person in a jury situation or other situations where our liberty can be affected is exercising total control.
Great. Thank you very much, Judge. My time has expired. I am not the chairman of this committee, even though I'm playing him on TV. I understand that under the previous order entered before he left, we're supposed to take a 10-minute break. We will stand in recess for 10 minutes.
Brief break here in the Senate Judiciary Committee. So we'll stay with you for the next 10 minutes and go back to the hearing live. You're watching our Washington Post coverage. I'm Libby Casey. Let's start off by just taking a look at some of the highlights that we've seen so far today. We'll go to that in just a moment as we watch senators filter out of the hearing room. Judge Kavanaugh has already left his seat. Let's check out those highlights now. Day 2 of the confirmation hearings of Brett Kavanaugh.
Under our system of government, the executive branch is subject to the law, subject to the court system. I think the first quality of a good judge in our constitutional system is independence. It's constitutionally dictated to pay attention and pay heed to the rules of precedent. I fully understand the gang violence, gun violence, drug violence that has plagued various cities. But as a judge, my job, as I saw it, was to follow the Second Amendment opinion of the Supreme Court, whether I agreed with it or disagreed with it.
Do you agree with Justice O'Connor that a woman's right to control her reproductive life impacts her ability to quote, participate equally in the economic and social life.
And I understand the importance of the precedent set forth in Roe v. Wade. Planned Parenthood versus Casey reaffirmed Roe and did so by considering the stare decisis factors. So Casey now becomes a precedent on precedent. I have repeatedly called U.S. v. Nixon one of the 4 greatest moments in Supreme Court history. It was one of the greatest moments because of the political pressures of the time. The court stood up for judicial independence in a moment of national crisis.
Can a sitting president be required to respond to a subpoena?
So that's a hypothetical question. I can't give you an answer on that hypothetical question.
In fact, you have said that, and I quote, "If the president were the sole subject of a criminal investigation, I would say no one should be investigating that at all." What did you mean by that?
There were ideas for Congress to consider. They were not my constitutional views.
What assurances can you provide that you will not allow the president's personal views on a case or personal interest to impact your decision?
Senator, I'm an independent judge. For 12 years, I've been deciding cases based on the law and the precedent in each case. If confirmed to the Supreme Court, that's how I'll do it. No woman should be subjected to sexual harassment in the workplace, ever, including in the judiciary, especially in the judiciary. This is part of a much larger national problem.
You said everyone agrees the pardon power gives the president absolute, unfettered, unchecked power to pardon every violator of every federal law. Could a president issue a pardon in exchange for a bribe? Yes or no?
Senator, I think that question has been litigated.
President Trump claims he has an absolute right to pardon himself, does he?
Senator, I'm not going to answer hypothetical questions.
If there was such a action by a state or a local government challenging Roe and it came before the Supreme Court, would you listen to both sides?
I listen to both sides in every case, Senator.
If you said at this moment, I don't want to have a cloud over this nomination, I'm prepared to suggest to the committee and ask the committee humbly, please withhold further hearings until you disclose everything. Why won't you do that?
Senator, I do not believe that's consistent with what prior nominees have done.
We don't care what the nominee thinks. We've got to follow the Presidential Records Act.
Following the Presidential Records Act involves the National Archives. And the National Archives have stated publicly that the way we are handling the records for this nomination are unprecedented, and they've had nothing to do with it.
Highlights from day 2 of Judge Kavanaugh's confirmation hearing to become the next justice on the Supreme Court. I'm Libby Casey, and I'm joined here by Michael Kranish, national political investigative reporter. Thank you for being here.
Thanks for having me.
Okay, you have been digging into Judge Kavanaugh's history, what he's written, also what he's decided on the bench. Are we learning more today as Democrats finally get a chance to ask him questions? Are you hearing anything different from what he's himself written and put on the record?
Well, you know, I have a sense of deja vu listening to today's hearing. This is the 3rd confirmation hearing that Kavanaugh's gone through. The first was in 2004. Democrats for 3 years stalled his nomination. Finally, in 2006, there was another hearing at which he was confirmed. But a lot of what I'm hearing today actually is reminiscent of what came up at those first 2 hearings. For example, there was a lot of discussion today about a staffer on the Senate committee who had hacked some Democratic emails. Well, the same senators who were there in 2004 asking Kavanaugh about this are on the committee today asking him about this. Now, they maintain that there's information that they still don't know about this, but for one of the stories I did for the Post a couple weeks ago, I listened to that 2004 hearing, and I'm hearing a lot of echoes of that today. You mentioned that Democrats were able to stall his name from going forward. They were able to get a couple years there of a delay.
we're not seeing any prospect of that this time.
No, you know, it's interesting. Back then, Democrats did not, they had a rule that basically said you need 60 votes to break a filibuster. So Democrats were able to use that. Today, that rule is no longer there for a Supreme Court nominee. So Republicans only need 51 votes, which is exactly what they have. And they may have more. They may get some Democratic votes here and so forth, but they have 51 seats in the Senate. So this hearing starts with the presumption that Kavanaugh will be confirmed because they already have the majority. We've heard no Republicans say that he or she would vote against him.
You know, one thing that has come to light in this process is his record on executive power. This was already a focus and already of great interest to Democrats as well as others because of his role in the Ken Starr investigation, because of what he subsequently wrote, especially after spending time within the White House as part of the George W. Bush team. But now it's of special interest, Michael, because of President Trump's own legal peril. Are we learning anything about how this potential Supreme Court justice would rule if the president was subpoenaed, if a question came before the court about where the presidential limits are in terms of legal protections?
Right. Well, this has been one of the most interesting issues from the first day when Kavanaugh's name was nominated to be a Supreme Court justice by President Trump. Kavanaugh, as it turns out, was for 5 years or so a top assistant to Ken Starr, the independent counsel who investigated Bill Clinton. Kavanaugh helped lead the investigation into the death of former associate White House counsel Vincent Foster. Interestingly, Kavanaugh himself later became an associate White House counsel. And then he worked on the Monica Lewinsky investigation. And during that time, Kavanaugh was very aggressive in wanting to go after Clinton. As we reported a couple weeks ago, he proposed 10 questions that should be asked President Clinton about his relationship with Monica Lewinsky. And they were very graphic, sexually graphic questions about things that Lewinsky allegedly did with President Clinton. Then he worked for President George W. Bush. And during that time, he was associate counsel, he was staff secretary, and he says he sort of had an epiphany. He saw how busy a president is, and he said, you know what, it's probably better if a sitting president isn't investigated the way he helped investigate President Clinton. Well, you can imagine Democrats' reaction to that. You're saying, oh, it's great to go after President Clinton, but not after, you know, a president later. And of course now, if he's confirmed, he could sit on the Supreme Court in a case that could involve whether President Trump, whose campaign is under investigation for possibly colluding with Russia, questions of whether Trump should be subpoenaed, have to turn over certain documents, sit for an interview, and so forth. So it's all come back around, and there were questions today about Kavanaugh's view on executive privilege and what might happen, in fact, if he does have to deal with questions about Trump.
When he was talking about an article he wrote in the Minnesota Law Review back in 2009, I believe, he was like, I was just spitballing. I was basically giving suggestions to you, the senators, as to how you could change the law and how you could do everything from create a tighter timeline on getting judges to the bench or not. And then, you know, take care of some of the concerns that a president shouldn't have to worry about if the president is potentially facing legal peril and needs to focus on the job of the country. So did you get the sense from him that he was able to separate out what he would propose if he were a lawmaker versus what he would decide as a Supreme Court justice?
Well, he was clearly suggesting to Congress that they adopt this point of view. He didn't just throw it out there and say, here's an idea. He was saying these investigations are very distracting, presidents are very busy, a sitting president shouldn't be subject to civil suits. And you remember that a civil suit is what got President Clinton in trouble. He under oath talked about not having a relationship with Monica Lewinsky, and then that came back later was used against him. So civil suits are very important in the Clinton investigation. He's saying they shouldn't be, presidents shouldn't have to deal with them while in office. And then also criminal investigations. Well, that could potentially take the Starr investigation out of the picture. So it's all, you know, very relevant. Today he was asked before the Senate Judiciary Committee, what can a president be subpoenaed? He said, I don't want to talk about a hypothetical. So it didn't answer the question directly.
That wasn't a surprise because we knew it would be very hard to pin him down on anything. But that to me seems the least hypothetical because I would assume that Democrats could argue based on legal precedent that's already happened, can a sitting president be subpoenaed?
Well, the reason this came up is because there had been an article in which Kavanaugh had been quoted at a seminar talking about the case U.S. versus Nixon. This, of course, is the famous case in which the U.S. Supreme Court unanimously said Nixon had to turn over the White House tapes, which eventually led to his resignation. So a landmark case. And Kavanaugh in the story said it might be heresy to say so, I'm paraphrasing, but perhaps Nixon was wrongly decided, and we don't know if that was sort of a theoretical discussion, but he said he went through this whole reason why perhaps it was wrong. So of course, members of the committee today wanted to know, what did you mean by that? He said, oh, that was taken out of context, quote unquote. And then he said the Nixon case was one of the 4 most important cases decided by the Supreme Court. So he seems to agree with the case. But it was correctly reported that he did say, it might be here to say so, perhaps it was wrongly decided. In that prior statement, he didn't say it was wrongly decided. And if you've listened to legal panels, it's not shocking that someone might put forward a hypothetical. Maybe that's what he was doing. In the article that described it, that wasn't clear, so it was correctly reported. But he apparently is arguing that's not how he actually felt about the case.
He talked about 4 different cases that he finds to be the most important or most significant. Does the phrase, this is the most important case, mean that he totally agrees with it? Or is it just that it was important and shaped judicial history?
Right. I mean, that's the question I have when I heard him say that. He did seem to say that he agreed with that case. The way I understood his answer was that he agreed. So he's saying, when he was quoted, maybe Nixon's wrongly decided, he's saying that was out of context, and he goes on to say, you know, this is one of the great cases ever, and he was asked, do you agree with it? And he essentially seemed to say that's the case. I was hoping that another senator would just basically get up and say, yes or no, do you agree with Nixon or not? So there'd be no question whatsoever.
We are not even halfway through the senators getting to ask their questions, and it goes into 2 rounds, 30 minutes for the first round, 20 minutes for the second round. Looks like Amy Klobuchar is speaking, so let's go back to the hearing room.
4th wedding anniversary, is that correct? Yeah, well, that's what she told me. I thought this was very romantic that you're gathered here. So I want to start, Judge Kavanaugh, going back to where we started yesterday, and that is about the documents and the production of documents from the time that you worked in the White House. Do you personally have any objections to the release of the documents from your time as staff secretary?
Senator, I'm not going to take a position. That's, in my view, a decision for the committee in consultation or discussion with the executive branch and the...
So you're not going to say whether or not you have a problem with it?
I don't think it's my role to say one way or another, at least as I analyze the current situation. That's a decision for the committee and the executive branch and the presidential library, the President Bush's documents ultimately.
Since right now we're not able to review those documents, in addition to the 102,000 that the White House has deemed theirs that we're not able to see and asserted a privilege that's never happened before in a Supreme Court nomination hearing. Is there anything in those documents or in the staff secretary documents that you think we'd like to know that's relevant to some of the topics we've discussed today? I mean, you must know what's in them.
Before you answer without taking time off of her time, it's incorrect that committee confidential, no senators can see those records. All 100 senators can see those records. In fact, we set up separate terminals so people can go there. We haven't had very many people take us up on the offer.
Okay, but Mr. Chairman, not to go into my time either, to respond to you, I wasn't talking about those 189,000 documents. I was talking about the ones that we're not allowed to see at all from the staff secretary time, as well as the 102,000 that the White House has asserted privilege on that we're not able to see. So I'm not even talking about the 189,000. Okay,
I stand
thank you.
corrected.
All right. So again, I asked if there's anything in those documents you think would be relevant to our discussion here.
Senator, those documents are President Bush's documents, and for the committee and the Bush Library and the executive branch to negotiate about. And as was discussed, I have 12 years of judicial record, and this is not a new issue. This is an issue that came up in Justice Scalia's hearing and Chief Justice Roberts' experience with the SG documents with Justice Kagan.
Those are Solicitor General for the viewers out there, but I'm talking about the ones in the White House. time.
Well, I guess I'm not seeing a distinction. They're both executive branch documents, so there's one executive branch.
I think one is involving the ongoing Solicitor General, but I have just one more question on this line. You've just said that rush decisions aren't always the best in answer to the discussion with Senator Lee. And you think a good judge would grant a continuance to someone who just received 42,000 documents on the day before the start of a trial?
Sarah, I'm not, that's a decision for the committee, and I'm not familiar with the circumstances of the document. On the Solicitor General documents, I just want to say one thing. With Chief Justice Roberts, it was not active cases. That was 4 years of his documents from the time he was Solicitor General. From 1989 to 1993. He's nominated in 2005. It's my understanding that those documents, so that my only point is it's not a new issue, but it's also not for the nominee to decide because they're the president's, former president's documents.
Okay. Why don't we move on to the executive power issues? And yesterday I mentioned your submission to the University of Minnesota Law Review. We thank you for making our law review so famous over the last month or so. In that article, you said that a president should not be subject to investigations while in office. You said in our meeting that Congress would likely act quickly if the president does something, in your words, dastardly, a word you also used in the article, and I'm struggling with the practical implications of that. What about a president who commits murder, or if she jeopardizes national security, or if he obstructs an investigation or a white-collar crime? How do you differentiate between these crimes when you characterize them as dastardly?
So I think there's several issues going on in that question, Senator. The first thing I want to underscore is that what I wrote in the Minnesota Law Review was in 2009, when President Obama was president, or becoming president, was thoughts on a variety of topics reflecting on my experience.
I just want to pick up the tempo a little with my questions because I have so many of them. Could we get to that point about the dastardly, if there's a way to differentiate?
Yes, but just to underscore, it's real important. That was a proposal for to be considered. It was not a constitutional position. I did not take any constitutional position on the issues you're raising. I want to underscore that. And if a constitutional question came to me, I would have an open mind and decide that. On your point,
but there isn't any clear text in the Constitution that speaks to the question. So instead, these are your own recommendations based on your own views and experience. Would that be a fair characterization?
But there are two different things going on. The one is about special counsel investigations, for example, or criminal investigations, or civil lawsuits. And that's a question for Congress to consider whether they want to supplement the protection provided by Clinton versus Jones, because there was a lot of criticism of Clinton versus Jones. The second question, getting right to your point, is what is an impeachable offense? And that's actually a decision for you, not for me. And because the House and the Senate.
But I'm just figuring out whether we know something is dastardly or not if we can't even investigate it.
Well, I think I'm going to repeat. That's a question for you're asking for. Is it a high crime or misdemeanor?
I'm asking about your position that you stated in this law review article that a president should be not subject to investigations while in office.
But the dastardly comment.
Are you you're only saying that they should be subject to investigation as part of an impeachment, and that there's no other investigation that could occur? Is that
no, I was first of all on constitutional position on criminal investigation and prosecution. I did not take a position on the constitutionality, period. On the idea that I talked about was something for Congress to look at if it wanted. So that's point one. The point two is the idea that what is an impeachable offense, and that really is a question for the House and the Senate.
Let me move on. This is about actual opinions, and really along the same lines. And I know Senator Coons is going to talk to you about the special counsel statute, and we're very concerned about that. But in the Seven Sky v. Holder case, I quote, this is you, under the Constitution, the president may decline to enforce a statute that regulates private individuals when the president deems the statute unconstitutional, even if a court has held or would hold the statute constitutional. And so then you told me when we had the talk in my office that you attempted to clarify your views 2 years later in the Aiken County case. But it seems inconsistent to me. So is it the case, your views, as expressed in actual opinions, not law review articles, that a president can just ignore a law until a court upholds it, like you said in Aiken County, or that a president can continue to ignore a law even after a court upholds it, like you said in Seven Sky?
So ignore is not the concept there, as I think we discussed when we met, and we had a good back and forth on that, was the concept's prosecutorial discretion. And that's the concept I referred to in the Aiken County opinion to explain the footnote you're referencing. Excuse me. And prosecutorial discretion is, of course, firmly rooted. United States versus Richard Nixon case says the executive branch has the absolute exclusive authority and absolute discretion whether to prosecute a case. That's an exact quote from United States versus Richard Nixon. And then Heckler versus Cheney says that that applies also in the civil context. And the limits, so prosecutorial discretion is well recognized. In other words, the U.S. Attorney's Office might prosecute gang violence but let low-level marijuana offenses go in terms of an exercise of prosecutorial discretion.
So if a court has held a statute constitutional, do you believe that a president should have to enforce it?
So, for example, let's talk about, for example, the marijuana laws. Those are constitutional, but a U.S. attorney or the attorney general could say we're not going to devote our resources to low-level marijuana offense. Those are perfectly constitutional.
Let me just try one other example with you. The Texas case on pre-existing conditions. The administration has taken the position that that is unconstitutional, that part of the Affordable Care Act down in the Texas case, taking the position that you could actually throw people off of their insurance if they have a pre-existing condition. So let's say that law is found to be constitutional. Could the president choose not to implement the part of the law providing protections for pre-existing conditions?
Senator, that's a pending case, so I cannot talk about it.
Okay. This is just my concern because of this expansive view of executive power, where it brings us and where we end up. I want to move on to some consumer issues. In 2016, you wrote an opinion, which was later overturned by the full D.C. Circuit, in which you found the Consumer Financial Protection Bureau unconstitutional. The majority recognized that millions of people were devastated by the financial crisis, and they upheld this bureau. And we know now in real time the Bureau has helped about 30 million consumers obtain more than $12 billion in relief. But you dissented in the case. And I want to talk about the consequences of this legally. I know you focused on the Bureau structure. We talked about that. You looked at the relevant history. And you said that agencies like the CFPB, the Consumer Financial Protection Bureau, amount to a headless fourth branch of our government, and that they, quote, pose a significant threat to individual liberty, end quote. So does it follow that you think that other independent agencies are also constitutionally suspect?
So the Supreme Court has, of course, upheld since 1935 Humphrey's executive decision the concept and practice of independent agencies. And on the CFPB decision, the structure of that agency deviated from the traditional historical practice of independent agencies.
Do you think the Humphreys case that was 80 years ago was correctly decided?
It's a precedent of the Supreme Court, and it's been reaffirmed many times. But on that CFPB case, I need to get this out, which is I did not say that the agency had to stop operating. It could continue operating, and it still operates. What my constitutional concern was the structure with the single member head, which had never been done before for an independent agency of that kind. And my remedy would not have been to invalidate the agency at all, but would have been to make that person removable at will. And then you could have, if you wanted, amended the statute to have a multi-member agency.
It also, concerns me because other agencies, like, say, the Social Security Administration, which you note in the dissent, in the opinion, they are also just headed up by one person, right? Well, so then does it follow that agency as well would be unconstitutional?
Again, Senator, my let's go from the back door, which is the remedy, if there's a problem, is not that the agency has to stop operating. The remedy is that the person, a single person, would be removable at will instead of for cause. But the agency would continue to operate in performance and
But wouldn't have anyone heading it up.
No, it would have a single person heading it up, but removable at will in the case of the CFPB. So the agency.
And I would like to. I want to turn to what the majority felt about your dissent, and I think they recognized that the dissent would threaten many, if not all, independent agencies. I think they specifically mentioned the FTC, and I would add other ones like the Federal Reserve, Securities and Exchange Commission. Does it follow that you think these agencies are unconstitutional?
No, I didn't say anything remotely like that, respectfully, Senator. In the case, all I was talking about was a single-headed independent agency.
But that's like Social Security.
But the SEC, the FTC, those are the traditional, the FERC, the NLRB, are all the Fed, multi-member independent agencies. And so those agencies are all the traditional Humphreys executor agencies. And the concern I explained with the single director independent agency goes back to your point about Federalist 47. Which is if you have an independent agency that is completely unaccountable to Congress or the president, and it's one person in charge, that becomes an extremely powerful position.
Okay, but Social Security has been like that for a long time. And so my issue is when we were talking about executive power, you talked about how Congress has to step in, right? That's a lot of the argument you've made to some of my colleagues. Senator Sass's argument, Congress has to step in. But in this case, Congress stepped in. Congress said we had this major financial crisis. That's why we started this agency. We have done this. And then you come in in a minority opinion here, and you say that it's unconstitutional. And I would throw another Federalist Society back at you. Federalist quote. You quoted Hamilton yesterday, right?
Yes.
Okay.
I
All right.
agree with
So it just doesn't make common sense to me that we would throw an agency out like that, or
but I
even
didn't.
the head of it. You're basically putting your judgment in the place of Congress.
But I didn't throw the agency out. I said the agency could continue operating as it was. The only change would be instead of being for cause removal, it would be at will removal. That was the only change. There was a judge, not me, on our court who said because of that constitutional flaw, the whole agency had to stop operating. I specifically and explicitly rejected that as a remedy and said, no, the agency can continue operating and doing its important consumer functions.
Let's go to one where you actually did throw out the rules, and that's net neutrality, right?
Mm-hmm.
And that is, in my mind, a bedrock of a free and open internet, allowing consumers and small businesses to have an equal playing field. But in U.S. Telecom Association v. FCC, in your own opinion, you went out of your way to dissent against the protections. This was the full D.C. court against you, and the rules were upheld by a panel of judges appointed by presidents from both parties. And here you relied on something else that you came up with called the Major Rules Doctrine. And I know it's been mentioned in dicta in a 2015 case, but in claiming that the FCC lacked authority to issue net neutrality rules because they were, in your words, major. So again, it feels to me like Congress set up the FCC, and the FCC is doing their job in a really complex policy matter. They put forward these rules on net neutrality, and you insert your judgment to say that they're unconstitutional. So tell me why I'm wrong.
The Major Rules Doctrine or Major Questions Doctrine is rooted in Supreme Court precedent, and therefore, as a lower court judge, I was bound to apply it. It was applied by the majority opinion in the Brown and Williamson decision. It's in the godfather of the Major Rules or Major Questions Doctrine is Justice Breyer, who wrote about it in the 1980s as a way to apply Chevron. The Supreme Court adopted that in the Brown and Williamson case, applied it in the UARG case, the one you referenced, Justice Scalia's opinion. And what that opinion says is it's okay for Congress to delegate various matters to the executive agencies to do rules, but on major questions of major economic or social significance, we expect Congress to speak clearly before such a delegation, and that's had not happened, in my view, with respect to net neutrality, and I felt bound by precedent, therefore, to apply the major questions.
So minor rules would be okay, but not major. And I know in the decision you say, well, you'll know the difference when you see it. And I think that's why the other judges on the court, appointed by both parties, went with the traditional and precedential view of how to look at this. And you used the 1986 law review article by, albeit, Justice Breyer, and then dicta from the King v. Burwell case in 2015. And it just, what I'm trying to show here is this pattern where it's to say, oh, Congress should step in and do everything. You're stepping in these cases.
So I would say it's a pattern of adhering to precedent.
Okay. Well, it seems that the precedent to me, when you look at, for instance, Chevron, and I know the White House touted the fact that you've overruled the federal agency actions 75 times. And they said that you led the effort to rein in executive agencies in the press release when you were announced. How do you explain? What did that mean, how you led the effort?
I don't know. I don't know what that's referring to. I know my record. I'm sure I've upheld agency decisions dozens and dozens and dozens and dozens of times. That we get agency cases. That's what we do on the D.C. Circuit, and I've upheld them. I'm sure in the same range, if not many more times. And so, and on the, and so I think my record will show that I've ruled both ways on those kinds of cases. I don't think I have a pro this or pro that record.
One last question in this area on consumer. So the major rules doctrine actually raises questions to me about your view of Chevron. And as you know, it's that 1984 case. I would think it's settled law, but I'll ask you that, where courts generally defer to reasonable interpretations of agencies. And what would you replace it with if you're not going to uphold it?
The precedent says that courts should defer to reasonable agency interpretations of ambiguous statutes. And the whole question of ambiguity has become a difficult inquiry, at least it has been in my 12 years of experience for the D.C. Circuit. How much ambiguity is enough? And I wrote a law review article in the Harvard Law Review about that problem of judges disagreeing about ambiguity and how much is enough. But I also said in that article that Chevron serves good purposes in cases where it's somewhat of an overlap with the State Farm Doctrine. So statutory terms like feasible or reasonable are terms of discretion that are granted to agencies, and that courts should be careful not to unduly second-guess agencies. And I've written an opinion, American Radio Relay League, where I made clear that courts shouldn't be unduly second-guessing agencies.
Okay, I want to move to campaign finance. Those were the documents that I received and were able to make public. Of course, I think they all should be made public, the ones that and I don't like this committee classification, what happened, but the chairman did allow me to make those public. And in those documents, in one email from March 2002, you discuss limits on contributions to candidates, saying, and I have heard very few people say that the limits on contributions to candidates are unconstitutional, although I, for one, tend to think those limits have some constitutional problems. I just want to know, with the Buckley v. Vallejo case from '76 being settled law, it seems like you have some issues with those rulings. How do you view the precedent created by Buckley, and would you respect it?
The Buckley divide, as you know, Senator, is that expenditures on the one side, Congress does not have substantial authority to regulate. Contribution limits on the other side, Congress does have authority to regulate and has done so. With respect to contribution limits, however, there are cases where the contribution limits are too low. So subsequent to the email you're talking about, the Supreme Court has twice struck down contribution limits, one in the case Randall versus Sorrell.
Now I'm aware of these cases.
Justice Breyer wrote.
Mm-hmm.
So I don't think there's, Buckley versus Vallejo is an important precedent. There's a lot of case law subsequent to those emails. McConnell, Wisconsin Right to Life, Citizens United, which fleshes out some of those
I mean, my issue is that we've had past nominees who said they would honor precedent, and then they joined the Citizens United opinion. And when I was hearing your discussion with Senator Whitehouse, in which you talked about how Congress should step in again, and they did with the McCain-Feingold bill, and we tried, and then it was struck down basically with Citizens United. And so that is the problem. We are left with nothing now but a constitutional amendment. And I personally view this as was a, lawmaking from the court, the Citizens United case. And so I'm trying to figure out where you are on this. Do you think contribution limits have constitutional problems, and what can Congress actually do to rein in the flood of money?
As a D.C. Circuit Judge, I've upheld contribution limits in 2 important cases. One, ruling against the RNC in RNC versus FEC, where it was challenging limits on contributions to political parties, and I rejected that challenge. And another, Blumen versus FEC, contributions by foreign citizens to U.S. election campaigns, and I upheld that law.
Let's just talk about that case, because your opinion left open the possibility of unlimited spending by foreign nationals in the United States on issue advocacy. The same kind of activity that we saw by the Russians in 2016. And in fact, a Russian company facing charges brought by Special Counsel Mueller actually cited your opinion in arguing to have these charges thrown out. Does that concern you at all?
Our case dealt with contribution limits, so that's what I was opining on in that case. So I'm not sure that there are, the state of the law on the expenditure limits was not before us in that case, and so I don't want to opine on expenditure limits.
Well,
what I
you
did
should
do,
know that it was, that opinion was cited by.
well, I don't know if it was cited. Well, I don't want to
Well,
talk.
I
I don't
need
want
to
to
have
talk
the
about a
charges
pending.
on it.
I don't want to talk about
All
a
right.
pending case, but my case, I upheld. Importantly, I upheld limits on contributions in the RNC case and in the Blumen case, and the Supreme Court has upheld contribution limits generally, but struck them down when they're too low in cases like Randall versus Sorrell and McCutcheon.
Okay. In light of the recent indictments, do you stand by your interpretation of the Bipartisan Campaign Reform Act in this case, in that case, the Blumen case?
I'm not sure the question
We can
there.
go back to it on the second round.
Okay.
Forward to it. Okay, antitrust. Senator Lee and I run the antitrust subcommittee, and as you know, in recent years, we talked about this in my office, the Supreme Court has made it harder to enforce our antitrust laws in cases like Trinco, Twombly, Legion, and most recently, Ohio v. American Express. This could not be happening, to my view, at a more troubling time. We're experiencing a wave of industry consolidation. Annual merger filings increased by more than 50% between 2010 and 2016. I'm concerned that the court, the Roberts Court, is going down the wrong path, and your major antitrust opinions would have rejected challenges to mergers that majorities found to be anti-competitive. So I'm afraid you're going to move it even further down that path, starting with the 2008 Whole Foods case, where Whole Foods attempted to buy Wild Oats Market. It's very complicated, so I'm just going to go to the guts of it from my opinion. The majority of courts what happened here is Republican majority FTC challenges the deal, and then you dissent. And you apply your own pricing test to the merger. My simple question is, where did you get this pricing test?
Well, I would have affirmed the decision by the district judge in that case, which allowed the merger, and the district judge, Judge Friedman, appointee of President Clinton's to the district court, and I was following his analysis of the merger. And that case is very, as I think we discussed, very fact-specific, really turns on whether the larger supermarkets sell organic foods or not, and so that was a fact.
But where did you get the pricing test is what I want to know, because you used a different test, and I'm trying to figure that out, what legal authority actually requires the government to satisfy your standard to block a merger. I think what I remember in our discussion, you cited these non-binding horizontal merger guidelines that you used to come up with this test.
Well, you're looking at the effect on competition, and what the Supreme Court has told us, at least from the late 1970s, is to look at the effect on consumers and what's the effect on the prices for consumers. And the theory of the district court, and Judge Friedman in this case, was that the merger would not cause an increase in prices because they were competing in a broader market that included larger supermarkets that also sold organic food. The question was really, is there an organic food market solely, or is there a broader supermarket market? And that's what the case.
I was just trying to get to where that new test came from. So in the second case, you also dissented in the Anthem case last year, and your opinion would have allowed a merger between two of the four nationwide health insurance providers, which was eventually blocked because it would lead to higher prices for health care in the long term and what was viewed as poor quality insurance. And here you actually went a step farther than Whole Foods. Instead of just trying to raise the bar on what the government would have to prove to block a merger, you also tried to lower the bar for merging companies trying to justify their deals. And your opinion suggests you would lower the bar for merging companies that are trying to prove their deals will not harm competition. Does that represent your views when it comes to mergers?
It's a very fact-specific case, and the market in question there were two health insurers that were not selling health insurance in the downstream market, but were acting as purchasing agents for employers in the upstream market where they negotiated prices with hospitals and doctors. And so the theory of, at least as I understood it, which I agreed with, was that by having a stronger purchasing agent, they would be able to negotiate lower prices from hospitals and doctors for the employers. And I pointed out at the end of my dissent, Senator, that there might be a problem in the upstream hospital doctor market, but I did not think there was a problem in the market that was at issue in the case. And I specifically said I would have sent it back to the district court for analysis of whether the merger was a problem in that other. So But
you did suggest that the court should disregard two cases that have been widely relied on for more than 50 years in antitrust, Brown Shoe and Philadelphia National Bank. Do you think courts now applying these cases are wrong to do so?
I think the Supreme Court in the 1970s moved away from the analysis in those cases because those cases focused on the effect on competition. On competitors, not competition. And in the 1970s, the Supreme Court moved to focus on the effect on competition, which in turn is really consumers. What will be the effect on consumers?
Okay.
Senator Cruz.
Thank you. And could I just, one sentence here?
Yes,
Mr.
proceed.
Chairman? Just that this antitrust issue is very, as you know, very dense.
Yes.
But again, I am very concerned about what's going on with these cases nationally. And then when I looked at these two cases, it appears to me that you would go even further. And I think we need less mergers, not more.
Can I
and
add
more
one
competition.
Thing?
Yes.
One thing, when I referred to the overlap of Chevron and State Farm, that's when I was talking about words like feasible and reasonable. I wasn't sure I was clear on that.
Thank you.
Senator Cruz.
Thank you, Mr. Chairman. Welcome back, Judge Kavanaugh.
Thank you, Senator.
Thank you again for your service. Before I get into questions, I just want to take a minute to recognize and thank the outstanding work at this hearing by the Capitol Police in terms of, in a calm and professional manner, dealing with the unfortunate disruptions we've seen and maintaining an environment where this hearing can focus on the record and substance of this nominee. And so thank you for the tremendous work that the men and women here are doing.
Mr. President, I think we'd like to second, and Senator Cruz second that sentiment on our side as well.
Thanks, both of you, very much. I've expressed it to many of the policemen individually as I see them. Proceed. Starting 30 minutes over.
Judge Kavanaugh, let's start with just a general question. What makes a good judge?
Senator, a good judge is independent, first of all, under our constitutional system. Someone who's impartial, who is an umpire, who's not wearing the uniform of one litigant or another, of one policy or another. Someone who reads the law as written, informed by history and tradition and precedent in constitutional cases. The law is written, informed by the canons of construction that are settled in statutory cases, that treats litigants with respect, that writes opinions that are understandable and that resolve the issues. I think civility and collegiality help make a good judge. A good judge understands that real people are affected in the real world, the litigants in front of them, but also the other people affected by the decisions the judge decides or the court decides in a particular case. A good judge pays attention to precedent, which is in constitutional cases, of course, rooted in Article 3 and critically important to the stability and predictability and reliance interests that are protected by the law. So there are a number of things that go into making a good judge. A work ethic, it's hard work to dig in and find the right answer in a particular case, and I think that's critically important as well. Judicial temperament. There are a lot of factors that go into it, and those are some of them. I'm sure there are more.
One of the things I was looking at, it's striking both the overheated rhetoric we have heard from some of our Democratic colleagues and also from some of the protesters over the last two days. I took a look at your record compared to that of Judge Merrick Garland. Judge Garland, of course, was appointed to the D.C. Circuit by Bill Clinton, and he was President Obama's nominee to the U.S. Supreme Court. What I found that was striking is that in the 12 years you've been on the D.C. Circuit, of all the matters that you and Chief Judge Garland have voted on together, that you voted together 93% of the time. Not only that, of the 28 published opinions that you've authored, where Chief Judge Garland was on the panel, Chief Judge Garland joined 27 out of the 28 opinions you issued when you were on a panel together. In other words, he joined 96% of the panel opinions that you've written when he was on a panel with you. And the same's true in the reverse. Of the 30 published opinions that Chief Judge Garland has written on a panel, you've joined 28 out of 30 of them, over 93% of those opinions. What is your reaction to those data and the level of agreement?
Well, I think we're trying hard to find common ground and to, as I've said before, he's a great judge, a great chief judge, and he's very careful and very hardworking, and we work well together and try to read the statute as written, read the precedent as written, and he's a judge who does not, like I try to be as well, judge who's not trying to impose any personal preferences onto the decision, but take the law as written, and that's what I've tried to do in those cases, and that probably explains some of that. I think it also goes back to I think judges are distinct from policymakers, and I think that shows up when you dig into the actual details of how courts operate and go about their business. You, of course, know well, Senator, from all your arguments and seeing judges decide cases in real time. And I think those statistics reflect the reality of how judges go about their business. Like I've said several times, I think of the Supreme Court as a team of 9, and would try to be a team player on a team of 9. That, of course, there are going to be disagreements at times, so I don't want to overstate. But if you have that mindset of we're a court without sitting on different sides of an aisle, without being in separate caucus rooms, trying to find what the right answer is, and I think there is a right answer in many cases, and maybe a range of reasonable answers in some others, and I think that's what those statistics reflect to me.
So you talked about the difference between your own policy preferences and what the law described or mandates. How would you describe a judicial activist?
I would describe a judicial activist as someone who lets his or her personal or policy preferences override the best interpretation of the law, and that can go in either direction. So a judge who strikes down a law as unconstitutional when the text and precedent don't support that result, or a judge in the other direction who upholds a law as constitutional when the text and precedent would suggest that the law is in fact unconstitutional. So too in statutory cases, it's the same principle. When a judge does not stick with the compromises that you've reached and written into the text of the statute passed by Congress and signed by the president, but thinks the judge can improve on it in some way, or maybe picks a snippet out of a committee report and says, well, I agree with that view in the committee report, and I'm going to superimpose that onto the text of the statute passed by Congress. That's, to me, the textbook definition of a judicial active, as adding to or subtracting from the text as informed by the precedent.
In your time on the D.C. Circuit, you've written a number of opinions addressing separation of powers. Why does separation of powers matter? Why should an American at home watching this on C-SPAN care about the separation of powers?
People should care about separation of powers because it protects individual liberty. And it's really the foundational protection of individual liberty. We think of the First Amendment, freedom of religion, freedom of speech, as foundational protections of individual liberty. But as Justice Scalia used to say, the old Soviet Constitution had a Bill of Rights, but it was meaningless in operation because they did not have an independent judiciary. They did not have a separation of powers system to help protect those individual liberties. So it works in two ways, I think, or more than two ways. First, the independent judiciary that helps enforce those rights. Secondly, the whole structure, as I've explained, tilts toward liberty in the sense that you start with a system. It's hard to pass a law to affect what you do or cannot do. Hard to get a law through Congress, and that's by design. There's the bicameralism principle, a House and a Senate, as well as adding the president, was designed to prevent the passions of the moment from overwhelming and enacting a law based on the passions as opposed to a more difficult process. That all helps protect individual liberty. Then even after you pass a law, the president has, as I was discussing with Senator Klobuchar, the executive branch has prosecutorial discretion when and how to enforce particular laws. Who is protected by prosecutorial discretion? Ultimately, it protects individual liberty. And then even when the Congress has passed a law and the executive has enforced a law, that doesn't mean you go straight to prison. You go, if you're charged with a crime, you go before an independent judiciary. And just to add further protections for liberty, you have the jury protections that are in the original text of the Constitution and also reflected in the Bill of Rights. So in check after check after check, the Constitution tilts toward individual liberty. The separation of powers also ensures that there are checks on the branches. So what do we do for example, members of Congress don't serve for life. You have to run for re-election. And that's a check, again, to help protect individual liberty, to help ensure accountability as well. So too with presidents. So the document's just chock full with protections of individual liberty. And that's ultimately why the separation of powers matters as much as the individual protections that are in the Bill of Rights and also in Article 1, Section 9, Article 1, Section 10 of the original Constitution.
How about the doctrine of federalism? That's been an issue you haven't encountered as much serving on the D.C. Circuit, but can you share with this committee why federalism matters, and again, why Americans watching this hearing at home should care about the principles of federalism?
Federalism matters for several reasons, Senator. Again, it helps further individual liberty in the sense of additional protection. So let me give you an example. If the U.S. Constitution only protects, the Fourth Amendment only protects you against unreasonable searches and seizures up to a certain line, it's possible that your state constitution will protect you even further under that, or your state legislature might protect you further. So further protections of individual liberty. Federalism also operates in a different way, a laboratory of democracy in the sense of experimentation around the country. There's not always the same views in Texas that there might be in California, for example, on particular issues. And so you have different laws. Yes, and different laws in those states. And also, I think the federalism serves the the more general idea of the government that's closest to you for most of your day-to-day activities. My wife's, of course, in local government now as the town manager, but federalism for the things that affect you on a daily basis, the paving of the roads, the leaf collection, the trash collection, the local schools, which is probably the most direct impact that many people have with the government, the local court system. My mom, of course, was a state trial judge. The whole system of state government is most people's interaction with government, and federalism in that sense ensures accountability because you know better, usually, your local and state elected officials than you do, and you can therefore make your views known on whatever governmental issues is of concern to you. For example, the schools is a classic one.
So what is the importance and the relevance of the 10th Amendment?
The 10th Amendment protects federalism in the sense of ensuring that the states have independent sovereign, they make clear, which is also clear from the structure, but reinforces the idea that the states are sovereign entities that have independent authority under the Constitution, and that they have the status as separate sovereigns under the Constitution. And so you were Solicitor General of Texas, of course, and I know you represented the state of Texas in many cases where the sovereignty of the state of Texas to pass its laws and to enforce its laws was critical. And the sovereignty of the individual states is important for the people, again, both for the accountability, the local government, and also for the protection of individual liberty. And I think the 10th Amendment underscores that. It also it helps underscore something else, which is the states can't be commandeered by the federal government. Commandeered is commandeering doctrine of the Supreme Court, which recognizes that, and this is from the structure as a whole and underscored, but the federal government can't order states to do certain things that the states themselves have not chosen to do. And so that's an important part of the federalism principles recognized by the Supreme Court, and that comes out of the Constitution as well.
What do you make of the 9th Amendment? Robert Bork famously described it as an ink blot. Do you share that assessment?
So I think the 9th Amendment and the Privileges and Immunities Clause and the Supreme Court's doctrine of substantive due process are three roads that someone might take that all really lead to the same destination under the precedent of the Supreme Court now, which is that the Supreme Court precedent protects certain unenumerated rights so long as the rights are, as the Supreme Court said in the Glucksberg case, rooted in history and tradition. And Justice Kagan explained this well in her confirmation hearing, that the Glucksberg test is quite important for allowing that protection of unenumerated rights that are rooted in history and tradition, which the precedent definitely establishes, but at the same time making clear that when doing that, judges aren't just enacting their own policy preferences into the Constitution. And an example of that is the old Pierce case, where Oregon passed a law that said everyone in the state of, this in the 1920s, everyone in the state of Oregon had to attend, every student had to attend a public school. And a challenge was brought by parents who wanted to send their children to a parochial school, religious school. And the Supreme Court ultimately upheld the rights of the parents to send their children to a religious parochial school and struck down that Oregon law. And that's one of the foundations of the unenumerated rights doctrine that's folded into the Glucksberg test and rooted in history and tradition. So how you get there is, there, as you know well, Senator, there's stacks of law reviews written to the ceiling on all of that, whether it's privileges and immunities, substantive due process, or 9th Amendment. But I think all roads lead to the Glucksberg test as the test that the Supreme Court has settled on as the proper test.
Let's talk a little bit about the First Amendment. Free speech, why is that an important protection for the American people?
It's one of the bedrocks of American liberty, the ability to say what you think, to speak politically, first of all, about policy issues, and to speak about, for example, who you want to support for elected office is a critical part of the free speech principle. But it's broader than that. It's the idea that there is no one truth necessarily that one person can dictate from on high in terms of policy issues or social issues or economic issues, and that the truth, or at least the best answer, emerges after debate and over time, and that freedom of speech is important to help advance that cause of the debate. And it's important just as an individual matter, I think, to have that protection written into the Constitution, because you may have an unpopular view at a particular point in time, and if that view were suppressed, that view would never take hold, even though that view would be the better view. And so it's particularly important in the Supreme Court precedent, I think, to protect unpopular views or views that seem out of fashion, or out of fashion at a particular moment in time, because of both the inherent dignity that provides to individual people, but also for the broader purpose of that advances societal progress or economic progress or social progress. Most good ideas were unpopular at one point or another and take time to take hold and I think the framers understood that. Look at where they came from and how they had to fight against suppression of speech and suppression also of religious liberty, of course, in how they came about. So for free speech is critically important. I think, again, Justice Kennedy and Justice Scalia in Texas versus Johnson, what could be more unpopular than burning the American flag? And yet they upheld the right to do that, not because they liked it, and that's the whole point of Justice Kennedy's concurrence, but because they thought the First Amendment had to protect the most unpopular of ideas in order to accord with the precedent and principle of free speech.
So you mentioned religious liberty. Religious liberty is one of our fundamental liberties, cherished by Americans across the nation, the right to live according to our faith, according to our conscience. Can you share your views on the importance of religious liberty and how the Constitution protects it?
Yes, Senator. To begin with, it's important in the original Constitution, even before the Bill of Rights, that the framers made clear in Article 6, no religious test shall ever be required as a qualification to any office or public trust under the United States. So that was very important in the original Constitution, that the framers thought it very important that there not be a test to become a legislator, to become an executive branch official, to become a judge under religion, recognizing the religious freedom, at least, to serve in public office. And then, of course, in the First Amendment to the Constitution, ratified in 1791, the principle of religious liberty is written right into the First Amendment to the Constitution. And the framers understood the importance of protecting conscience. It's akin to the free speech protection in many ways. And no matter what God you worship, or if you worship no God at all, you are protected as equally American, as I wrote in my Newdow opinion. And religions, if you have religious beliefs, religious people, religious speech, you have just as much right to be in the public square and to participate in the public programs as others do. You can't be denied just because of your religious status, and the Supreme Court has articulated that principle in a variety of different ways in particular cases. You look at, for example, in other countries around the world, in China, for example, public.
He is a threat to people with
So if you look at other countries around the world, and you're not free to take your religion into the public square. You know, crosses are being knocked off churches, for example, or you can only practice in your own home. You can't bring your religious belief into the public square.
Without the information about Judge Kavanaugh, you can't tell. Many people don't know that he lied in the first judge.
Being able to participate in the public square is a part of the American tradition, I think, as a religious person, religious speech, religious ideas, religious thoughts, that's important. So too on the Establishment Clause, some of those cases are, as you know, particularly complicated in the Supreme Court precedent, but the Supreme Court precedent, for example, in the Town of Greece case and others has recognized that some religious traditions in governmental practices are rooted sufficiently in history and tradition to be upheld. And so in that case, the Town of Greece case, the Supreme Court upheld the practice of a prayer before a local legislative meeting, as Marsh v. Chambers, of course, also a local town meeting, I should say. Marsh v. Chambers had upheld it in a legislative meeting as well. So the religious tradition reflected in the First Amendment is a foundational part of American liberty, and it's important for us as judges to recognize that and recognize too that, as with speech, unpopular religions are protected. Our job, we can, under the Religious Freedom Restoration Act, question the sincerity of a religious belief, meaning is someone lying or not about it, but we can't question the reasonableness of it. And so the Supreme Court has cases with all sorts of religious beliefs protected. Justice Brennan, really the architect of that. So religious liberty is critical to the First Amendment and the American Constitution.
How would you describe the interaction between the Free Exercise Clause and the Establishment Clause? And are they at cross purposes in intention, or are they complementary of each other?
I think in general it's good to think of them as both supporting the concept of freedom of religion. And in the Newdow case I wrote, tried to explain some of those principles, but I think it's important to think that, to begin with, you're equally American no matter what religion you are, if you're no religion at all. That it's also important, the Supreme Court has said, that religious people be allowed to speak, enter, participate in the public square without having to sacrifice their religion in speaking in the public square, for example, or practicing their religion in the public square. At the same time, I think both clauses protect the idea or protect against coercing people into practicing a religion when they might be of a different religion or might be of no religion at all. So the coercion idea, I think, comes really out of both clauses as well. The cases that are Establishment Clause cases that don't involve coercion, but are some of the religious symbols cases, as you well know, Senator, that's a complicated body of law, but in each probably area of that has to be analyzed in its own silo. But as a general matter, I think it's good to think of the two clauses working together for the concept of freedom of religion in the United States, which I think is foundational to the Constitution.
When you were in private practice, you represented the Adat Shalom synagogue pro bono. You did that for free. Can you describe for this committee that representation and why you undertook it?
I undertook that representation to help a group of people who wanted to build a synagogue, but were being denied the ability to do that based on a zoning ordinance that seemed to be the application, at least, of a zoning ordinance in a way that seemed to be discriminating against them because of their religion, and that may have allowed other buildings to be built there, but they were being blocked or at least challenged from building a synagogue there. So it seemed to me potentially a case of religious discrimination that was being used to try to prevent them from building. So I wanted to I agreed to represent them because I wanted to do pro bono work, and I always like to help the community. In that case in particular, I thought these people who want to build their synagogue have the right to do so, as I saw it under the law, and I thought I could help them do so, and we did prevail in the district court in Maryland, and that synagogue now stands, and they were very grateful, and so that was the kind of litigation. That was the couple years I was actually at a law firm, but did some pro bono work, and that was very rewarding pro bono work to have a real effect on real people in their practice of their religion in the state of Maryland. So that's something that means a lot to me. They gave me something, a thing to hang on the wall, Justice, Justice, Shalt Thou Pursue, which has hung on my wall in my chambers the whole 12 years I've been there, as just a reminder of a representation I had in the past and the importance of equal treatment and religious liberty and a successful pro bono representation that meant a lot to me.
Well, and I'll note some of the Democratic senators on this committee. Some of the Democratic senators on this committee have suggested that you would somehow side with rich and powerful entities at the expense of the little guy, but at least in that instance, representing the synagogue against the power of government that was trying to prevent it being built is very much an instance that you chose to give your time and your energy and your labor for free to a litigant that I think most would view as the little guy in that battle.
That's correct, Senator, and I've tried as a judge always to rule for the party who has the best argument on the merits, and that's included workers in some cases, businesses in others, coal miners in some cases, environmentalists in others, unions in some cases, the employer in others, criminal defendants in some cases, the prosecution in others. And I have a long line of cases in each of those categories. And the little guy, big guy is not the relevant determination. If you're the little guy, so to speak, and you have the right answer under the law, then you'll win in front of me.
Earlier in the questions from Senator Graham, he asked you a question, are you a Republican? And he asked it in the present tense. And your answer, you acknowledged that you had been a registered Republican. Indeed, you'd served in a Republican administration previously. But of course, you've been a federal judge for 12 years. Do you consider yourself a Republican judge?
I'm not sure what the current registration is, but shortly after I became a judge, I assume this registration, I haven't changed it, but I don't know if it's still listed, but shortly after I became a judge and had voted, I think, in one election, I read about the second Justice Harlan having decided that he didn't want to continue voting while being a federal judge. And I thought about it, that practice, and I will be the first to say I'm not the second Justice Harlan, and not trying to compare myself in any way to him, but I thought that was a good model for a federal judge, just to underscore the independence, because we're not supposed to participate in political activities, go to rallies, give money, and that kind of thing, and it seemed to me that voting is a very personal expression of your policy beliefs in many ways, and your personal beliefs, and I'm not trying to...
Let me ask one final question, because my time is expiring, and I want to end on a lighter note.
Yeah.
You and I have both had the joys of coaching our daughters in basketball. Can you tell this committee what have you learned coaching your daughters playing basketball?
Well, it's been a tremendous experience to be able to coach them for the last 7 years, and all the girls on the team. And I've learned about something I saw in my own life, but the importance of coaches to the development of America's youth. Teachers too, but coaches can have such an impact, I think, on building confidence. And when you see, I've coached girls, so when you see the girl develop confidence over time, or you see their competitive spirit, the teamwork, the toughness that's developed over time, the drive, win with class, lose with dignity, winning and the ability to lose, but still put forth your best effort. And so I've learned just how important, I think I understood that from my own experience, as I said, but learned how important it is for people, for coaches, and the effect that you can have on people's lives. And I've heard from a lot of the parents over the last 8 weeks while I've been in this process about effect I had on some of the girls' lives, which was very nice to hear in terms of my my coaching. So, like I said yesterday, coaches have such an impact on people, and I've learned that. That's why, as Senator Kennedy said in my individual meeting, I hope you keep coaching, and I'm going to, either way this comes out, I'm going to try to keep coaching. Thank you, Senator.
Senator Coons.
Thank you, Chairman Grassley. Thank you, Judge Kavanaugh. As we discussed in my office and in a letter I've sent to you to follow up, I hope to question you today about your views on rule of law, separation of powers, presidential power. And Chairman, I'd like to start by entering into the record a series of articles that I think lay some of the foundation for my concerns.
Without objections ordered. Well,
thank you.
Go ahead. If
First,
you want.
who is Brett Kavanaugh? By Chicago professor Eric Posner and Emily Bazelon. Second, the Kavanaugh nomination must be paused and he must recuse himself. By former Third Circuit Judge Timothy Lewis, former White House Ethics Counsel Norm Eisen, and Harvard Law professor Tribe. Third, Brett Kavanaugh's radical view of executive power by Professor Bettenschneider. Brett Kavanaugh's devoted to the presidency by law professor Garrett Epps. And Brett Kavanaugh's legal opinions show he'd give Donald Trump unprecedented new powers by Fordham professor Sugarman.
As I previously said, without order.
You repeat who the third one was? Sorry, I want to make sure I know the names.
I think it was Brett Kavanaugh's radical view of executive power by Brown University professor Corey Brettschneider, if I'm not mistaken.
Okay, that's not a law professor though, right?
Correct.
Okay.
It's a range of opinions from a range of folks from a range of backgrounds. Judge, the rule of law requires that those who are governed and those who govern both be bound by the law. And a key way to ensure, as you said in your opening, that no one is or should be above the law is to ensure that the president is not above the law by preventing him from firing someone appointed to investigate him. Sitting on a panel at Georgetown in 1998, you took a different view. You said at that time, and I quote, "The prosecutor should be removable at will by the president." Given what's in your record, a long record of writing and speaking on this topic, I think there's legitimate cause for concern about your views on presidential power and whether it's possible President Trump chose you so you would protect him. Please answer directly. Do you still believe a president can fire at will a prosecutor who is criminally investigating him?
Well, that's a question of precedent, and it's a question of that could come before me either as a sitting judge on the D.C. Circuit or if I'm confirmed as a Supreme Court justice. So I think that question is governed by precedent that you'd have to consider. United States versus Nixon, of course, the special prosecutor regulation in that case was at issue in United States versus Richard Nixon and the subpoena.
Judge, if I could, I'm just asking whether you stand by your record, something that you chose to write in 1998. You expressed a view at the time that a president can fire at will a prosecutor criminally investigating him. Is that still your view?
Well, that would depend.
I'm not asking for a recitation of precedent. We will get into some precedent later. I'm just trying to make sure I understand if you stand by that publicly expressed view back in 1998.
I think all I can say, Senator, is that was my view in 1998.
Okay. Well, then let's move to a more recent statement that I think is equally important. In the wake of the Watergate presidential scandal, a scandal precipitated by a president who committed some crimes and then was investigated, Congress passed the Independent Counsel statute, a statute which restricted, in part, when the president can fire an independent counsel. And during a recent speech, a 2016 speech, you described this law as, and I quote, a goo-goo post-Watergate reform and a constitutional travesty. Do you stand by your criticism of the independent counsel statute as a constitutional travesty.
Well, that was understated compared to what members of this committee and others said in 1999 when the decision
But
was
Judge, I'm
made.
interested in your views, not
Right.
views of members of this committee. And when you chose in a public speech as a sitting judge to say that that statute was a constitutional travesty, you had something in mind. What are your views on this statute, and why do you view it as a constitutional travesty?
So let me make a few things clear. This is the old independent counsel statute. That's distinct from the special counsel system that I've specifically said is consistent with our traditions. I said that in the Georgetown article, as you know. I said that actually in the PHH case most recently. The statute you're talking about, the independent counsel statute, was a distinct regime that Congress itself decided not to reauthorize in 1999. I think Senator Durbin said it was unrestrained, unaccountable, unconstitutional statute. That
But I'm
statute
interested,
doesn't
if I might, Judge, in your views. You chose to describe the independent counsel as a constitutional travesty. What did you mean?
I meant, I think, what Justice Kagan said when she said at Stanford a few years ago that Justice Scalia's dissent in Morrison v. Olson, and this is a quote, was one of the greatest dissents ever written and has gotten better every year. By identifying Justice Scalia's dissent as one of the greatest dissents ever written, Justice Kagan seemed to be saying, at least I think this is the only reading of it, that the Morrison v. Olson decision was wrong.
I'll actually strongly disagree. You offered that quote, that cite of Justice Kagan when we met. I was struck. Perhaps I should call Justice Kagan and tell her she's one of your judicial heroes. I think that citation is actually literally true but misleading in context. Justice Kagan wrote in a famous Harvard Law Review article in 2001, strongly rejecting the unitary executive theory, which is at the root of the Scalia dissent in Morrison v. Olson. I believe Justice Kagan was complimenting the forcefulness and the clarity of Scalia's writing in the dissent, not agreeing with the legal theory. I'm trying to get to the point of...
I think I disagree with that, Senator.
Well, I look forward to exchanging some papers on this, and perhaps in our next round tomorrow we can have more fun on it. But it's an important point.
It is, but I think in that article, and I've read that article, it's a great article, Presidential Administration by Justice Kagan,
Yes.
then Professor Kagan. I think she was referring to the concept of independent agencies generally, so the Humphreys executor line of the cases. So I think she's referring there, at least I read her as referring there to independent agencies are traditional and permissible. The independent counsel statute was something quite different from the traditional independent agencies that had existed with the Federal Trade Commission, the Securities and Exchange Commission. So I did not read her old article to in any way.
Let's put it this way. Justice Kagan may have complimented Scalia's dissent in its writing or its holding. You've criticized the independent counsel statute as a constitutional travesty, and I'm simply trying to get to the bottom of why you held that view and why you chose to say that in a speech just 2 years ago.
Well, it was Morrison v. Olson was a one-off case about a one-off statute that hasn't existed for 20 years. The statute's gone. The case, as Justice Kagan, I think I took my lead from her comment. I know I read that. I've cited it many times in speeches I've given. But that statute, it's just real important to be clear here, and I know you know this, Senator, but so everyone understands. That statute hasn't existed since 1999.
But
special
Morrison v.
counsel
Olson is
system
still good law, is it not? But the holding by the Supreme Court in Morrison v. Olson, even though the independent counsel statute has passed into history, Morrison v. Olson, as a decision of the Supreme Court, is still good law. In
Well, I
fact,
think-
your own circuit said so forcefully this year.
I think
correct?
Humphrey's executor.
I think
is
that's a
good
yes
law.
or no question. The D.C. Circuit held this year in PHH, where you wrote a dissent, that Morrison v. Olson is still good law, correct?
I think they were applying Humphrey's executor. They might have cited Morrison, but the principle
They
being
literally said, and I quote, Morrison remains valid and binding precedent, and
in how it applied
criticized your-
Humphreys.
criticized your minority as flying in the face of Morrison.
And again, we're talking about independent agencies, so the traditional independent agencies on the one hand, and the old independent counsel regime that is long gone on the other. And the independent counsel regime, this committee and the Congress as a whole decided was a serious mistake. It's just Senator Durbin's words, unrestrained, unaccountable, unconstitutional.
So what
And I
I'm
think the
concerned
case-
about, Judge, what I'm concerned about, Judge, is not so much whether there are members of this committee or other justices who viewed the independent counsel statute as a serious mistake, but whether you view Morrison v. Olson and the majority holding there as a serious mistake. So let's move to that point if I could. In Morrison v. Olson, as you well know, the court upheld a restriction on the president's power to fire the independent counsel. In fact, by a vote of 7-1, it's an opinion written by your first judicial hero, Chief Justice Rehnquist. It was only Justice Scalia who dissented, in arguably a well-crafted dissent. But for those 7 justices, they wrote an important decision, which I believe you have challenged and criticized because it restrained the president's power to fire the independent counsel. Just 2 years ago, you were asked at a public event to name a case that deserved to be overturned, any case. And after a pregnant pause, you said, well, I can think of one. There was some chuckling.
Yeah.
And then you said, well, sure, Morrison v. Olson. And I'm struck by that, having watched that speech. Not Korematsu, not Buck v. Bell, cases that, are taught to all first-year law students as terrible examples of shameful decisions. No, you chose Morrison v. Olson to say it's already been effectively overturned, which I disagree with, and I would put the final nail in the coffin. So here's a recent public statement by a sitting D.C. Circuit judge who's now before me as a nominee to serve on the Supreme Court. So I've got a question. Would you vote to overturn Morrison?
Senator, first of all, Korematsu's been now overturned, and Buck v. Bell's a disgrace.
Right.
So
So it's striking you didn't choose either of them. You reach out and say, oh, this old 30-year-old decision about a statute long gone, that's the one I'm going to hold up to get rid of.
I really did have Justice Kagan's comment foremost in mind. I thought she had already talked about Morrison v. Olson and
Nothing to do with a view of presidential power.
well, I've written about the special counsel system, and I've said in the 1999 Georgetown article that the special counsel system is the traditional approach used when there's a conflict of interest in the executive branch. There's a need for an outside. When I said that again in the PHH case that you just cited.
And is that special counsel fireable at will or only for cause?
And
in
that's-
your conception of what's the most appropriate structure?
So that's the hypothetical that you're asking me, and I think what that depends on is there some kind of restriction on for cause protection, either regulatorily or statutorily, that is permissible, that is different from the old independent counsel, for example. And that's the kind of open question, gray area question that you would want to hear the briefs, get the oral arguments, keep an open mind on. What is the specific statute you have at issue? Remember, the old independent counsel had a lot of moving parts to it that were all of which were novel and together produced Justice Scalia's dissent. No, I don't think any one aspect.
So given your enthusiasm for Justice Scalia's dissent, given your choice to say, forgive me, I would put the final nail in, let me go back to that question. Would you vote to overturn Morrison?
Sir, I'm not going to say more than what I said before.
Well, I think what you said before is clear. I think your enthusiasm for overturning Morrison is unmistakable.
Executive immunity has no place in democracy. For all of you who support this, it is un-American. It is absolutely un-American. And shame on you, and shame on all of you.
I want to repeat two things, Senator, because they're important. One is Humphrey's executor is the precedent that stands, and I've called it an entrenched precedent in an opinion, on independent agencies generally. And two is the special counsel system, both in the PHH decision recently and in the old Georgetown Law Journal article. I've specifically said that that's the traditional way that criminal investigations proceed when there's a conflict of interest in the usual Justice Department process.
Humphrey's executor has been settled law now for 83 years, right? And early on you said that you would be willing to offer views on long settled cases. Can you just tell me if Humphrey's executor was correctly decided? It's long settled precedent, yes. You've said that about a number of cases. But a key difference here is whether you'll say that something was rightly decided. I'm struck about this, frankly a little concerned about it, because in your own opinion, in your dissent in PHH, you went into a long criticism of Humphrey's executor. At least that's how I read it. You laid out a very strong articulation of this unitary executive theory, this theory that the president is imbued with all the power of the executive branch, which is the core of Scalia's dissent in Morrison, which is a radical theory that has been rejected by the Supreme Court, I would argue. And you go on to then say that Humphrey's executor, yeah, it's long settled. But you know, if we were to overturn it, it wouldn't mean the elimination of independent agencies. This is long. Why did you need to go there? Why have that conversation if this long settled case is actually well reasoned?
What I said in the PHH case is that Humphrey's executor is the precedent that governs independent agencies. I've applied it dozens of times, Humphrey's executor, and referred to it that way. What concerned me constitutionally as a judge in the PHH case was that the CFPB did not follow the traditional model of independent agencies and therefore departed from this traditional exception, one might say, to the idea that a single president controls the executive branch. And I explained all that the having one head of an independent agency both diminished presidential authority more than Humphrey's executor and posed a serious threat to individual liberty and was a departure from historical practice, which under the Supreme Court's precedents makes a big difference, as you know, of course. And so I referred, so that's why I concluded in the CFPB case that the statute was the Bureau was unconstitutionally structured, but the remedy was not to get rid of the whole agency. The remedy was simply to make the person removable at will.
So Humphrey's executor was essentially about whether or not the head of the FTC could be removable at will or have a good cause removal protections.
Right. President Roosevelt wanted to fire Humphrey, who was a Republican holder.
Will you simply just state that it's well-reasoned, well-decided, long-settled law?
I'll say it's an important precedent of the Supreme Court that I've applied many times, has been reaffirmed.
It's troubling to me that you can't say that Humphrey's executor was well-decided.
But again, I'll follow the 8 nominees.
Marbury versus Madison, well-decided.
Of course. Of course it is. The concept of judicial review wasn't even invented in Marbury versus Madison. It's right here in the Constitution as I read it and also referred to in Federalist 78. We mistakenly say Marbury created the concept of judicial review. It actually exists right there. But it's a correct application. But the reason I'm hesitating...
So let me bring this back to the current context and why all of this is of concern to me and relevant.
But I didn't finish my answer.
We have a series of public statements by you that are recent about your enthusiasm for overturning Morrison. And you're not going to comment on that here. You won't answer that question here. You've got a recent decision as a D.C. Circuit judge where you forcefully articulate this unitary executive theory that would give the president significantly more power. And if Humphrey's executor is at any risk, we might then see a whole series of agencies moved or a whole series of long-established protections from at-will removal at some risk. Let me just make sure I get this right. In your view, can Congress restrict the removal of any official within the executive branch?
Under the Supreme Court precedent, which I've applied many times, Humphreys, and referred to it as an entrenched precedent, Congress historically has restricted the removal of independent agency heads, and that is law that has been in place for a long time.
For decades.
On Morrison, you may disagree with what I'm about to say, but the reason I think Justice Kagan probably felt free to talk about Morrison, and I did as well, is it seemed a one-off case about a statute that doesn't exist anymore, and that Humphreys is the precedent on independent agencies. Now, you may disagree with me on that, but I think that's the premise on which she spoke. I don't want to put words in her mouth, but that's certainly the premise on which I spoke. But I was not intending to do either of two things. I was not intending to say anything about Humphreys, and I was not intending to say anything about traditional special counsels, which I've explicitly distinguished multiple times over the years.
So I'm concerned that I'm having difficulty getting what I think is a clear and decisive answer from you on a number of things. Would you overturn Morrison? What's your view of executive theory? Is it appropriate for a president to fire a special counsel investigating him? I'm just going to come back to a decision that you rendered this year, this PHH decision. And I urge folks who are having any interest in this or trouble following it to just read your decision in this case, because you lay out, you embrace this theory of the executive, that the executive has all the power of the executive branch, which I think is directly relevant to the question whether a special prosecutor should be fireable at will by the president or could be protected from being fired by the whims of the president. This is a theory that was rejected not just by the Supreme Court in Morrison v. Olson, not just by the D.C. Circuit, but by a number of members of this committee in a recent vote, a bipartisan vote, advancing a bill that's predicated on the idea that Congress can impose some restrictions on the executive's power to fire at will executive branch junior officers.
Just with respect, Senator, I think you're significantly overreading what I wrote in that case. I did not in any way say that the traditional independent agencies are in any way constitutionally problematic. In fact, I took that as the baseline on which I said that this new agency departed from that traditional model and was problematic. So I did not cast doubt on Humphreys in that case, at least as I read it. I guess you don't agree with the opinion, but I explained in great detail why I thought this deviation from Humphreys mattered as a matter of historical practice.
Let's get then, if we could, Judge, in the few minutes I've got left, to the question of investigations, because this is also something you've written about, you've spoken about, and it's related, I think, to this issue. Now, back in Georgetown, on a panel in 1998, you said, and I quote, "It makes no sense at all to have an independent counsel investigate the conduct of the president. If the president were the sole subject of a criminal investigation, I would say no one should be investigating that." Is that still your view, that if there's credible evidence that a president committed crimes, no one should investigate it?
That's not what I said, Senator. So two things on that. One, the independent counsel you're referring to there, it's just important because people forget this, is distinct from the special counsel system. So it's very important. I specifically in that Georgetown Law Journal approved of the traditional special counsel system.
And the traditional special counsel system has a special counsel that can be fired at will by the president, correct?
Well, in the Watergate situation, there was a regulation that protected the special counsel from
and what happened to the special counsel in Watergate?
Well, there was a new regulation then put in place, as you know, and then in United States versus Richard Nixon, that new regulation was parsed pretty carefully. And then more generally—
This is exactly why your quote that the independent counsel statute was a goo-goo post-Watergate reform gave me some agita.
But that wasn't but that was a statute put in well after Watergate, of course, 1978. That in Watergate itself, what the system that was in place was the traditional special counsel system with a new regulation put in after the episode you're referring to. And then when the independent counsel system came up in 1999 for reauthorization, there was everyone agreed it was. I think I'm not.
You're not alone.
I'm not exaggerating to say that the quote you put up before that one was understating what everyone here said about the independent counsel system.
Well, in a 1999 article in that exact period, I think this is the American Spectator article, you called it constitutionally dubious for a criminal prosecutor to have the responsibility to investigate the president. Help me understand that. Is that still your view, Judge? Is it still your view that it's constitutionally dubious for a criminal prosecutor to investigate the president?
No, I've never taken a position on the constitutionality. All I've done is point out that, as I did in the Minnesota Law Review article, that Congress might want to consider the balance of, and that's when President Obama was in office.
So this is just a policy argument, not a constitutional argument?
Correct. If I have a constitutional case come before me as a judge on the D.C. Circuit, or if confirmed on that court, I'll have an open mind. I'll listen to the arguments. I'll dig into the history. I've seen all sides of this. I will have a completely open mind on the constitutional issue. And again, briefs and arguments. I think I've also shown a capacity to, if I'm presented with a better argument than something I've had before, to adopt the better argument. I've certainly done that. A good example of that in the national security context in the In the first Belul case, I pointed out how I had reconsidered something I'd written before in a national security context. I'm not a, but the larger point is that I've not taken a position on constitutionality before.
Well, and I'll just come back to a point we've now talked about several times. In several different contexts, in several different ways, you've chosen to make a constitutional point, either expressing enthusiasm for overturning a 30-year-old long-settled precedent in Morrison v. Olson, or arguing for the unitary executive theory that Scalia advanced in his dissent there. Or I'll give you another quote. In a different 2016 speech, you said there, Justice Scalia never wrote a better opinion than his dissent in Morrison v. Olson, and you may have been commenting on the quality of his writing. But you go on to say you believe his views will one day be the law of the land. I assume here you're talking about the constitutional analysis in Scalia's dissent, and you're expressing a hope, an expectation that it'll someday be the law of the land. You sit before me as a nominee to be in a seat where that will be eminently within your reach.
But again, Senator, I just want to avoid melding a lot of different things into one, because they're very important to keep distinct here, very important. The first is the independent counsel statute, and I view Morrison as only about the independent counsel statute, and I realize you may have a different view on that. But if it's only about the independent counsel statute, as I see it, and the independent counsel statute doesn't exist anymore, that's where, that's why Justice Kagan probably felt free to comment about Morrison as well. And then on special counsels, I've said what I've repeated many times here on investigation and indictment of a sitting president. Number one, I've never taken a position on it. And number two, it's important to underscore the Justice Department for 45 years. This is the Justice Department, not me. The Justice Department for 45 years has taken the position in written opinions that a sitting president may not be indicted while in office, but it has to be deferred, not immunity, but a deferral. And Randy Moss, who was head of President Clinton's Office of Legal Counsel, wrote a very long opinion on that. He's now President Obama appointed district judge in D.C. and an excellent district judge. I'm not saying I agree with that or disagree with that. I'm saying that's the consistent Justice Department view for 45 years. So before a case like this would come before the courts, whether I'm on the D.C. Circuit or otherwise, the Justice Department presumably would have to change its position. That's one. Two, a prosecutor at some point in the future would have to decide to seek an indictment of a sitting president at some point. And three, it would have to be challenged in court. Then all the briefs and arguments, and then it would come up on appeal to me in the D.C. Circuit. So there's a lot of things that would have to happen before this hypothetical that you're presenting even comes to pass. And if it does come to pass, you can be assured that I have not taken a position on the constitutional issue that you're raising on that specific question, at least as I understand the question. And that's totally distinct from the Morrison issue as I understand it.
Well, and I'll tell you again, the reason this has been gravely concerning to me, why I raised it in our meeting and sent you a letter about it, and why I've dedicated so much time to this question is I really don't view the issue in the independent counsel statute in the Morrison v. Olson decision as dealing with some now long past statute and some really sort of obscure and now not particularly relevant issue. I think the reason you reached out and volunteered that you'd love to overturn Morrison v. Olson isn't because Scalia wrote a powerful and moving dissent. It's because of a view of the executive branch having all the power of the executive branch in the president's hands that you've articulated across speeches, interviews, writings, and an opinion this year. I think that's really your view of the executive branch.
But I've not said,
I've
never said that. I've never said that, number one. So there are two issues here, and I want to be very, very clear on them so people understand that too. One
this is how I read your dissent in PHH this year, is arguing, advancing a unitary executive theory.
And I refer to a single president, but same concept. But
single president means the president is the chief law enforcement officer of the United States and should have all the power of the executive branch, including the ability to fire at will, which is really what's at issue in all these articles and cases. The ability to fire at will a special prosecutor, correct?
So I have taken as a given in all these cases.
That's a yes or no. Is that what you
But
mean?
I just want to be real clear, and I'm going to be repeating myself for about the 10th time, but I have repeatedly said that Humphrey's executor is the precedent that allows independent agencies, and that I have applied time after time. That's point one. Point two is I've specifically said what I've said about special counsel systems being the traditional mechanism. Point three is I've never taken a position on the constitutionality of indicting or investigating a sitting president. And point four is that the question of who
I've got
controls
just a
the
minute
executive
or
power.
two left, if I might. On that point, that you've never taken a position on the constitutionality of investigating a president, it was this
Constitutional.
American Spectator article where you said, and I'm quoting, if there's an allegation of presidential wrongdoing, a congressional inquiry should take precedence over the criminal investigation, including an investigation of any presidential associates. This American Spectator article was striking to me, this one in which you said it was constitutionally dubious for a criminal prosecutor to investigate a president, because you suggested not just that the president should not be criminally investigated as during his term, but that even his associates shouldn't be held accountable through the criminal justice system. You mentioned you might make an exception for violent crime, and I
Now that's
a last question for you, if I might. What if a presidential aide commits an assault, an act of domestic violence?
I never said anything like that, Senator, in terms of.
I'll let you answer that, and then we'll go on.
And I'd like
to
to
the
conclude, if I might.
Yeah, I've not said anything approaching what your broad description is. There has always been a question based on the Justice Department's own position for the last 45 years. The Justice Department's own position assumes that the proper thing to do is to wait for indictment, is that occurs after a president leaves office, whether that's because the term ends or because of the impeachment process. And that's how the Justice Department, again, for 45 years, that's been the law. Right. But that's not my law. That's the Justice Department's law, again, with Randy Moss writing the most important opinion on that.
I recognize I'm out of time. I'd like to conclude, if I might, Mr. Chairman, briefly. I look forward to continuing this line of discussion with you in our next round, Judge. I do think that there is good reason for members of this committee, myself, principally, to be concerned about a whole range of things that you've said, that you've written, and that you've decided as a judge about whether or not a president can be held accountable. I think the ability of a special counsel to conduct an independent investigation of the president is foundational to the rule of law.
I've said the same thing.
And
Okay.
I look forward to a next round where we can investigate
said the
that
exact
more
same
thoroughly.
thing.
But frankly, Judge,
Yeah.
your views about executive power, as I think you have detailed, your statements about what you'd like to overturn and what limits you think there should be, really leave me concerned. And it's because of our current context. It's because of the environment we're operating in. And I look forward to another round and to more questions.
I
Thank
look
you.
forward to it, but just to reiterate, what you said about special counsels is exactly what my article said in '99, and exactly what PHH said.
Thank you, Mr. Chairman.
Before I call on Senator Sass, a couple things. One, in regard to independent counsel statute at issue in Morrison, that statute was never renewed and does not have any effect today, and we in Congress chose not to renew it because it was nearly universally condemned. I often quote Senator Durbin about independent counsels, quote, unchecked, unbridled, unrestrained, and unaccountable authority. According to him, unchecked power is tyranny. We had Eric Holder, President Obama's Attorney General, said the law was too flawed to be renewed. Also, I want to insert in the record 30 op-eds from all across the country that support the confirmation of Judge Brett Kavanaugh. The editorial boards of the Los Angeles Times, the Chicago Tribune, the Wall Street Journal, among those 30 supporting confirmation. Without objection, I'll enter it in the record, all 30 of these op-eds.
Mr. Chairman,
Senator
Mr.
Sass.
Chairman, while we're on that exact point, there are 4 committee confidential documents that I would I wanted to be able to question our witness about today, the nominee, the judge. I'd like to submit those for the record. They reveal his thinking on a unitary executive theory.
Give that, and I can advocate that you get them, and we will put into it, just like we said to Senator Leahy, give us the citations, and we'll try to get them. So far, we've been very fortunate. Senator Sass.
Thank you, Mr. Chairman. Judge, by my count, you're about half done. Congratulations. You're going to be here past midnight, I think. I also want to talk about limited government in general and about limits on executive power in particular. I think today's been, Senator Cruz did a nice job complimenting the Capitol Police. I think today's been a tough environment to manage, and I think we all are glad that people get a right to express their First Amendment views and have the right to protest. I don't want to draw too much more attention to it, though, because I think it disrupts the events. But 4 things that have been said that I think are relevant to this question, protesters that have been carried out or let out in the last couple of hours. Just a few minutes ago, woman shouting, "Please vote no on Kavanaugh. President shouldn't have the power to do whatever they want." Vote no on Kavanaugh. This is one of the loudest shouts of today. He'll be a Trump puppet. A separate one, he will support presidential criminality. And executive immunity has no place in a democracy. I think that I want to empathize with concerns that people have about those kinds of statements. And frankly, if I thought that you would be a puppet for this or any president, if you would support presidential criminality, if you believe that executive immunity is something that is fitting for our system, or if you believe that presidents should have the power to do whatever they wanted, I couldn't vote for you either. So I'm headed toward voting for you because I don't believe any of those things are true, but I think the American people need to understand why not. So already today, you cited the Federalist Papers and said the president is not a monarchy. I think it would be useful, the presidency is not a monarchy. I think it would be useful to just have you back us up and let's go, again, I think Senator Coons asked lots of fair questions, but as a non-lawyer, at many times we got lost in weeds, not critical of his questioning, but I'd like to have it at a high school sophomore level for a little while. If you were going to explain to the American people what the limits on executive power are, what are they? Where do you start?
I start with the fact that the president is elected by the people through the electoral process specified in the Constitution. So not a hereditary monarchy was something that was specified in Federalist 69. Secondly, the president serves a term in office, not an unlimited term in office, again specified in Federalist 69. The president is subject to the laws. No one's above the law in the United States, including the President of the United States, and that's something that is made clear in Federalist 69. The president does not, a president does not have absolute power to make the laws, because Congress has the power to make the laws. The president doesn't have the power to adjudicate disputes, because an independent judiciary has the power to adjudicate disputes in cases and controversies along with a jury. As Justice Jackson's framework in Youngstown famously made clear, it's important to understand that, though, even in the national security context where the Constitution gives the commander-in-chief power to the president remains subject to the law, both the Constitution and the laws passed by Congress. So, for example, as I've said in writings, in my review of Judge David Barron's book on war, for example, in some of my cases, Congress has substantial power, and this is often forgotten, substantial power in the war powers arena, of course, to declare war, authorize war, but also to regulate the war effort, and Congress has done so historically and currently, including post-September 11th, on issues such as interrogation, detention, military commissions, surveillance. Congress has been actively involved in those areas historically and through post-September 11th. And I've made clear in my writings that the president has very limited power in Youngstown Category 3 to disregard such a law and or practice. The historical example that's accepted by the Supreme Court is command of troops in battle, for example, that Congress couldn't get in the middle of that, but outside examples like that, narrow examples like that, Congress can regulate the war effort. Now, Congress often chooses to give the executive branch broad discretion on national security policy, but sometimes not, because the Congress doesn't like what the executive has done. Usually we're very reactive, and that's understandable. Something happens that seems bad, Congress will come in and say, we don't want that to happen again in wartime or otherwise in the national security context. And Justice Jackson set forth that framework, which has stood the test of time and been applied by the Supreme Court. And that's a very critical part, because where else would we expect the executive to really exercise unilateral power but in the national security context? But also, at the same time, what else is a greater time of threat to liberties than the national security context? Youngstown Steel, again, being the classic example where the president said, well, we're trying to win the war so I can seize steel mills. And that didn't work by a 6-3 vote of the Supreme Court, given the statutes Congress has passed. So, too, no president is above the law in the sense that a president remains subject to, the Supreme Court said in the Clinton versus Jones case, civil process. So that's a precedent of the Supreme Court on civil suits while in office. So, too, the criminal process. Hamilton specifies this in Federalist 69. A president is not above the law with respect to the criminal process. The only question that the Justice Department, as I was saying to Senator Coons, has opined on for 45 years is the timing of the indictability question. And the Justice Department, through Democratic and Republican administrations for 45 years, has said that should occur when the president leaves office, either because the term's expired or because of the impeachment process.
Can I interrupt to unpack there, and then I'll come back. I want to have you finish, because I think you're building a list that has duration and time of the office of the presidency, authorities that the legislature may or may not have given to the executive branch, powers of the purse to fund things that may have authorities but may not have current dollars available to them. I think a lot of your debate with Senator Coons, again, I think it's an important debate, is about personnel matters. But for just a second, let's play out this question of criminality versus civil charges against a president. And I admit that I'm sort of, as a non-lawyer, I follow in the Midwestern tradition of the chairman of being a non-lawyer on the committee. I know a whole bunch of big legal brains told me if I ask any hypothetical, you'll run circles around me telling me why you can't answer. But I kind of want to try the start of a hypothetical. Imagine 10 years in the future, there's a president from the Purple Party. So it's none of the current participants in public life, and it's none of these parties even. And this president ran for office with an instinct to demonstrate self-reliance, and she decides that they won't be a part of any motorcades. They're going to drive themselves. And they're drunk one night, and there's a motor vehicle homicide committed by the president. That's both a criminal and a civil matter. Is the president immune from either being sued or being charged with a crime because they're president?
No one has ever said, I don't think, that the president is immune from civil or criminal process. So immunity is the wrong term to even think about in this process. The only question that's ever been debated is whether the actual process should occur while still in office. That's the Jones v. Clinton case, where strong arguments were presented by both sides, and the Supreme Court ultimately decided that the civil process could go forward against President Clinton. President Clinton was arguing that the civil process should be deferred until after he left office. The Supreme Court rejected that. So, too, the only question with the criminal process is not immunity. That's the wrong term. It's timing. And as I've said, the Justice Department for 45 years has taken the position that the timing of the criminal process, a criminal process, should be after the president leaves office. Now, that doesn't prevent investigations, gathering of evidence, questioning of witnesses, I wouldn't think necessarily. I don't want to opine too much, but that's certainly how it's proceeded under the special counsel system that we've had traditionally, that has coexisted with the Justice Department position on the ultimate timing question. So those are just timing questions from Jones v. Clinton and from the Justice Department position, but immunity is not the correct word, and I don't think anyone thinks of immunity. And why not? No one's above the law. And that's just such a foundational principle of the Constitution and equal justice under law, and that's what Hamilton was concerned about in Federalist 69, and that's what the framers were concerned about. even with having, if you read the Constitutional Convention debates, even with having a single president, they were concerned, well, that may seem like a monarchy, and that's why Hamilton felt the need to convince the people, no, this is not a monarchy. And how did Hamilton go about convincing the people of that? He wrote all the ways it was distinct in Federalist 69, some of which I've outlined to you. Appropriations is another important one to as Senator Byrd reminded me when I met with him in my 2006 process, Senator Byrd pulled out his pocket constitution, and Senator Byrd, as everyone who remembers Senator Byrd knows, was very focused on the appropriations clause of the Constitution, the fact that the Constitution...
As any drive through West Virginia will show you.
Yes, exactly. So.
I want you to finish that list, and then I want to ask some personnel-specific questions. So I think you have duration of the president's term in office, specific authorities that the president may or may not have been given, appropriations, personnel questions. Are there any other categories? I guess vertical and horizontal federalism, so there isn't just executive legislative distinction here. In my hypothetical, the drunk driving accident could have happened in Virginia or Maryland instead of D.C., and so then we'd have to have debates about which level of government would be involved. Are there any other categories of limitation on executive
Well, I
action?
think a huge one, really the hugest question, as I've said many times in my writings, in the entirety of constitutional law, is the president's ability unilaterally to take the country into war. That really dwarfs all other questions in many ways. And Hamilton made clear in Federalist 69 that the answer to that question was no. Now, it's sometimes thought and opined by commentators or even scholars that, oh, actually, that's changed over time, and actually presidents have that really has not changed in practice, at least over time. Obviously, there's no definitive Supreme Court case. But you look at all the significant wars, and I wrote this in the book review of the Barron book, which I recommend to you. I think you would enjoy that.
Thanks for calling me a nerd on national TV. I appreciate that.
Yes, I know you would enjoy it, really, is all the significant wars in U.S. history have been congressionally authorized, with one major exception, the Korean War. And the Korean War is an anomaly in many respects, and I think some of the fact that it was undeclared and unauthorized really did lead to the Youngstown decision. But Vietnam, the Persian Gulf War, the AUMF against Al Qaeda, the 2003 Iraq War, and then going back World War II, World War I, the War of 1812. They're all congressionally authorized. You can go back throughout, and I specify that, and so. The war power, the power to take the nation into war, at least a significant one, and there's some questions about short-term air strikes and things like that, but a significant war, that's the biggest of all, and that's something that Hamilton talked about in '69 and that our historical practice, I think, has actually lived up to. I don't mean to footnote Korea, that's an enormous exception, but since then, they've all been congressionally authorized. People debate the Gulf of Tonkin resolution, but the words of it are quite broad.
This isn't the place for this full detour, but I just want to underscore one thing you said about Hamilton and just in the Federalist Papers more broadly, how many times we see our founders writing about the norms of our civics. And one of the things that goes wrong in these kind of proceedings is we so regularly conflate policy and politics with civics, and I think that our jurisprudence should fit inside our civics, not inside our politics, because it's the overarching thing. We have Ken Burns often says, "E pluribus unum" is a core motto for America, and we have a whole bunch of pluribus and very little unum right now. We should have a lot more unum, a lot more unity about what we think the role of a judge is, and I think Senator Cruz did a really nice job of unpacking how often you and Judge Garland have been on the same side of issues, 93 and 96% of the time. Your comments yesterday about being on the team of 9, about there being no center aisle that needs to be crossed over at the court, about there being no caucus rooms in the Supreme Court, that's another way of saying if we're doing civics right in America, we should be seeing fewer and fewer political disputes trying to be settled at the court, and it means that we need to attend more to the norms of when things are going wrong in America, and we should all admit that things are a mess in this country. We've had in the governance of of our country. There's a lot that's great in America right now, but in the idea that in our public square we agree on very much, I think we know that that's not true. And if you look at survey data of what high school students turn up if they try to take the immigration and naturalization test, and huge shares of high school juniors don't know that we have 3 branches of government, shame on us, not shame on them, that they don't understand that because we're not doing that basic civics. Well, Washington thought it was essential that when he was explaining what his job is as president and that it not be confused with a monarchy, he wanted to be called Mr. Washington, not honorifics. He rebuked people for bowing before him because we might confuse our kids and grandkids that the presidency is a monarchy. So one of the fundamental problems about not understanding the limits on executive power is that we're not doing a very good job of talking together in common about all the ways that all 3 branches of government should be limited. But let's go back to Senator Coons' point about personnel. I sit on the Armed Services Committee as well, and one of the things that we do there, I don't know, every second week maybe, is that we have confirmation votes of dozens, scores, sometimes hundreds of promotions and flag officers. And why do we do that? It's because there are all sorts of constraints on executive power at the level of personnel. And when somebody is getting promoted in the Navy, or when somebody's getting promoted at the Air Force, the Congress actually has oversight of that. And because that process works so well, because there is so much collegiality between the legislature and the executive branch, it tends to not turn up on TV. It's often a pretty pro forma moment at the start of our hearings, even though any senator, Republican or Democrat, that wants to delay the promotion of those officers, we can do that because almost all that stuff is moving by consent. So there are things where there's unity in hiring or in promotion. It's just a lot of that is non-controversial, so it doesn't end up salacious. It doesn't end up on TV. Jump in, please. I know you're trying to say something.
I think that's an important addition, is that the president, and this goes to Senator Coons as well, does not have the unilateral power to, under the Constitution, to appoint even members of the cabinet, which, if you were thinking of a monarchy, of course you'd be able to dispense offices and dispense. You can't create offices, first of all, and can't unilaterally fill even Secretary of Defense or Secretary of State because the framers were so concerned about overbroad executive power that they required Senate confirmation for even those positions who, if confirmed, then become executive officers. That's another really hugely important check on the executive branch, which is a reality. And of course, the confirmation process for executive officers, as you say, becomes a part and parcel of the oversight in many ways. And I think that's very important. And I think I spent a little too little time. I mentioned it on appropriations, but that's the lifeblood of the government, of course, is the money that causes the government to, allows the government to be able to operate in terms of without money, you can't do things, and a president does not have the unilateral power to appropriate money. And so Congress ultimately, through that appropriations power, and you all know this better than anyone, can restrict activities of the executive branch in multiple ways. And I think that's an important thing that Hamilton also talked about. So Congress has substantial power. Now, that's not to say the president has large powers, of course, under the Constitution, but what we sometimes forget, and I think your civics lessons are a reminder, that all these checks and balances work together, including on judges, in a way that has served the test of time, but could always be improved in some respects, I suppose.
And one of the reasons that the executive branch seems so powerful right now is, again, because of how weak the legislature is. I mean, it's a fundamental part of why we have the term president. In the 1780s, this wasn't a very common term in the English language. President was just a nounified form of the name presiding officer, and we made it up. Our founders made it up so that we wouldn't have a term that sounded a lot like a king. And so we wanted to be sure that the term presiding officer sounded pretty boring and administrative because the legislative, the policymaking powers were supposed to sit in this body, and the Article II branch is supposed to preside over and execute the laws that have been passed. It's not supposed to be the locus of all policymaking in America, but one of the reasons we have some of these problems with so many of these executive agencies is because Congress regularly doesn't finish its work, punts those powers to Article II, and then it's not clear who who exactly can execute all those authorities. And so we end up with this debate about the unitary executive, and you had a different term for it. But unpack for us a little bit why you have a different view about both the prudence and the constitutionality of one-person-headed independent executive agencies or pseudo-independent agencies versus commission structure-headed independent agencies.
The traditional independent agencies that were upheld by the Supreme Court and Humphrey's executor in 1935 are multi-member independent agencies. And so usually, sometimes 3, 5, occasionally more, but they're multi-member independent agencies. And that's been all the way through. And then for the significant independent agencies, the CFPB, and I had it's not my role to question the policy or to question the creation of the new agency. In fact, I think it was designed for efficiency and centralization of certain overlapping authorities. It's not my role to question that policy. Someone challenged the fact that it was headed for the first time on something like this by a single person. And a couple things then I wrote about in my dissent in that case. I'll just repeat what I wrote in the dissent. I said, first of all, that's a departure from historical practice of independent agencies, and that matters according to the Supreme Court. They had a previous case involving the PCAOB where they had different innovation there. The Supreme Court had struck down in part because of the novelty of it. So departure from historical practice matters because precedent always matters, including executive precedent. Then a diminution of presidential authority beyond the traditional independent agencies in this sense. With the traditional independent agencies, when a new president comes in office, almost immediately the president has been given the authority to designate a new chair of the independent agencies. So when President Obama came in, was able to designate new chairs of the various independent agencies, and the chairs, of course, set the policy direction and control the agenda. That's historically been the way. That does not happen with the CFPB. And finally, having a single person, just going back to Liberty, who's in charge, who's not removable at will by anyone, not accountable to Congress, in charge of a huge agency, is something that's different and has an effect on individual liberty. So a single person can make these enormous decisions, rulemakings, adjudications, and enforcement decisions, all of them. And from my perspective, I'm just repeating what I wrote here. I'm not intending to go beyond what I wrote in that opinion. That was an issue of concern. And I did put in a hypothetical because it seems abstract that I think we'll realize this issue with that agency or any other when a president comes into office and has to live for 3-4 years with a CFPB director appointed by the prior president. And then I think everyone's going to realize, of a different party in particular, and then I think everyone's going to realize, wow, that's an odd structure. Now, maybe not, but that's what I wrote in my opinion, that will seem very weird because that's not what happens with all the traditional independent agencies. And so whenever any president leaves and is appointed in the last 2 years, the CFPB director, the new president might campaign on consumer protection. Let's imagine, presidential campaign candidate campaigns on consumer protection and consumer issues, and then comes into office and can't actually appoint a new CFPB director for the whole term of his or her office. That's going to seem, I think, quite odd structurally. At least that's what I said in my opinion. Again, not intending to go beyond what I said in my opinion.
So is it fair to say that if you have a single person-headed agency and the president doesn't have the authority to hire or fire this person, that person having policy-making functions, executive functions, and judicial functions functionally becomes a fourth branch of government? Because who are they accountable to? Is that a fair summary of the concern?
Absolutely, that's a fair summary. It branch unto itself.
I want to ask unanimous consent to enter into the record, Mr. Chairman. I've got a letter from several dozen legal scholars. They're professors that teach at Harvard, Stanford, Yale, Duke, Northwestern, and other schools. Diverse group of folks, very varied politics and legal scholarship. But a few of their quotes I want to include here are that they all, quote, agree that Judge Brett Kavanaugh displays outstanding scholarly and academic virtues, and that he would bring to the court an exceptional record of distinction in his judicial service. As well, Judge Kavanaugh's long record of teaching and mentoring students of diverse backgrounds is to be applauded. And, quote, Judge Kavanaugh would continue to help build productive bridges between the bench, legal practitioners, and the academy, close quote. Mr. Chairman, can I ask unanimous consent? Chairman, can I ask unanimous consent to include it? Thank you. I have a series of questions I'd like to ask you about both precedent and the First Amendment, but I'm going to be out of time too soon, so I'm going to do some smaller ball stuff first and save for the next round. I'd like to go back to the Kagan quote on Scalia and the "we're all textualists now" point. What's a fair way to characterize the position that folks would have held before Justice Kagan said, we've all become textualists now? When there were non-textualists, who were they and how does it make any sense? What's the fairest construction you can put on it?
Well, I think one way to describe it is that judges would try to figure out what the general policy was reflected in the statute and then feel free to shape the particular textual provision in a way that the text itself wouldn't bear to serve that broad policy end. And so I think that's probably one way to think about it. Another way is that judges would sometimes use a snippet of a committee report or a floor statement and say, that's really what Congress was getting at in terms of the statute, and therefore we're going to follow that committee report or floor statement rather than following the text of the statute. So that's another way, I think, in which judges would depart from the text of the statute. And that mode of statutory interpretation, I do think Justice Scalia had a very profound effect on the Supreme Court itself and the lower courts in particular. And one of the things Justice Kagan said in that speech was he probably didn't get 100% of what he wanted in terms of moving the statutory interpretation, but he got pretty darn close in terms of moving the ball in his direction, and that everyone really does pay attention to the text. And if you sat in my court for a week and listened to argument after argument, which I do not recommend, Senator, but if you did that, you would hear judge after judge saying, well, what about the text of the statute? What about Clause 2 of the statute? Every judge is focused on the text of the statute, again, because that's what you've passed, and that's what matters under the Constitution, and because we know the compromises that are inherent in any legislative product, and we have to respect that compromise.
So I think one of the things that concerns me about the way we've talked about your nomination and a lot of media reports about it is that it's been said that you've been nominated to the so-called swing seat on the court. I think two ways that we can go wrong. One of them are thinking about judges as Republican versus Democrat, and you are supposedly, because you've worked in Republican White House, you've worked in the George W. Bush White House, and because you're being nominated by a Republican president today, there are a whole bunch of people who say, heck yeah, we won the election, we get our guy on the court, we're your jersey, you're supposed to be a Republican when you're on the bench. And then there are other people, I think that's a terrible view, there are other people who say, well, hopefully he can grow in office, and because he's going to be nominated and confirmed to the swing seat, the Kennedy vote, the Powell vote on the court, he will be big enough to rise above all the muck of politics. And when there are really big issues facing the country that get to the court, at least in a 4-4 court, this could be the guy who rises to the level of giving us Solomonic wisdom and functioning not just as a judge, but maybe as a quasi-kingly figure. What do you say to people who have a conception of a swing seat on the court? What does that mean?
Not entirely sure what it means to individual people who use that term.
Are you being considered for the swing seat?
I am being nominated to replace Justice Kennedy, who was his own man, as am I, my own judge, and I've talked about his jurisprudence and his devotion to liberty, which he found as the unifying theme of all the constitutional provisions, and as I said, established a legacy of liberty for ourselves and our posterity as the framers established this Constitution to secure the blessings of liberty for ourselves and our posterity. But I've read that he publicly in public statements didn't like that term, and I'm not sure I always know what people mean by that term. As I said repeatedly, but I really believe it, I think of the court, at least if I'm on it, as I think of the court, period, as a team of 9. And if I'm on it, I'm fortunate enough to be confirmed. I think of myself as trying to be a team player. I do think things through a sports lens sometimes, as I know you do too, Senator. And I think that's important. I'm not naive. There'll be cases where people divide, but I do think that mindset and that attitude matters in any collegial body, and the court is a collegial body. And so different cases.
I'm only interrupting you because I watched the chairman pull his little gavel.
Yes.
And if I don't get my question in before the bell, I'm done. So I can get one more off if I fire fast.
Make sure it's a short question.
Yes, sir. When I was writing my dissertation, I struggled to find my voice at one point, and I had an advisor who was great. He said, put an 8x10 picture up next to your keyboard and make it be somebody that you're writing to every day, and make it be somebody who's smarter than you but knows nothing about your topic. This was great advice. I took a picture of my aunt from one of the farms I used to work on when I was a kid, and she's far smarter than I am. She didn't know anything about the topic I was writing about, and it was an incredibly helpful device for me to every day figure out who I was writing to that day. When you write your opinions, who are you writing for?
Multiple audiences, Senator. I'm thinking first and foremost about the litigants before us, and I want the losing party in particular to respect the opinion. They're not going to agree with it by definition, but I want them to respect the opinion, the clarity of the opinion, the thoroughness of the opinion, the fact that I understood the real world consequences, that I grappled with the law, that I grappled with the best arguments. So I want the losing party to come away saying, he got it. As a litigant, I knew how important that was when I lost. At least I felt like I got a fair shake. Why does that matter? Both due process in the individual case, but it builds overall confidence, I think, in the judiciary to know you're getting a fair shake even when you lose. I'm also writing for the parties affected by the decision. So we decide cases and controversies, but we write opinions that have precedential effect, as we've discussed often. So the opinions need to be clear. They need to be organized. They can't, if there's a screwed up footnote or something, that's going to cause, I've seen it in my executive branch and private practice experience, that's going to cause all sorts of complications. So to get it just exactly right is so important, which takes draft after draft after draft. But I'm thinking about the affected parties, whether it's agencies or regulated parties or the criminal defense bar or the prosecution or the U.S. Attorney's Office. I'm always thinking about that. I'm thinking about someone like you, I think similar to your model, someone who just picks up the decision and is a lawyer, and I want them to be able to read it and understand it and get it and to be able to follow it. So I always try to have an introductory paragraph or a few pages, as you've seen in a few of them, like the PHH case is a long introduction, where they could just read the introduction, say, I got it, and then they can read the whole thing if they want. I think that's very important as well. I'm writing, I think about students. So students, where do they learn law? They learn law oftentimes by reading opinions. I've taught for 12 years, and I certainly understand the value of teaching, but teaching through your opinions, that's not the first thing I'm thinking about, but that is, okay, could a student learn from this about the criminal, the Fourth Amendment, or learn about the First Amendment if they read my opinion? If I give to Senator Coons' conversation, if I give the historical backdrop of the independent agencies, maybe a student will pick that up and think that's good. And then I think also about professors as well, not in a sense of trying to convince necessarily, if it's not something convincible, but the sense of professors are thinking for years about things I might, by definition, have a week or two or 4 to spend. And so and they're writing treatises and law review articles, and I want them to at least be able to understand and help look at my opinions to build the body of law. Thank you. I'll end. Thank you, Chairman.
How come you didn't ask that question first?
You told me to ask last.
We're going to take a 10-minute break, but if you can be back in 5 minutes, it would benefit Senator Blumenthal.
Yes. Okay. I'll do it.
Senator Blumenthal.
Thanks, Mr. Chairman. Good afternoon, Judge. I want to begin by talking about the elephant in the room, non-theoretical. The President of the United States, who has nominated you, is an unindicted co-conspirator implicated in some of the most serious wrongdoing that involves the legitimacy of his president. There's a distinct possibility, even a likelihood, that issues concerning his personal, criminal, or civil liability may come before this Supreme Court as early as the next term. The issues may involve his refusal to comply with a grand jury subpoena or to testify in a criminal trial involving one of the officials in his administration or his friends, or even his own actual indictment. We're in uncharted territory here. It is unprecedented for a Supreme Court nominee to be named by a president who is an unindicted co-conspirator. In the U.S. versus Nixon case, 2 of the justices had been appointed by Richard Nixon, but not while he was an unindicted co-conspirator. I would like your commitment that you will recuse yourself if there is an issue involving his criminal or civil liability coming before the United States Supreme Court. In other words, will you take yourself out of ruling on any of the issues involving his personal criminal or civil liability?
Senator, one of the core principles I've articulated here is the independence of the judiciary, which I know you care about deeply too, and I think undergirds some of your comments yesterday. And the independence of the judiciary is critical to the confidence of the American people in the judiciary and to the rule of law in the United States. But one key facet of the independence of the judiciary, as I've studied the history of nominees, is not to make commitments on particular cases.
I'm not asking for a particular commitment, and I'm going to take your answer as a no. It's really a yes or no question. You will not commit to recuse yourself. You will not commit to take yourself out of that decision despite the unique circumstances of your nomination?
Senator, I think to be consistent with the principle of independence of the judiciary, I should not and may not make a commitment about how I would handle a particular case, and the decision to participate in a case is itself a decision in a particular case, and therefore following the precedent set by all the nominees before me, I need to be careful. And again, you may disagree with this, but this is part of what I see as independence of the judiciary.
Well, I do disagree, and I am troubled and disturbed by your refusal to say that you will take yourself out of that kind of case. I want to move on to some examples of real-world impacts on real people, and taking that as a factor, as you've articulated it, in the decisions that you've made. I want to talk about Jane Doe in Garza v. Hagen. As you know, she was a 17-year-old unaccompanied minor who came across this border having escaped serious, threatening, horrific physical violence in her family, in her homeland. She braved horrific threats of rape and sexual exploitation as she crossed the border. She was 8 weeks pregnant. Under Texas law, she received an order that entitled her to an abortion, and she also went through mandatory counseling as required by Texas law. She was eligible for an abortion under that law. The Trump administration blocked her. The Office of Refugee Resettlement forced her to go to a crisis pregnancy center where she was subjected to medically unnecessary procedures. She was punished by her continued request to terminate her pregnancy by being isolated from the rest of the residents. She was also forced to notify her parents, which Texas law did not require. And the pregnancy, which was 8 weeks, was 4 weeks further when you participated on a panel that upheld the Trump administration in blocking her efforts to terminate her pregnancy. The decision of that panel was overruled by a full court of the D.C. Circuit Court of Appeals. It reversed that panel, and the decision and opinion in that case commented, quote, "The flat barrier that the government has interposed to her knowing and informed decision to end the pregnancy defies controlling Supreme Court precedent." And it said further, "The government's insistence that it must not even stand back and permit abortion to go forward for someone in some form of custody is freakishly erratic." In addition to being erratic, it also threatened her health because she was unable to terminate her pregnancy for weeks that further increased the risk of the procedure. One study said 38% every week. Her health was threatened. She was going through emotional turmoil. And yet, in your dissent, you would have further blocked and delayed that termination of pregnancy. All of what I've said is correct as to the facts here, correct?
No, Senator, I respectfully disagree in various parts. My ruling, my position in the case would not have blocked.
It would have delayed it. And it would have set it perilously close to the 20-week limit under Texas law, correct?
No, we were still several weeks away. I said several things that are important, I think. First,
well, I want to go on because I can read your dissent, but I want to go to...
Well, but you read several things respectfully. First of all, I think the opinion was by one judge that you're reading from. That was not the opinion for the majority. Secondly, I was trying to follow precedent of the Supreme Court on parental consent, which allows and some delays in the abortion procedure so as to fulfill the parental consent requirements. I was reasoning by analogy from those. People can disagree. I understand on whether we were following precedent, how to read that precedent, but I was trying to do so as faithfully as I could and explain that. I also did not join the separate opinion, the separate dissent that said she had no right to obtain an abortion at all. I did not say that. And I also made clear that the government could not use this immigration sponsor provision as a ruse to try to delay her abortion past, to your point, the time when it was safe.
Let's talk about your dissent in just a moment. But first, I want to talk about a list. It's the list that Donald Trump circulated in May of 2016 of his potential Supreme Court nominees. May of 2016. Mm-hmm. Was your name on that list?
It was not.
And then he circulated another list in November of 2017. Another list of Supreme Court nominees. November 2017. Was your name on that list?
2017, yes. There was another list in the interim between those two. But.
And his litmus test for that list was that a justice that he'd nominate would have to automatically overturn Roe v. Wade, correct?
I'm not going to comment on what he had said. Whatever he had said publicly.
He said it.
Yeah.
That's not in dispute. And in between,
I'm not sure the exact words you just used are consistent with what he said, but whatever he said publicly will stand in the record.
Exactly. October of 2017, your decision and dissent in Garza occurred, correct?
It did, but that case came to us in an emergency posture. I didn't seek that case. That was not a speech. I was driving home on a Wednesday night, as I recall, and the clerk's office called and said, we have an emergency abortion case, which is very unusual in our court. First time I'd had one.
Okay. What occurred then between May of 2016 and November of 2017, besides your Garza dissent, that put you on that list?
Well, Mr. McGahn was White House counsel, and the president had taken office by then, if I'm looking at the dates. I think I got it. May.
We can hold it up higher.
No, that's okay. I got it now.
So
I'm just missing the interim list. But so President Trump had taken office. Mr. McGahn was White House counsel. Those are just facts. And then what else happened?
It's a mystery.
No, it's not a mystery. I'm just debating whether I want to say. But a lot of judges and lawyers who I know.
Let's talk about your dissent.
Can I answer the question? Can I answer the question?
I want to talk about your dissent.
But I had an answer to your question. You said what else happened, and I have an answer.
Go ahead.
A lot of judges and lawyers I know made clear to, I think, various people that they thought I should at least be considered based on my record for the last 12 years. And colleagues of mine thought I should be considered. And I think that, I appreciate that.
And maybe more than a few of them cited your dissent in Garza.
I think it had happened long before that, actually.
Well, let's talk about the dissent, though. In that dissent, 3 times, you used the term abortion on demand. Abortion on demand, as you know, is a code word in the anti-choice community. In fact, it's used by Justices Scalia and Thomas in their dissents from Supreme Court opinions that affirm Roe v. Wade. They've used it numerous times in those dissents, and it is a word used in the anti-choice community. And in addition, in that dissent, you refer to Roe v. Wade as existing Supreme Court precedent. You don't refer to it as Roe v. Wade protecting Jane Doe's right to privacy or her right to an abortion. You refer to it as existing Supreme Court precedent, not Supreme Court precedent, existing Supreme Court precedent. Now, I don't recall seeing a judge refer to existing Supreme Court precedent in other decisions, and certainly not commonly, unless they're opening the possibility of overturning that precedent. It's a little bit like somebody introducing his wife to you as my current wife. You might not expect that wife to be around for all that long. My current wife, existing Supreme Court precedent. And throughout your opinion, you're careful to never say that the Constitution protects the right to choose. You concede that the parties have, quote, assumed for purposes of this case, end quote, that the plaintiff has a right to end her pregnancy, but not that she actually has that right. You write, quote, as a lower court, our job is to follow the law as it is, not as we might wish it to be.
Well, there I have to interrupt, Senator, because I was referring to the parental consent cases as well, which I just talked about at some length there. And my disagreement with the other judge was that I thought I was, as best I could, faithfully following the precedent on the parental consent statutes, which allowed reasonable regulation. As Casey said, minors benefit from consultation about abortion. That's an exact quote from Casey. And the Supreme Court had upheld those statutes even though they occasioned some delay in the abortion procedure. And Justices Marshall, Brennan, and Blackmun dissented in those. And so on existing Supreme Court precedent, I put it all together, Roe v. Wade plus the parental consent statutes. And I said different people disagree about this from different directions, but we have to follow it as faithfully as possible. And the parental consent was the model, not the model, the precedent. And can I say on abortion on demand, I'm not familiar with the code word. What I am familiar with is Chief Justice Burger in his concurrence in Roe v. Wade itself. So he joined the majority in Roe v. Wade, and he wrote a concurrence that specifically said that the court today does not uphold abortion on demand. That's his phrase, and he joined the majority in Roe v. Wade. And what that meant in practice over the years, over the last 45 years, is that reasonable regulations are permissible so long as they don't constitute an undue burden. And that's been the parental consent, the informed consent, the 24-hour waiting period, parental notice laws. And that's what I understood Chief Justice Burger to be contemplating and what I was recognizing when I used that term. I'm not familiar
Well, it
with
also
code words.
was a signal. Let's be very blunt here. It was a signal to the Federalist Society and the Heritage Foundation and to the preparers of those lists. The President outsourced that task to those groups that you were prepared, and you are, to overturn Roe v. Wade. Abortion on demand has a very specific meaning in the dissents after Roe and the concurrences, existing Supreme Court precedent, and reference to that precedent, not as you wished it to be, but as the law, Supreme Court precedent existing now, required. Is it a fact, Judge, also, that while you were in the Bush White House, you took the position that not all legal scholars actually believe that Roe v. Wade is the settled law of the land and that the Supreme Court could always overturn it as precedent? And in fact, there were a number of justices who would do so.
I think that's what legal scholars have, some legal scholars have undoubtedly said things like that over time. But that's different from what I, as a judge, my position as a judge is that there's 45 years of precedent, and there's Planned Parenthood versus Casey, which reaffirmed Roe. So that's precedent on precedent, as I've explained, and that's important. And that's an important precedent of the Supreme Court. It's not the only. It's not the only precedent, though. In Casey, it's very important to understand, I think, and it goes to your point about existing. Planned Parenthood versus Casey reaffirmed Roe, but at the same time upheld Pennsylvania's waiting period, its informed consent provision, and the parental consent provision of the Pennsylvania law. And Justices Blackmun and Stevens dissented from that part of the decision in Planned Parenthood versus Casey. That was Justices Kennedy, O'Connor, and Souter who upheld that. So in many ways, Casey reached, in applying the undue burden standard, reached a position that allowed some reasonable regulation, as the court put it, so long as it doesn't constitute an undue burden. And so existing Supreme Court precedent is the body of precedent on the regulations, too. It's Roe, but then what regulations, and that's the body of existing Supreme Court precedent.
And that's exactly the point here. You were telling the Trump administration that if they wanted someone who would overturn Roe v. Wade, you would make the list. These were your bumper stickers in that campaign. Abortion on demand, existing precedent, law not as it necessarily was as you wished it now.
Well, I'll just say two other things, Senator. One, I did not join the separate opinion of another dissenter who said that there was no constitutional right at all for the minor in that case. I did not join that opinion. And secondly, I'll say three things. Secondly, I said in a footnote, joined by Judge Henderson and Judge Griffith, that my whole dissent was joined by both of them, that the government could not use this transfer to the sponsor procedure as a ruse to delay the abortion past unsafe time.
You didn't join that dissent, but let me ask you now.
And I said thirdly, that if the 9 days or 7 days expired, that the minor, at that point, unless the government had some other argument, it had not unfolded yet that was persuasive, and since they hadn't unfolded it yet, I'm not sure what that would have been, that the minor would have to be allowed to obtain the abortion at that time. So the whole point was simply, and it wasn't my policy, my question was to review the policy set forth by the government, and the question was that policy consistent with precedent? And it was a delay, undoubtedly, but a delay consistent, as I saw it, with the Supreme Court precedent on parental consent provisions.
Well, let me just ask you then, can you commit, sitting here today, that you would never overturn Roe v. Wade?
So, Senator, each of the 8 justices currently on the Supreme Court, when they were in this seat, declined to answer that question.
I understand your answer. You've given it on other issues before. But you can understand also, given what we've seen in Garza and the pattern here of sending a signal about your willingness to overturn Roe v. Wade, that your response leaves in serious question your commitment to this precedent. And in fact, given the real-world consequences here, a young woman's health was put in serious jeopardy. She came close to being unable at 20 weeks to even have the opportunity to terminate her pregnancy. She was deprived of options because of that wait, and you would have delayed it further and perhaps completely. And I think that you needed to send a message to the Trump administration that you should be on that list. Let me move on to other health care issues. You've taken the position in Seven Skies, and I'm going to put up a poster. That the president's authority, under the Constitution, the president may decline to enforce a statute that regulates private individuals when he deems the statute unconstitutional, even if a court has held that, or would hold, the statute constitutional. Under the Affordable Care Act, as you know, there are protections for millions of Americans who suffer from pre-existing conditions. That protection has real-world consequences. Pre-existing conditions include Alzheimer's, arthritis, congestive heart failure, Crohn's disease, hepatitis, lupus, mental disorders. That's just a very partial list, including being pregnant. You have answered my colleague, Senator Coons, that you wouldn't say whether or not the president would have the power to strike down that statute unilaterally or decide that he would not enforce it because there's a case pending. Do you believe that the president can refuse to enforce that statute even if the United States Supreme Court upholds it?
Senator, a couple things. First of all, just to close out the prior discussion, you said delayed completely. That's not what I said. In fact, I said it could not be delayed past the point of a safe time. I just wanted to close the loop on that and make clear the record on that. On this, I was referring to the concept of prosecutorial discretion. And this is in a broader, which is established by United States versus Richard Nixon case, which says the executive branch has the exclusive authority and absolute discretion whether to prosecute a case. That's an exact quote from U.S. v. Nixon, if I'm remembering correctly. And then in Heckler v. Cheney, the Supreme Court says that that principle applies to civil enforcement as well. And so that's the precedent of the Supreme Court that I was referring to and explained later in Aiken. But why did I have that in there at all? I was in the Affordable Care Act case, I wrote a decision saying that the court should not consider it at that time because it was not ripe under the Anti-Injunction Act, and that we should wait to consider it when.
But here's my question to you. The enforcement of the Affordable Care Act is a matter of prosecutorial discretion. And my question is, even if the United States Supreme Court in that Texas case should hold it to be constitutional, could President Trump decline to enforce it and put at risk the health of literally tens of millions of Americans, including 500,000 people in Connecticut who suffer from those diseases, including those homeless people who come to the shelter where you distribute meals?
So a couple things on that, Senator. The concept of prosecutorial discretion, as you know, of course, former U.S. attorney, is well rooted in American law. So if a U.S. attorney decides we're going to go after bank fraud and not after low-level marijuana, that's classic prosecutorial discretion.
But we're not talking about that discretion. We're talking about the president saying that law, the Affordable Care Act, or for that matter, civil rights statutes, which this president, unfortunately, could decide he's not going to enforce, or consumer protection statutes, or even anti-corruption statutes. We're talking about statutes that, as you said here, regulate individuals, and they protect them. Simply because he deems them unconstitutional, refuse to enforce them. Not in selected cases, across the board.
A couple things, Senator. First of all, for a few of your examples, of course, there are private causes of action as well.
There are private causes of action, but the government is the chief enforcer.
I agree with that. I'm not disputing that. On prosecutorial discretion, what I said in the subsequent Aiken County case, I elaborated on that, but then a subsequent Marquette speech that's published in the Marquette Lawyer that you have, I indicated that the limits of prosecutorial discretion are uncertain, and it would be important for academics and others to study that history and figure out what the limits are. So, for example, in the deferred, in the immigration
my point
context,
is there are no limits here.
but that's what the Supreme Court, if you look at the quote in United States versus Richard Nixon, which I know you've read, it says the executive branch has the exclusive authority and absolute discretion whether to prosecute a case. Now, Heckler v. Cheney refers back to that, cites that, and that's in the civil context. There's some limits, presumably on prosecutorial discretion, but this came up in the immigration context in President Obama's administration. That's still something I won't comment on directly, but there are always questions about prosecutorial discretion of...
Well, let me just point out, and I apologize for interrupting you, but my time is limited. In Seven Sky v. Holder, in your dissent, you said under the Constitution, this is in your dissent in that case, you cited Justice Scalia in Freytag versus Commissioner as your authority.
Yes.
The president may decline to enforce a statute that regulates private individuals when the president deems the statute unconstitutional, even if a court has held or would hold the statute constitutional. I'm going to leave this topic. I hope we'll have an opportunity to return to it tomorrow. And I want to talk about the Second Amendment and your position on gun violence prevention. As you know, my state has a tragic history and experience, recent, with this issue. But literally every community in the whole country has some experience with gun violence prevention because 90 people every day die from it. And I am deeply troubled by your position on this issue that history and tradition govern here, that any weapon in common use is protected. The reason that some weapons are not in common use is that they are banned, like machine guns. If our standard is going to be whether assault weapons are in common use, we're going to have more and more of them. And they are in common use. They are commonly used to kill people. That's what they were designed to do. So I want your explanation as to how possibly you can justify requiring that gun violence protection statutes have to be longstanding or traditional, and that they cannot in any way protect people from weapons, assault weapons, that are, as you put it, in common use, because they're in common use only because they are not in any way regulated for public safety.
As you need to answer that question. Okay. And then when you're done answering that question, I'm going to call on Senator Flake.
Okay. A few things, Senator. First, at the end of my Heller opinion, I pointed out that I grew up in this area, and this area has been plagued by, in the 70s and 80s, plagued by gang and gun drug violence, and it's known for a while as the murder capital of the world. So I understand and appreciate your initial comment on that. Secondly, where did I get the test? I got it right out of the Supreme Court's opinion in Heller, which uses those exact phrases and then elaborates on those in the subsequent McDonald's case. And I know people passionately disagree with the Supreme Court's decision in Heller and with the Supreme Court's decision in McDonald, but as a lower court judge, I'm following all the precedent. I'm not a cafeteria where I can pick which precedents I want to apply. I have to apply all the precedent. I did that. I explained it in painstaking detail why I thought the test I was applying was appropriate in that case, and went through the test. I made clear that the Supreme Court, Part 3 of Justice Scalia's majority opinion in Heller still allowed a lot of gun regulation. Machine guns can be banned. Laws, traditional laws, felon in possession, concealed carry were identified there. Laws prohibiting guns possession by the people with mental illness, government buildings, schools, those are all pre-identified. And then it's important to point out also the footnote in Heller says this list is not meant to be exhaustive. And so I think that's guidance to the lower court when applying that test. As Chief Justice Roberts said at the oral argument in Heller, you reason by analogy from those historical exceptions and regulations, and that's something that I think is appropriate, and I said in my opinion. But ultimately, I had to apply the test to the Supreme Court, and I understand people may disagree, A, with the Supreme Court opinion, or B, with how I applied it, but I tried to do it as faithfully as I could.
Senator Flake.
Thank you, Mr. Chairman. Thank you, Judge. Thank you for your...
Hey, wait a minute. Would you please start his time over? Judge, you've been attacked for this short footnote that you wrote in the Affordable Care Act case about when a president may decline to enforce the laws passed by Congress. But in a different opinion, you actually ordered the executive branch to comply with the law. You wrote, quote, "It is no overstatement to say that our constitutional system of separation of powers would be significantly altered if we were to allow executive and independent agencies to disregard federal law," end of quote. Obviously, you do not think the president has a blank check to ignore the law. Senator Flake.
Thanks. Always happy to defer, Chairman. I appreciate your endurance here today, Judge. And let me just ask, you've mentioned your mother as one of your judicial heroes. Who else would you put on that list? What people do you admire and why?
My mom, as you mentioned, of course, trial judge, real world consequences, real people in the real world, and saw her operate her courtroom with firmness and civility, and was well respected as a prosecutor first and as a judge, and her civility and work ethic or something, and remembering that cases have real world consequences. Justice Kennedy, as I've mentioned, model of independence, fiercely defended judicial independence throughout his career, model of civility and collegiality. You can look in 30 years of his opinions, and what's the harshest thing ever written? It's not, you can't find it. Just a model of civility in his judicial opinions. Oral argument, always so courteous to counsel. In his public speeches, someone who always celebrated the Constitution and its protection of individual liberty, and showed by his example, I think, how to conduct oneself as a judge off the bench. When I became a judge, and I was sworn in May 30th, 2006 in his chambers, and he said, you're going to go back and you're going to feel soon, you're going to feel lonely. You've been doing this job at the White House. It's all energetic, and you're going to feel quiet. And he said, you get out and teach. And he's taught since 1975, I believe, when he became a Ninth Circuit judge. And I followed that example. And teaching's been an important part of my life. So he taught, he instructed that. He, the legacy of liberty he left for the United States is written all through the U.S. reports. Justice Scalia, someone I knew, and also a fierce adherent to the Constitution, and someone who changed statutory interpretation, as we've discussed, in terms of his focus on the text, but it was rooted in his appreciation for the Constitution and the rule of law. And he had, as he often said, but it's true if you look through his jurisprudence, the decisions where he ruled in ways that people did not expect, protection of the Fourth Amendment, for example, the thermal imaging case, Kelo, the Jones case on GPS tracking, First Amendment, Texas v. Johnson. He had a Hamdi, the dissent, so he was a fierce, also protector of individual liberty, even in a national security context. I look back to Chief Justice Rehnquist and Justice Jackson, for whom Chief Justice Rehnquist clerked, as two people who had experience in the executive branch and then came to the Supreme Court and I think became models of independence. Justice Jackson, of course, with his beautiful prose, also in cases like Morissette, Korematsu, and Youngstown, Barnett as well. Rehnquist, I think, such a firm but also affable manner. I wrote about Rehnquist. I gave a speech about him and wrote I refer to the fact The Brethren was this book that came out in the late 70s, very critical of, well, the sources were very critical of the Supreme Court, not saying the authors were, of some of the justices individually. But Rehnquist is referred to by all these terms throughout that emphasized his collegiality, and I think that's why he was such a hero. And then I'll end it with, anytime you look at the Constitution and you think about people who've had an effect on it and what it means today, you have to identify, and you should identify, Thurgood Marshall because of what he did as a justice, but perhaps even more. He had a huge record as a justice that's very important. And he was a real-world consequences person. I pulled up an old oral argument one time in a First Amendment case that was argued in the early 70s, and it was about ads on a bus, on the interior of a bus. And I guess it was political ads on the interior of a bus, and the question was whether they were permissible, and the First Amendment right to run these ads on the interior of the bus. And the worry was that they would be identified. It would look like the city was putting its imprimatur on the political candidate. And Thurgood Marshall started the oral argument. Why? Why are you banning them? And then they said, well, people might think that the city's endorsing the political candidate. And he said, do you really think people are that stupid? And it just showed he got the real world consequences in a way that no one else. But of course, his legacy is towering in terms of what he did as a litigator and helped, not single-handedly, but he had colleagues, but he helped bring the end of Plessy versus Ferguson and achieve the greatest moment in Supreme Court history in Brown versus Board. So I always think about Thurgood Marshall's legacy as well. So that's a much more long-winded answer than you expected, Senator, but appreciate you giving me the time.
That's important insight. I appreciate it. I had the opportunity to sit next to Anthony Kennedy last Saturday for John McCain's funeral, and I think all of us have the same opinion of his collegiality, friendliness, and that certainly is important. We'll talk about that a little later. I noted yesterday some concerns back to the real world here about an administration that does not seem to understand or appreciate the separation of powers or the rule of law. I worry that the president, the head of our executive branch, may be using executive power to advance personal political interests. Now more than ever, I think that we have to ensure that our institutions are independent and are firm against encroaching partisan politicking. There's nowhere important, obviously, than the judiciary. Alexander Hamilton famously wrote in Federalist 78, you've cited many times, that the judiciary is the least dangerous branch of government, based on the understanding that the judicial branch lacks what he said, but the power of the executive branch and the political passions of the legislature. I believe that if you are confirmed to the Supreme Court, I don't believe that you would erode judicial independence or otherwise disrupt the separation of powers between the three branches. You've been discussing your reverence for the separation of powers with us today, particularly the importance of keeping the judiciary the least dangerous branch by making sure that it stays apolitical. And I'll discuss that more in a moment, but specifically I'm a little concerned about the executive branch and the powers therein. And I reiterate some of the concerns that Senator Sass just identified. And in response to Senator Sass, you walked us through some of the founding documents, Constitution, Federalist Papers that endow the president with positive powers. You've also discussed today cases. You mentioned Youngstown, U.S. versus Nixon, those that you admire because they involved the judiciary standing up to the president and putting limits on executive power. These precedents certainly restrain presidential power. But I'm curious, what limits are there, if any, that would prevent a president from centralizing executive power and using it for his own political or personal purposes? What protections are there, statutory, constitutional, judicial, that are built into the system. Can you talk a little about that? We've talked about the positive things that give a president or endow the executive with power. What constraints are there?
First, Senator, there are the constraints built into the Constitution, which the appropriations power, the Senate confirmation power, which is often used, as you know, of course, as a way to restrain executive action, or at least to prevent not only to prevent the appointment of people for principal executive officers who might be the Senate might not approve, but also sometimes as ways of restraint.
Right.
There are also built into the constitutional. There's the ultimate remedies in the Constitution there's remedies for how judges can be removed, how members of Congress can be removed through the expulsion power, and how presidents can be removed. Those are built in. Those are the ultimate checks that are built into the constitutional system for all of us. There's no one who is guaranteed a permanent time because of the ultimate checks that are in the constitutional system as well. There are statutes then beyond the Constitution. And I didn't mean that to be an exhaustive list, but there are innumerable statutes that, of course, regulate presidential and executive branch conduct in all sorts of ways, whether it be statutes that regulate war powers, surveillance, detention, interrogation, the War Powers Act, statutes that regulate in the domestic arena, statutes that regulate the operations of government, Freedom of Information Act, Federal Advisory Committee Act, Inspector General's Act, that all are efforts by Congress, as has historically been understood, to make sure the executive branch does not operate in a way that Congress disapproves of. And their norms. Norms are important. I think norms, historical practices, Madison talks about that in Federalist 37. I think historical practice is relevant to judicial decision-making, as we've seen in a lot of judicial decision. But when I worked in the executive branch, one of the questions I always ask, and I ask as a judge, is how has this been done before? And I think that's always two things I always tell students, two things to always ask yourself. What does the text of the relevant law say? Regulation, code, statute, Constitution, and how has it been done before, which is really a question of precedent or norm within the executive branch or norms within Congress. Those are important as well. So I think there's constitutional and statutory structures as well as custom or norm that all constrain Congress and constrain the executive branch and constrain the judiciary as well.
You discussed with Senator Sass the danger of independent agencies that amass too much power in any individual. Mm-hmm. Would that not be true with the executive as well?
So that was the debate at the Constitutional Convention, Sarah, was whether to have a plural executive, in other words, multi-member executive, or to have a single president. And ultimately, the framers at the convention decided to go with and Wilson and Gouverneur Morris, James Wilson and Gouverneur Morris were really the architects of the presidency at the Constitutional Convention. And they ultimately convinced the others to go with a single president. But at the same time, the fear that you just discussed, or the concern is a better word to put, right, you just discussed, was certainly raised by people at the time. And that's why Hamilton wrote Federalist 69. Well, that's why they put all the checks into the Constitution, and why Hamilton wrote Federalist 69 to point out for the people who are voting on ratification all those differences between the king and a monarchy. And so that fear has existed throughout American history, I think, of a executive that's unchecked. And it's why, for example, the Supreme Court has been willing. Marbury is another case. President Jefferson, of course, is trying, is the one who loses in Marbury versus Madison. President Truman loses in Youngstown. President Nixon loses in United States versus Richard Nixon. Hamdi, national security is not a blank check for the president. That was President Bush.
Let me bring it up to today. You mentioned a couple of times that you live in the real world.
I try, yes. I work, that's important for a judge.
And let me bring it to the real world. This week, there was a tweet by the president that said, and I mentioned this yesterday, 2 long-running Obama-era investigations of 2 very popular Republican congressmen were brought to a well-publicized charge just ahead of the midterms by the Jeff Sessions Justice Department. 2 easy wins now in doubt because there is not enough time. Good job, Jeff. Should a president be able to use his authority to pressure executive or independent agencies to carrying out directives for purely political purposes?
Senator, I understand the question, but I think one of the principles of judicial independence that judges, sitting judges, and I am a sitting judge, and nominees sitting here need to be careful about is commenting on current events or political controversies. I don't think we want judges commenting on the latest political controversy because that would ultimately lead the people to doubt whether we're independent or whether we're politicians in robes. And so maintaining that strict independence of the judiciary requires me, I think, to avoid commenting on any current events.
All right, forget I just said that.
Well, I said I understand, but I just...
Just answer this question. Yeah. Should a president use his or her authority to pressure executive or independent agency officials into carrying out directives for purely political purposes?
Well, Senator, I think that hypothetical that you're asking is directly analogous to the current events, and therefore I hesitate to get in. It's also me commenting on something that's not a case or an issue or something I've written about, and I've thought about this principle as well and looking at all the nominee precedent of the Supreme Court nominees in the past. And I think about Chief Justice Roberts, and I think an underappreciated aspect of his chief justiceship is how he's fervently stood up for the independence of the judiciary and tried to keep the judiciary out of politics through what he does off the bench as well as on the bench. And I think he sets the tone for the entire American judiciary, and I think that tone of not getting us involved in politics means I need to stay not just away from the line, but 3 zip codes away from the line of current events or politics. And so I understand, but I respectfully decline.
Let me rephrase it a different way. If you have an executive who's abusing his or her authority by instructing independent agencies of government to use or to pursue political ends, are there any remedies other than the one that you mentioned, political remedy involving Congress? Or is there something short of that? And I understand your aversion, as many in this body had, I wasn't here yet, to the independent counsel statute that we did away with. You've expressed you're a little more sanguine about a special counsel. But what other remedies are there? And what other constraints are there on a president?
Well, the constraints are on the executive generally are important ones. The appropriations power is a huge check. That is an enormous check if employed as fully as it might be. The confirmation power of executive branch officials, the ultimate check, of course, that you referred to is always part of the system. And then just to be clear on the special counsel system that I've spoke approvingly of in the 1999 Law Journal article, and I've referred to in my PHH opinion just last year, the traditional system that exists. And then I have said what I said about the old independent counsel statute, but that was a statute that had a lot of parts to it. Right. And if a case came before me that had a different statute that you had enacted, or that statute, I would have an open mind about considering the arguments in favor of that and against it, of course. And so those are, that possibility is present to the Congress, of course, in general.
But if the president could fire an independent counsel or the special counsel, is that any restraint at all?
Senator, that hypothetical was tested, I suppose, in the September of 1973, if I have my month right. And might not have my month right, but it might have been a different month, but in 1973. And the system held.
Right. Thank you. We'll move on and maybe get back to this tomorrow. Conversation you and I had about separation of powers leads to a host of other related legal issues, including Chevron deference and agency overregulation. In your written opinions, you've suggested that you have concerns with Chevron deference. I share those concerns, as we spoke about. You've explained that Chevron deference can allow executive agencies to stretch the meaning of the law beyond what Congress intended. I think we've certainly seen that. You've also encouraged Congress, it can also encourage Congress to abdicate its legislative power by punting its lawmaking responsibilities to the other two branches. We've spoke at length about that in conversation with Senator Sass and others about our inability here in Congress to actually legislate on important issues. You were discussing with another senator our failure here to authorize war. I've had that frustration for years now, myself and Senator Tim Kaine and others trying to, unsuccessfully, to express Congress's opinion and to provide some kind of template, at least, if nothing else, for the executive branch to follow in terms of these long unauthorized wars. But that aside, your opinion suggests that a Chevron analysis has a two-part test, one determining if there's statutory ambiguity, and if so, determining whether an agency's interpretation of the statute is reasonable. So the real question when it comes to Chevron is not just whether to defer to an agency, but rather how a judge approaches statutory ambiguities. How do you know when a statute is ambiguous?
Well, that's a huge problem, Senator, and I think that's at the heart of the concern I have about how certain canons of statutory interpretation have been applied, including Chevron, legislative history, constitutional avoidance as well. They depend on a threshold finding of ambiguity. And after several years as a judge, I thought about why is it that I disagree with a colleague after a particular case? What is at the root of that disagreement? Because we're both independent judges, and why are we disagreeing? And it occurred to me in some cases that the disagreement is not about what the best meaning of the statute is or what the precedent says. The disagreement's about whether something's ambiguous. And then I would think about going to the judge's umpire vision that I believe in. How can we get neutral principles for determining ambiguity? And it turns out it's really hard to get neutral principles for how much ambiguity is enough. And there are two problems at the heart of that. First of all, just to try to reason through this, is 60% ambiguity enough, or 80% ambiguity, or 95% ambiguity? Where's your ambiguity trigger, so to speak? And then second of all, when applying whatever trigger you come up with, how the heck do you figure out whether a particular word or phrase or statutory provision crosses that ambiguity threshold? And this is something that Justice Kagan and Justice Scalia both have talked about in the past. Justice Kagan actually said at that same speech where she said we're all textualists now, she also said, some people just find ambiguity more quickly than others do, which I think is a true statement, observation of human nature, but also leaves the judge's umpire vision in real trouble in those cases, because if there's no neutral principles to determine ambiguity, then we're going to, and this is not a minor deal. So if you're in a case about deference to an agency, the fate of huge regulations can, so to give you the example, 3 judges could be sitting around after oral argument, and all 3 could agree, actually the agency's reading of the statute's not the best reading of the statute given the words, but 2 judges will say, I think it's ambiguous, and the third one says, I don't think it's ambiguous. So the two will defer to the agency, even though it's not the best reading of the statute. That can be a billion-dollar decision right there. Fate of huge regulations, rise or fall just on that. And one judge will say, well, I think it's not ambiguous. Well, I think it is. And there's not a great, in my experience, sitting in those conference rooms, a great neutral principle. And to my mind, that's a concern if you have, as I do, the idea that judges should be umpires and we should have neutral rules of the road. So that's something I focused on. I explained that at some length in that Harvard article. I know you and I talked about that as well.
Let's talk about the stare decisis precedent. You talked a little about, I think with Senator Lee, about 5-4 decisions. They have the same weight, same precedent as those decided unanimously. Kelo, 2005, was a 5-4 decision. Obviously concerning the government's ability to seize property for economic purposes. Those of us in the West are very concerned about issues like this. Arizona, for example, is 85% publicly owned when you take state, federal, and tribal property. Only about 15% of the state is in private hands. So decisions that the federal government makes, whether it's the legislative branch, executive agencies, or the judiciary, has an outsized impact on a state like Arizona. Judge Gorsuch, coming from the West, was familiar with many of these issues. You, serving on the D.C. Circuit, have addressed these issues more than perhaps others. Do you want to talk a little about that, about some of the Western issues or these issues, and Kelo in particular? That's a big concern out West.
So I think Kelo was something that was controversial in the East, too, in the Midwest and the West. In terms of its that decision.
Duly noted.
Yes, but I know it's a special concern in the West as well, and but it is a precedent in the Supreme Court. But to your point, I've had cases involving regulations. A couple of examples. One where a critical habitat designation based on a fairy shrimp that was found on a property, Otay Mesa case, and I wrote in that case that the statutory term was occupied, and the fact that you couldn't see it to the naked eye, that the fairy shrimp had been present in a tire rut 3 years earlier was not enough to designate a huge swath of.
You said it was the size of an ant or something?
I did, yes, Senator. So I had that case, and I think there I was just applying the statute as I saw it, but I was trying to do it in a way that understood the concern of landowners. I had another case, Carpenter's case it's called. It was another designation of land in the West, and the issue involves standing of someone who was deprived of their business because of the designation, and I found standing because I think it's important to understand that when something like that happens, there are lots of affected parties. I've talked about this in other cases like my Mingo Logan case when the government regulation, if it's law, the policy is not my concern, but in assessing standing, for example, or retroactivity, which was another case I had, you need to think about the affected parties, so businesses, workers, the coal miners in the Mingo Logan case, or the people in the lumber, the timber industry in the Carpenter's case. But I also sympathetic to the fact that Westerners don't think people in the East always understand what's going on with those designations. I put right in
Not even remotely.
Yeah, not even remotely. I grant you that. I tried to put out, in my opinion, something. I said, for Easterners reading this opinion, this is in the second paragraph of the opinion, for Easterners reading this opinion, the size of this designation is twice the size of the state of New Jersey. And I said, so if you're an Easterner, imagine driving up the New Jersey Turnpike and then all the way back down it, and you'll have some sense of what it would take to drive across this designation of land, which was just my way of saying, trying to appreciate what the effect of some of these things in the West.
Oh, getting back to precedent, when you're not on the Supreme Court, if you're in one of the lower courts, then you always look to the Supreme Court, and those precedents are of equal weight, I guess, any decision that's made. But when you're on the Supreme Court, precedent is only precedent until it's not precedent anymore, until there's a decision made. And my question, I guess, is what a decision like Kelo, decided in 2005, 5-4 decision, does it have the same weight as, say, Texas versus Johnson, decided in 1989 on the flag burning issue? How do you, what weight do you give it once you're on the high court?
Well, I think you start with principles that the Supreme Court itself has articulated about precedent. And those principles look at, of course, whether the decision is wrong, grievously wrong, whether the decision's inconsistent, deeply inconsistent with other legal principles that have developed around it. You look at the real-world consequences. To your point, the workability and real-world consequences. You look also at the reliance interests. Those are very important, the Supreme Court has said, in looking at precedent. But one of the things I'll say about Kelo, this is kind of a offshoot of your question, is that a lot of states in the wake of Kelo have enacted, or their state Supreme Courts have interpreted their own constitutions in a way that prevents takings of private property for what appears to be not the traditional public uses, but going to economic development for private parties. And so, again, I think I've cited this before, but Judge Sutton on the Sixth Circuit, his book, 51 Imperfect Solutions, is a great book about how state constitutions can, and state constitutional law and state statutes can enhance protection of individual liberty even beyond what the Supreme Court has interpreted the federal Constitution to be. That's not a direct answer to your question, but it is another way that the people who are affected can, who are upset about that kind of land use designation, can find protection.
Thank you, Mr. Chairman.
Senator Rana.
Thank you, Mr. Chairman. Mr. Chairman, I have some letters of opposition to Judge Kavanaugh's nomination. These are letters from Lambda Legal and 63 national, state, and local LGBT groups, from Earth Justice, from Muslim advocates, from 63 women lawyers and supporters of whole women's health, from Secular Coalition for America, and from Asia Pacific American advocates. I ask unanimous consent to enter these letters into the record.
Without objection.
Thank you. Judge Kavanaugh, Chief Justice John Roberts has recognized that, quote, the judicial branch is not immune, end quote, from the widespread problem of sexual harassment and assault, and has taken steps to address this issue. As part of my responsibility as a member of this committee to ensure the fitness of nominees for a lifetime appointment to the federal bench, I ask each nominee 2 questions. First question for you. Since you became a legal adult, have you ever made unwanted requests for sexual favors or committed any verbal or physical harassment or assault of a sexual nature?
No.
Have you ever faced discipline or entered into a settlement related to this kind of conduct?
No.
I started asking these questions about sexual harassment because it's so hard to hold lifetime appointees to the federal bench accountable, and because I did not want the Me Too movement to be swept under the rug. While Senator Hatch asked you some questions about this, I have some additional questions for you. Last December, 15 brave women came forward and shared their stories of sexual harassment and assault by former Judge Alex Kozinski. Some of them are detailed on the chart behind me. Very explicit allegations of sexual harassment and assault. We know from the reporting that Judge Kozinski's behavior was egregious and pervasive. It went on for more than 30 years. It affected law clerks, professors, law students, lawyers, and in at least one case, even another federal judge. And those are just the women who came forward. Judge Kozinski's behavior became so notorious that professors began to warn female students not to apply for clerkships with them. Judge Kozinski's behavior in this regard was an open secret. A short time after Judge Kozinski's accusers went public, the judge abruptly resigned, which effectively shut down the federal investigation into his misconduct. I do not think this was a coincidence. In 2008, in connection with another investigation into Judge Kozinski, The LA Times wrote a story about something called the Easy Rider Gag List, an email group that the judge used to send what the Times reported was, quote, a steady diet of tasteless humor, end quote. The report describes the list as made up of friends and associates, including his law clerks, colleagues on the federal bench, prominent attorneys, and journalists. Senator Hatch asked you if you were on this Easy Rider gag list, where Judge Kozinski would send inappropriate materials. Your response was that you don't remember anything like that. Are you telling us that you may have received a steady diet of what people on the list have described as, quote, a lot of vulgar jokes, very dirty jokes, but you don't remember it?
No, I don't remember anything like that, and I'm not.
Oh, the answer is no. Have you ever?
If I could elaborate.
I think that's a complete answer. Let me go on. Have you otherwise ever received sexually suggestive or explicit emails from Judge Kozinski, even if you don't remember whether you were on this gag list or not?
So, Senator, let me start with no woman should be subjected to sexual harassment in the workplace. And
Judge Kavanaugh, you already went through all of that, and I will get to your perspective about making sure that women in the judiciary do not get sexual harassed. I just want to ask you, during and after your clerkship with Judge Kozinski, did you ever witness or hear of allegations of any inappropriate behavior or conduct that could be described as sexual harassment by Judge Kozinski?
No, Senator, and there were 10. I worked in Washington D.C. There were 10 judges in the courthouse with him in Pasadena. Prominent federal judges in the courthouse with him. And we worked side by side with him day after day while he was chief judge of the Ninth Circuit.
To be clear, while this kind of behavior on the part of Judge Kozinski was going on for 30 years, it was an open secret. You saw nothing, you heard nothing, and you obviously said nothing. Judge Kavanaugh, do you believe the women who recently came forward to accuse Judge Kozinski of this kind of behavior?
I have no reason not to believe him, Senator.
So, let me just put this into a context, because you have testified that you basically saw no evidence of this kind of behavior at all. You never heard of it, but you worked closely with them on a number of projects. It wasn't just during the time you were clerking for him. You kept in touch with them while you were in the White House. He introduced you to the Senate at your 2006 nomination hearing, and he called you his good friend. Yesterday, you called each of the people who introduced you a friend, and I presume you felt that way about Judge Kozinski when he introduced you in 2006. You joined him for panels at the Federalist Society, where you patted him on the shoulder and said, I learned from the master about hiring clerks. And I believe I have a photo of that. Here's Judge Kozinski. You told us that you have hired many women clerks, how you are a mentor to women, how important you think it is for women to have a safe working environment where they feel that they can report sexual harassment. I conclude that you consider yourself an advocate for women. If a judge was aware that another judge was engaging in sexual harassment or sexual assault, would the judge have a duty to report it?
Had I heard those allegations, Senator, I would have done three things immediately. I would have called Judge Tom Griffith, who's on our court, who's on the Codes of Conduct Committee for the Federal Judiciary appointed by Chief Justice Roberts. I would have called Chief Judge Garland, who's chair of the Executive Committee. I would have called Jim Duff, who's head of the Administrative Office of the U.S. Courts. If for any reason I was not satisfied with that, I would have called Chief Justice Roberts directly.
So you believe that all judges who, including yourself, if you ever heard or any allegations about these kinds of behaviors, you would report it, you would go through whatever processes were set up by the courts to prevent this kind of behavior and to hold people accountable. And yet, someone that you've been close to, that you clerked, and I did go through the various encounters, more than encounters, that you had with Judge Kozinski, and yet you heard nothing, saw nothing, And obviously, you did not say anything. So let me just mention that this is why the Me Too movement is so important, because often in these kinds of situations where there are power issues involved, and certainly there are between judges and clerks, that often, it's an environment where people see nothing, hear nothing, say nothing. And that's what we have to change.
I agree with you, Senator.
That's good.
I agree completely. There need to be better reporting mechanisms. Women who are the victims of sexual harassment need to know who they can call, when they can call. They need to know first that the way
Judge Kavanaugh, perhaps if all of those situations or those processes had been in place over the 30 years that Judge Kozinski was engaging in this kind of behavior, maybe he would have stopped, but he did not. I have one more question, Judge Kavanaugh. Were you aware of the serious allegations of domestic violence against Rob Porter before you recommended him for staff secretary to Donald Trump?
There's a premise in there that I'm not sure is accurate.
The premise being that he engaged in domestic abuse?
No, the recommendation premise. But put that aside. No, I was not aware of those allegations until they became public, when there was the news reports about them.
Let me turn to another set of questions that I have for you. In 1999, you joined Robert Bork in writing an amicus brief in support of Harold Freddie Rice, who challenged the voting structure for Hawaii's Office of Hawaiian Affairs, a state office charged with working for the betterment of Native Hawaiians.
Yes, sir.
You argued that Hawaii could not limit those who voted for the office as trustees to only Native Hawaiians. You not only made this argument in a legal brief, but you also published an opinion piece in the Wall Street Journal under your own name entitled, quote, "Are Hawaiians Indians?" In the piece you wrote, the Native Hawaiian community was not indigenous because, as you said, after all, they came from Polynesia. It might interest you to know that Hawaii is part of Polynesia, so it's not that they came from Polynesia, they were part of Polynesia. Hawaii is part of Polynesia. Native Hawaiians did not come from Polynesia. Let me repeat that. They were part of Polynesia. You also implied that Native Hawaiians couldn't qualify as an Indian tribe and therefore were not entitled to constitutional protections given to indigenous Americans because, and I quote you, they don't have their own government, they don't have their own elected leaders, they don't live on reservations or in territorial enclaves. They don't even live together in Hawaii. Let me tell you why each of these assertions are wrong, but it is the basis on which you determine that the OHA elections were unconstitutional.
Well, the Supreme Court agreed, though. The Supreme Court agreed 7-2.
They did not agree based on necessarily your arguments. Let me go on. To say that there is no system of law is an insult to the society that evolved in the Hawaiian Islands over centuries, even before the creation of the United States. To say they don't have their own elected leaders in a historical sense just betrays, in my view, your ignorance of Native Hawaiians. They were a self-sustaining, self-governing society for 1,000 years prior to the so-called discovery by Captain Cook. You said they don't live on reservations or in territorial enclaves. They don't even live together in Hawaii. It's hard to know what to say to this assertion. It sounds like you're saying that Native groups in the United States derive their rights from having been herded into reservations and cheated out of their land, or that they surrendered their rights when they move outside of these artificial boundaries. It is not only factually wrong, but also very offensive. Judge Kavanaugh, it is hard to believe that you spent any time researching the history of Native Hawaiians. Now, I'm going to refer to an email that you
May I respond to that?
sent out. I'm going to get to my question.
Okay.
You sent out an email on June 4th, 2002, and I'm going to read in part. Any programs targeting Native Hawaiians as a group is subject to strict scrutiny and of questionable validity under the Constitution. Now, you sent out this email after the Rice decision had already been made by the Supreme Court. When you wrote this email saying that all Native Hawaiian programs should be undergo strict scrutiny because there are constitutional, questionable validity under the Constitution, were you looking to Rice v. Cayetano as a basis for this view which you expressed in your email?
So, Senator, first of all, appreciate your perspective. The amicus brief I wrote was the Supreme Court agreed with by a 7-2 decision written by Justice Kennedy in that case, Rice versus Cayetano. And that decision in the case, just so I'm clear, it was a state office that denied African Americans the ability to vote for that state office. Latinos and other people were denied the ability to vote for a state office, and the question was whether that was permissible under the Constitution, and the Supreme Court by 7-2.
Yeah, Judge
That was
I attended that Supreme Court hearing.
Mm-hmm. I did
And
too.
I believe that one of the reasons they kept asking about trying to figure out whether Native Hawaiians constitute tribes is probably because of the amicus that you put in there that raised this issue. So let me go on. You know, you didn't answer my question as to whether or not, when you said that any program targeting Native Hawaiians as a group is subject to strict scrutiny and of questionable validity under the Constitution. My question to you was, were you thinking about the Rice decision, which you continue to say, yes, the Supreme Court agreed with you. Were you thinking about the Rice decision when you made this view known?
That's an email 16 years ago. I don't recall what I was thinking about when I wrote
It was right after the Rice decision. This is a 2002 email. The Rice decision was 2000. Well, let me ask you this then. Do you think Rice v. Cayetano raises constitutional questions when Congress, not the state, because Rice was a state action case. It had to do with the 15th Amendment, not the 14th Amendment. The 15th Amendment having to do with voting rights. So my question to you is, do you think Rice v. Cayetano raises constitutional questions when Congress passes laws to benefit Native Hawaiians?
I think Congress's power with respect to an issue like that is substantial. I don't want to pre-commit to any particular program, but I understand that Congress has substantial power with respect to declaring, recognizing tribes.
But you believe that any of these kinds of programs or laws passed by Congress should undergo strict scrutiny and raises constitutional questions?
As I sit here today as a judge, I would listen to arguments under that 16 years ago, and I'm working in the administration and the executive branch and putting forth the position there. But if I were a judge, I would listen to the arguments. To your question, Congress has substantial power with respect to programs like this. I appreciate what you've said about Native Hawaiians. The specific case was about an election to a state office.
Yes, that's why it's a state action case. I am well aware of the basis on which the Supreme Court made that decision. So, Judge Kavanaugh, Rice is often cited for the proposition that laws that benefit Native Hawaiians are unconstitutional because they are race-based. Do you think Rice can be cited for that view, knowing, as you have acknowledged, that it is a state action 15th Amendment voting rights case? Rice, I know this, Rice is often cited for the proposition that all Native Hawaiian programs enacted by Congress can be challenged as unconstitutional as race-based. I'm asking you if that is an appropriate citation of the Rice decision.
Senator, I think Congress has substantial power, of course, in this area that you're discussing. And I would want to hear more about how Rice applies. I would want to hear the arguments on both sides. I would keep an open mind and appreciate your perspective on this question.
You know, when the Supreme Court keeps an open mind and listens to the litigants and the advocates, one would hope that the advocates will actually proffer facts to the court, and that is not what you did when you filed your amicus to the court. And I think you have a problem here. Your view is that Native Hawaiians don't deserve protections as indigenous people under the Constitution. And your argument raises a serious question about how you would rule on the constitutionality of programs benefiting Alaska Natives. I think that my colleagues from Alaska should be deeply troubled by your views. And I know that in your amicus brief and in your Wall Street article, you did not mention one word about Alaska Natives. And it could be because there is no Commerce Clause reference to Alaska Natives as there is for American Indian tribes. I want to go on to another set of questions because I am running out of time. I want to follow up on your discussion with Senators Feinstein about Roe v. Casey and your conversation with Senator Durbin about Garza, and also raised by my colleague, Senator Blumenthal. You talked about the importance of precedents. You said you understand the strong feelings about abortion. You said you recognize the real-world effect of cases and you don't live in a bubble. But I think when you talk about respect for precedent, it's misleading because there are ways to say you are relying on precedent, i.e. Roe and Roe v. Wade and his progeny, but still severely limit a woman's right to make her own reproductive choices. And that is exactly what you did in Garza. Because we all recognize that even if Roe v. Wade is not overturned, there are going to be many cases that will continue to come before all of the courts, including the Supreme Court, that will probably be laws enacted by states that will limit a woman's right to choose. So, including things like parental consent, spousal consent or notification, limits on where abortions can be performed, i.e. whole women. So both Senators Durbin and Blumenthal explained the facts in Garza, so I won't go over that, but when the case reached you, you took any opportunity you could to prevent that girl from getting an abortion. You said you were relying on precedent, but you weren't. You turned this case into a parental consent case, which it wasn't. Then you looked at the facts and ruled against, in my view, all common sense, that keeping a young woman behind lock and key against her will by ORR, Office of Refugee Relocation, insisting that ORR be allowed to delay beyond the time abortion would no longer be feasible by finding her sponsors that she did not need, and that you deemed these factual circumstances not an undue burden on her constitutional right for an abortion. Let me read you a portion of your dissent in this case. You say the majority points out in states such as Texas, the minor will have received a judicial bypass. That is true, but is irrelevant to the current situation. Why? The current situation was all about parental consent and the need to get judicial bypass, which this young woman did. So if there's anything that's irrelevant, is your argument that this was a parental consent case. Then you went on to analyze this case on the basis of whether or not keeping her under lock and key, insisting that there be sponsors found for her, which could have ended up being an unfeasible time frame for her to get an abortion, and you deemed those not to be undue burdens. The young woman had already received a state judicial bypass, as referenced before. The fact that she did not have, you thought that parental consent, that was not even an issue. It was irrelevant. So this is very disturbing. Is it any wonder there are so many people who, even if you are not sitting there, in spite of the fact that President Trump said his nominees to the Supreme Court will overturn Roe v. Wade, even if Roe is not overturned, there will be, as I mentioned, all of these cases that will put barriers that will put barriers before a woman's right to choose. So I find it really a rather unbelievable. And by the way, you also mentioned, you said several times that in Garza you did not join the dissent, which basically says an alien minor does not have a constitutional right to an abortion. So does the fact that you didn't join this dissent mean that undocumented persons do have a constitutional right to an abortion?
Well, I decided that case based on the precedent of the Supreme Court and the arguments that were presented in the case. I made clear that I was following as carefully as I could the precedent. You mentioned parental consent and spousal consent. Just the Supreme Court has upheld parental consent laws, but has rejected spousal
Usually
consent.
it requires a judicial waiver, which was the case in the Texas case. You can't just require parental consent, as in this case where parents were beating her up. How can you expect parental consent in a situation like that?
That would be a situation for the bypass. This was an analogy for a woman who was a minor, that's critical, who was in a immigration facility by herself in the United States and had...
She had already gotten a judicial bypass. There was no issue of parental consent, and in this case you would have substituted a foster family for parental consent. That's not even an issue. But I do have a question, since you mentioned several times that you did not join the dissent, and the crux of the dissent was that there was no constitutional right for an alien minor to have an abortion. I want to ask you, did you join or did you not join that consent because you disagree with that in fact, alien minors do have a right to an abortion in our country?
Well, so as a general proposition, well, first of all, the government did not argue in that case that aliens lack constitutional right generally to obtain an abortion.
Yeah, even they didn't argue it because probably they figured that that is a decided issue, but maybe you don't think so. Do you think that that is an open question as to whether or not alien minors or in fact aliens in our country have a constitutional right to an abortion? Do you think that is an open case?
The Supreme Court has recognized that persons in the United States have constitutional rights.
Okay. So I hope that's why you didn't join the dissent. Moving on to another set of questions. Relating to your dissents, I think you can learn a lot about a judge by looking at his or her dissents. And that's why judges go out of their way to voice their disagreement with the majority and show what their views are. And you have the highest dissent rate among active D.C. Circuit judges, 5.1 dissents per year. I'm going to talk about several studies that analyze your decision. The first study by Professor Elliot Nash and Professor Daniel Chen shows that compared to other circuit court judges elevated to the Supreme Court since the 1980s, you not only had the highest rate of dissents, you also had the highest rate of partisan dissents. So I think I have a chart on that. Well, maybe not. Suffice to say, there is such a study, and I ask unanimous consent to have the study by Professors Ash and Chen be entered into the record. The second study by people, thank you. I'm on a roll here, Mr. Chairman. The second study by People for the American Way shows that you consistently sided against workers or immigrants and only once favored consumers in your dissents. Mr. Chairman, I ask unanimous consent to have the People for the American Way study entered into the record.
Without objection.
A third study by Public Citizen shows that in cases where there was disagreement among the judges, you consistently sided against helping people who wanted to protect our clean air and water. Mr. Chairman, I ask unanimous consent to have the Public Citizen study entered into the record as well.
Without objection.
A fourth study, a detailed study by Professors Cope and Fishman found that you are, and I quote their study, no judicial moderate, and that, quote, it's hard to find a federal judge more conservative than Brett Kavanaugh. Mr. Chairman, I ask unanimous consent to have the study of Professors Cope and Fishman entered into the record as well.
Without objection.
Judge Kavanaugh, why do you rarely dissent on behalf of consumers, workers, or the powerless? And please, don't talk to me about all the times that you were with the majority or where you joined other majorities.
Well, Senator, I've ruled for workers many times. I've ruled for environmental interests many times in big cases that involve clean air regulation, particulate matter regulation, affirmative defense for accidental emissions, the California Clean Air Law over a dissent by a fellow judge.
So, Judge Kavanaugh, I cited, how many studies did I enter into the record? At least 4 studies that indicate that there is a pattern to your dissents, and your pattern is that you do not favor basically regular people.
Well, I wrote one of my most important dissents, Senator, was in United States versus Burwell. That was a criminal case, an in-bank case for a convicted drug distributor. The question was whether he had been sentenced to a 30-year mandatory minimum permissibly, and I, joined by Judge Tatel, who's an appointee of President Clinton, ruled that the jury instructions were flawed. I was in dissent for him because mens rea requirement had been omitted from the jury instructions, and I wrote a very lengthy dissent about that. That is that's one of my most important dissents, and that was on behalf of a criminal defendant.
Judge Kavanaugh, the thing about patterns is that there are exceptions to the pattern. So all of these studies that I cite to, we're not talking about the exceptions to the pattern. We are talking about the existence of a pattern. You know, it bothers me I would expect a judge to follow the law. In fact, I think you started off several times saying that you are how did you describe yourself in terms of following the law? You said several times.
Independent and pro-law.
Pro-law,
Another important decision is a case, I think I wrote the leading opinion, or one of the leading opinions on battered women's syndrome, a case called United States versus Noy, over a dissent of another judge where I reversed a conviction of a woman on the ground that she hadn't been
Judge
able.
Kavanaugh, I hate to continue to interrupt you, but 30 minutes goes by awfully fast, and there are always exceptions to the pattern. So yes, you describe yourself as a pro-law judge. Assumes that means that you consider yourself to be someone who follows precedent and the law. But over and over again, your colleagues in the majority criticize you for not following the law or Supreme Court precedent. Where Congress is clear, you miss the plain language. Where the Supreme Court clearly states rules, you ignore them. Let me cite you to some examples where your colleagues actually took the time to criticize your dissents. So in a 2008 case, Agri-Processor v. NLRB, the majority said your dissent, creates its own rule. Instead of following Supreme Court rules, they said that your dissent abandons the text of the applicable laws altogether. Or in 2011, the majority in a case called Heller 2 held that Washington, D.C. could ban semi-automatic weapons, and the majority wrote an entire appendix to explain why your dissent was wrong and how you misread the Supreme Court. Mr. Chairman, I ask unanimous consent to have the 10-page appendix in Heller 2 entered into the record.
Without objection.
In 2017, and U.S. v. Anthem, the majority sharply criticized your dissent. They said, quote, rather than engage with the record, much less adhere to our standard, the dissent offers a series of bald conclusions and mischaracterizes the court's opinion, end quote. They said that you, the dissenting colleague, applies the law as he wishes it were, not as it currently is. This doesn't sound like such a pro-law judge to me. Now, why do your colleagues go out of their way
Senator,
so
if you
often?
could begin to wrap up, please, ma'am.
Why do your colleagues go out of their way so often to point out that you aren't following the law or relevant Supreme Court cases?
Senator, I stand by my record. I've been in the majority, the vast majority of the time, 90 to 95% of the time. I've written opinions joined by colleagues of all stripes. I think there have been studies that shown the affiliation of the judges who joined me in majority opinions when there's been a dissent. I stand by my record. I am proud of my record. I have explained thoroughly my decisions in each case. I appreciate your perspective, and I understand the cases you've raised, but my opinions speak for themselves, and I'm very proud of them.
And I
Senator
think all
Crapo.
these studies speak for themselves also. Thank you, Mr. Chairman.
Thank you, Senator. Senator Crapo.
Thank you very much, Mr. Chairman. And Judge Kavanaugh, you can relax for just a short moment because I'm going to take a few minutes at the beginning here and introduce some documents for the record. First, Mr. Chairman, I'd like to introduce and ask unanimous consent to enter an op-ed from the San Bernardino Sun editorial board stating that Brett Kavanaugh nomination might be the calm before the storm. The editorial board says that Judge Kavanaugh is impeccably credentialed, conventionally conservative, and less likely than other shortlisted judges to overturn landmark culture war case law. In addition to his qualifications and nationwide respect, Judge Kavanaugh brings a reassuring image of normality and judicial cohesion. I ask unanimous consent to introduce this document to the record.
Without objection.
Secondly, Mr. Chairman, the San Diego Union Tribune, why Supreme Court nominee Brett Kavanaugh may be more independent than you expect. This op-ed goes forward to say that it is strongly, the editorial board is strongly inclined to support Judge Kavanaugh's confirmation, has endorsed nominees from both Republican and Democrats in the past. The board advocates for the deference to the president in picking justices so long as the nominee has the requisite credentials, and it applauds Judge Kavanaugh as straight out of Supreme Court central casting. I ask unanimous consent to put this document in the record.
Without objection.
Third, a document from the Harvard Black Law Students Association. This is a letter that exhibits Judge Kavanaugh's commitment to fostering diversity in the legal profession. Last year, Judge Kavanaugh reached out to the Harvard Law School chapter of the Black Law Students Association to express his interest in organizing a clerkship event for their members. Also on the panel with him was Judge Paul Watford, an African-American judge on the Ninth Circuit Court of Appeals. The Black Law Student Association described that event. Judge Kavanaugh explained that one of his priorities is to encourage more students of color to apply for judicial clerkships. Several recent reports have indicated that minority law students are significantly underrepresented in federal clerkships. During the event, Judge Kavanaugh provided his insight and advice on how students should navigate the entire process. They continued, the judge not only graciously offered his time for that panel, but also has continued to mentor numerous Harvard students whom he has taught or worked with in a number of capacities. Again, I submit this document for the record.
Without objection.
Fourth, the Georgetown Prep letter. Judge Kavanaugh's former Georgetown Prep classmates. These men grew up with Judge Kavanaugh. They've known him for 35 years. They know him as a man of high character and intellect before he became a judge, and in high school he was the team captain and a multi-sport athlete. Years later, despite his great achievements, he remains the same grounded and approachable person they knew from class sports and student body activities. Their letter goes on with shining accolades. I'd like to put this letter into the record, Mr. Chairman.
Without objection.
And then finally, for documents for the record, Governor Matthew Mead of Wyoming has sent a letter which states that Judge Kavanaugh embodies the qualities we need in an independent, thoughtful judiciary. He will be an effective and fair member of the United States Supreme Court. I ask to submit this letter to the record.
Without objection.
Well, thank you very much, Mr. Chairman and Judge Kavanaugh. I'd like to now turn to some questions. Before I get into the questions I had intended to ask, though, I wanted to get into the discussion, go back and try to bring some clarity to the discussion that was held earlier in some of the questioning with regard to the independent counsel versus the special counsel circumstances and laws, statutes that we've had in the United States. My colleagues have asked you a lot about the old independent counsel statute. I think it's important that we walk through some of the differences between that statute, which is now no longer law, and the new special counsel regulation. And I'm going to mention three important differences, and then I'm going to just ask you, Judge Kavanaugh, if you would like to give any clarity to this situation and the issues that were raised with you earlier. First, the process for appointing a special counsel, which is the current situation. The decision to appoint a special counsel and the choice of whom to appoint is solely within the discretion of the Attorney General. The old independent counsel had to be appointed and selected by a panel of 3 D.C. Circuit judges. Second, the scope of the investigation. The scope of the current special counsel inquiry is determined solely by the Attorney General. The scope of the independent counsel's jurisdiction when it was the law was essentially boundless, no limits. Third is the process for removing a special counsel. The Attorney General can remove the special counsel for good cause. The independent counsel could only have been removed by a 3-judge panel. I think those are important differences related to the conversations you had earlier. And Judge Kavanaugh, just with that clarification, I'd like to ask you if you'd like to give any more comment or clarification to the discussions that were raised with you earlier.
Thank you, Senator. I appreciate the distinctions, which I think are accurate, and it's important to understand that, as you underscore, the old independent counsel statute had many parts to it that combined to make it such a departure from the traditional special counsel system, all of which were part of the analysis that I think Justice Scalia engaged in his dissent, and that the Congress looked at when it decided that that statute had been a mistake, and you overwhelmingly decided not to reauthorize it in 1999.
Well, thank you. And I felt like you didn't get an opportunity to make that clarification and that the record needed to be clear for the American people.
Thank you, Senator.
Before we move on from that topic, I just want to state that Eric Holder has noted that the fundamental structural flaws with the old statute. Senator Durbin, as has been said, called that law unchecked, unbridled, unrestrained, and unaccountable. And as we've heard, Justice Kagan has praised Justice Scalia's dissent, calling that law into question. So I just did want the record to be clarified somewhat in that context.
Thank you, Senator.
Now, what I want to do during the rest of my questioning in a number of different ways is to get into your judicial record. I will start with this, however, by going back to what this set of hearings began with yesterday, which was an attack on the documentation that has been produced by you and others for your record. I'll state again, there is no nominee for the Supreme Court who has ever been asked a more robust questionnaire by this committee than you. And you provided, I believe, around 17,000 pages of documents in response to that questionnaire, which was more than any other nominee has been asked. Secondly, you've provided over 440,000 other documents that, or pages, I believe it is, of documents that in and of itself is more than the entire number of documents or pages of documents that were provided by the previous 5 nominees to the Supreme Court. You've also got a record, a judicial record, which is acknowledged by senators constantly as the most important part of the documentation for a nominee to the Supreme Court, of over 10,000 pages of your decisions. And unfortunately, we haven't seen a lot of focus on that yet in the questioning that you've received in this hearing. So I want to try to get into that. Before I do, however, I want to note, everyone has heard this many times, but I'm not sure that the normal American really understands. You are a judge of the D.C. Circuit. It has been said in this room a number of times that that is often called the second most powerful court in the nation. It's a circuit court. There are a number of circuit courts. What is different about the D.C. Circuit Court from, say, the Ninth Circuit Court, in which I sit in Idaho for the Ninth Circuit? What's different between all of the other circuit courts and the D.C. Circuit Court?
Thank you, Senator. All the courts of appeals are important and have important dockets and important caseloads, and the judges on all of those courts do important work. The D.C. Circuit does get more regulatory cases because we are, the D.C. Circuit's in the nation's capital, the seat of government, and therefore more of the administrative law regulatory cases come. So EPA cases, for example, or NLRB cases, EPA, Environmental Protection Agency, NLRB, National Labor Relations Board, Securities and Exchange Commission. We'll get more of those cases involving agencies of the government here in D.C. as a percentage of our docket than you would get in other courts. And that includes some of the separation of powers controversies that traditionally arise of relating to national security cases. We have all the Guantanamo-related cases in our court. So there are cases related to government operations, government separation of powers, administrative law, the agencies that are a bigger percentage of our docket. But I do want to underscore all the courts of appeals of this country do important work, and all the judges have important dockets, and there are different distinctive characteristics or characters of each of those courts in terms of, for example, the Ninth Circuit has a good deal of immigration law, Fifth Circuit has a good deal of that, the 11th Circuit, of course, has a very, all the circuits have an important docket. So I just wanted to not, I want to underscore that D.C. has a lot more separation of powers, but I don't want to, I have a lot of friends on the other courts of appeals, Senator. I don't want to, I don't want to diminish the work that they do, because it's very important work and what they do as well.
Well, I appreciate your answer, and believe me, those of us who live in the Ninth Circuit understand the power of the Ninth Circuit Court of Appeals, and sometimes we chafe under its rulings, but we are very aware of the incredible power. The point being, though, that the D.C. Circuit is distinctly different, as you indicated, in that it gets a much higher level of caseload dealing with the operation of executive agencies and with operations of government, the kinds of things that we've been talking about extensively here, these types of issues. And I just think it's important for that to be brought out.
Thank you.
With regard to the D.C. Circuit on which you sit, you've spent how many years as a judge on that circuit?
12 years and 3 months.
And how many decisions? Do you know the number of decisions you have participated in?
I think I've handled well over 2,000 cases, including all the cases counted up together.
And how many of those were you the author of the opinion?
I've written majority opinions, published majority opinions in, I believe, 307 cases is the current number.
And there's been some discussion even with the last questioning that you received about what the norm is, what the pattern is with your decision-making. I will note before I ask you this question that the current active judges on the D.C. Circuit are made up of 7 nominees from Democrat presidents and 4 nominees from Republican presidents. So the current makeup of the active judges on the D.C. Circuit is more Democrat than Republican in terms of who nominated them. But I guess I'm going to lead you a little bit with this question, but in this several thousand cases that you have been involved in deciding with this group of judges, what percentage did you agree with? In other words, in what percentage were you in the majority?
It has to be in the 90s, I would believe.
I heard yesterday from the chairman it was 97.
Yes, I believe that sounds correct.
So if there's a pattern here, it's that you are right there with the majority of your colleagues on the court on most cases. And I don't mean just 51%, it's like 90+%, probably 97% if I remember from yesterday correctly.
That sounds about right, Senator. Appreciate it. We're judges. We don't wear a partisan label as judges, and I've tried to work well under the law with all my colleagues.
So those who want to try to create the impression that you are an outlier have to use that last 3%. In fact, I think it's 2.7% in which you are actually in the dissent, or maybe you are a member of a partial majority. But they have to go to that very small number of cases and then try to figure out a way in there to make it look like you have disagreement with norms in the judiciary. I just think it's important for us to note when people start talking about let's look for patterns. The pattern is that you are working with your colleagues on that court in a united way, and that there seems to be a pretty high level, a pattern of a high level of consensus in the rulings in which you participate. In terms of the decisions that you have written, the 307 decisions that you have written, how many of those do you recall? Have you analyzed it? How many of those were majority decisions for a majority?
The vast majority of those are majority opinions.
So it was a small number that would have been dissenting opinions.
This is dissents and also some concurrences.
And some concurrences.
Yes.
Again, I don't know that you would have these statistics, but I assume some number of those cases were appealed to the Supreme Court. Did the Supreme Court, when your cases were brought to the Supreme Court, the ones that you wrote, were they overturned regularly or were they sustained mostly? Do you know the numbers on that?
I believe there are 13 cases where the Supreme Court has agreed with the analysis that I had, or the decision I had made, either in a dissent or in a majority opinion for the D.C. Circuit.
And how about reversals?
I'm aware of one case where there was a reversal.
Excuse me, so 13 to 1. Again, if you're looking at a pattern, it appears to me that you are, again, in the mainstream of the American judiciary. With regard to the question of how the Supreme Court has treated your cases, I seem to recall that they actually adopted your line of reasoning in a number of cases. Is that correct?
That is correct, Senator. I don't know if you have a. Well, I'll let you.
I don't have the number on that.
Yeah, no. Of the 13, that is correct. Where they either cited or quoted or otherwise agreed with the reasoning or decision I had made in a concurrence or dissent, and I'm happy to talk about those. But
well, let me ask you this question, and you can use it there.
Of course, I'm happy to talk about that.
What I was going to ask you next is, before I go into some of the cases that I'm aware of that you participated in that I think are notable, are there any of the cases that you've participated in as a judge, particularly those where you've written the opinion, but any cases you would like to note. Like I said, we haven't really gotten into your judicial record much here. I'd like you to have an opportunity to talk about your judicial record. Are there some that you would like to discuss with us before I go on to some that I have on my papers?
Well, I'll let you ask a few, and if there are any others I want to go to.
Well, I'll probably run out of time before I'm done with mine, but
I'll try to be succinct.
well, the first one is, back to an issue that you've been criticized for, is equal treatment of women. One of the cases I'm aware you participated in is the United States versus Noye, where you defended the rights of vulnerable women and reversed the district court on grounds that a female criminal defendant was prejudiced by her lawyer's failure to introduce evidence of her suffering from battered woman syndrome. Would you discuss that case a little bit?
Yes, there had been a criminal conviction of a woman for extortion, and she claimed duress defense. She claimed that she was a battered woman, that she had been repeatedly beaten by her boyfriend. The district court had ruled against the woman on the claim that her counsel was ineffective by not presenting the battered woman's defense. It came up to our court, and I wrote a lengthy opinion explaining why it was ineffective assistance of counsel not to present the battered woman's defense, over a dissent from another judge, I should add. And I explained the point there that the jurors needed to hear the evidence from the expert about the battered woman's defense, because otherwise the jury might not believe the claim she was making, because they might think, well, why didn't she walk away, or why did she not do something else? And the expert testimony would explain what happens when you're beaten repeatedly, and would explain that the jurors would benefit from having that expert understanding that sometimes you can't walk away. That's the whole point when you're in a relationship where you're beaten repeatedly.
Well, I appreciate that.
And I therefore reversed the conviction in that case that Noye had received.
And the ACLU said your opinion in a way demonstrated a sympathetic and nuanced understanding of intimate partner violence and its effects. I'm going to skip over another case, Adams versus Rice, because we're running low on time. What about Artis v. Bernanke, in which you voted to reverse the dismissal of a Title VII complaint by an African-American female group of secretaries alleging race discrimination by the Federal Reserve Board? Can you tell me about that case?
That's a discrimination case where as we analyzed it, the evidence presented was sufficient to raise a claim of race discrimination based on the treatment that the African-American secretaries had received in that case. And that was our ruling in that case.
Well, thank you. And I've got pages more of cases on this issue, but only 10 minutes left in our time, so I'm going to shift to another issue. Again, looking at cases that you have decided, race and diversity. Let's talk about Ayesi Ito versus Fannie Mae. In that case, an African-American employee was fired from his job at Fannie Mae. He brought an employment discrimination claim alleging his supervisor had used a despicable racial slur and created a hostile work environment. Not only did you join Judge Merrick Garlick and Judge Thomas Griffith in the court's per curiam opinion, but you also wrote a separate concurrence. And in your concurrence, you wrote that the severity of this racial slur, even a single use of the N-word by a supervisor, is sufficient by itself to create a hostile work environment. And I could go on, but I'd rather give you a chance to just describe that case a little bit.
Well, that case was a powerful case. The plaintiff argued it pro se in front of our court, which is unusual. And the situation was that he had been called the N-word by a supervisor. The question was whether the single utterance of the N-word constituted a racially hostile work environment under the Supreme Court's precedent, which says severe or pervasive. So the question really was, is a single utterance of that word severe under the precedent? I wrote a separate opinion to make clear that it was, that word, that no other word in the English language so instantly or powerfully calls to mind this country's long and brutal struggle against racism. which I've emphasized in many cases, is the long march for racial equality in the United States is not over. And you look back to I cited some of the history of the country, and the original sin of the Constitution was its tolerance of slavery. Fugitive slave clause, the importation clause, which allowed the slave trade from 1788 to 1808, which during that 20-year period, 200,000 additional slaves were imported into the United States. The history that corrected in part on paper in the 13th, 14th, and 15th Amendments, but then, of course, a century of backtracking from the promise of the 14th Amendment, Jim Crow and racial discrimination, leading up to Brown versus Board of Education, of course, again, and the Civil Rights Act, and the Voting Rights Act of '65, among the most important pieces of legislation ever enacted by Congress in terms of changing America. But still work to be done after centuries of discrimination, racial slavery, racial oppression, racial discrimination. In this case, to my mind, was one case with one person arguing one claim of one incident. But to me, the whole history of the country was represented on race relations, and racial discrimination was represented in that one case. And I tried to capture that as best I could in the opinion I wrote in that case.
Thank you, Judge. And let's move on to Ortiz-Diaz versus the Department of Housing and Urban Development. In that case, you joined an opinion holding that denying a lateral job transfer with the same pay and benefits may be an adverse employment action when the employee alleges he sought to transfer away from a biased supervisor. And in that case, you wrote a concurrence in which you said that the court sitting en banc should establish a clear principle that all discriminatory transfers and discriminatory denials of requested transfers are actionable under Title VII. And you went on to make it clear that denying an employee's requested transfer because of the employee's race plainly constitutes discrimination. And I'll let you go further on that if you would.
Well, the question was, if you're transferred laterally and you get the same pay and benefits, is that really a change? And suppose it's an oral argument in that case. If anyone's interested, I encourage them to listen to the oral argument in that case, where I said something that I explained later in the opinion. Look, in the real world, a transfer, even if you get the same pay and benefits, may hugely affect your later job opportunities, your career track. And to think that discriminatory transfers were somehow exempt from the civil rights law merely because you had the same pay and benefits was blinking reality. And so that's what I said in the opinion. Our case law at that point basically said some transfers can be actionable, others not. And what I wrote was, I don't see how all discriminatory transfers aren't unlawful under the Civil Rights Act.
Well, I think it's important for America to know that your attitude is that strong on this. And we already went over the Artis versus Bernanke case when we were talking about women's rights issues. But this, again, is a group of African-American secretaries who were alleging discrimination, and you ruled in their favor. Again, I have a number more cases on this, but I got a different question on, still on race and diversity. I recall the Black Law Students Association letter from Harvard that I introduced the letter on previously. But I also note here that your commitment to promoting civil rights extends back to your personal law school days when you wrote one of your first pieces of legal scholarship, your law school note, which was titled Defense, Presence, and Participation, a Procedural Minimum for Batson v. Kentucky Hearings. Now, what that means, you can explain.
Yes.
But essentially, it was an article about this topic that you chose when you were in law school. And I guess my question is, explain the topic, but why did you choose this topic in law school?
Well, because I was interested in trial procedure at that time, but I was also a product of a city where, as I've described yesterday, and described what my mom did in terms of teaching at McKinley Tech, where race relations and race discrimination were an issue that was of of concern to me, and so I wrote after the 1986 Batson opinion, which prohibited race discrimination in peremptory challenge in jury selection. I worried or wrote, well, what's to prevent backtracking from that decision by prosecutors who will be able to assert seemingly race-neutral reasons but still have the effect of excluding African Americans from juries. And so I wrote a law review article published explaining that we needed good procedures to detect even subtle discrimination in the jury selection process to ensure that the Batson v. Kentucky decision was not evaded, and so that the legacy of all white juries convicting African American defendants is, of course, a painful part of our criminal justice legacy. And one of the things I wanted to make sure, and the Batson decision came out, was that that was not circumvented procedurally.
Well, thank you, Judge Kavanaugh. I just want to commend you on this. And as I said at the outset, it seems to me that an awful lot of the time in this hearing has been spent trying to create criticisms of you in areas like women's rights or race relations and what have you, when in reality your record is strong and deep in terms of protecting women's rights and protecting those who are in unfavored positions and protecting against racial discrimination. And I hope that we can get a strong focus on your true record, because whether it's these issues, whether it's the independent counsel versus special counsel issues, or whether it's just the balance of your decision making and whether you are somehow out of the judicial norms in terms of your approach to decisions that you have entered into as a circuit judge, your record reveals the truth. And the attacks that have been made on you today are absolutely unfounded. And I just hope that we can get a much deeper look at your true, honest record as we move forward. Now, I've only got a minute and 12 seconds left. The most important issue to me in your nomination is whether you will be an activist justice or whether you will follow the law as it is written. I know what your answer is, but I'd like to hear you in the last minute that I have. Tell me again, what kind of a judge, what kind of a justice will you be on the Supreme Court if you are confirmed?
Senator, I appreciate that, and I appreciate your comments. Be an independent judge who follows the law, Constitution as written, informed by history and tradition and precedent, follow the statutes that you pass, the Congress passes as written, informed by the canons of construction. I will remember Hamilton's admonition in Federalist 78 that the judiciary exercises not will but judgment, and Hamilton's admonition in Federalist 83 that the rules of legal interpretation are rules of common sense. And I will give it my all, as I've tried to do for the last 12 years as a judge on the D.C. Circuit.
Thank you very much. I commend you for that answer and your approach to it.
Thank you, Senator.
Thank you, Senator. Judge, we're scheduled to take a 30-minute break. If you need all of it, just say so. If you do, I'm not suggesting you shouldn't take it.
25?
25. We'll be back. We'll be back at, I've got 20 of 8. We'll be back at 5 after. If you need a few additional minutes, take them. When we come back, Senator Booker will begin.
Thank you, Senator.
We're coming back.
Senator Booker.
Thank you. Thank you, Mr. Chairman. Judge, in a 1999 interview with the Christian Science Monitor about the Rice case, you discussed with Senator Hirono a little bit, but you said, and I quote, "This case is one more step along the way in which I see as an inevitable conclusion within the next 10 to 20 years when the court says we are all one race in the eyes of government." It's been about 20 years now, or about 6 months away. Do you think that you were wrong at that point, that racial discrimination in America would be over by 2019?
I think that was, Senator, an aspirational comment, and one that, to your point, of course, I've said in my decisions, as you and I have discussed, that the march for racial equality is not finished, and we still have a lot of work to do as a country and as a people on that. So
I appreciate that. I really do. But I want to know what you were thinking in 1999 that would make you make such a bold, aspirational comment that, hey, in 10 years, the court can view us all as one race. What was going on in the 1990s that led you to have that belief?
Hope.
Okay, because you and I know, you and I are both aware of where the trends were going in the 1990s. This was the period where the drug war was in full blare, where the prison population exploded. Since 1980, we've been up 800% in the federal prison population. The massive increases in racial disparities of incarceration. Blacks constitute roughly 13% of drug users, but were 46% of those that were being jailed for drug offenses. Even our schools in the 1990s were becoming more segregated. And so your brief in the Rice case invoked Justice Scalia's argument that we should be, quote, one race. And this, let me go on with the Scalia quote, because he said that government can never have a compelling interest in implementing race-conscious programs that seek to address this nation's wretched history of racial discrimination. He said never. He said that race-conscious programs, I'm going to quote him now, are racial entitlement. Now, do you think that someone who wants to remedy the fact that they could not get a loan from the Fair Housing Administration because of the color of their skin is racial entitlement, or are they seeking racial justice? Do you think someone, a person who tries to remedy the fact that they were denied the chance to go to college under the GI Bill because of the color of their skin is seeking racial entitlement, or are they seeking racial justice? So to be specific with Scalia, do you agree with Justice Scalia, who you reference in your brief, that it's never permissible for the government to use race to try to remediate past discrimination, to try to achieve justice?
Senator, that was a brief for a client, first of all, so I was not saying something in my own voice particularly there, so I'm writing a brief for a client.
But if I can correct you, sir, you said it's just a brief for a client, but you seem to invoke Scalia's one race theory quite often. You invoked Justice Scalia's one race theory to a reporter. You again mentioned it in the Wall Street Journal op-ed you wrote around the same time, and you cited his opinion, yes, in this brief. Are you saying that you do not share Justice Scalia's beliefs about this idea that people who are seeking to address past discrimination, past harms, that they are seeking racial entitlement?
I think, first of all, the Supreme Court precedent allows race-conscious programs in certain circumstances. So the precedent on the Supreme Court, as you know, Senator, is different. I was writing a brief trying to cite all the principles from the different cases that would support the brief. But to your point, there's when you're trying to remedy past discrimination as a general proposition, you're seeking racial equality and seeking to remedy both past discrimination and the lingering effects.
So you disagree with Scalia that he says it's never permissible for the government to use race to try to remediate past discrimination to try to achieve justice. You disagree with Scalia?
The Supreme Court law.
I know what the precedent is. I know what the law is. I'm asking what you believe. Do you agree with Scalia that, again, that it is never permissible for government to use race to try to remediate past discrimination to try to achieve justice, that that's racial entitlement?
That position has never been adopted by
I'm asking what you believe, sir, not the Supreme Court.
Okay. The term I used was that what you're seeking is equality. Equal and what
and right. So if you're seeking equality, I appreciate you grant that. Is it never permissible for government to use race to try to remediate past discrimination?
There are a couple of things that the Supreme Court's pointed out in its case law,
and again, I know the Supreme Court case law. Maybe I can approach this in a different way.
Okay.
The aftermath of Katrina. In a case brought by plaintiffs in New Orleans who challenged the way government provided grants to homeowners as having a discriminatory impact on African Americans, you joined the minority in denying them relief. If the findings had shown that the grant program systematically disfavored African Americans, would a government effort that uses race to remedy that disparity be unconstitutional? In other words, do you believe that all such efforts that the government using those efforts amount to what Scalia called a racial entitlement? I'm trying to figure out if you agree with that point that Scalia is making.
Senator, first of all, I approach questions like you are asking with a recognition of two things. One, the history of our country, and two, the real world today.
Yes.
And I try as best I can to understand both the history of our country on that issue and the real world today. So I'm coming at it from that perspective. You're asking a question, I think, about specific remedies for discrimination, and there's a lot. I'm a judge, as you know, and so I have to follow precedent, and the precedent allows remedies in certain circumstances.
And again, sir, I've heard you use that with a lot of my colleagues, and I know what precedents are, especially dealing with a lot of very important Supreme Court issues. I'm asking about your opinions because your opinions matter, what you've saved matter. Let me give you an example. In April in 2003, you wrote regarding a program designed to benefit Native American small businesses by saying the desire to remedy societal discrimination is not a compelling interest.
That's what the Supreme Court has said, and
hold on. The Supreme Court said that the desire to remedy societal discrimination is not a compelling interest.
The Supreme Court has let's go to Bakke, for example.
I'm going to get to Bakke. Okay. Just answer this question. Do you still believe, this is what you said, that race can never be used to remediate clearly proven discrimination? If it's clearly proven discrimination, I'm just using an absolute. Do you still believe that it can never be used?
Well, I think the Supreme Court has said it can be to remedy.
I know what the Supreme Court, but what do you believe, sir?
Well,
come on. You know the history. You've recited it numerous times.
What I would say, look, I have trouble departing from the Supreme Court precedent and saying.
But you don't. You opined about it in emails. You've opined about it in Wall Street Journal articles. I've heard you opine about these things in race. You just can't say right now what you believe.
Well, a couple things, Senator, just to back up. Lawyer for client in the email you're reading as well.
Christian Science Monitor article, Wall Street Journal, your comments to reporter. Let me approach it this way, because you're not answering the question, but let me see if I can approach it in a different way, now getting to some of the things you were talking about. The Supreme Court has said for decades, this gets us to Bakke, the Supreme Court said for decades that institutions of higher education have a compelling interest in student body diversity, and that race can be used as a factor, not the only factor, but a factor in admissions if it is done so in a way that is narrowly tailored to serve that interest. You said, the court said this in Bakke, you and I know these cases, said it in Grutter in 2003, Fisher most recently in 2006. The simple question here is, do you believe these cases were rightly decided?
Senator, important precedents of the Supreme Court, and as Justice
I didn't
Kagan-
ask you if there were precedents. I've heard you go through this before. Do you, sir, if you can't answer it, just say it, Corey, I can't answer this. Do you believe that those cases, you say Marbury versus Madison was rightly decided. You said that. You said Brown versus Board of Education, rightly decided. And by the way, desegregation cases could come before the Supreme Court. Do you believe that these cases, yes or no, do you personally believe they were rightly decided?
Senator, I am following the precedent of the set by the 8 justices currently sitting on the Supreme Court, and to put it in the terms of Justice Kagan, who was asked a lot of these same questions, it would be inappropriate to give a thumbs up or thumbs down on.
Yeah, but sir, there's a distinction between you and Kagan, you and Ginsburg on these issues, because let me just tell you the
It's
distinction.
Roberts, Alito, Gorsuch,
And I'm going to tell you the
Kagan,
distinction
Breyer.
between that excuse you're using with many of my colleagues. And the distinction here is none of those nominees had voiced personal opinions that government should refuse to defend these kind of programs. And let me give you an example. You wrote in an email about Adirond versus Mineta, a case that involved benefits to minority-owned businesses. You wrote that the government should file a brief saying that the program is unconstitutional. And let there be no confusion, sir. You went on to write that, in fact, this is my personal opinion. And so you said that then. My question is do you still think a diverse student body is a compelling interest? You opined on it then. You wrote it then.
Right.
What do you believe now?
So a couple things there, Senator. First of all, the Adirond case is in the context of contracting. The Bakke case is in
So
the
you think that those cases using race to remedy past discrimination is unconstitutional? That's what you wrote then.
Well, in light of the precedent of the Supreme Court representing a client in that case. And I go through, I think the email you're referring to, I go through, actually, the SG should make a recommendation first that this should not be a White House dictated answer, and the Solicitor General is ordinarily, I think if you're referring to the email I'm thinking of, but in any event, I think, as you know, and I just want to reiterate, there's precedent in the higher education context, in the contracting context, that are somewhat distinct, and those precedents have been applied by judges. And my record on race discrimination cases, I'm happy to talk about my cases, the E.C. Ito, the
But you're not happy to talk to me about the opinions you've expressed in the past. Do you still hold those opinions now?
Well, that's what I wrote then as a lawyer for a client.
But you said that, again, that is in fact my personal opinion.
That's before the case is decided and
So
subsequent.
you expressed a personal opinion on this issue then. Do you still hold that same opinion now? It's unconstitutional.
I think you're taking, I believe, respectfully, personal opinion out of context there. Personal opinion about what the government position, so personal recommendation, because I said, the distinction there is I said the Solicitor General should first make a recommendation, and then the White House should respond, or the President. As to personal opinion, it was not my personal opinion, Kavanaugh. It was what the government's position recommendation would be based on President Bush's
sir,
stated
it
policy.
seems that you were pretty clear there what your personal opinion was.
Well,
let me approach it again.
I don't want to.
Sir, we don't have to go back and forth. I want to ask you a simple, direct question. Do you think having a diverse student body is a compelling government interest? Do you believe that? Do you think having it's not a complicated question. Do you believe having a diverse student body is a compelling government interest?
The Supreme Court has said so, and my efforts to promote diversity, I'm very proud
But I know
of.
what the law is now.
No,
I'm worried about
personal,
what the law is going to be, sir, when you get on the court and have the ability to change those precedents. But let me go back to your words. I just want to ask you about your words and maybe give you a chance to explain something else, because you haven't answered my question, and I understand that you're going to stick to that. You've also written that an effort designed to benefit minority-owned businesses, an effort to try to give them a fair shake because they had been historically excluded, and these are your words now, used a lot of legalisms and disguises to mask what is in reality a naked racial set-aside. That's what you said. That's how you referred to it.
What are you reading from, Senator?
Sir, I'm reading from an email dated August 8th. These are your words, but I don't need to know about.
Can I get a copy of it?
You certainly can, but let's ask you what you believe now. I'll leave aside then.
Yeah.
Okay, you said it, but you wrote it, but my question is, what are your views right now? Do you believe that government efforts to promote racial diversity are a naked racial set-aside. Those are loaded words. Do you believe that now, sir?
The government efforts to promote diversity in the higher education context are constitutional, and I've made clear my own personal efforts to promote.
But you refer to it in the past, sir. You refer to minority-owned businesses trying to get a fair shake after historically being excluded. You call that which is very powerful.
I don't have the email, Senator, so I'm a little.
So have you ever used the term naked racial set-asides? Do you remember ever using that term?
That would, if you're saying there's an email, but I would like to see an email if I'm getting questioned about an email.
Okay, I'm going to ask my staff to provide you an email while I move on.
I have promoted diversity in law clerk hiring and made a big difference in that.
Sir, you've told me about the diversity you promoted in law clerk hiring, and I'm so grateful for it. You've told me a lot of things about the diversity that you personally have practiced in your own life. I really, really appreciate that. I'm not asking you about the 5 black clerks that you have. That's good. You're seeking a position on the highest court in the land that's going to affect millions of people. Mm-hmm. You've expressed opinions about these subjects to the media, to the press, in speeches, in past emails, but you're not willing to say if you still hold those positions that you held before. And I want to just move on to specifically something that you have expressed opinions in some of your cases as well, sir, and that's the issue of racial profiling. You once discussed the use of racial profiling after 9/11 with your colleagues in the Bush White House.
Can I see the email?
What's that, sir?
Can I see the email?
Yes, I will get you the email, but there was
But I can't answer if I.
I'm going to ask you about your views now, sir, and I'll provide the email, but I'm more interested in your views right now, before you may be confirmed as a Supreme Court justice. There was a debate going back and forth, and one of your colleagues said that there was a school of thought in the administration that if the use of race renders security measures effective, if using race renders security measures effective, then perhaps we should be using it in the interests of safety now, in the long now and in the long term, and that such actions, your colleague said, may be legal under such cases as Korematsu.
It sounds like you're quoting someone else.
I am quoting somebody else.
Well, sir,
I'm not going to stick you with that. I know you've already said Korematsu.
But
bad.
don't attribute.
I'm not attributing it to you, sir. Please don't accuse me of that. I'm not. I said that was your colleague. I clearly said that was your colleague. You did not respond in the email by denouncing racial profiling or expressing outrage at the idea of relying on a case as odious as Korematsu.
Mr. Chair, point of order.
Can I ask for my time to be paused, Mr. Chair, while you make this point?
Please do.
Please, pause, Senator
Mr. Chair, just as a courtesy to the witness, we just saw an example there where I even believed that the words that were being repeated were words in an email authored by Judge Kavanaugh. I think it'd be helpful if we could suspend for long enough to have the documents available to the judge so that he can be answered in proper context. Is that an appropriate request?
Do you have any objections?
I do have an objection. If my colleague has an issue with that agenda, I think he should bring it up after my time. I'd like to get back to my question.
Okay, let's proceed. Don't take time away from Senator Booker.
Thank you very much. Sir, your response to that colleague's email was that you generally favored race-neutral security measures, but you thought that there was, and I'm quoting you now, interim question of whether the government should use racial profiling before a supposedly race-neutral system could be developed sometime in the future. So it seems that you are okay with using race to single out some Americans for extra security measures because they look different, but you're not okay with using race to help promote diversity and equal opportunity and correct for past documented racial inequality.
Sounds like I rejected the racial profiling idea. What's the date of the email, Senator?
The date of the email is January 17th, 2002. Mm-hmm. And so have you ever suggested or expressed an openness to, even in a temporary circumstance, like this email seems to indicate, in an interim question of using racial profiling? Have you ever suggested that, sir?
I'd like to see the email.
I will provide the email, sir, to you.
But it sounds from what you read like I rejected the concept, but I'll look at the email.
It seemed to me that you were open to the concept, sir, clearly. This is critically important because right now in our nation, there are law enforcement practices, and I think you're aware, that are overwhelmingly target African Americans and other people of color. Yet I've read opinions such as yours in the United States versus Washington that upheld a search, and I quote, in a neighborhood in southeast Washington, D.C. that you called crime-plagued, in Wesley versus District of Columbia, where you would have protected police from liability when they made warrantless arrests at a house that was in, quote, in east of the Anacostia River. You and I both know that those are predominantly black areas.
Yes.
Predominantly African-American communities.
Yes.
I understand there's case law that says police can justify some actions by saying that they were in areas that were high crime. But you know how some of these opinions, using this type of racially coded language, can further the disparate treatment of people of color with the police. And so the way I see it, and I'll give you a chance to respond, is that you're willing to consider using racial profiling and to accept police practices like heavy policing of African-American neighborhoods, but you're hostile to the use of race when it is used to promote diversity or remediate past proven discrimination.
Can I get 60 seconds?
Sir, go ahead.
Okay. On the Wesby case, there was a call to the police. It was not the police patrolling the neighborhood. In the Wesby case, the Supreme Court reversed the majority decision that had been written by other people that I dissented from. They reversed it 9-0 this past term. So what I wrote in Wesby, and was cited, and the Supreme Court agreed with the approach that I had suggested, 9-0. On the general concept, you and I have discussed this in our meeting. I'm very aware of the reality and perception of targeted policing or police activity in minority neighborhoods, and I try as best I can to be aware and understand that, and you and I talked about that, and the Wesby case, in my view, had nothing to do with that issue, and the Supreme Court.
Sir, I try to give you some time there, but this is what I'm hearing right now, sir. And you know, and I appreciate your rhetoric on these matters, but again, you're going to be a judge on the Supreme Court if you are confirmed, and have a power to make massive differences in our country. And these are real issues. And so I asked you, was the Fisher case, I just asked if it was rightly decided. You refused to answer. I asked you again whether you believe diversity is a compelling interest. You didn't answer that, sir. That's not good enough for a nominee to the highest courts, particularly one who is expressed, and I'll provide you with the emails as well as other quotes for the record as well, opposition to affirmative action and efforts to address systemic, provable discrimination, such as, and yet you also have an openness to racial profiling. And again, I'll provide that email. The cases I raise are about addressing documented systemic structural inequality in our country. This is about the fact that children in this country still encounter a different experience of America based upon the color of their skin and not the content of their character. They are more likely to drink dirty water and breathe dirty air and less likely to have access to equal educational opportunities. They're more likely to be stopped by the police. They're more likely to be shot by the police and become unfairly entrapped in our broken criminal justice system. Like you said you're an optimist. I'm a prisoner of hope, but even I have a troubling understanding in your eyes how America could be just months away or a few years away from becoming one race in the eyes of the law, as Scalia, who you've quoted numerous times. We are a good country with great people, and we're great people because people of all races in America have worked together. Black folks, white folks, all folks have worked together to make progress. But you said it yourself, we have so much work still to do. The Supreme Court, plays a vital role in that work, just as it did generations past with cases like Brown. And so, Judge Opportunities, you've answered my questions. I want to move really quick in the remaining time I have to voting rights, which is a crown jewel of the civil rights movement. It's designed to prevent states from putting up barriers for the rights of African Americans to vote. It's in the 21st century, voter ID laws, which we're seeing more and more, many people consider them the modern day equivalent of poll taxes. These laws are being enacted despite the fact that in-person voter fraud is incredibly rare. You're more likely to be struck by lightning in America than to find a person committing in-person voter fraud. You wrote an opinion in the South Carolina voter ID law that you said you were proud of that decision in my office, and I heard you say it here. I'm taking you at your word that you're proud of this decision. But you were aware at trial that the author of the South Carolina voter ID law admitted that he received an email from a supporter of the bill that said African Americans, that said if African Americans were offered a $100 reward for obtaining a photo ID to vote, it would be, and I quote, like a swarm of bees going after watermelon. In response to that racist email, the author of the voter ID wrote, and I quote him directly, "Amen, Ed. Thank you for your support." You were also aware that based on the evidence in that case that minority voters in South Carolina were 20% more likely than white registered voters to have a valid photo ID. So how could you have concluded that the voter ID law would not have a disparate impact on minority voters and poor voters in general? If a registered voter didn't have a photo ID, isn't it true that their only option was to write out a sworn statement that could expose them to criminal penalties? And isn't it true that even then they could only vote on a provisional ballot? Is that true?
So the decision was unanimous, joined by Judge Culler-Catelli, who's an appointee of President Clinton's, and Judge Bates, President Bush appointee. But it was a unanimous decision where we blocked implementation of the South Carolina voter ID law for the 2012.
So you're telling me things I know. Can you just get to your feelings on this? Couldn't you see
Yes.
that this was going to provide an impediment and disparate impact on African Americans? Couldn't you see the problems that this would create?
That's why we said that the reasonable impediment provision could not just be the form that they had prepared, but we essentially said what would have to occur.
And you said you were proud of me of the reasonable impediment provision. That's the point we had to stop when I talked to my office. Can I just ask you, because this is how I see the reasonable impediment provision. South Carolina tried to enact this law that wouldn't disenfranchise minority voters. When the people who enacted this law realized that they had to make changes to it, you remember this?
Yes.
They created a second class of voters, those without an ID. They had to go to a separate line, fill out a form under the threat of criminal prosecution, wait for an attorney or a poll worker to witness that, and then after all that, they had to cast a provisional ballot that may not have counted at all. Now, this is a lot of a process, and you said to me, and I appreciate you saying this, you said what looks good on paper may fall apart in practice.
Mm-hmm.
And you told me, hey, Corey, I was keeping an eye on this to see what was going on.
I think I said senator, but yes.
Oh, sorry,
otherwise,
of course.
yes.
I'm sorry, Judge. I'm sorry. I feel comfort with you. Can I just show you what was up in South Carolina polling places? You can see this sign. Here's a picture. This is a sign that was in the polling places in South Carolina after the passage of their voter ID law. I mean, look at this sign, sir. This is what people without a photo ID would have seen. This is confusing and intimidating. It doesn't show the what you call the reasonable impediment option that they had. It just shows this very thing. Do you see how this poster board, might not be really much of, I don't even know if you can see any reasonable provision aspect on this. It doesn't matter that the average voter seeing this poster could be intimidated by this process?
That's why I said in the last paragraph, the opinion, what looks good on paper may fall apart in practice. And what we did in the decision was we said, to your concern, I was concerned about the same thing you're asking about here when I was questioning the lawyers at oral argument. And we said the proposed reasonable impediment form wasn't good enough and that there had to be a catch-all box where you could put in any reason. Then we listed all the reasons.
Well, sir, I appreciate you saying all that, but this is the result. And let me go with something different from a person. You and I are nearly the same generation. I want to talk to you about somebody from a different generation that we all think is the greatest generation. Mm-hmm. They did try to get a photo ID under the law that you were a part of establishing. That was hell. And this is what it was: a 92-year-old South Carolinian named Larry Butler, a military veteran and a pastor of the Lord. He voted in the 2010 election, but in his attempt to get a photo ID, he had to chase down paperwork from his high school records, then go to get his birth certificate, then go to get court records. He went to the DMV, to the official vital records office, and the court. And after all that, actually, he still was having trouble. He still couldn't get a valid photo ID. According to the study by the Harvard Law School, the cost of his filing efforts were $36. That's how much all this process cost. Now, I'm not counting for his time. If he was working, it would have been a lot more. Yeah. And so I just want to ask you, because many people call this the modern-day poll tax that we're going back. Do you know what the infamous poll tax was in South Carolina in 1895? Do you know how much it was?
The exact amount? I do not.
I didn't think, but I'll tell you, sir, it was $1. Yeah. That was the poll tax that you and I think is despicable and disgusting. It was $1 then, which is roughly $30 today, less than what it cost the veteran pastor, Larry Butler. That's less than what he incurred trying to get to vote after the 2011 law. And if it wasn't for him holding a press conference with the governor intervening and others giving him a special dispensation. And so here is this great generation where black folks and white folks in this country joined together. They fought and they bled, they died. Goodman, Cheney, and Schwerner dying for voting rights. They grew up at a time when the states like South Carolina routinely placed these burdens on the right to vote and made it impossible and even dangerous to try to cash these votes. I don't know if you see that this isn't that much different in terms of the cost to this person of trying to ultimately do what was in effect a poll tax. Now, my time's about to run out, and I want to say you can answer after this because I've only got a minute and 30 seconds. So let me just conclude, and then I know they'll ask you this. But this isn't complicated to me, sir. Costs like this create structural barriers that systematically disenfranchise African Americans, people of color, and actually poor people of all colors. I'm concerned that a person who believes that we are all one race, like Scalia says, in the eyes of government, that could happen months from now, a couple of years from now, a person who believes that efforts to promote racial justice are, your words, naked racial set-asides, that will be blind to the reality of someone like Mr. Butler and the experiences of poor folks all around this country. You refuse to answer a lot of my questions about your views of the race and the law, talking about what Supreme Court precedent is. We are at a time when states are enacting these laws all over our country, designed to disenfranchise voters. As one federal court said about a North Carolina law, targeting them with almost surgical precision to disenfranchise them. And now we don't even have the benefit of the Voting Rights Act provision designed to curtail discriminatory laws before they go into effect. Your answers don't provide me comfort. As a justice of our nation's highest courts, that you will fairly take into account the barriers that continue to disenfranchise minority voters like Mr. Butler today. Sir, I'm an optimist. I'm a prisoner of hope like you. But we have a long way to go. We have work to do. Black folks and white folks honoring the history of a united America fighting to make us more just. The Supreme Court has a vital role in that. And nothing you've said here today gives me comfort. Gives me comfort that should you get on the Supreme Court, that you will drive forward and see that we have that work to do and make the kind of decisions that will make a difference for people like Mr. Butler, people living east of the Anacostia River, north of the river, south of the river, all over this nation. Thank you, sir.
Can I take a minute to respond?
Sure, and then I'm going to recognize Senator Lee.
Senator, a couple things on that. I pointed out in the South Carolina opinion, I wrote the majority opinion, that we see on an all too common basis that racism still exists in the United States of America. The long march for racial equality is not over. I cited, I think you've seen, after an African-American hockey player scored the winning goal, and a burst of racial commentary about him, and that was just one of many examples I could have cited in that case.
Racial commentary can be more specific?
Okay. Racist. I should have said racist. Racist comments is what I should have said online. And that was just one example I pointed to say the reality, just one example. I made clear that the reasonable impediment provision had to be rewritten. I was all over the real world effects during the trial that you're raising here. I was all over that. So were the other judges of how's this really going to work in practice? How's it we drilled down and drilled down and drilled down and caused the rewriting of the reasonable impediment provision to make sure. I talked about the fact, for example, that African Americans in South Carolina at that time didn't have as many cars on the same percentage, and so to get to your point about getting the photo IDs, I made clear that I understood that. We blocked implementation for 2012 because we were worried, to your point about the form, that it wouldn't be enough time to get all this in place and to educate people. It was a unanimous decision. Again, neither side. The Obama Justice Department did not appeal our decision to the Supreme Court. I assume that's because they thought our decision appropriately accommodated the interests of the parties in that case and would ensure that African Americans in South Carolina were able to vote on the same basis as before. And talking about my life and record, and you were talking about that, going back to growing up, but the Law Journal note that I wrote on race discrimination talked about something that I know you've been talking about a lot, which was bias in the criminal justice system. And I said at the end of that Law Journal note that both racial equality and the appearance of racial equality were critical to the fairness of the racial justice system. I provided specific mechanisms for rooting out race discrimination in the jury selection process. And talked about what you've talked about, implicit bias or subconscious racism. I specifically talked about that in that decision. I've been I think, a leader. So there's 2010 testimony before the Congress about the lack of minority law clerk hiring at the Supreme Court, and Justice Thomas and Justice Breyer were testifying before the Appropriations Committee, and they were asked about minority law clerks and the lack of them at the Supreme Court. And they said, in essence, well, we're hiring from the lower courts. And I remember reading that and thinking, well, I need to do something about that. I'm the lower court. I'm one of them. And so after that, I thought, what can I do? And I didn't just sit there. I went and thought, what can I do? And I started on my own going to the Yale Black Law Students Association every year starting in 2012. I think I'm the only judge who's done something like that, or certainly one of the few. And I just cold called them, cold emailed them, and said, I'd like to come speak about minority law clerk hiring because I'm told there's a problem there. And I showed up the first time wondering how it would go, and I explained, and I got a good crowd from the Black Law Students Association. I said, we need more law clerks. There's a problem, and let me tell you how to do it. And here's why you should clerk, and here's how you clerk, and here's how you, here are the classes you should take, and here's the things you need. And at the end of that meeting, I gave them my phone number and email and said, call me anytime, email me anytime if you want help. And then it was a big success. I got a lot of emails after that. I helped students get clerkships with other judges. One of them recently finished at the Supreme Court, emailed me thanking me for starting him on that road. And then it was a success, and I've gone back almost every year there. And as you know, we're graduates of the same law school. That's a lot of people clerk from there, so it's a good place to go. And I've continued to encourage African-American law clerks, but it's not just encouragement. I've given them help and advice and been a source of counsel. I've tried to be. And why is that? Because I saw a problem to the extent of the kind you're talking about. And it's one small thing, I suppose, but those are the future people who are going to be sitting around here and sitting here, I think. Those are the pool. And I've tried to be very proactive on that, including my own clerk hiring, where the old networks that prevented women and African Americans and minorities from getting law clerkships. I've been very aggressive about trying to break down those barriers and be very proactive on that, recognizing that part of this is professors who have research assistants. And so I've done my cases like the E.C. Ito case and the Ortiz-Diaz case, and I think the South Carolina case, I understand your concern about it, but I'm proud of what we did in that case. So I think if you look at your broader question about my life and my record, I understand what you're asking about a few comments in the Hawaii case. But if you look at the sweep of it, I hope it gives you confidence that I at least done my best to try to understand the real world and tried through my actual decisions to understand the real world and apply the law fairly, and through my other role as a judge and hiring law clerks to be very proactive in trying to advance equality for African Americans.
Senator Lee.
Sir,
Senator Lee.
Mr. Chairman, thank you. I think it's important. The rules of fairness and the rules of the committee require us to treat our witnesses with respect, with certain minimum standards of respect, such that you can't cross-examine somebody about a document that they can't see. Now, in this circumstance, the document that was referred to by my distinguished friend and colleague from New Jersey, Senator Booker, was designated as committee confidential. Now, there are ways we can deal with this. We can deal with this either in a closed session so that he can see the document to which you're referring, or we can also go about different procedures to make it public. We've already done this in this very set of hearings with Senator Leahy and with Senator Klobuchar, who identified some documents that were identified as committee confidential. The one thing we cannot do is refer to a document, cross-examine him about that document, but not even let him see it because he can't see it. We wouldn't do that in a courtroom, and we can't do that in our committee. Our rules don't allow it, so I would just suggest that we go through the proper procedure to either deal with this in a closed session or ideally go through the process that Senator Leahy and Senator Klobuchar went through in order to allow us to address this in open committee.
Mr. Chairman,
may I respond? The objection is duly noted. 30 seconds, Senator.
I really respect my colleague from Utah, and I appreciate that. I'm not the first colleague that has referenced committee confidential emails, not the ones you said at the exception. There's been they were referenced before. And that's why this system is rigged, is because we have been asking, I have letters here, sir, that have asked for. Now, the one email specifically entitled racial profiling, that somehow, I mean, literally the email was entitled racial profiling. That somehow was designated as something that the public couldn't see. This wasn't personal information. This wasn't personal information. There's no national security issue whatsoever. The fact that we are not allowing these emails out, as we have asked, as I have asked, joined a letter with my colleagues asking, and that's why I'm saying the system is rigged. More than that, Senator, you have this system where there's whole areas of his career where he
Senator, if you could begin to wrap up.
I will wrap up. Thank you, sir, for the generosity. Where there's whole areas where we're not allowed to let these out. And so I see you're outlining a process, but I'm saying that process is unfair, it's unnecessary, it's unjust, and it's unprecedented on this committee.
Okay. Gentlemen, I'm trying to be fair to everybody. I know Senator Lee wants to respond. With respect, if he would do that briefly, I'd like to continue on.
Senator Booker, I will go with you hand in hand, literally, to work with committee leadership staff to get that going. I agree with you. There's no reason why it shouldn't be something that we can discuss in public. I don't know why it was marked committee confidential. Wasn't in charge of that. Regardless, we do have to follow a procedure so that he can have access to it, so that he knows how to respond. I'll work with you on that.
Thank you, gentlemen.
Now that the
I'm
hearing's
next.
half over.
And I don't have an email. I want to start, I watched you for the last couple of days, Judge, and I want to compliment you on your demeanor. And I mean that. I know you're on your best behavior, but I appreciate your humility. We both know some federal judges who can pretty much strut sitting down. And I appreciate your attitude and your demeanor, and I mean that.
Thank you very much, Senator.
I just want to ask you a few questions about the law. I'm not going to ask you to violate the canon of judicial ethics. I'm not asking you to go thumbs up or thumbs down. I'm truly not. I may have to interrupt you a few times just to move us along. I'm not trying to be rude. I want you to understand that.
Sir.
You know, you have been nominated for the most powerful unelected position in the most powerful country in all of human history. Congratulations, but you understand also where we're coming from. There's no margin for error.
Yes, sir.
We've got to get this right. Yesterday, gentlemen, take it outside, would you? Yesterday, I talked a little bit about the fact that judges have limits on their power. And I don't know if I said it this way, but I said I think it's inappropriate for a federal judge to try to rewrite the Constitution every other Thursday to advance an agenda that either he or her supporters can't get by the voters. You agree with that?
Yes, of course, Senator. The judges interpret the law. They don't make the law, and that's obviously something that's repeated a lot, almost cliche, but it actually matters. If you keep that in mind, it matters.
Judges also have another duty, though. I didn't get to talk about it yesterday. Federal judges and state court judges have an obligation to protect inalienable rights, even if the majority wants to take them away. That's why they call them inalienable. And I said this when Judge Gorsuch was here. If you think about it, in many cases, the Bill of Rights is really not there for the high school quarterback or the prom queen. The Bill of Rights is there for the person who kind of sees the world differently, but has the right to do that. And I think that's important for a judge. Can we agree on that?
Absolutely, Senator. I think the Bill of Rights protects all of us, but that includes
And it's most relevant for free speech of the unpopular
Right.
or the unpopular criminal
Even
defense.
if the majority says
Yes.
we're the majority, because we both know that sometimes the majority just means that most of the fools are on the same side. I mean, that just because you're the majority doesn't mean you're right. Correct?
Just because you're in the majority does not mean you're right is absolutely a correct
Right.
proposition.
That's why we have a Bill of Rights.
Yes.
All right, I want to talk about, now that's the easy part. I want to talk about how we go about making these decisions, and there's a tension there, and that has to do with the language. If I talk about, and you've talked about it a little bit, but if I talked about the Holy Trinity doctrine, you'd know what I'm talking about, I'm sure.
Yes.
Okay. Now, the Supreme Court has rejected the Holy Trinity doctrine.
Right.
Okay.
Yes.
You talked about we're now textualists and are originalists, and you call the originalism constitutional textualism, I think.
Original public meaning,
Right.
originalism, constitutional textualism, I think those describe the same thing.
Okay. You start with the language. Let's take a statute, with the language in the statute.
Yes, sir.
And the first question you ask as a textualist, is it ambiguous or unambiguous? Correct?
If there's a canon of construction that is there that depends on a finding of ambiguity, that would be the question. Otherwise, other than that, you would just see what's the best meaning.
You read the statute.
Yes,
And
read the
say, does
statute.
it make sense? It either makes sense or it doesn't. How do you determine that? How ambiguous? You alluded to this, but how ambiguous does it have to be? Does it have to be 100% ambiguous?
Right.
Does it have to be 51% ambiguous? Is there really any principled way to compare clarity to ambiguity? Or do some judges use it as an excuse to get to those canons of interpretation about which they've already read in the brief to do what they want to do? Did you know?
Yes. So I've said many times in my cases and talks to students that judges shouldn't be snatching ambiguity from clarity. So that's one thing. I think that goes right to your question. But to your broader question is, that's one of my concerns about a few canons of construction that depend on an initial finding of ambiguity, which sounds great in theory, which is, oh, if it's ambiguous, go to that canon or this canon or this canon. But in practice, over 12 years, what I've found, and I've written about this, is that there's not a good way to find neutral principles on which two, or in my case, three judges can agree on how ambiguous is ambiguity. And that's hard to even talk about with you. Oh, I find it ambiguous. I don't think it's ambiguous. And that is, in my view, frustrated the goal that I have of the judge's umpire, the even-handed application of neutral principles in the rule of law, and ultimately that's concerned me because some of these cases where that's come up are big deal cases, yet it's dependent on this initial determination that when you unpack it and you actually sit in the judicial conference room like I do, it turns out to be very hard to apply in an even-handed way. So that's been the concern I've identified.
I read your review article.
Yes.
You advocate the best reading of the statute.
Mm-hmm.
Okay.
Yes.
Okay, let's talk about that. And I want to talk about it not in terms of the statute, but the Second Amendment, and talk about the Heller case. You defined originalism as constitutional textualism, and the way to interpret the Constitution is to ask yourself. Tell me if I get this wrong now. How would a reasonable person at that time have understood the Constitution? The public knowledge.
The original public meaning. I always want to add, of course, precedent is a huge part of what we do in constitutional law, but if you're looking at the words, the original public meaning, you look at what the words mean. Sometimes the meaning's changed, oftentimes it hasn't, but to your point, I agree.
And it's almost an objective test.
You're trying to make it as objective as possible, absolutely.
It is an objective test. I mean, sometimes there's different evidence about what the meaning of the word was, I think.
Sure, but you're not looking at intent.
Correct. You're not looking at the subjective intent other than to the extent that helps show the
We've thrown that out.
Yes.
Okay, if you look at the Heller case, and I'm talking about the D.C. v. Heller by the U.S. Supreme Court, it wasn't a balancing case.
Mm-hmm.
You made that point clear at the Court of Appeal level. It was a text, history, and tradition case.
Mm-hmm.
And Justice Scalia wrote the majority opinion. Justice Stevens dissented, and they both took an originalist approach. And I went back and looked. Scalia, this is what he relied on. He relied on founding-era dictionaries, founding-era treatises. He looked at English laws, American colonial laws, British and American historical documents, colonial-era state constitutions. He looked at post-enactment commentary on the Second Amendment. And Justice Stevens, also using an originalist approach, looked at the same documents, and then he relied on linguistic professors, an 18th century treatise on synonymous words, and a different edition of the colonial-era dictionary that Justice Scalia used. Pretty impressive. Here's my question. Doesn't the originalist approach just require a judge to be an historian? And an untrained historian at that?
I mean,
wouldn't we be better off hiring a trained historian to go back and look at all of this commentary?
Well, the Heller case was one of the rare cases where the Supreme Court was deciding the meaning of a constitutional provision without the benefit of much, if any, relevant precedent. On most of the constitutional provisions, there's been a body of cases over time interpreting the provision, and you don't have to do the kind of excavation that Justice Scalia and Justice Stevens did in that case because it's been done before. The reason I think why the Second Amendment posed a challenge in that case in terms of figuring it out is the prefatory clause in the Second Amendment, which the question was did that define the scope of the right indicated afterwards, the right of the people to keep and bear arms shall not be infringed, or did the prefatory clause merely state a purpose for which the right was ratified, and therefore you read the right as written, the right to keep and bear arms shall not be infringed. And to figure out what the prefatory clause meant, you had to figure out as a general proposition how legal documents at the time used prefatory clauses and what the purposes of those were, and that required a lot of historical excavation by the two justices who had the competing positions.
Okay, fair enough. Somebody commented yesterday, maybe it was you, Judge, they talked about how our judiciary was one of the crowning jewels of our government, and the fact that it separates us from other countries.
Yes.
I think one of the reasons so many of our neighbors in the world want to come here is because of our independent judiciary. They know their person, their property will be protected. I think that singles us out. You know, you never read about somebody trying to sneak into China. They want to come to America. But there have also been studies, I think Senator Booker talked about this, maybe it was Senator Whitehouse. People have, in America, many of them think the United States Supreme Court is a little Congress, that is political. And that's unfortunate because that means we lose confidence in an independent judiciary. I'm not saying it's true, but perception is important in government. Do you think having cameras in the courtroom would help?
Senator, that's an issue that I've thought about. And let me just give you a little perspective on our court. We've gone to same-time audio in our court. We started with release of tapes much later, then release of tapes later in the week, then release of tapes later in the day, and now we're same-time audio in our court. And I think that's been that's worked at the Court of Appeals level for us. I know nominees who've sat in this chair in the past have expressed the desire for cameras in the courtroom only to get to the Supreme Court and really change their positions fairly rapidly. So that gives me some humility about making confident assertions about that. And of course, joining a team of 9 means thinking about that if I were fortunate enough to do so, in hearing the perspectives of why did they change their position, what's their view. I will say one thing about that I do think is important. Oral arguments are a time for the judges to ask testing questions of both sides, and there's a perception sometimes, and you see it in the media, that the oral argument, Judge X is leaning this way at oral argument. I really can't stand that kind of commentary about oral argument, because I, at least, have always approached oral argument as the time to ask tough questions of both sides, and I do sometimes wonder whether people would get the wrong impression of oral argument. Now, I've always thought, too, though, the announcement of the Supreme Court decisions, when they issue the opinions, that's a different point in time when if there...
What did you say Justice Marshall said? People aren't fools?
Well,
you have to trust the people sometime, Judge.
And as to the decisions, right, that's when the court is announcing its decision, and that is the decision of the court. Oral argument, lawyers people are asking tough questions of both sides, and sometimes you would think, oh, Judge X thinks this because of the oral argument question.
I understand.
But the decisions, I think that's, let's put it this way, if I were starting, I think I'll stop there.
Well, I get your point, and they're good arguments on both sides, but I do think that the American people have lost confidence in the institution of the Supreme Court and Congress and the presidency. And it's ironic, given my generation, that the only institution that the American people I think have a lot of confidence in right now is the military, which wasn't true in my era.
Well, that shows.
But you know, you got to trust the people, and too many up here in the Beltway don't.
I agree with your general.
You know, they don't. The people don't read Aristotle